The committee will come to order. We are meeting this morning to consider 4 bills within the committee's jurisdiction. We will consider each bill individually with a separate opening statement and a separate walkthrough for each. I will begin by my opening statement, and then I will recognize Mr. Levin for any opening comments. I understand that House will have votes this morning. The committee will recess when the votes are called and then resume business immediately after the vote series. Before I get started, I want to remind everyone that under the rules of the House, the chairman is responsible for maintaining order and preserving decorum in the committee room. I expect audience members to be respectful of the witnesses and of the public. We have our staff director of the Joint Committee on Taxation, Mr. Barthold. We have the counsel of the USTR. Tim, is that your title? General counsel at USTR, Tim Reif, no stranger to the committee. And we have our staff director and counsel for the majority staff trade subcommittee, Ms. Ellard, who will be doing the walkthroughs. So let me just get started. I think I picked the right morning to do my yoga. We're going to have a long day. We need to all keep our cool, I think. This is an issue that has passion on both sides. We all want a healthier U.S. economy. We all want American workers to succeed. We all want more jobs. And we all want America to continue to lead in the world on the economy and all these other fronts. We sometimes disagree on how best to achieve that goal. And so I just hope that for this day's markup, we're going to have lots of amendments. We're going to have lots of debates. Let's respect each other's views. Let's operate the committee with the kind of decorum that we're accustomed to doing. And I anticipate and expect a healthy and vibrant debate, and this is the legislative process. I'm going to talk about more about TPA, but I want to start with a couple general things. The reason we are doing all of this is to promote American trade. The more we trade with other countries, the more opportunity we will have in this country. And the stronger ties that we will have with our allies, the more credibility we will have on the world stage. So what we're doing here today will make America stronger, will make America more prosperous, will make America more secure. All of these bills are crucial to promoting American trade and promoting free enterprise around the world. So I want to thank all of our members for their hard work. Everybody on this committee cares deeply about these issues and has been very involved in this process. And I look forward to bringing this legislation to the floor. I'll say more about the various bills as they come forward. Yeah, so, okay, we'll be brief and then we'll do on the opener. So let me just turn it over to Mr. Levin for any opening comments.
Thank you very much. I very much agree with how you describe how we should proceed. I very much agree with your statement about the importance of trade. We've been working, so many of us, to expand trade, to be sure it's done in the right way, to expand trade, to shape it so that the benefits are spread. And so we need to discuss these issues. It isn't a matter of pro or anti-trade. It's not a matter of free trade versus fair trade in a sense, though I think free trade has to be fair. It's not a matter of protectionism. It's a matter, as we expand trade, we expand opportunities overseas, but also for our people. So I hope we proceed within that spirit. We have some very serious questions about the TPP bill as it is now in process. Our bill, our substitute, addresses these issues. I understand kind of at the last minute there's been a question raised regarding the rules and I guess germaneness. I hope very much that which has been raised at the very last minute after we were told that our bill was within the rules will not prevent our having a thorough discussion of our substitute. There are 4 bills up here. The preference bill, which we support, Mr. Rangel will do the opening statement. I will do that in terms of the TPA bill and our substitute. We have a number of amendments. We then will go to the TAA bill, where we have some very serious questions regarding the pay-for. And then the customs bill, I understand there's been some further discussion between members on our side and your side, and we'll see if we can dispose of that bill without some broad, deep disagreement, since I think except for one issue, we're in agreement, but we also will have some amendments to that customs bill. So let's proceed, and once again, Mr. Chairman, within the spirit that we're trying to expand trade, but in the right way, but also I hope within the spirit that we don't let a rules issue prevent our having a thorough discussion and a vote on all of these issues. Thank you.
Let me just respond. We won't end debate on that. So it's a Rule 10 germaneness issue, and putting that aside, I want you to have what you need to debate your substitute. So let's have a thorough discussion. Let's have a walkthrough. Let's have a debate on your substitute. But because there is a Rule 10 violation, we will obviously uphold that. But it won't be until after we have discussed thoroughly your opinion, your thoughts, and your substitute.
Let me just say that's been raised at the last minute. I don't understand why in your bill there are references to congressional role, but we cannot provide it in ours. But let's discuss that later.
Okay.
I think it would be a serious mistake to let what is allegedly a rules issue stand in the way of having a deep, substantive discussion about where TPP is, where it isn't, where it should go, and what should be the role of Congress as TPP is further negotiated.
It
so
won't.
I just hope that we don't let process stand in the way of a thorough discussion of policy and a vote on that policy. No. And I also hope that it won't be that if a vote is prevented here, that we have to do it by challenging the ruling of the chair. I would also hope that that kind of a rules discussion would not prohibit or prevent the ability for the minority to raise a substitute on the floor of the House. Because I've heard there might be a way, if there's an objection here, though the issues discussed in your bill, that the same might be tried on the floor of the House, and that would be a serious mistake. Trade policy deserves better than that, to be tied up by what is allegedly a question of rules. Thank you very much.
The gentleman states his point. The first order of business is the AGOA Extension and Enhancement Act of 2015. Mr. Teaberry, you are now recognized for an opening statement on this bill.
Thank you, Mr. Chairman. Thank you for your leadership. I'd like to acknowledge the bipartisan work on this bill, and I'm so glad that Chairman Ryan, Ranking Member Levin, and I, and Trade Subcommittee Chairman Rangel have all been able to work together along with Representatives Young and Representative McDermott in a productive bipartisan way. In particular, the entire process of developing this long-term extension and enhancement of AGOA reflects the strong bipartisan commitment that has always surrounded this bill and the bipartisan commitment of this committee. AGOA has been a clear success in economic development and national security terms. In the 15 years since it was first enacted, it has become the cornerstone of our relationship with Africa. Since AGOA was enacted, trade has tripled and investment has grown almost six-fold. By one estimate, AGOA supports well over 1 million direct and indirect jobs in sub-Saharan Africa and about 100,000 jobs in the United States of America. And we know that countries that participate in AGOA have higher average incomes per person and higher good governance scores, including on rule of law and political stability criteria, than sub-Saharan African countries that do not participate in this program. The bill we are considering today will extend AGOA for 10 years, the longest extension that Congress has ever considered. It will also strengthen the program by simplifying certain rules of origin, encouraging greater regional integration, building in additional flexibility, improving certainty and predictability, and expanding transparency and participation in the AGOA review process. For all of its success, we have also heard concerns about conditions in sub-Saharan Africa, including very significant concerns about South Africa on issues that affect agriculture industries in poultry and in pork. I've heard that from producers in my state. This bill provides new mechanisms for addressing these concerns, including a petition process and an out-of-cycle review. This bill also renews the generalized system of preferences program through 2017 and provides retroactive relief to eligible products that were imported during GSP's lapse. GSP promotes economic development by providing duty-free treatment for approximately 5,000 non-sensitive products. 5,000 non-sensitive products from 126 developing countries. GSP helps companies in Ohio, like the Cannon Group in my congressional district, so they can grow their businesses and ultimately create more jobs. Finally, the bill ensures that Haiti will continue to benefit from the Hope and Help programs by extending those preferences through 2025. This will encourage continued investment in Haiti and support its economic development and recovery efforts. I'd like to yield to Representative Young, who's been a strong voice for Africa and represented this committee at last year's AGOA Forum and Leader Summit, for the remainder of my time.
Well, thank you. I'd like to thank both Chairman Ryan and T. Berry for their dedication to swiftly extending AGOA and the GSP program this Congress. This impressive bipartisan effort reaffirms Congress's commitment to Africa. And I'd reiterate, it was achieved in no small part thanks to the tireless efforts of my good colleagues, Mr. Rangel and Mr. Levin. This 10-year extension provides for the long-term development of sub-Saharan Africa and will be vital to attracting investment in the region, creating jobs throughout Africa, and as importantly, of course, creating jobs here at home in the United States. The improved bill enhances transparency to beneficiary countries and ensures predictable notification timelines should countries fall out of compliance with fair trade practices. Again, I appreciate the efforts of our senior leadership on this committee, as well as our countless African partners, and I look forward to continuing to advance this strategic partnership, and I yield back.
Gentlemen, Mr. T. Berry, yield back as well? Okay. Mr. Rangel, you are recognized for an opening statement on AGOA.
Thank you, Mr. Chairman, and thank you, Mr. T. Berry, and also thank you, my colleague and friend, Mr. Levin. This is an emotional issue with me, not only from an economic point of view as to what's best for the United States, but when Jim McDermott was saying that we have to do something for developing countries to be able to participate and to be partners in terms of improving the economies of their countries and ours at the same time, it seemed like an emotional national security economic type of thing where America has to show that we're just not motivated by profit, but we are concerned about the quality of life for people all over. I don't want to cause you any embarrassment, Mr. Chairman, in terms of your cooperation and bipartisanship. I know that's not very popular at this time, but the truth of the matter is there was just serious threats that we're going to take this bill that everyone felt that had to be corrected, had to be improved, that we're going to take the general specialized preferences and make it complicated and throw it into the Trans-Pacific Partnership. It was a frightening thought, but those things happened. But because of your leadership, Senator Hatch, and Republicans and Democrats, this has been set aside so that we can move forward. And there was a lot of controversial things that could be raised on both sides, but in an effort of getting this out the way and making up for the delays that we have, I want to thank the Republicans and the Senate for keeping this apart to make America proud and to help these countries join the developing countries in improving the quality of life for them and workers on both sides of the ocean. Thank you so much.
Thank you, Mr. Rangel, for your leadership. And this law would not have been where it is if it weren't for your leadership on this issue over the years. The committee will now proceed to consideration of H.R. 1891. Without objection, the measure will be considered as read and open for amendment at any point. I will now turn to Angela Allard, Staff Director of the Trade Subcommittee, to provide a description of the trade provisions in the measure, and Tom Barthold, Chief of Staff to the Joint Committee on Taxation, to discuss the revenue provisions, as well as Tim Reif, General Counsel at the Office of U.S. Trade Representative. I ask all members to hold their questions until after the presentations. Ms. Allard, why don't we start with you?
Thank you, Mr. Chairman. Ranking Member Levin. H.R. 1891 is the AGOA Extension and Enhancement Act of 2015. Title I contains the AGOA provisions. Section 103 extends AGOA and the special rule of origin on third country fabric from September 30, 2015 to September 30, 2025. Section 104 contains provisions relating to promoting greater regional integration, allowing the accumulation of the direct costs of processing operations performed in one or more of the sub-Saharan African beneficiary countries. Section 105 contains provisions relating to monitoring and review of eligibility. New provisions providing for at least 60 days notification and explanation to Congress and the sub-Saharan African country in question of his intention to terminate the designation of any such country as a beneficiary. Section 105 also allows the President to withdraw, suspend, or limit duty-free treatment if he determines that such treatment would be more effective in promoting compliance with the eligibility requirements than simply terminating benefits. There are also provisions requiring an annual review, a request for public comments, a new petition process. In addition to that, in Section 105C, the President is authorized to initiate out-of-cycle reviews with respect to any beneficiary sub-Saharan African country at any time to determine whether it is making continual progress in meeting the eligibility criteria. The President is to consult with Congress during this investigation. In addition, the section expresses a sense of Congress that the President should initiate within 30 days of enactment a review of South Africa or any other beneficiary country that is not in compliance with AGOA. Section 106 contains biennial AGOA utilization strategies. Section 107 contains provisions to deepen and expand trade and investment ties between sub-Saharan Africa and the United States. Section 108 contains some new reports. Title II contains an extension of the generalized system of preferences, extending it until December 31st, 2017, and applying it retroactively until when it had expired, July 31st in 2013. Section 202 contains provisions relating to cotton to put us in compliance with our WTO obligations. And finally, Title III contains provisions relating to Haiti, extending Haiti preferences through 2025. The bill is offset in part, Section 401 with customs user fees, and I turn to Mr. Barthold about the remaining revenue provisions.
Thank you, Ms. Ellard. Corporate taxes are due in 4 quarterly payments that are to equal 100% of the corporation's tax liability for the year. The provision in Section 402 of the legislation would increase the required payment amount that a corporation would make in July, August, or September of 2020 by 5.25% and provide an offsetting reduction for payments that are otherwise due in October, November, or December of 2020 by an equal 5.25%. The effect is to have the increased amount of 105.25% earlier, reduced amount 94.75% of the otherwise payable amount later.
Thank you. Anybody have any questions for Mr. Doggett?
Thank you very much. With reference to the eligibility criteria, if under the generalized system of preferences, if some country steals intellectual property, is there a remedy? If a country is not doing what it should to protect U.S. intellectual property, is there a remedy with reference to GSP?
Yes, Mr. Doggett, in the underlying GSP statute, the eligibility criteria do refer quite strongly to intellectual property, and then the administration would implement those
Has that
standards.
ever been enforced? Has action ever been taken on intellectual property?
I would let the USTR, who
Okay.
administers that statute, to answer that question. Has IP ever been used to terminate?
Morning, Mr. Doggett.
Good morning.
Yes, intellectual property, the two criteria that have been applied in suspending a country from GSP have been intellectual property and labor standards.
And that's been done before, where you suspended benefits because a country was stealing intellectual property or permitting the stealing of intellectual property. And with
Fairly,
reference,
yes.
and is there also a provision then that protects labor rights?
Yes, labor is the other area where we've acted.
How long has the complaint concerning Uzbekistan been pending on labor rights? Some say it's the #1 country in the world in terms of organized forced labor, and there have been complaints for many years, haven't there?
So I don't know if I can describe the way, though, that our office works when labor complaints are raised under the GSP statute. We have an office that deals with GSP, and also our labor office, our regional office, would all be involved. Typically, what we try to do in instances like this is to work with the country. We've had success in a number of instances, for example, some years ago in Central America.
Have you had success in Uzbekistan, or has anything been done about the years of complaints that have been pending there? I know
I'm
there was
not-
a hearing
not-
about giving these benefits to Uzbekistan.
I'd be glad to get back to you on that, sir. I don't have current information on Uzbekistan.
Do you have current information, if this bill is passed and it provides retroactive benefits, how much money we will be sending to Yemen, which is another of the beneficiaries of GSP?
I would have to look into that, sir, in terms of the level of imports that might have come in.
If a country is trading in rhino horn or ivory or some other endangered species, is that a basis for denying GSP benefits?
We have other statutes under U.S. law that deal with the Treaty on Trade in Endangered Species. It's not,
Yes.
and so we work with countries on that. It's not a criterion under GSP.
So
We have
does
other
that-
statutes that we use.
Does that mean that if a country were trading in endangered species, violating its CITES obligations, that it could be denied the benefits of GSP?
Well, we have an import regime that covers trade in endangered species that is
Yes, which is separate
and
from
actually-
GSP. And I'm just asking you, there are intellectual property provisions, there are working condition or labor provisions. Under GSP, there are no environmental criteria, are there?
But Mr. Doggett, if you're not able to import the product, it wouldn't benefit from GSP.
Thanks. But my question is,
So it actually,
are there any environmental criteria of the type you mentioned that exist for intellectual property and for labor conditions under GSP?
right, there are no environmental criteria on GSP, but through our Customs Administration, there are other areas where the restrictions are actually stronger because there
That
may
might
not
be
even
true about imports
trade.
into the United States, but it would not, you would not be able to do anything about imports from one country to another, other than the United States, that was actively trading in endangered species.
That's correct, but that wouldn't be available under GSP either, sir.
Will you be able to get back to us in this week or next on how much retroactive benefits are likely to go to Yemen and the other countries under GSP?
Sir, if those data are available, if they can be derived from our customs or our census service, we would be happy to provide those to you.
Do you have any basis, given the current conflict in Yemen, for example, in suspending those benefits under this legislation, or will we just send a check?
Well, if there were issues as to any particular country, suspension going forward under GSP, we would want to look at those carefully, sir.
Thank you very much.
Yeah.
Thank you, Mr. Chairman.
Thank you. Does anybody else have a question for the witnesses? Anybody wish to strike the last word? Mr. Levin's recognized.
Thank you, Mr. Chairman. I just want to say a few words as we pass this bill. that we take note of its background, the work that was done on these different parts, and also to emphasize these are examples, these bills, of expanded trade, but paying attention to their impact, paying attention to the impact overseas, but also the impact here in the United States. We've been careful as we've worked on these bills to make sure that they're done right, as I said, and to take into account what would be the impact on jobs in our country as well as jobs elsewhere. That's been true of all of these bills. Mr. Rangel, Mr. McDermott, and others, Phil Crane, who passed away, worked on this, always trying to make sure there was expanded opportunity for African nations, and that it be done in a way that we were careful about the impact on companies and workers in the United States of America, always. And the same was true of the Haiti bill. Mr. Rangel is being modest about it. It was difficult to put together, very difficult, because it was necessary to help the Haitian people. It was also to be done in the way that understood the impact on jobs in the United States of America. And so a balance was found. And I think it's important that we continue this balance. And I now want to say just a few words about GSP, because the same is true of GSP. As we provide these preferences, we always need to take into account what the impact will be on conditions overseas, but also the impact on jobs and companies in the United States of America. We don't provide these preferences blindly. We don't do so simply assuming that more trade is always better, no matter which way it flowed. We've had, I want to finish with this, an issue as to the preference bill in Bangladesh. A number of us pressed the administration to withdraw GSP from Bangladesh because of the immense problems there in terms especially of the textile industry. And we did so even though textiles are excluded from GSP. But we wanted to send a clear signal to the government of Bangladesh and to the companies that operate there, and also our companies that purchase the apparel from Bangladesh, that the status quo in Bangladesh was simply unsustainable, that having 1,000 people die because a building collapses, working under horrible conditions, that we could not continue to be a party to that. And so, with some major back and forth, the decision was made to not extend GSP to Bangladesh. And that's another example, I think, of how important it is to do expanded trade in the right way, to really insist that more isn't always better, that simply having cheaper goods come into the United States is important, but isn't the only consideration, that you also had to look at the conditions under which people were making those products, and therefore the conditions under which we were buying those products. So, Mr. Chairman, I favor this bill. As we do so, I think we should remember the framework within which each of these bills has been tailored, and I think it's a tribute to those who have worked on this on both sides of the aisle that we today, in good conscience, can now vote to extend these three bills.
I believe, Mr. Doggett, you wanted to seek recognition?
I
And
do.
then I think
I move to strike the last word. Thank you.
gentleman's recognized.
Thank you, Mr. Chairman. I too support the African Growth and Opportunity Act, and I think the concept of general GSP or general system of preferences has merit also. The real focus of today's hearing, of course, is on high-speed rail and how fast the fast track will occur. It is not unrelated to this particular piece of legislation. The GSP program expired last year. Bipartisan legislation was offered at the beginning of the last session to continue it, but there were some people who thought that it might help provide a little more speed for that high-speed rail and get fast track passed. And that's why I think that the AGOA bill and GSP linger at the current time rather than having already been resolved. The benefits of AGOA are significant in some places. They're not unqualified. One of the countries that has gotten benefits is Zimbabwe. Rule of law has apparently not been a benefit of trade there, given its very troubling past. The other area, though the General Counsel of USTR is not familiar with the background, is that Uzbekistan, there have been complaints about labor right violations since before 2010 when USTR put it on the watch list, again in 2011 when it was put on the watch list, again when USTR conducted a hearing in January of 2012. As recently as last month, a labor rights consultant was thrown out of the country. He was one of the more fortunate ones because the thug who runs Uzbekistan has been known to boil his opponents. The country has the largest state-organized system of forced labor in the world, apparently involved in perhaps as many as 1 million people involved in forced labor, and yet GSP benefits continue, and we will be sending a check for back benefits there. I think it's important, just as the AGOA bill and the GSP bill are really about getting votes for high-speed rail fast track, that it's important to consider how meaningful the labor rights guarantees in the fast track proposal and TPP are against this backdrop of what has not happened with Uzbekistan. Because while the complaint has been pending for years, all we've had is talk and a hearing and total inaction to address an incredibly abusive system. I had intended to offer an amendment concerning environmental criteria in GSP. There is an understanding that the only way at this point GSP can move forward is if it has no amendments from anyone. So I will not offer that amendment, but I think we should not be approving any trade legislation that does not have environmental criteria. And the short answer to the question that I had some difficulty getting an answer to is that while having environmental criteria might be as meaningless because of indifference and failure to implement as it has been with the criteria that do exist for labor rights in Uzbekistan and other countries, I think it should be there. And that if a country is trading in endangered species, if it's violating its other international agreements concerning the environment, that ought to at least provide a basis for denying benefits. It has to be evaluated in the overall context. But at present, this GSP provision has no environmental criteria whatsoever. And finally, I think the committee is acting without really knowing the full consequence of its actions. If you look over the list of countries that will get GSP benefits, there are many countries well-deserving. One of those countries is Yemen. And I think before we act on the floor, we ought to know exactly how many dollars to the country that we have some rather significant differences with at the time will be flowing to Yemen under this act. So I plan to vote for the bill, not offer an amendment that would slow its passage, but I think these are important considerations as we move forward to the floor and consider the other issues that we have today and whether USTR is capable of enforcing under the current approach labor rights or environmental rights. And I yield back and thank you for the time.
Absolutely. Did you have a point you wanted to make, Mr. Reif? I saw you raise your hand.
Mr. Chairman,
An
thank you.
answer to a question you wanted to provide?
May I make two brief comments on behalf of the administration?
Sure.
Very briefly. First, just to say the administration is very appreciative of you and Mr. Levin, the committee, marking up these extensions. They're very important to the efficacy and utility of these programs, GOA and the Hope Help programs and GSP going forward. And the second, Mr. Chairman, is that the role that this committee has played over a number of years with respect to the preference programs is a legacy that I think is terribly important for every member of this committee. Mr. Levin mentioned current and past leadership, Mr. Crane and others, who played a critical role. And since 20 years ago in the Uruguay Round Agreements Act, when 5 reports were called for with respect to trade between the United States and Africa, was the first time that that issue began to receive attention. And building on that legacy consistently and persistently, all of the leadership of this committee on both sides of the aisle have worked, and with their excellent staffs, have worked to improve those programs. It's still a work in progress, but the improvements to Americans' lives and to the lives of people in those countries have been very important. So I wanted to leave that in the minds of every member of this committee. Thank you, sir.
Thank you. Just to clear up any confusion, we are not marking up high-speed rail today. Mr. Blumenauer, you'd like to move to strike the last word?
I would, Mr.
The gentleman's recognized.
Thank you very much. I have appreciated the opportunity, Mr. Chairman, to discuss with you and staff on our side the inclusion of a couple of provisions that have had broad bipartisan support in this committee. The Outdoor Act, which I've worked on with Mr. Reichard, and I think will be reintroduced again, the Athletic Footwear Initiative. These are areas that would make a big difference for the areas that I represent, developing specific classifications for performance outerwear, eliminating duties on such products, that deals with, in the area of footwear, where it deals with the notion that simply having waterproof protection puts it in a different classification, penalizes consumers with a pretty significant financial penalty. We've been working, I understand, Mr. Chairman, that we'll be able to proceed going forward. There are provisions here in terms of costs. I appreciate your willingness to work with me as it moves forward and on into conference. On that basis, I'm not going to introduce any amendment or go through the formality of introducing and withdrawing, but I want to indicate that I appreciate interest in working with us on these two bipartisan provisions and look forward to working with you to see that we can get them in the final package.
If the gentleman will yield, I think the gentleman's proposals have a tremendous amount of merit. We just need to see what we can do to move on it, and I look forward to working with you in the days to come.
Thank you. I yield back.
Mr. Chairman.
Mr. Reichert.
Thank you.
Mr. Reichert.
Well, I just want to add my support to Mr. Blumenauer's comments, and we have worked on this together and appreciate the chairman's willingness to work with us. This is very important to our community in Washington and Oregon, as you probably guessed, and had the opportunity to work with Mr. Blumenauer for several Congresses on this measure to make apparel more affordable and to encourage participation in outdoor activities. In the Pacific Northwest, the enjoyment and exploration of the outdoors is not just a cornerstone of American recreation, but it's also the basis of major job-creating industry for us. So I appreciate the chairman's comments.
Absolutely. I think that both gentlemen have merit, and it's something I look forward to working with them on. I think we're going to, Mr. McDermott, I think, did you want to be recognized? And Mr. Desai.
Thank you, Mr. Chairman. I strike the last word.
Gentleman's recognized.
I learned a long time ago not to talk very much if you got the votes. But I think it's necessary at least to say that when we started this in 1992, it was a single amendment in the NAFTA bill, which was the Democrats were in control. By the time we got the bill together, the Republicans were in control, and the first person who testified for this bill was Newt Gingrich, sitting right out there. It's hard to believe with Africa, with respect to Africa, that in 1992 there was no one at USTR, There was no one at Treasury, there was no one at Commerce, there was no one at State who had responsibility for trade policy for Africa. That's where we were 20 years ago. And to be here today with an extension of this nature is really a major step forward, and my hat's off to you, Mr. Chairman.
Absolutely. Mr. Bustani, do you move to strike the last word?
Yes, I do. Thank you, Mr. Chairman.
Gentleman's recognized.
Mr. Chairman, I strongly support this legislation, but I want to focus on the Generalized System of Preferences program and highlight some things that have happened since the expiration. Expiration has cost American companies more than $1.1 billion in new taxes, and Louisiana companies have paid nearly $20 million of that in my home state. Just to highlight a further example, in my district alone, one company, K2 Coolers in New Iberia, a small town, is one of the companies that's been hurt by this expiration. This company, it's a small business, paid about $80,000 in new taxes last year because of the expiration. And this is at the expense of hiring new people and creating new jobs. So I urge our colleagues to support this wholeheartedly. It's good legislation. And I yield back.
I thank the gentleman. Mr. Crawley, did you move to strike the last word?
Yes, I do, Mr.
The gentleman's recognized.
Mr. Chairman, thank you. The GSP program is something that many of us here all agree on. I just have a couple of clarifying questions, if I can take this moment. Is there anything in the GSP program or the legislation before us that would preclude minority groups in a country from participating in the program, whether that is on the basis of religious belief, ethnic minority status, or sexual orientation?
Mr. Crowley, there isn't anything specifically in the legislation that addresses that issue, no.
Thank you. I think that's a useful point to have placed on the record, so thank you for your answer. Because in some of the countries that get GSP benefits, there are minority groups that face real discrimination, whether we're talking about Christians in Pakistan, the LGBT community in Uganda, or the Copts in Egypt. Those people, if they want to participate in the GSP, should not have their goods blocked on the way to market because there is nothing in the U.S. GSP program that would encourage discrimination against those minority groups. I would add women to this list of groups who face discrimination because we all know that in some countries women face very real problems. Mr. Chairman, I'm not going to offer an amendment to the GSP bill today, but I would like to work with the majority on this issue to ensure that countries who participate in GSP do not work to prevent minority groups who may have different beliefs or lifestyles from participating in this program. Our development programs like GSP should be available to all peoples within those countries, not contribute to discrimination or enrichment of those unjustly in power solely. So, Mr. Chairman, thank you.
I think the gentleman from his concern, his point is duly noted and made. Are there any others who seek recognition to strike the last word or to ask questions of the witnesses? There seeing none, are there any amendments to the bill? If there are no amendments, I will now recognize Mr. Johnson for the purpose of offering a motion.
Mr. Chairman, I move the committee favorably report H.R. 1891 to the House of Representatives.
The question is on favorably reporting H.R. 1891. All those in favor signify by saying aye.
Aye.
Those opposed signify by saying no. In the opinion of the chair, the ayes have it, and the motion is agreed to. You want a roll call? No? What do you want to do? All right. H.R. 1891 is ordered favorably reported. Without objection, I ask that the staff be authorized to make technical and conforming changes to the bill, and that members may have 2 additional days to file with the committee clerk's supplemental, additional, and dissenting minority views. I think the next one will go just as well, correct?
Which bill are we going to take up?
We're doing TPA now. Yeah. All right. The second order of business is the Bipartisan Congressional Trade Priorities and Accountability Act.
What do you mean by that?
All right. So let me just start with this. TPA, as we all know, Trade Promotion Authority, it's a process. It's a process for negotiating and considering trade deals. Some people wonder why we care so much about this process, but that's only because a good process will get us a good result. We are negotiating a lot of trade deals right now. And our negotiators, they need this process in place so they can get a fair deal for the American worker. The reason is our trading partners will not make concessions if they don't trust us. If they think Congress will simply rewrite the deal, then they won't put their best offers on the table. So Congress and the President together have to provide a united front. And what I think is particularly impressive with the moment we are in, this is on a bipartisan basis. And by the way, there's not a lot of bipartisanship going around these days. So I think it really is fairly noteworthy that what we have here before us today is a Republican majority Congress working with a Democratic president on a united front to put good trade agreements together. Now, some people think that that means Congress needs to defer to the administration. Far from it. What we're saying here is that the administration needs to defer to Congress. TPA puts Congress in the driver's seat because we set the agenda. What we say to the administration is, first, here are the negotiating objectives. Tear down our barriers to exports. Beef up protections for intellectual property. Get rid of kickbacks for government-owned firms. And many, many, many more. Second, here are your transparency and consultation requirements. Every member can read the negotiating text. Every member can attend the negotiating rounds if he or she chooses to do so. And 60 days before the administration finalizes the deal, it's got to publish the full text of the agreement so that the American people can read it for themselves. Third, if the administration does not meet all of these requirements, then we can revoke TPA for that particular agreement. Congress gets the final say. But if you do meet all of these requirements, then we will vote on the deal in a timely manner. This strikes the right balance in my judgment. Once we show our trading partners that we are trustworthy, then they will put their best offers on the table. And look, many of us have met with these foreign governments, with these leaders. They are waiting for us to do this so that they can put their best and final offers on the table. And it's very clear to many of us who have spoken to these leaders, we have one coming next week, the Prime Minister of Japan, they're waiting for this in order to put their best offers on the table. So why are we doing all this? Because more American trade, it means more American jobs. Let's never forget the fact that 96% of the world consumers, 96% of the consumers of goods in the world, they don't live in this country. They live in other countries. So if we want to create more jobs here, we need to open those markets. We had 3 cabinet secretaries from this administration telling us that by the year 2030, we're going to have something like 3.2 billion people in Asia entering the middle class. This is an enormous opportunity, an enormous market for our American workers. Other countries have been keeping our products out with all sorts of trade barriers, denying us of these opportunities. We have a unique opportunity to write the rules of these trade deals to tear down these barriers and to open up these markets for American products. And TPA will increase our bargaining power so that we get the most effective trade deals possible. So we tear down more trade barriers and create more opportunity right here in America. If we don't do this, countries like China are more than happy to step in and write the global rules. I think that's the big point here as well. We are in the 21st century. So many new issues are emerging. You know, cross-border data flows, intellectual property, the rule of law, investor-state dispute, all of these things are in flux, they're new, they're happening, and the rules of the global economy are being written right now. There's no doubt about that. The question is, who's going to write them? We think America should write them. And if America doesn't get engaged and write these rules with our allies, then guess what? Other countries that don't necessarily share our interests will write them instead of us. That's the point. We want to put TPA in place so that we can level the playing field for the American worker, so that we can create more jobs and higher take-home pay, so that we can build a healthy economy and more opportunity for all. So I look forward to a very vibrant debate. I look forward to the fact that all of us have passion on this issue, all of us have good constructive ideas, and all of us aren't necessarily going to agree on how best to accomplish these goals. And with that, I'd like to recognize Mr. Levin for any statement he might have on this bill.
Thank you very much, Mr. Chairman. A lot can be said about the common nature of our goal, and it's true. Our goal is to expand trade. Our goal is to do that with a TPP that contributes to economic growth, that does set high standards, that's sensitive to the needs of developing countries and to our country. The problem is that the TPP negotiations today are not on the right track. In some areas, vital areas, we do not know where USTR is headed. And in other cases, we don't like where they seem to be. So before we turn over our leverage, we need to be sure that the negotiations are headed in the right direction. It is simply incorrect to say that this TPA puts Congress in the driver's seat. What it does is to put us in the back seat. The negotiating objectives in this bill are so vague in most cases. They aren't anything close to anything that's binding. In so many cases, they give very tremendous leeway as to what the negotiators are doing and what the result will be. And by the way, that's true not only for TPP, but for the other agreements that are now being negotiated. Essentially, what this bill would do is to TPP and to TTIP and others, essentially give something close to a blank check to the administration, and that is a mistake. So as I said, what we're doing today is putting forth a substitute that will take a different approach. It will focus in on TPP, since that's the negotiation that the administration now intends to close. And instead of vague negotiating objectives that only serve to suggest that the details of TPP don't matter or matter very little, our substitute would include specific negotiating instructions, and I stress the word instructions, that the administration would have to follow. And instead of saying to the administration, you certify whether these vague negotiating objectives have been fulfilled, and that's what this bill does. It essentially says to the administration, you do the certification whether these vague objectives have been fulfilled. Our substitute would create an advisory body that would have to sign on whether the negotiating instructions had been adhered to. And why does this matter? Because on issue after issue, our negotiators are either not asking for the right things or not willing to share with us what they're asking for. On currency manipulation, which has cost America's middle class millions of jobs, millions, we should ensure that TPP includes an obligation that our negotiating partners don't manipulate their currencies, as Japan did in the 90s and China has in the last decade, costing millions, as I said, of jobs. The Democratic substitute does just what I said needs to be done. On worker rights, we must not just include core labor standards, the May 10th agreement that we Democrats essentially wrote, but we have to ensure that countries like Vietnam and Mexico are bringing their laws into compliance, that the standards are being met. That's what we did with Peru and others. We didn't simply say, just do it sometime. The Democratic substitute addresses this. On the environment, we can't simply list the 7 multilateral agreements from the May 10th agreement. It's an approach that's not consistent with what's taken in TPP. Instead, we have to address specifically what these issues are, including climate change issues. On investment, let me just say, I know the argument is the status quo is okay. This country has never lost a case, but times have changed. Countries' regulations are now being challenged through arbitration panels, even where those countries have adequate rules of law. That's happening in Australia. It's happening in Canada on several occasions. Investors not going to the courts where the rule of law abides, but say, let's take it to an arbitrator. And we need to do much better and clarify this. On autos, we can't simply say, expand competitive market opportunities for exports of goods without some guidance as to what is happening and what will happen. Japan has kept out our products for decades, and we need to be sure where this administration is going. I say this in terms of empowering them. They need to be empowered to do the right thing. Otherwise, we lose our leverage. So this is an effort from rules of origin to agriculture, to tobacco control measures, to state-owned enterprises. This is an effort to provide instructions and not simply give an essentially blank check to the administration. Let me say a word about withdrawing TPA after we give it. We can already do that. This is a rule. The House can withdraw fast track at any point. So can the Senate. And so these provisions in this bill really do not add anything or remedy the lack of our leverage. So, Mr. Chairman, I ask that someone from our staff be able to come forth to explain this bill and for us to have substantial, major discussion of it. This issue deserves that.
Without objection, would you introduce who it is you have? This is
Yes,
your
Jason Kearns.
Jason Kearns, your staff director of the subcommittee, right?
Yes.
Yeah. Without objection. The committee will now proceed to consideration of H.R. 1890. Without objection, the measure will be considered as read and open for amendment at any time. I hear there may be an amendment or two. I will now turn to Angela Ellard, Staff Director of the Trade Subcommittee, Tim Reif, General Counsel of the Office of the U.S. Trade Representative, and your Staff Director as well, for the purpose of describing your amendment when your amendment comes up. And I ask members to hold their questions until after the presentation. So let's go with Mrs. Ellard, Mr. Reif. Let's do questions about the underlying bill. Let's get through that, and then for your amendment, that's when you want your staff person to answer questions. Is that correct?
I want him to be able to discuss what's in our substitute.
Yes. Okay.
And to answer any questions.
Okay. So let's proceed with Ms. Ellard, Mr. Reif, and then questions, and then we'll go proceed. Then we'll continue with amendments. So, Ms. Ellard, you're recognized.
Thank you, Mr. Chairman. Section 1 sets out the title of the bill, the Bipartisan Congressional Trade Priorities and Accountability Act of 2015. And Section 2 sets out the overall negotiating objectives, the principal negotiating objectives, and capacity building and other priorities. Among the principal negotiating objectives are provisions relating to agriculture, goods, services, intellectual property, digital trade, labor and environment, regulatory reform, transparency, and state-owned enterprises. Section 3 sets out how Trade Promotion Authority applies to trade negotiations. In particular, it applies to all trade agreements signed by July 1st, 2018, with automatic renewal upon request by the President through July 1st, 2021, unless Congress disapproves the extension. Only those provisions that are strictly necessary or appropriate to implement the agreement can be included in an implementing bill considered under Trade Promotion Authority. Section 3 also sets out reports by advisory committees to USTR. Section 4 establishes congressional oversight, consultation, and access to information provisions. During the negotiations, implementing the TPA states that if a member wishes to meet with the administration, with USTR, that member would be entitled to a meeting. It also provides to the member access to documents, to pertinent documents, and with respect to Ways and Means as well, and the House Advisory Group on negotiations, there are particular provisions that apply there. There are also consultations prior to entry into force of the trade agreement. Throughout this section, there is a provision relating to written guidelines that USTR would develop in consultation with the committee with respect to information sharing and consultation with Congress, with the public, and with advisory groups. In addition, there are provisions in Section 4 relating to congressional advisors, and specifically stating that if any member wishes to be a congressional advisor, that member will be so designated. And in addition, that member can be accredited to attend negotiating rounds. There are also provisions regarding publication of information to the public, making information available to the public, as well as advisory committees. Also in Section 4, the bill creates a Chief Transparency Officer within USTR who will serve as the liaison with Congress and the public. Finally, Section 4 establishes provisions relating to the sharing of detailed and timely information with members and their staff with proper security clearances as appropriate regarding those negotiations and pertinent documents related to the negotiations. Section 5 establishes notification, consultation, and reporting requirements. USTR is to consult with Congress before entry into negotiations. In addition, with respect to the ITC, the International Trade Commission, at least 90 days before signing, USTR is to provide to the ITC pertinent information, details concerning the negotiation, and not later than 105 days after signing, the ITC shall report to Congress and the President concerning the negotiation and the agreement. There is a provision with respect to ITC reporting on the impact of Trade Promotion Authority that's due to Congress within 1 year, and then another report that is due 5 years later concerning the impact of TPA. There are provisions relating to consultations with Congress on enforcement actions taken by the administration. And finally, within Section 5, any member may submit views to the committee, and the committee shall receive those views for consideration. Section 6 concerns the implementation of trade agreements. The administration is to provide to Congress notification 90 days before entering into agreement. That means 90 days before the agreement is signed. And in addition, 60 days before signing the agreement, the administration is to publish the text of the agreement for the public to see. Within 60 days of signing, the administration is to provide a description of changes to U.S. law that would be necessary to implement the obligations of the agreement. at least 30 days before submitting the implementing bill to Congress, which triggers the TPA procedures, the administration is to submit the Statement of Administrative Action and the final text of the agreement. The Statement of Administrative Action being the document that goes through chapter by chapter and lays out how the administration intends to implement the agreement. The administration is to submit the implementing bill when both the House and the Senate are in Congress, are in session, and that triggers congressional procedures. 45 days consideration of the implementing bill without amendment within the Ways and Means Committee, 15 days for House consideration, 15 days for Senate Finance consideration, and 15 days for Senate consideration. At least 30 days before entry into force of the agreement, the President is to submit a notification to Congress that the party is in compliance with the terms of the agreement. Section 6 also sets forth two resolutions. The first is a procedural resolution. This is a resolution that dealing with whether or not the President has failed or refused to notify or consult with Congress or to meet the negotiating objectives. It would be considered by the Ways and Means Committee. If both houses pass that resolution, TPA is stripped with respect to that implementing bill. The legislation also provides a new resolution, a consultation and compliance resolution. If Ways and Means reports an implementing bill with something other than a favorable recommendation, and a member has introduced such a resolution, the Ways and Means Committee must consider that resolution within 4 days, and it is discharged if it has not reported it by the 6th day. This resolution relates as to whether or not the administration has failed to meet the negotiating objectives or to consult with Congress. And the effect of the resolution, if it's passed by the House, is to strip TPA for the House, and there is a similar procedure in effect for the Senate as well. Section 6 also provides that TPA is an exercise of the rulemaking authority of the House and the Senate, and therefore is subject to change at any time by that body. Section 8 contains sovereignty provisions stating that no provision of a trade agreement that is inconsistent with U.S., state, or local law shall have effect or prevent amendment of U.S., state, or local law. In addition, Section 8 provides that dispute settlement reports that may be generated under the underlying agreement have no binding effect on U.S. law. Section 9 details specific provisions with respect to small business. And that concludes my presentation.
Mr. Reif, do you have any comments?
Mr. Chairman, I do not have any comments at this time to add, available for questions.
All right. Are there any questions for Mrs. Ellard?
I have a question.
Mr. Engel, recognize you. Turn your mic on.
Are there any provisions in this bill that provides the Congress an opportunity to direct the power that we're giving to the President to comply with the wishes of the Congress if this authority is given to him or her? I would like Ms. Ellett to treat this as though it was a power of attorney that we have, that we're giving to the President, and it's a limited power of attorney. Is there anything in this outline that allows us to tell the President, we give you the power of attorney, but these are the things that we want to see in that power to be done?
Mr. Rangel, the legislation lays out the negotiating objectives that are directions from Congress to the administration as to what Congress would like to see in the agreement.
Well, that's what I would give. When I give this power to the attorney, I would say, this is what I want you to conclude with, but I want to make certain that while you continue to negotiate, before I sign off on this, I want to make certain that there's certain things in this. And I would tell my lawyer, who I'm giving the power of attorney, if you can't do this, I'm not going to give you this authority. Can you promise me, Counselor, that you're not going off and do what I don't want you to do while you're negotiating? I've given you the objectives. Are there any things in here that at the end of the day I can say, I want to vote on this contract that my lawyer has provided for me, but I don't want to have to be able to say I'm out of business because I couldn't stop him from agreeing to something during the course of the negotiating with the power I've given to him. Is there any provision here that could be so interpreted?
Mr. Rankel, there are 3 provisions that relate to the role of Congress and the control over the implementing bill, and to what extent trade promotion authority procedures would apply to that implementing bill. So, in other words, if members feel that the negotiating objectives have not been met, the legislation provides 3 different mechanisms. One is...
I'm so sorry, my time is limited. I don't want to know what we could do after the fact. If I told my negotiator, whatever you do, don't you hurt the automobile industry, I mean, it's absurd. Don't you dare touch the automobile industry, no matter what you sell out to these foreigners for, make certain that we are protected there. And I don't want to hear anything about what you had to do to negotiate it. And I don't want at the end of the deal to tell me you did the best you could. Is there any way that I can say during the course of negotiation, because I've told you ahead of time, don't go there. Don't leave me with the opportunity that I've wasted my time giving you with the power of attorney, and you telling me at the end of the deal I did the best I could.
Well, the Trade Promotion Authority legislation has many provisions that mandate consultation between members and the administration, so that members would be guaranteed an opportunity to provide their views. For the administration to take into
I'm not being rude.
Let me get in here.
I'm not being rude, but consultation is a lot different, Mr. Chairman, when I say don't go there. Take manipulation of the currency. My attorney would say, I cannot deal with that. Now, I can't proceed if you're going to insist that I represent you and deal with it. And so then I would say either I won't give you this authority or do the best you can. If you think I'm going too far, I yield back the balance of my time, but I just wanted some answers.
No. I want to clear this up and try and give you an answer, and I appreciate him yielding because we got a long day ahead of us. I don't think it's accurate to say that we're giving the administration power. There's nothing that stops a president from going out and getting a trade agreement right now. He can do it on his own without talking to Congress or thinking about Congress or doing anything, and then he just plop it on our desk. Now, it's probably not going to go well for him if he does that.
I thought that was unconstitutional.
No, it's not. He can go out and do that. We have to vote on it at the end of the day, but he can go do that. So
I thought the Constitution said
no, the president.
It's impractical that only we have the authority.
That's what we're asserting here.
No, asserting it means that we have the right.
Let me say, but to go into law, you're right. But there's nothing stopping a president from going out and negotiating a trade agreement right now if he wants to.
You're talking about what he can do illegally.
So there's
Are
no
you saying
granting.
what he can do illegally?
The gentleman will yield. The gentleman will yield. There's no granting of some power that he doesn't have. It's an understanding that says, if you want us to have this up or down vote, here are the conditions.
Will the gentleman yield?
No, because I think
The gentleman's time has expired. He already yielded his time. What I'm trying to do is
I ask
indulge.
unanimous consent to say I think constitutionally you're dead wrong.
Well, okay.
And I hope that a parliamentarian would say that we have the sole power that we can delegate for practical reasons to the executive branch. Now, if I'm wrong about that and I'm wrong on the law, I have nothing more to say about the process.
No.
But I think I'm entitled to staff a point of order is that because you said if I'm going through the law, I'm right. Didn't you say something like that?
Yes, the Congress has the final say-so on implementing a trade agreement into
No,
law.
I'm talking about negotiating the trade agreement.
So the purpose of this bill is to engage ourselves in the negotiations early on with all of these contingencies, with all of these negotiating priorities, and with all the consultation procedures, and with the transparency provisions that we've added in here, so that we can work with the administration concurrently while they're negotiating these agreements so that we can get a good outcome at the end of the day. I don't see, this is my opinion, but I don't see that as giving power. I see it as asserting
Well,
power.
if it's your opinion, I yield back the balance of my time until I can get a better understanding of the United States Constitution, and thank you for the
My
opportunity.
pleasure. Does anyone else have questions for Mr. Reif? Did you really want to get in on this? Okay.
Can I try?
Go ahead.
Let me try to describe what the bill provides. At the beginning, sir, Mr. Rangel, at the beginning of a process, the President needs to notify the Congress of his intention to begin negotiations. There is then a 90-day period to discuss with the Congress. During the negotiations, where your question was focused, there is a mechanism in the bill where the Congress can vote to withdraw TPA from the agreement that is being negotiated. So at the beginning, the President has to come and tell the Congress what he intends to do. During the negotiation, at any point,
So they do this first.
okay, let me take, yes, sir, let me actually take a step further back. The first step is to approve the TPA bill with the authority and the direction, the negotiating directions to the President of the things that the President should be negotiating. Once TPA is in effect, what I was trying to describe is when the President comes to the Congress and says, I want to negotiate this agreement, during the negotiation, at any time during the negotiation, from day one through the very end of the negotiation, the Congress has the opportunity to withdraw the power of attorney you were describing.
Mr. Reith, you answered my question, but you're not asking the chairman's question. He said the president can start the negotiation now without TPA and without the authority of the Congress. And that shifts my entire interest in what the president can do without the authority of the Congress. So I appreciate your effort to answer the question I asked Ms. Ellard. The question before me now is, can the president legally negotiate and bring to this Congress an agreement where we have the power and the sole power to say yes or no? And I don't want to get in a debate with you, Mr. Reif, nor with the chair. I just need a good lawyer.
He's the chief counsel of USTR, so go ahead.
Now, I would appreciate the fact if he gave me some legal advice.
If I'm not mistaken, you were
Question
the
I
staff
asked.
director for Mr. Ringel in the past as well, correct? So you guys know
And
each
the
other
President
well.
of the United States of America, without the approval of the Congress, negotiate with foreign governments a trade agreement and just leave it to us to say either you want it or you don't want it, yes or no, without trade promotion authority, which I call power of attorney.
So, sir, as to the quality of my legal advice, you should be careful who you hire in the future. The President has the authority at any point in time to negotiate an agreement with a foreign country, a trade agreement, another kind of an agreement. The key in the trade area is the importance of getting congressional approval, since to do anything with respect to U.S. law, obviously, the Congress is in the driver's seat. So that is why we're discussing these procedures under this bill going forward. The President has the authority under the Constitution to negotiate with foreign countries.
Well, how can we be in the driver's seat? What do you mean by in the driver's seat? He can negotiate with Vietnam. He can negotiate with Red China.
Okay.
We have the responsibility of international trade. Yes. So what do you mean we're in the driver's seat? The Constitution, wrongfully or not, gave us that authority. So now you're telling me the president can do it? The president can do anything you want. That's why we have impeachment.
Well, sir, Article 1, Section 8 provides Congress the authority, you're absolutely right, to regulate foreign trade.
That's all I'm asking.
And that
yes.
requires changes or amendments to U.S. law.
And we give him the authority to negotiate on our behalf, right? And if he doesn't have that authority legally, he can negotiate all he wants, and he's violating the Constitution by coming saying, I asked you for the authority to do the best thing I can for the United States of America. You denied that to me. as you've done to no other president. So I have on my own, through executive order, negotiated an agreement with 12 other countries. Take it or leave it. Can he do that?
The President can negotiate. He can then come to the Congress and ask for approval of legislation. And he has no, outside of TPA, if there is no TPA, he has to come to the Congress, and he has to abide by the normal legislative process of this committee and the Congress.
We can amend it.
You can
When
amend
we
it.
say yes or no, we can't. That's what Mr. Rango's pointing out. That's the difference. When you give TPA whatever the consultation mechanisms, in the end, all we can say is yes or no.
That's correct, but what I was trying to answer is that there is a mechanism in the bill, two mechanisms, where the Congress can say, stop, I don't approve of this agreement, I don't approve of the use of the yes or no mechanism for this agreement. That's in the bill.
We already have that power, Mr. Reif. It's a rule. We changed it as to Colombia. We don't need that language. We can say yes, we can withdraw by changing the rule at any time in the Senate or the House.
First of all, we're not arguing with the witnesses here. They're answering our substantive questions. So let's just dial it down a little bit here. They're here to not argue with us, but just simply to answer our questions.
Okay.
You told him not to get involved.
But you responded, so thank you for giving us
I'm just trying to
the same
clarify
leeway
this.
that you have.
Absolutely, I'm giving you some leeway. Okay, so Mr. Neal, did you have a quick?
Just a moment, Mr. Chairman. I think he just walked out, but
did
it
he?
would have been a nice moment to recognize the former chairman of this committee and a good friend to all of us here. Bill Archer was here a minute ago, and a Republican who actually accepted Democratic amendments.
Yeah, those are good old days, right? So, reclaiming the time. Mr. Kind, do you have questions for the witnesses?
I do indeed, Mr. Chairman. Thank you
The
very
gentleman's
much.
recognized.
Thank you. Mr. Allard, thank you for a brief summary of the legislation. And Mr. Reif, help us understand as far as the congressional ability to intervene and cut this process off. In my review of the legislation pending before us, an individual member of Congress now can file a resolution to desert TPA authority with you. Is that correct? That an
Yes.
individual can, and that it's something that cannot be amended by either Ways and Means or the Finance Committee if that resolution is pending?
Yes, that's correct. The text of the resolution is set forth in statute and specifies that the president has failed to meet the negotiating objectives or to consult with Congress, and therefore TPA is withdrawn, and that cannot be
And
amended.
that resolution is something that the committee does have to take up and consider within a certain time period?
Yes, with respect to the consultation and compliance resolution, if when the committee meets to consider the implementing bill, it reports out that implementing bill with something other than a favorable recommendation, it is mandated to take up the resolution within a time certain.
Great. Thank you for that clarification. And I'm also trying to understand some of the significant differences between the legislation pending before us today and previous TPAs. And as I read the legislation before us, we have as one of the core negotiating objectives that our trading partners must adopt and maintain core international labor standards with trade sanctions if they do not comply with that. Is that correct?
That is correct.
And that's something that had never existed in a prior TPA before Congress.
That is
right?
correct.
And also, as one of the core negotiating objectives, our trading partners must adopt and maintain common multilateral environmental agreements, and again, with trade sanctions that would apply if they don't comply with that. Is that correct?
Yes, that is correct.
And that had not existed in prior TPA agreements.
Yes, Mr. Kine.
It also has a provision in there that establishes the Directive for Trade Agreements to foster innovation and to promote access to medicines, prescription medications with our trading partners. Is that correct?
Yes.
And it also has, for the first time, a negotiating objective, recognize the importance of trade agreements in advancing human rights in the implementation of these trade agreements. Is that correct?
Yes.
That's something that we had never touched upon in prior Congresses with TPA authority.
That's correct. It had never been mentioned before.
And another significant difference is the whole transparency issue and the publication. Obviously, we've got a reporting requirement for when an administration does reach an agreement that they have to report to Congress, and then that starts the clock for a 90-day period in working with Congress and publicizing the agreement, the terms of the agreement with us.
Yes. that 60 days before signing the agreement, it must be published.
To the entire public?
Yes.
I'm just talking about the congressional trigger, and there's a 90-day that gets triggered before the president is even allowed to sign the agreement?
Yes, 60 days before the president is allowed to sign the agreement, it must be made public to everyone, posted on the web.
Okay, and that's something that had not existed in prior TPA agreements. That's new to this legislation as well. So there's some significant differences with the legislation that we have pending before us today that we have never seen in prior TPA in order to advance and elevate core labor standards, environmental standards, and I think with the honest attempt to try to level the playing field for our workers, our businesses, our farmers, so they have a better chance of competing successfully in the 21st century global marketplace. I think those are some key provisions that I think need highlighting and something that's new that the Congress is taking upon in the course of this legislation. So, Mr. Chairman, with that, I'd yield back.
Gentleman yields back balance of his time. Mr. Neal, let's try it one more time.
I think it's noteworthy that we have two former chairmen of the Ways and Means Committee standing there, and it's also an acknowledgement of why, when you see the two of them, this is still the premier committee to serve on in the House of Representatives. Bill Archer and Charlie Rangel.
Let the record reflect we have Bill Archer and Charlie Rangel over in the corner. Good to see you, gentlemen. Thank you. And his name is Archer. Archer, great to see you. You too. Mr. Doggett, gentleman's recognized for 5 minutes for questioning.
Actually, as far as this being unique to this bill, with regard to negotiating objectives, and indeed, I think 90+% of the bill, doesn't it duplicate what was introduced last year by Mr. Camp? It's almost indistinguishable from the Camp bill. There are some areas of difference, but it's very close, isn't it?
There are some key differences between the legislation from last year and this year.
But on negotiating objectives, are pretty much the same.
There are similarities in the negotiating objectives. There is, as Mr. Kine indicated, in the overall negotiating objectives, a recognition of internationally recognized human rights, for example.
Right, that's one of the few changes. And with regard to those negotiating objectives, about how many are there? Is it over 100?
Yes, about 150.
So there's nothing in this bill that prevents the administration from coming back and saying, we got half of them. That's a good batting average in the National League. You wouldn't expect them to achieve every one of those objectives, would you?
That is a decision for the members to make as to whether they're satisfied with what the administration has brought back.
Exactly. And but there's nothing in here that mandates that they satisfy the objective on human rights or on labor or on environment or on intellectual property. They have to look at all of the objectives and do what they think is the best job possible.
It leaves it in the discretion of the members of Congress to determine whether, given the totality of the circumstances, the administration has brought back the best deal possible. And if members feel that that is not the case, there are disapproval resolutions that are available to strip TPA, and then ultimately members retain the ability to vote against the agreement if they feel it's a failure.
Yes. And let me ask you to focus now on the transparency section, Section 4. The transparency has been discussed a great deal. I assume in working on this act, you looked at existing law. Did you not, concerning the authority of the U.S. Trade Representative?
Existing law concerning the old Trade Promotion Authority?
The old Trade Promotion Authority and the statutory authority granted to the U.S. Trade Administration.
Yes.
With regard to existing authority, there is no limitation on the number of meetings that the trade representative can have here. I think he's boasted of hundreds of meetings and pep rallies to promote this bill. There's no limitation under existing law, is there?
There's no limitation, no.
And there's no limitation in this bill. He can meet as much or as little as he wants to.
What the bill does is it establishes a threshold, not a ceiling.
Yeah.
It's the minimum number. Whenever a member requests a meeting, that member is entitled to a meeting.
With reference to access to documents, currently he has discretion to make trade text and proposals from other countries and from USTR. The U.S. Trade Representative has discretion to make those available to members of Congress and our staff.
Yes, that's correct.
And under this proposal, he'll have the same discretion. There are words like appropriate and pertinent and coordination, but it is pretty much at the whim of the U.S. Trade Representative now, and it will be the whim of the U.S. Trade Representative afterwards. Specifically, is there anything, for example, in this bill that will prevent the U.S. Trade Representative from demanding that the only people that can see this agreement on our staffs have to have top secret classification, even though the documents show on their face that they have no top secret classification and are stored in unsecured places? Is there anything in the bill that will address that?
Mr. Doggett, the bill contains in several places the mandate that USTR develop in consultation with Congress guidelines for the dissemination and sharing of that information with Congress.
Is there anything in the bill that requires the U.S. Trade Representative to share with members of Congress the proposals that it forwards to the Vietnamese Politburo? For example, if there is a labor annex that's sent to the Vietnamese Politburo, is there any requirement that with them or another trading partner that a member of Congress can access that proposal as it's made?
The legislation very strongly directs the administration to share information, classified information with members, and the guidelines that will be developed will provide more clarity with respect to that. And then ultimately, if a member believes that the administration has failed in this regard, the resolutions are available. But perhaps Mr. Reif might want to address how...
Let me ask you just one more. If the administration, for example, has put forward a proposal concerning climate change or global warming, and then it withdraws that proposal and substitutes another, is there anything in this proposal that will permit the members of Congress to access that prior proposal, or is it at the discretion of USTR as it is now to deny access to that?
The guidelines that will be developed according to this bill, we would imagine would be very similar to the guidelines that would have been the process for developing guidelines in the 2002 bill, which made it very clear that members were very much entitled to see U.S. negotiating proposals, whether they were initially submitted or subsequently submitted.
Last question.
The time for the gentleman has expired. If he wants to seek time from someone else, we just need to enforce these rules, or else we're never going to get out of here.
I do.
No, I already recognize Mr. Thompson.
I yield my time, Mr. Doggett.
Okay.
Just one more question, Ms. Ellard, because I never could get Mr. Froman in months of asking to tell me what the legal basis was for denying our request to all of those types of documents that I just described, or to provide any legal basis for refusing to let members of our staff who could go over with their security clearances and look at documents about Yemen or ISIS or Boko Haram or any of the other terrorist organizations, why he would refuse to let them look at the TPP texts over the Easter recess. Could you find any legal basis in your research for why USTR so stonewall and insisted on so much secrecy and obstruction to congressional access to these documents?
Mr. Doggett, I really can't respond to something that the administration did. Perhaps Mr. Reif would like to do that.
I'd be glad for him to.
So, Mr. Doggett, what the bill would require us to do is to consult with...
My question that I asked to her, and if you have a legal basis as a lawyer for USTR, it will be historic. It'll be the first time USTR has answered my repeated questions on this. What is the legal basis, and I'll ask them separately, what is the legal basis for USTR denying members of the staff of this committee who have top secret clearance, the individual staffs of the members, from accessing documents and reviewing the text over the Easter recess we just completed?
Well, sir, just a few weeks ago, a number of steps that the U.S. Trade Representative has already taken.
Do you know the answer to my question, Mr. Reif? I'd be glad for you to answer other questions too, but what is the legal basis? As you know, you have my letters. You know I've been asking this question for months. You know I've asked it of Mr. Froman. What is the legal basis for denying access to our staffs who have top secret clearance to looking at the text of the TPP agreement, which Mr. Froman did during the recent Easter recess.
So, thank you, Mr. Doggett. I was trying to answer your question. The USTR has taken a number of steps, and more are described in the bill before you, to enable members as well as cleared staff to view the text that's being negotiated, not only U.S. proposals, but also the text that's being negotiated with attribution of country positions.
Mr. Reif, can you cite a statute? Do you have any legal basis at all?
Mr. Doggett, we're marking up a bill, and the questions are on the bill.
Well, and the question
so
on the bill
this
is whether
question goes beyond the bill. So I'm indulging the gentleman, but
I appreciate
going
it.
beyond the
And
bill that's
you've been
in front of
present
us.
when I've asked this question repeatedly, and I don't think there is any legal basis. And my concern is that the bill grants the same discretion to USTR, which USTR has abused as recently as the Easter recess. And if there's a legal basis, I've asked for it in writing, I've asked for it in private, I've asked for it in public. If there's a legal basis for what USTR is doing in demanding a higher security clearance of our staff than the documents reflect, or for denying our staff the opportunity to go review these texts, or refusing us to provide us the text that is provided to Vietnam of any consistency agreement, or refusing to provide us copies of the text of proposals that the U.S. has submitted and abandoned, I'd just like to know what it is in order to fashion the amendment that I'll offer to try to prevent it from happening in the future.
So, sir, what I can say is, when the United States tables a proposal in a negotiation, that proposal is shared with members. And at any stage of the negotiation, if there is a negotiating text that the different countries are involved with, that text is also shared with members and also with cleared staff. That's the procedure just recently announced by our office in an expanded way to try to address the concerns that you, some other members, have raised with us.
So there is no legal basis you can cite for restricting access to this information?
The texts are documents that we work on with foreign governments. There are classifications involved in those texts.
Is the consistency plan with Vietnam something you work on only with Vietnam? The consistency plan or an annex similar to what was done with Peru with regard to labor rights and whether Vietnam will eventually provide at least modest labor rights? Is that something you're doing only with Vietnam? Because you've been unwilling to share that information.
I think our office has offered detailed briefings on an ongoing basis with respect to very important labor negotiations with Vietnam and other aspects.
Thank you, Mr. Chairman.
Time for the gentleman's expired. Mr. McDermott, do you seek questions?
Thank you, Mr. Chairman.
Gentleman's recognized for 5 minutes.
I have a question. Listening to this, I happen to remember that I think the Louisiana Purchase was done by Thomas Jefferson without consultation with the Congress. He brought it to the Congress fait accompli, and they had to agree after it was all done. But my question is this. Explain to me the process, because I don't remember back to NAFTA very well. We gave fast track to the president, and he went and negotiated and then brought it back, and we voted yes or no. And then was there any implementation legislation that had to pass afterward? Or was the acceptance of the treaty itself implemented a bunch of language into the law? Or did we didn't have to change anything, maybe? Just Canada and Mexico had to change things. I mean, I raise this because we say to Peru, we won't let you have this treaty with us unless you change your laws around labor. Will there be anything in this agreement where we have to change our laws? Microphone, I can't
This
hear you.
legislation retains for Congress explicitly the sole authority to determine which portions of an agreement Congress will implement. So what happens when the president negotiates a trade agreement and he brings it back to Congress, whether it's under TPA or not, that agreement does not take effect under U.S. law unless Congress passes legislation to implement, to make changes to U.S. law to come into compliance with that agreement. So members retain the authority to make that decision as to whether to implement the agreement. And that is retained in this bill in Section 8.
So if I understand that correctly, the process is if we vote for this, the president's been negotiating through the USTR. He's been negotiating an agreement up to this point, which he could bring back to us tomorrow if he thought it was good enough, and this TPA would be irrelevant, really. Is that correct?
If the president were to negotiate, I'm sorry, I didn't quite hear.
If he finished the negotiations with all these 11 countries, he could bring it back up here and just drop it on the table and say, here, implement this thing. Agree to it.
Traditionally, what happens is Congress and the administration work together to produce an implementing bill that would implement our obligations, and that is the instrument that Congress considers under TPA.
So the bill that when we're going to vote after this up or down vote that the TPA anticipates at some point, will have all the implementing legislation in it.
Yes.
So we will know every change that we are making in our law at that point.
That's right, because the trade agreement itself cannot make changes to U.S. law. Only Congress can do that. And this bill preserves the authority of Congress to make that decision.
Do you, I realize this may be a little bit tough, but do you know of any changes that were in the NAFTA law? What did we change in the NAFTA? Or did we just, we let them make their own changes in the Canadian law, and in the Mexican law, we didn't make any?
Well, we did make some changes to U.S. law to come into compliance. And there's also a provision in this legislation that says that the president has to provide notification to Congress before the agreement can enter into effect that the country we have negotiated with is in fact in compliance on day one with the terms of the agreement.
So all 11 countries will have to have changed their laws in whatever way they agree to in this agreement before it will go into effect.
That's correct. The president must, before the agreement can go into effect, the president must certify to Congress that each of the countries that's party to the agreement will be in compliance with the agreement on day one, whether it had to change its laws or not, whether it is in compliance on day one.
So is it then possible that the bill that's brought up to us may in fact only affect 6 countries or 7 or 8, and that 3 will be decided, they're not compliant, so they're not in it?
That 3 of them won't have to make changes to their laws, or that
They
won't?
haven't made them, so the president won't certify
so
it, so
they-
therefore it doesn't affect them.
Well, that is an issue to be determined in TPP, for example, or in the particular trade agreement as to how the agreement will enter into effect. I mean, what is required, how many countries must be party to the agreement, must be ready to undertake the obligations of the agreement for the agreement to enter into effect. That's something determined in the agreement itself.
The gentleman's time has expired.
Thank you, Mr. Chairman.
Okay, let me just, we've got, I'm looking here, we got 4 votes. My goal here is to finish questions before the votes, recess for the votes, come back immediately after the votes, and then start amendments, beginning with the ranking member's amendment. So with that goal in mind, I recognize Mr. Becerra. Oh, no, it's Becerra then you? Is that how you want to do it? Okay. Okay. Mr. Becerra.
Thank you, Mr. Chairman, and I thank the ranking member as well. Let me try to see if I can narrow the scope of my questioning so that Mr. Levin has time as well. And I pose this to either one of you, Ms. Eller or Mr. Reif. We have, as has been discussed, a number of objectives in this Trade Promotion Authority legislation that we submit to USTR, to the administration, to try to achieve. If you look up the definition of an objective, essentially what it means is it's something you hope to attain or accomplish. You're trying to get something done. That differs from an obligation. And in our trade deals, we have a number of obligations for the parties of a trade deal. So I'm correct in saying that there's a difference between an objective and an obligation, correct?
Yes.
Okay. So as I look at some of what are considered objectives, one of them, for example, with regard to currency and how countries treat their money. Because what we've encountered over the last several decades is that some countries have figured out a way to game the trading system, with or without a trade agreement, whereby manipulating the value of their currency, they can make their products look pretty cheap. If you keep the value of your currency low compared to, say, the US, all of a sudden that product produced in that country looks really cheap because you're going to end up buying it in the currency of that country. And what we have found is that upwards of 5 million American jobs have been lost as a result of countries, whether China or Japan, many others, who've gamed the system by playing with their currency and depreciating it, at least for a time, so they can then make their products look cheap. One of the objectives that we have in this trade regime is that we try to work out a deal with partner countries in these trade deals that they stop manipulating their currency. But since that's just a goal and not a requirement or an obligation, if we fail in that goal of getting these countries to stop tinkering with their currency for the sole purpose of gaining an advantage over American companies and American workers, we can't do anything to those countries once the deal is in effect, right?
Well, ultimately, Congress retains the ability, the right, to say this agreement is not enough. So if you make that determination and vote down the agreement, vote down the implementing bill, then you're not faced with that problem of, in other words, if you are unsatisfied with what has come out of the agreement because it doesn't provide enough for, with respect to currency, let's say.
But I won't know I won't know what's in the final trade deal until after I voted to give the administration the authority to move forward on negotiating that deal with one of the objectives, not a requirement, to be to deal with currency. And so isn't that, to me at least, it seems that we're rolling the dice. Rather than try to finally get countries to stop cheating, as they are, we're going to say we have an objective to stop you from cheating. But if we don't do it, then you've got a trade deal that probably moves forward. You're now talking about an up or down vote with no ability to amend the trade deal to say, no, we wanted to have that be an obligation, not an objective to stop countries from cheating. And so there is a very big and important difference between an objective and an obligation. And we could go through any number of these and talk about objectives and obligations. I guarantee you, most Americans, as they try to understand what's going on in this trade deal and this Trade Promotion Authority legislation, are trying to figure out what the heck is good for me. And if they knew that we were willing to move forward in the blind and say something we know is happening out there, which could have cost us upwards of 5 million jobs, is something we only will make an objective but not an obligation to stop, I bet you they'd tell us right now, stop. Make sure that before we let these countries deal with us and have access to our markets, we get them to stop cheating. And if we want to get the companies in these countries to stop cheating, gosh, how are we going to do that if we're letting the countries themselves cheat in the first place? And so my sense is that there's a big difference between an objective and an obligation, and I hope we recognize it. With that, I'll yield back.
Time for the gentleman has expired. Mr. Levin is recognized for 5 minutes.
Well, Mr. Becerra has really highlighted a major, major difference between the substitute and this bill. And the purpose of the substitute is to have instructions so that in the end, our main role and power is not simply yes or no. And these negotiating objectives, I could refer to others, like on agriculture, it's to reduce or eliminate. It doesn't say anything. Japan's already agreed to reduce. The question is how much they'll eliminate. And the investment state is identical. You were asked, Angela, Ms. Ellard, how much is there similarity between the bill of last year and this in terms of the objectives? Except for human rights, they're identical. And the human rights is only a kind of a wish. And so let me just say quickly, Mr. Doggett asked about Vietnam and the annex. The fact is, and I have to be careful because it was classified, members of this Congress, by and large, have no idea what is being discussed between the U.S. and Vietnam as to the implementation of their obligations. And I say this as the co-author with Charlie Rango of May 10th. And I believe in it so much that I want it to be implemented in a meaningful way before we vote. And so let me just ask you one other question. In terms of the implementation bill, if you look on page 42, and I'm really concerned about this, it's changed. And where it says only such provisions as are, it used to read necessary or appropriate. Now it reads strictly necessary or appropriate. That is a change. It's wrong. We had a fight over Columbia about placing the labor action plan that I helped to negotiate with the administration in the implementation bill. And there was a refusal to agree to have that in the implementation bill by the Republican majority. And that was a mistake. And we've had trouble getting enforcement of Columbia, which I want very much to happen. And adding the word strictly before necessary or appropriate, that's a change, is it not, Ms. Ellard?
It is a change, yes. It's a difference from 2002.
Mr. Chairman, that makes the situation more problematical for us. Objectives that aren't really meaningful enough or meaningful at all, work that's been done that is not satisfactory, and then language in this that says anything that's negotiated, anything regarding the implementation bill has to be strictly necessary. That's a mistake. I yield back.
Gentleman yields back. No more questions being sought. I'll make a quick announcement, housekeeping. We've got 4 votes. I'm going to recess subject to the call of the chair, and then I ask members to come back immediately thereafter, and we will begin consideration of amendments. So the committee stands in recess subject to the call of the chair. Committee will come to order. Committee will come to order. Our guests will please take their seats. Members as well. I'd like to entertain, before we get into amendments, I believe Mr. Smith and Ms. Noem want to engage in a conversation for purposes of a colloquy. Mr. Smith, you're recognized.
Thank you, Mr. Chairman, and thank you for your persistence in developing a modernized TPA legislative package. We have issues, obviously, with foreign markets relating to biotechnology that involve, I think, some unfair practices and regulations, and certainly unjustified regulatory and commercial requirements that are actually designed to keep many of our products out. Corn and soybeans are the primary products, but we know there are concerns with other non-tariff trade barriers and other products as well. So I just, again, I appreciate your efforts, and I'm wondering if you could confirm that the language intended to, in the TPA bill as it relates to trade and agriculture is intended to address the full range of non-tariff trade barriers that our agriculture producers face, including unjustified, delayed, reduced, or denied access for biotech crops as a result of foreign regulatory approval processes.
Yes, it is precisely the intent of the referenced principal trade negotiating objectives relating to agriculture to ensure that foreign regulatory approval processes are not misused to cause such delayed, reduced, or denied market access for U.S. agriculture products. Our biotech exports are often target number one. The trade negotiating objectives on agriculture in the TPA bill are designed to ensure that our trade agreements address the full range of barriers that our biotech producers face, commercial, regulatory, or otherwise. I appreciate you raising this issue, and we'll work with you to ensure that the committee report language makes clear that this is the intent of the statutory language.
Thank you, Mr. Chairman.
Ms. Noem, did you have a comment?
Yes, thank you, Mr. Chairman, and I appreciate that necessary language in the report and your willingness to work with us on this issue. Agriculture is South Dakota's #1 industry, and in countries where we have trade agreements, we sell 11.5 times more goods to those countries than we do to countries where we do not have trade agreements. So it's critically important not only that we establish the agreements, but also that they work for our products. And biotechnology has been an important part of the ag industry and our ability to feed the world. The EU's recent actions to put up barriers to these products has raised many concerns, and I know that the administration shares these concerns as well. So we need to use our TPA negotiating power and objectives to address the issue. And I want to thank the chairman for working with us on this.
I think gentlelady from South Dakota, the gentleman from Nebraska, they've been very deeply involved in this issue. They've kept the committee apprised of these specific problems, and it is the intent of this legislation to deal with this, and we will make sure that we reflect that in our report language. And so I thank them for their indulgence. We're through the question period. We will now turn to amendments. Are there any amendments?
Yes, I'd like to introduce the substitute TPA bill.
The gentleman, the ranking member, is recognized. The clerk will distribute the amendment, and I ask the gentleman to suspend for a moment while the clerk distributes. Mr. T-Berry?
Mr. Chairman, I reserve a point of order.
Point of order is reserved. It looks like they're mostly handed out. Gentleman is recognized.
Mr. Chairman, I gave an opening statement that related to this, and I think yours did also. So let me suggest that Mr. Kearns proceed to describe the bill, if that's okay with you.
All right, without objection, the committee will allow Mr. Kearns, the Minority Staff Director of the Trade Subcommittee, did I get that right? For the purpose of describing the amendment. Mr. Kearns.
Thank you, Mr. Chairman. Section 1 includes the short title, Right Track for the Trans-Pacific Partnership Act of 2015. Section 2 zeroes in on 12 negotiating instructions for the TPP negotiations, one of each for each critical outstanding issue in the TPP negotiations. On currency manipulation, the President is instructed to include strong and enforceable currency rules. This means the same dispute settlement mechanism that applies to almost all of the rest of the TPP obligations. However, if a dispute settlement panel finds that a TPP country is manipulating its currency, the IMF can render that decision null and void if it concludes within 60 days that the country is not manipulating its currency. On labor rights, the amendment lays out what Vietnam, Mexico, and other TPP parties need to do to bring their laws and practices into compliance with the May 10th standards, which are based on the fundamental rights identified in the by the International Labor Organization. These instructions address issues such as Vietnam's current prohibition on the right to freely associate, Mexico's use of protection contracts, and Mexico's broken labor arbitration system. It also provides that changes to these laws need to be made before Congress votes on the implementing bill. And it calls for the establishment, from the date of entry into force of the agreement, of an independent panel of experts to regularly determine whether Vietnam is in compliance with its labor obligations. On environment, the President is instructed to obtain a level of environmental protection at least as high as the standard established in the May 10th Agreement of 2007. The amendment calls for strong commitments such as, quote, prohibiting trade in illegally harvested goods. On investment, the President is instructed to make 4 changes to the text: clarifying the minimum standard of treatment, giving the 2 governments the opportunity to dismiss an investor claim, allowing governments to impose capital controls to prevent or mitigate a financial crisis, and including the preambular language from the May 10th Agreement that provides that the agreement does not accord greater substantive rights than U.S. investors have under U.S. law. On access to medicines, the President is instructed very clearly to follow the May 10th Agreement of 2007. On automotive market access, the President is instructed to not reduce or eliminate U.S. tariffs unless or until Japan opens its automotive market. Alternatively, the President is instructed to begin reducing U.S. tariffs, to not begin reducing U.S. tariffs until year 25 of the agreement, and to not eliminate tariffs before year 30. On automotive rules of origin, the President is instructed to adopt a rule of origin at least as stringent as the NAFTA rule of origin. On tobacco products, the President is instructed to ensure that non-discriminatory public health measures should not be challenged as inconsistent with the agreement. On state-owned enterprises, the President is instructed, among other things, to ensure that any enterprise controlled by the government, including where the government owns less than a majority of shares, shall be covered by the disciplines in TPP. On agricultural market access, the President is instructed to eliminate tariffs on virtually all products. On food safety, the amendment calls for strong SPS, sanitary and phytosanitary disciplines for U.S. exporters, while also preserving the right of governments to put in place legitimate measures to protect life and health. On human rights, the President is instructed to consider whether each TPP party consistently demonstrates respect for internationally recognized labor rights in determining whether to conclude the agreement. Section 3 of the amendment creates House and Senate trade advisors made up of equal numbers from the majority and minority parties. Section 4 provides expedited consideration of the TPP agreement based on certain conditions being satisfied, including, importantly, whether the House and Senate trade advisors believe that the instructions, the negotiating instructions, were followed. Section 5 provides specific consultation requirements, including how members of Congress will have access to the text of the agreement. It also includes 2 usable mechanisms to remove fast track if necessary. First, the Committee on Ways and Means or the Senate Finance Committee can decide to remove the agreement from fast track. This is a provision that was in the 1988 Omnibus Trade and Competitiveness Act, but which was not included in the 2000 bill or the bill before us today. Second, if 1/3 of the members of the House and the Senate co-sponsor a resolution to remove TPP from fast track, that resolution must be voted on in each chamber. If it passes both chambers, TPP would not receive fast track. Section 6 describes the process for congressional consideration of implementation of the TPP, including new reporting requirements not found in previous fast-track legislation. Section 6 also provides that the TPP implementing bill may include anything that is, quote, necessary or appropriate, not, quote, strictly necessary or appropriate, to implement the trade agreement. It gives the House and Senate trade advisors the opportunity to recommend provisions that the President would include in the implementing bill if the House and Senate trade advisors believe those provisions are necessary or appropriate. Those provisions may include legislation to impose a WTO-consistent import fee or other measure to permanently fund food safety inspections of imports, and also legislation addressing issues that directly relate to TPP parties, such as human rights issues. Thank you.
Mr. Levin, do you have any additional points you'd like to make in describing your amendment?
Well, let me ask questions of Mr. Coon.
Okay. Gentleman's recognized for 5 minutes.
And I hope other colleagues will, including on the Republican side. This is an effort to lay out instructions for the administration, clear instructions as to what should be accomplished, having some specific suggestions, not the vague negotiating objectives that's in the present bill. I'll ask Mr. Kearns at times to contrast what's in this bill with what's in the other bill, but I want to go through some of these, and I hope our colleagues will continue this so it becomes absolutely clear. I'll take them one at a time, and when my 5 minutes are up, I guess other colleagues will have to continue. So I'll just go one by one. The currency instruction, if you could describe it, also if you would, Mr. Kearns, respond to the arguments that this provision would essentially limit our Treasury Department to carry out monetary policy. Just describe it so everybody understands it. And if you want to, you can refer to what's in the present bill, but I've already done that, and it just says, or other procedures, as I remember it. It just leaves it completely up to the executive. So let's take these one at a time. Describe, if you would, the instruction here and respond to the criticisms.
Sure. The instruction is for the President to establish strong and enforceable rules consistent with or building upon Article 4 of the Articles of Agreement of the International Monetary Fund and related guidelines. And the guidelines will be very important to answering your question about U.S. monetary policy. And requiring each TPP party to avoid manipulating exchange rates to gain an unfair competitive advantage in international trade. The rules shall be enforceable through the same dispute settlement and remedies as other obligations in the TPP agreement, provided that a panel finding that a TPP party is engaging in currency manipulation shall have no effect if, not later than 60 days after the panel makes its finding, the Executive Board of the IMF disagrees with the panel finding. In terms of U.S. monetary policy, I don't have the 7 guidelines in front of me, but there's virtually none of them. Only one mentions even monetary policy. The first one, and consider the most important, is protracted large-scale interventions in the currency markets. As I recall, the United States has intervened in the currency markets only 3 days in 15 to 20 years. And in every case, it did so in cooperation with the other government. The other guidelines provide, for example, that you look to see whether or not the country has excessive foreign exchange reserves. And there are certain measures economists have developed, including Greenspan and Gudati, that determine whether or not that's been satisfied. The U.S. Exchange reserves are very small by comparison, smaller than what Saudi Arabia has or Algeria has.
So is this written so there's a clear distinction between currency manipulation and steps taken under IMF guidelines like quantitative easing?
Yes, sir.
All right, and maybe others want to go back to that. I'd be glad to have somebody challenge that because we've worked on this, put out a blog on it, spelled it out. Simon Johnson, who worked with the IMF for 5 or 6 years, has made it very clear that there is a clear distinction as reflected in this bill, and how inactive really the IMF has been in terms of any cracking down on currency manipulation that has so badly hurt our workers over the years. Then let's go on to the labor rights provision. Please.
Have a follow-up question on your fine point about the IMF, because I think the blog is really important.
Okay, well,
I have you next in the queue to ask questions of the witness.
so if you could ask.
Yeah, you have 24 seconds. How about he takes the next 5 and then pick up where you leave off? How's that sound?
Okay, I guess my 5 goes quickly. All right, so why don't you just pick up this theme, and I hope that our colleagues will raise other issues so we go down the line.
Mr. Neal is recognized for 5 minutes for the purposes of questioning.
Thank you, Mr. Chairman. I want to follow up on the point that Mr. Levin is making and refer to the blog that I thought was exceptionally well done. Yesterday, when the Secretary of the Treasury was here, and I intend later on to offer an amendment consistent with the position that Mr. Levin has offered at the right moment, but when the Secretary of the Treasury was here yesterday, he once again offered the refrain that we've heard from successive secretaries over many years, that allowing the Secretary of the Treasury to address these questions would be better for America rather than having legislation, because according to the Secretary's testimony yesterday, that there could be, based upon monetary policy that was embraced by the Federal Reserve Board, notably QE2, that in some instances would be defined as currency manipulation. And I think that we strongly object to that, given the testimony that Mr. Levin has offered a moment ago, based upon IMF considerations. So, Mr. Kearns, is it your understanding, based upon the testimony that you've offered to date, that there would be an opportunity here for us to build in or construct a currency manipulation amendment that would be consistent with IMF considerations, contrary to what Secretaries of the Treasury, from Nick Brady to John Snow to Bob Rubin to Larry Summers, you go right through the litany of those suggestions, and they've all said, we know how to manage this better than anybody else. And I'm going to refer to it specifically in my amendment later about where that argument has gone as it relates to geopolitical considerations. But not to miss the point, I think that Mr. Levin's position here has been that the IMF does have the ability to, the guidelines as to instruct. So would you speak to that issue?
Yes, I'd say, in my view, it is very much possible to include it in the TPP. I think the important point here is all of the TPP countries have already agreed on those IMF guidelines. Every one of them is a member of the IMF. They live by those guidelines now. The problem is the guidelines are not enforceable the way the IMF works, because essentially countries have veto rights. So we've already agreed on the guidelines. Now we just have to make them enforceable.
Thank you. Thank you, Mr. Chairman. Yes, Mr. Levin.
Why don't we just keep going? Just keep going down the row so others have a chance.
I think the last hand I saw was Mr. Doggett. Anybody else who want to keep going?
We've got. I think I have a couple of minutes left.
You got two. You got.
What? I was going to give it back to Mr. Levin so that we could use the time to talk about this important consideration.
Did you? But I think he just wanted other members to get in.
Okay.
Yeah. So, Mr. Doggett. Mr. Dockett's recognized for 5 minutes.
The opportunity to strike the last word at an appropriate time in support of the amendment.
Okay. Does anybody else seek time to Mr. Becerra?
Thank you,
recognized for 5 minutes.
And let me, I asked previously the question about the difference between an objective and an obligation. This substitute amendment, I see, has instructions on those same types of issues that we are calling objectives in the underlying legislation, but here they are instructions, and we're talking about specific instructions. And I look with regard to the issue I raised previously on currency manipulation, and I note that the instruction that is provided for the negotiators is a very specific one, and that with regard to currency manipulation, it says, Congress's instructions to the President regarding currency practices are to establish strong and enforceable rules et cetera, requiring each party to the agreement to avoid manipulating exchange rates. The rules shall be enforceable, and there's a big difference between the word shall and may, correct, Mr. Kearns?
Yes, sir, that's correct.
What's the difference between saying shall be enforceable or may be enforceable? What would be the difference between shall versus may?
Shall is a requirement, may is permissive.
And so, like an objective, which is a goal, if it's not met, there's no consequence and you can't enforce something. But if it's a requirement and you say it shall be done, and if it's not done, then you can enforce that. Can you explain the difference between what we see in the substitute with regard to instructions, for example, on currency manipulation, as opposed to what we see in the underlying bill, which has to do with objectives?
Yes, sir. As I mentioned to Mr. Levin, the language in, we've already read the language in the right track. In the underlying bill, the language is that the principal negotiating objective of the U.S. with respect to currency practices is that the parties to a trade agreement with the U.S. avoid manipulating exchange rates in order to prevent effective balance of payments adjustments or gain an unfair competitive advantage, such as through cooperative mechanisms, enforceable rules, reporting, monitoring, transparency, or other means as appropriate. And I think the only other point to make here is that under the right track, members of Congress, these House and Senate trade advisors I mentioned, determine whether or not the instructions have been followed. And in this bill, the President determines that.
So we have another mechanism that makes sure there's a check here to make sure that the instruction has been followed and the obligation is going to be met.
That's correct.
Thank you. I yield back, Mr. Chairman.
Does anybody else seek time on the amendment? Ms. Pasquarello is recognized.
Mr. Chairman, I wanted to compliment Mr. Levin.
I do.
This alternative and your specific efforts mirror, I think, a noble attempt to place the American worker and the American consumer at the center of what is a very complex and oftentimes mysterious and onerous trade negotiations. I doubted whether this ideal could be at the center of a trade agreement. I doubted. I had personal doubts about it. Instead of being corporate-driven, you have proven quite the contrary. Peru was a shining example of your efforts and others, of your strong feeling. You wrote into the narrative reasonable standards, which didn't blow up the world, which was successful in Peru and was successful in the United States. It can be done. And I thank you for bringing it here. We may not be able to vote for it here, but we will be able to vote for it on the floor of the House of Representatives. And I thought it was a great effort, and I pause to commend you for doing that. Thank you, and I yield back.
I think I have Mr. Thompson next. Mr. Thompson, would you like to move to strike last word?
Thank you.
Gentleman's recognized for 5 minutes.
I have a question regarding the difference between the underlying bill and Mr. Levin's substitute on the issue of investor-state dispute settlements. Mr. Kearns, are they addressed in the substitute amendment?
Yes, sir, they are.
One of the concerns, and I raised it yesterday in the hearing, that my district has is that California, apply to anybody's state or district, but in my case, California has some good laws on the books dealing with workers' health and safety, the environment, clean air, clean water type of issues, and they're very concerned that the underlying proposal would put those at risk. Does the Levin substitute protect those states' rights in regard to their efforts to keep workers and their families safe, keep our drinking water and our air clean?
Yes, sir, I believe they do. There are two provisions in particular. A common challenge to those kinds of measures you mentioned is that they deny the investor the minimum standard of treatment. It's a fairly vague obligation in our agreements. Mr. Levin's bill would require the president to clarify what that standard means and in a way consistent with customary international law. It would also provide an opportunity for the two governments to weed out any investor challenges that they don't believe are appropriate for the ISDS mechanism.
So, for instance, if a state were to pass a law that said that workers couldn't work around the clock or had to have health and safety equipment, safe working places, guards on the equipment, physical guards on equipment so they wouldn't be put in danger. The underlying bill would allow a foreign government to sue based on those worker safety laws, and the Levin substitute would protect workers by disallowing that?
The underlying bill would allow that if the investor could make a claim that, for example, it constitutes an expropriation, a breach of the minimum standard of treatment, a breach of national treatment discrimination. The Levin substitute continues with those same obligations, but provides more clarity on how they should be interpreted.
Thank you. I yield back.
I think I've got Mr. McDermott. Do you wish to ask questions or strike the last word?
Mr. Chairman, I strike the last word and yield my time to Mr. Levin.
Okay, the gentleman's recognized for 5 minutes. Turn your mic on.
Take up Mr. Davis first, if you will.
Davis? Okay.
And Mr. McDermott later.
Mr. Davis, you wish to be recognized? You move to strike the last word?
Strike the last word.
Gentleman's recognized for 5 minutes.
Thank you very much, Mr. Chairman. You know, one thing I guess I've learned doing these processes is that no matter what you propose, what it is that you decide to do, at the end of the day, you always have to have a way to pay for it. And when I look at the proposed pay-fors in the majority's bill, I find the Levin bill to be an alternative. And I find it to be an alternative because it restores levels of funding for training. It restores funding for TAA. It restores public sector workers and restores the health care tax credit at 80%. It strengthens the capacity of the TPP parties to promote respect for core labor standards. The Levin substitute enhances benefit to the U.S. automobile industry by changing the United States' relationship with Japan by negotiating a rule of origin at least as stringent as the rule in the North America Free Trade Agreement. The Levin substitute provides that the TPP must include strong and enforceable currency manipulation consistent with IMF guidelines and spells out what an enforceable provision looks like. It also takes the position that Congress cannot leave it to an executive branch to decide how to interpret enforceable. That over the past two administrations, the executive branch has not done what needs to be done on this particular issue. The Levin substitute describes what needs to be done to bring Vietnam, Mexico, and other countries into compliance with the international labor standards as reflected in the May 10 agreement, and to help ensure compliance after the TPP agreement enters into force. It also requires that the changes needed to bring our trading partners into compliance occur before Congress takes a vote. It also instructs the President to ensure a level of environmental protection at least as high as the level provided under the May 10 agreement. It also recognizes the need to replace weak commitments with strong ones, such as prohibiting imports of illegally harvested wildlife products. And so when I look at the two, I find that the 11 substitute is more consistent with the way to protect the interests of the United States consumers, to protect jobs and economic development opportunities. And so, Mr. Levin, I commend you for putting together this substitute, which is much more in compliance with my thinking and the thinking of people in the district that I represent, and I yield back.
Gentleman yields back. Mr. Engel.
Thank you, Mr. Chairman.
Gentleman's recognized for 5 minutes.
In the substitute, there is a provision that does say that after this becomes law, that the U.S. Trade Representative will tell us exactly what the impact has been, what markets have we opened up, what opportunities we have, what will be imported, what will be exported, and generally speaking, what import has it had on the labor market as relates to income disparity. It's abundantly clear that we won't be able to find this information out before we vote yes or no. So, Mr. Reif, do you think that this is information that the Congress should have? We enact the bill, everyone agrees to it. Could we ask what industries are going to get hurt, what industries are going to have these opportunities, and how it affects the working market? Does it make sense to have something like this?
Thank you, Mr. Rangel. Good afternoon. Yes, and the underlying TPA bill will provide that kind of information to the committee, to all the members who would have to vote. There are reports that are to be...
You mean is this amendment would be unnecessary?
Yes, sir.
Well, what about if we asked also that we want to know what infrastructure would be necessary in order for us to take advantage of these new opportunities? Would we have a chance to know that so that we can prepare in another bill to make certain that we give this trade bill the support it needs? Is there provision in that?
So the infrastructure would be something that could be taken up in dialogue with, for example, the Department of Transportation, where
I'm
members
saying
of the
that as
committee...
relates to trade, would we be able to talk to the Department of Transportation and say, we want to support the President's trade bill, and this is what we would need? You see, when we pass a trade bill, we want to be effective, and whatever it takes for trade, whether it's education, infrastructure, we want to know. Not that we can do anything about it, because we can't do anything about the agreement except up or down. So do you think this type of information is germane to a good trade bill?
So it could be germane to the consideration of a trade bill, and what the members of the committee could do would be to reach out to the Secretary of Transportation, for example, and ask about port facilities.
I'm talking about the basic bill. In any event, I yield back to balance my time. I want to make certain that we have this type of provision that the USTR reports to us after this becomes law, so we can make certain that if indeed the trade agreement passes, that we'd be able, as a trade committee, to get the necessary information to make certain that it's successful and we take advantage of all the opportunities. I yield back.
Gentleman yields back the balance of his time. Does Mr. Lewis seek time to ask questions or strike the last word?
Mr. Chairman, I move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I want to speak in support of the Levin bill because I think it's a better bill. It's a courageous bill. It is simple. It expresses some of the concerns that I have when it comes to labor rights, to human rights, to working people in these countries and here in America. And with that, Mr. Chairman, I yield back my time.
Thank you. The gentleman yields back balance time. Mr. Kind, do you wish to strike the last word or to ask?
I'd like to ask a question, Mr. Chairman.
Gentleman's recognized for 5 minutes to ask a question.
Thank you, Mr. Chairman. First of all, I just want to commend the ranking member, Mr. Levin, for the tremendous amount of work and effort he's put into the whole negotiations and this effort in putting together a TPA bill. I don't think anyone has worked harder or studied these issues more. If you've seen him go home at night, you'd see the multiple files tucked under each arm for him to dig into. And I commend him. There's probably no greater expert in what's going on with the various provisions. But there is a little concern that I do have with the substitute that is being offered, and it's the tricky issue of currency manipulation. And we've known this was going to be an issue for some time, and there's been bipartisan support to figure out further means to empower any administration, whether the current one or future ones, to do a better job, more effective job in dealing with currency manipulation. But I think the legislation that's before us today, Mr. Allen, or Ms. Ellen, that addresses the negotiating objective on currency manipulation is different from past TPA agreements. Is that correct?
Yes, for the first time, there is a negotiating objective on currency manipulation.
And one of the difficult issues involving that is whether there's any enforceability with teeth behind the currency manipulation. But this legislation before us today has some enforcement mechanisms behind it too, does it not?
Enforcement is mentioned definitely in the negotiating objective.
Could you extrapolate a little bit more of just what additional requirements are placed on the administration when it comes to addressing currency manipulation with our trading partners?
Yes, in the negotiating objective, it states that parties to a trade agreement with the United States, that it is the objective of the United States that parties to a trade agreement with the United States avoid manipulating exchange rates in order to prevent effective balance of payments adjustment or to gain an unfair competitive advantage over other parties to the agreement, such as through cooperative mechanisms, enforceable rules, reporting, monitoring, transparency, or other means as appropriate.
Yeah. Mr. Kearns, as far as the Levin substitute is concerned, could you give us a little further detail on how he addresses currency manipulation, especially the enforceability provision? How defined is that in the substitute?
Yes, sir. The instructions are to conclude an agreement that has strong and enforceable disciplines on currency. It then spells out what that means in terms of enforceability. The rules shall be enforceable through the same dispute settlement and remedies as other obligations in the TPP agreement, but then it has one change to how we enforce the other rules, and that is, in essence, to allow the IMF the ability to find that a country is, in fact, not manipulating its currency, in which case the finding of a panel that that country is manipulating its currency would have no effect.
Okay. Now, this is the concern I have with this, Mr. Chairman, and I'd be happy to yield some time to Mr. Levin for his response, but if the administration is to believe those who have been directly involved in negotiations with TPP, they're claiming that they're concerned that if we take this additional step that I think, Sandy, you're proposing, it may undermine the entire TPP negotiations now coming in at this 11th hour. And I don't know if you've had an opportunity to look at what Senator Bennett had offered in finance yesterday in the language that was actually adopted during the Senate markup dealing with currency manipulation, but I think Senator Bennett takes an additional step in our direction. But I'm wondering if you would share the concern the administration has been expressing to us that we adopt your language on currency that could undermine the whole TPP negotiations right now.
Well, thank you for your kind words and in our working together, Mr. Kind. The answer is we've worked so hard on this, and currency manipulation has caused more job loss than anything else directly related to trade. It's not the only factor. Innovation is, globalization. But anybody who denies the impact of currency on middle-class jobs really is in denial. So we've been talking to the Treasury and others. I want to be clear. I'm working to get a TPP that would have broad partisan support, not to eliminate it. That's the purpose of this substitute. So we've written this so that it has some meaning. The present, it's true that this is in the TPA for the first time, but it was in the Camp-Baucus bill, the exact same language. And it's essentially toothless. I won't say meaningless. It's toothless because it talks about various procedures or other means as appropriate, which leaves it to Treasury. So we've set up a system so for the first time, if you would just give me another 30 seconds, I'll be done. For the first time, there is some action, and essentially we give to the IMF a veto because there have to be some teeth. Otherwise, it's going to be more of the same. Japan is not now manipulating the currency, but they have. China is still. And we say we don't want China to write the rules, we want to. We're now trying to write the rules on currency. And the message will get through to
Well, thank you, Mr. Chairman, for your indulgence.
Time for gentlemen has expired. Mr. McDermott, do you still want to get in this? You had your hand up earlier. Did you? You want to move the strike last order, or do you have any questions?
I have a question.
Okay, gentleman's recognized for 5 minutes.
I thought I'd given up my time by giving it.
Oh, that's
Take
right.
it back. It's
So how do
his-
we, yeah, I
it's
just
his
didn't
time.
recognize him, so I'll recognize you now.
I have a question. The President has the right to negotiate treaties under Section 2, Article 1 of the Constitution. And where does the right come for us to ratify, or the requirement that we ratify treaties? Is there a section in the Constitution under which?
Article 1, Section 8, Mr. McDermott. Article
Section-
1, Section 8.
Section 8 requires that anything he does is ratified.
Well, it gives the power to Congress with respect to regulating trade between nations, commerce between nations.
So this is a trade treaty rather than any other kind of treaty that, like the president with, I was thinking about the Louisiana Purchase, which was a treaty between us and France, in which we took the Louisiana Purchase for $15 million. It was never discussed by the president with anybody. He brought it back to Congress, and by a vote of 59 to 57, they ratified it. Now, I didn't understand whether they had to do that or they did that. I mean, I'm trying to understand the process, because the president says he needs to have this fast track because no one will deal with him man to man or man to woman or whatever unless they know that there's going to be an up or down vote. That's what this is all about, is guaranteeing an up and down vote on the, but is there a requirement that actually happen? And you're saying,
Yes, Mr. McDermott, the changes to U.S. law that would be made by an executive agreement like this are not, an executive agreement like this is not self-executing. So therefore, it requires an implementing bill and the president does not have the power to change U.S. laws. It requires an implementing bill because the agreement is not self-executing. It's also not a treaty that is passed by Congress, by the Senate, by two-thirds.
can you give me then a little example from NAFTA or any of the other trade agreements that what we have changed in our law as we've had the implementing language?
Yes. In all of our trade agreements, we change tariffs, U.S. tariffs, in order to comply with our obligations. We reduce our tariffs.
How about substantive non-tariff barriers?
Non-tariff barriers, one example would be in the government procurement area, where the United States, in return for getting concessions by other countries to open their procurement markets to us, we open our procurement market to them, and that requires a change to U.S. law. So that's one example.
What did the law say before, and what did it say after? No one could do government business or business with the government except Americans?
Yes.
And you had to open it up to the world?
Well, that particular country because it did not have a trade agreement with the United States, would not have access to the U.S. government procurement market.
So it's those kinds of provisions that we should anticipate we will have in this implementation bill that's put in front of us 60 days before the president even signs the agreement with the other country. He can't sign it until we've had 60 days to look at it. Is that correct?
That is correct, Mr. McDermott, yes.
Under the bill as it's proposed here in the committee.
Yes.
And Mr. Levin makes some changes to that. Okay, thank you. That's what I needed to know, Mr. President.
Thank you. I haven't forgotten. Mr. Doggett, I believe you want to move the strike last word.
I do, Mr. Chairman. Thank
Gentleman's
you.
recognized for 5 minutes.
Unfortunately, so much of the discussion here in Congress about the issues we're talking about today on trade is strictly on a flashcard basis. You're either for trade or you're against trade. I happen to believe that more international commerce is in the interest of our country and our economy. That's why I voted for agreements with a number of the countries that are in TPP in favor of free trade with Australia, Singapore, Peru, and I endorsed NAFTA with Mexico and Canada. I think the question is not whether we should have more trade, but what the terms of that trade will be and what the nature of involvement by the Congress will be in establishing those terms. That's why I support this amendment and commend the ranking member for his efforts to offer a right track. This right track amendment, while it contains many ideas that Mr. Levin has been advancing for years, has been put together hastily in response to the fast track bill, which if it's not high-speed rail is close to it and is moving quickly through this Congress since it was introduced last Thursday. The right track bill is a step forward. It's an important, it contains many important guarantees that are not found in the base legislation, but it's not necessarily contain all of the provisions that I would like to see in future similar legislation. I commend the effort and think that it gives us a good basis for moving forward in the future and perfecting its provisions to assure that we realize the full benefits of a 21st century trade policy. I believe that the alternative is essentially to post a yield right-of-way sign to the fast track and the train that's moving through here. And the proposal that we have today really is about as new as last year. It is overwhelmingly, with only minor substantive differences, the same proposal that was advanced by Chairman Dave Camp last year. It contains a lengthy wish list of negotiating objectives. Mr. Levin has pointed out earlier that really the only change is to add another wish with regard to human rights. And I'm pleased there's a wish there, but under the base bill there is not a mechanism to assure that the objectives are any more than wishes and hopes and dreams of the type that have not been realized in the past. We do have some experience in the past, and I think that it is more persuasive than the lavish promises of some of the fast track promoters. We have the experience of USTR with regard to the environment. The fact that though we worked so hard to get the May 10th agreement in 2007, USTR has never filed an environmental complaint. It's had complaints from outside groups brought to its attention concerning the incredible amount of illegal logging that continues to dominate Peru, but it has not taken enforcement action. On labor complaints, if anyone ever pulls out their watch concerning when USTR might act, they need to pull out a multi-year calendar instead, because USTR has taken many years to respond and still has not fully responded to a number of the labor complaints that are out there. I think that the Financial Times of London, really the Wall Street Journal of the United Kingdom, which has endorsed today's bill and has endorsed TPP, said it best in its editorial of support when it said, quote, "In too many aspects, TPP looks like a charter for corporate America rather than the high-level trade agreement it purports to be. It is a charter for corporate America, and that's not all bad. I want corporate America to be successful and competitive, but I want corporate America to do so in a way that advantages all of our country and respects environmental and working rights and recognizes that a race to the bottom is the wrong way to go. I think there's also an issue that has not been fully addressed in our discussion, that this fast-track bill is not only about authorizing action by President Obama in the remaining months of his presidency, but authorizing our next president, whomever she may be, to adopt that charter for corporate America with any country, at any time, on almost any terms. So when we look at what authority we in Congress are yielding to an administration, we're not talking about just this one, but the next one. We're not talking about just the countries that were picked out in Asia, but the agreement in Europe and agreements that could occur with any other country. It is a really significant piece of legislation extending for years, and therefore the safeguards that are included in Mr. Levin's right track approach are extremely important to working families across this country to have there. Finally, I would say I understand there's been some question raised about whether this amendment in its current form is in order. The Rules Committee shares jurisdiction with us over certain aspects of this bill. It yielded that jurisdiction and chose not to have any substantive hearings on this bill. It is the congressional authority part that is one of the most important aspects of Mr. Levin's bill, and I fully support it. Thank you.
Time for the gentleman's expired. Mr. Blumenauer, do you wish to ask a question or strike the last word? Gentleman's recognized for 5 minutes.
Thank you. I appreciate the comments of my friend from Texas, and I agree with him in part, have modest disagreement in another area. I mean, I could not agree more about the challenge of enforcement. And that is why I've offered up a proposal to establish an enforcement trust fund that would enable us to have a dedicated source of resources to be able to do a better job enforcing these items. And I think we all have ought to share in that commitment to make it work, and I think it can help change the dynamic. I do modestly disagree with the sense that this is simply a retread of what had happened with the Camp Baucus proposal. I think this draft is significantly better. It's something that I feel comfortable supporting, but I don't think we're through with it yet. It's why I appreciate Mr. Levin offering up his alternative. I think there are a number of things in there that I think have merit. I think that all of us should look at them, and I think there are items that should ultimately be in the final package. One of the lessons I take away from this is that we need to work better to be able to accelerate this process, because I agree that we're getting a lot thrown at us at the last minute. And I think if we'd had a little more time working together, we'd find that there were more areas of agreement and cooperation. And I hope that we, on our side of the aisle, do a better job of engaging. I hope that you will meet us more than halfway. That said, I appreciate Mr. Levin's hard work. I'm going to support his amendment, and I hope that even though I'm confident that it's probably not going to pass, but that people look at the elements and the spirit with which it's offered and see if there are ways that we can make this ultimate package better. Because I think that is our challenge at this point. The chairman has indicated there are lots of moving pieces here in a package that we're developing, and I take him at his word that we'll be able to help fine-tune and move some of these forces forward. But I hope we don't lose sight of the fact that the Trade Promotion Authority is to provide a framework for the administration and also for us, that we evaluate it. These things are not meaningless words that are on paper. I know that the administration has taken a number of these items seriously, as they took seriously the May 10th provisions that I was pleased to work with Mr. Levin on, and I think have added a permanent step forward in our trade efforts. All of us, at the end of the day, are going to have an opportunity, and because of what's been negotiated already, we'll have more time to evaluate it along with our colleagues and our constituents about whether it measures up. And I hope that we'll work cooperatively to have more tools to help it measure up, and that we will work so that the total package is one that meets objectives that I think most of us agree on. Because I think at the end of the day, when we're through all of this back and forth with the Senate, our work, conference committees, we ought to have a package that doesn't have to be along narrow partisan lines or leave unnecessary questions about our intent and our resolve. And I hope that before the day's over, we are able to take a couple steps that move us in that direction. I thank you, Mr. Chairman, and I yield back.
Thank you. I will move to strike the last word and recognize myself for 5 minutes. I'm kind of having an out-of-body experience here. I find myself defending the President and his Treasury Secretary against amendment from his own party. So let me give this a crack here. Yeah, this is a strange world we're in these days. I want to say to the gentleman, the ranking member, our offices are right next door to each other, so you have a very, very hardworking ranking member. He's always walking late at night with all these papers under his arm, so I know the absolute sincerity with which you approach this issue and how committed you are. Having said that, I oppose the substitute for various substantive reasons. Let me try and articulate some of them. First, there's a process problem, which is important parts of this are outside of our jurisdiction, and we can talk more about that in a minute, I think. It provides TPA only for TPP, not for the other important negotiations that we are conducting right now or that we might initiate. What's interesting about that is, to defend the president here, a guy I ran against in the last election, why should we treat him differently than any of the past presidents we've had? We've always given trade promotion authority for a period of time so that the president can go out and get agreements in that period of time, not on an agreement by agreement basis. So why lower the standard or diminish the authority for this president when we've never done that for past presidents, and why should we do that for whoever the next president's going to be? So I just don't think that that's the right thing to do. It also leaves out important negotiating objectives like cross-border data flows, regulatory barriers, digital trade, trade in goods generally, trade in services, and intellectual property. The purpose of these agreements is to get us at the seat of the table to write the rules of the global economy, and these are the things that are the rules that are going to be written in the 21st century global economy, and we shouldn't be silent on those. And the negotiating objectives it does include, I believe, are very problematic, and they don't have bipartisan support. As we heard yesterday, and we can get into this, and I think we're going to have some more amendments to do this, so I'll briefly get into the currency thing. And I think, Mr. Neal, you've got an amendment on this coming up? Okay, so we'll talk about currency a little bit later. Secretary Lew told us yesterday that the administration will oppose this kind of language and that our trading partners would never agree to it. So it's basically a deal killer. And the labor and environmental provisions in this substitute go way past May 10. The procedural provisions, as a practical matter, make TPA unworkable in my judgment. There are too many opportunities for a subset of members to unilaterally turn off TPA. That is a power that that should be required by the action of the full House. And so this approach, in my strong judgment, does not provide our trading partners with the confidence they need to put their best offers on the table. It's all about getting the right balance. Giving the administration direction and guidance, but not being so constrictive as to basically having 536 negotiators at the table. You've got to give our negotiators room to negotiate. At the same time, you have to have a process that our trading partners have confidence in so that they can put their best offer on the table and not fear that it would be easily turned off, and then Congress will just rewrite the thing. Because why would they give us their best offer if they think we're just going to undo it, in a week or two by bringing it through Congress? And I think this disrupts that balance. And, that's an eye of the beholder thing. I grant you that. But I do think that this goes way beyond the confidence that the process is designed to inspire and instill in our trading partners. So for that and other reasons, I just think it makes TPA unworkable, and therefore I oppose it. Let me, I'm going to go to Mr. Brady, but I've got what? Oh, you didn't turn the clock on for me. You should have done that. Let me just ask the administration, do you have concerns with this amendment? Mr. Reif.
So, thank you, Mr. Chairman. We think that the underlying bill provides the right kind of authority, the right balance in many of the areas that Mr. Levin and others who've spoken in favor of the substitute identify. The right balance on intellectual property rights and the right balance in a wide variety of areas. So we're supportive of that. We think it is an approach that gives our negotiators the ability to negotiate good agreements for American workers, for businesses, farmers, and ranchers, and as well be able to engage and consult with, take the counsel of the Congress, and also provides the kinds of mechanisms for Congress to ensure that the administration is heavily engaged in negotiating the kinds of agreements that it wants. So yes, we are supportive of the underlying bill.
Thank you. I'll note that 7 Democrats in the Senate Finance Committee voted for the underlying bill as well, so this is bipartisan. With that, Mr. Brady, I believe you want to move to strike last word?
Yes, I do.
The gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. First, my friend from Texas and the high-speed rail references. Given the 12 years it's been since we've modernized and updated our trading objectives, the 5 years since the Customs Reauthorization Bill has been substantially complete, the years it takes to launch and negotiate and complete these trade agreements, as well as the dispute resolution mechanisms, the phrase high speed and trade have never actually appeared in the same sentence for most of our lives. In fact, most of us believe that given an economy of ours that needs more customers around the world, that it's important that we set a process that both parties can agree to that allows us to get on that playing field and find those customers with the chance to compete and win. First, I too want to join others in complimenting Mr. Levin for laying out an alternative proposal. Given his expertise and sincerity, we know it is a constructive one. But I want to point to an area of this that I think, frankly, undermines the whole approach, and it is, in this amendment, it creates, in effect, a super committee appointed by the Speaker and the Minority Leader, who will be given the power to certify and turn off TPA for an agreement such as the Trans-Pacific Partnership. Seems to me, in this regard, we're going back the wrong direction. In this overall bill, supported by Republicans and Democrats, as Mr. Ryan said strongly in the Senate, the common ground is that we open up the negotiating objectives so people know clearly what we are asking the White House to negotiate to. We set very strong consultation authorities and directives, allowing members to actually be part of the negotiating rounds, again, opening up this process to each member of Congress. And then, because of the timing, we actually create openness for the public, 60 full days to see what's in this agreement, and the ability for this committee and the House to turn that off if the White House, to hold the White House accountable if they don't comply with each of these directives. This amendment creates a super committee that actually puts power, shifts power to the hands of a few. The full House puts in place this trade promotion authority, and only the full House should be allowed to remove it. When I look around this committee room, the most knowledgeable members on trade are sitting right here on this committee. You understand the issue. You make constructive amendments. You argue it because you know the impact of it. Do we really want to relinquish to a super committee the ability to supersede our judgment and expertise in this area? And if you can do it in trade, will we do it also in tax? Will we do it on Social Security, Medicare, and all the authority in our jurisdiction that we have spent years, frankly, understanding and shaping solutions for? And so I think this amendment takes us back away from the openness and transparency that we need. I know it would be difficult to ask a member to vote against their ranking member who they respect. My only caution would be, once we stand on the record in favor of supporting super committees that supersede our authority, other committees take notice, leadership in both parties take notice, and it is important, regardless Republican or Democrat, that we maintain the jurisdiction that goes with the knowledge that comes with members of the Ways and Means Committee. So I strongly and respectfully ask that we oppose this amendment.
Gentleman yields back the balance of his time. Mr. Bustani, do you wish to seek the
Yes,
last word? The gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. The world is not standing still. Economic activity is going on at a furious pace in Asia and around the world, and this activity is not waiting on the United States. So to limit TPA, Trade Promotion Authority, only to TPP right now sends exactly the wrong signal. We need to be sending the signal that American leadership is back. We've had far too much inertia when it comes to trade policy for several years now. It's time to move. And so putting the base bill in play, enacting that, sends that very strong signal that America's back. We're back fully engaged in economic foreign policy. We're back to lead, and the rest of the world is waiting for us. They want us to lead, but they're not going to wait for us forever. And these trade agreements are going on all over the world. So that's my first objection to this amendment. Secondly, sending the signal is critically important from a national security standpoint, because our economics are linked to our national security, and our partners want us engaged, both in Europe as well as in Asia. But if we're going to get back to a global trading system with a trade and services agreement and many of the other agreements we've got going through the WTO, environmental goods agreement, and so forth, we need a strong, robust TPA to put the United States back in a position to negotiate all of these deals. I fully agree with the statements that Chairman Ryan made in opposition, as well as my friend Mr. Brady. I have deep concerns about the approach. It's a thoughtful approach by Mr. Levin on currency, but I have deep concerns about the consequences of it. And I am very concerned that given we have the world's reserve currency, we've had a demonstrated ability to push others to back away from currency manipulation. We were successful with Japan in the 80s. Why do we want to set up a proposal unilaterally that would invite retaliation and put us into a bad place, potentially wreck TPP as an agreement? I think we ought to act on the world stage with confidence. And by putting forth the base bill, this puts those trade priorities in place. It's got strong enough currency language to empower Treasury to get engaged further and work through multilateral fora and bilaterally to deal with these currency issues. So for all of these reasons, if you believe in American leadership, if you believe that America should lead economic engagement and trade policy around the world, this is the most far-reaching TPA proposal we've ever had. I would say let's unanimously vote for this and send a very strong signal to our friends and foes alike around the world that we're ready to engage and we're ready to set the rules for formal engagement with trade. And with that, I yield back.
Gentleman yields back the balance of his time. Mr. Buchanan, do you move to strike the last word?
I do.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I want to as we go down the road here a little bit, Mr. Levin and myself actually were both from Detroit. A lot of our family grew up in a lot of the plants and things there. And in full disclosure, I've been in the auto business for the last 25 years. I've owned a lot of dealerships, a lot of Toyotas, Lexus, Honda, and I've owned a lot of different domestic dealerships. But my biggest concern, and I want some assurance about market access. When you look at, I'm a free trader, but I want at the end of the day for it to be fair for Americans. You look at the fact that the Japanese, rough numbers, sell 6 million in the U.S., and basically, I think someone told me 20,000 that we sell in Japan. Where's that sense of fairness? Now, I'm for TPA, but I don't want to tie the hands of our negotiators. But at the same time, I want to make sure we have some assurance in terms of market access. You're the attorney writing the bill, or in terms of looking over the language on behalf of all of us. What's your sense, I might add, Mr. Reif, in terms of where market access, where we're at on that?
Thank you, sir. Market access has a number of different components. There's, for example, there's reductions of tariffs. There are non-tariff barriers. There are other kinds of areas in digital trade and other kinds of intellectual property protection. All of that has to do with ensuring that our manufacturers are able to compete on a level playing field. And the negotiating objectives contained in the bill give our negotiators the right kind of directions, enable them to meet with their foreign counterparts, and to say that we need a high standards agreement for American jobs, for American families, to bring it home so that the Congress will approve it. And all the while, of course, sir, our negotiators are in close consultation with the Congress and with our stakeholders in designing the objectives that we are seeking and seeking to carry them out.
I just look in terms of the auto industry, it's not even, in my mind, close. It's really ridiculously over the top, one-sided, and I know this has been going on for years, and maybe at one point we give them the benefit of the doubt. But as we move forward in the 21st century, I want to make sure that there's some sense that we're going to have the same opportunities that they've had in the U.S. And I can tell you, as someone that sells General Motors and Ford products, too, over the years, our quality is a lot better. So it's not a quality question, it's a market access question. And I want to make sure we're doing everything in terms of our negotiators to give us more access, have some sense of fairness, because when you compare the numbers 6 million to 20,000, it's completely out of whack. There's no sense of fairness. But I want to know that going forward, there's some sense of fairness for our manufacturers and our jobs in the U.S.
Thank you, sir. In the auto sector, we have a two-part strategy. The first part of the strategy is to have the longest possible phase-out periods for U.S. tariffs to address the disparity that you described. The second piece directly addresses the problems that have helped to create that disparity, which is opaqueness in regulations that are not fair, and dismantling those and enabling our producers to export more effectively and compete in the foreign markets of the TPP.
Again, thank you. I'm going to support TPA, but at the end of the day, I want to make sure we're doing everything we can in terms of our negotiators, that we're getting the best possible jobs for our manufacturers and our jobs here in the U.S. And with that, I yield back.
Thank you, gentleman. Yields back. I believe Mr. Levin's prepared to close. Mr. Becerra, do you want to strike the last word on this? On his amendment? Okay. All right. Is that all right?
Thank you, Mr. Chairman.
Gentleman's recognized.
You're the boss. Thank you, Mr. Chairman. I know we're trying to accelerate this, so I will keep to the point on this. First, I have to say thank you to Mr. Levin, because as the chairman knows, it's not easy to come up with a bill that incorporates all these ideas and puts it in a way that can garner the support of a lot of members with a lot of different ideas. So I just want to acknowledge my colleague and friend and our ranking member, Mr. Levin, for the work he has done. And I want to thank the chairman for allowing there to be a robust debate and consideration of this substitute amendment. One thing we keep hearing from a lot of members, including those who are proponents of this particular Trade Promotion Authority legislation, the underlying bill, is that if we don't do this, if we don't get in there and write the rules, who will? Will it be our competitors or adversaries who end up writing the rules that we have to live with? And so I think it's a great rule, or excuse me, a great question to ask, because we do have to know who will write the rules. We know competition around the world is fierce. America's feeling the brunt of it, and it's not always fair. And all you have to do is ask some Americans, whether they're business owners or former business owners, and American workers who felt the sucker punch of losing their job or their business because that business or job was outsourced. It's a tough world. And so we do want to make sure that we're there writing the rules. But here's the funny part, and it's very telling, that the very trading partners that want us to go forward with a TPA so we can sign the Trans-Pacific Partnership deal that's in the works, are telling us, you include a provision on currency manipulation, and we're out of here. To me, that seems very strange because for decades we've been trying to grapple with this issue of countries devaluing their currency for the wrong reasons and manipulating it to gain advantage, principally over the U.S. And so for them to be telling us, you put currency provisions in this bill and we walk, that's very telling. That's very telling. Because if they're not willing to do it now when they have so much to gain by doing a trade deal with us and no access to our markets and all the provisions that are in it, then the question is, if they won't do it now, when will they agree to stop manipulating? And if they won't do it in this deal, where will they do it? And for us not to take this action is to simply say we're willing to agree that we want to aspire to stop currency manipulation. Aspiring is not doing. Wanting is not getting it. Objectives in this Trade Promotion Authority are not obligations. And what we're telling that American got sucker punched and lost his business or her job is that we're willing to live with an aspiration to try to get those fierce competitors to stop tinkering with their currency to gain an advantage over us. We need teeth in any agreement we sign. We need obligations, not objectives, in anything we agree to. And we need rules that will promote and protect the rights of our workers, the rights of our businesses, big or small, here or abroad. And we need to know that we can protect the air we breathe and the water we drink. And so we owe it to those Americans, workers, business owners alike, to fight now, not tomorrow. Fight here, not somewhere else, for things that we know we must do. And one of those things is currency manipulation. There are other things as well I could go through, but to me, the threshold consideration is, are we going to stop countries from cheating? And if we're not going to say we're going to stop countries from cheating, let's stop kidding ourselves. We can't expect that they will stop their companies in those countries from cheating. If the person that's going to sign on the dotted line won't commit to stop cheating, no way they're going to stop all those underlings that are doing the cheating within their borders. And so I hope that we understand what Mr. Levin was able to put together here, that it's something that really moves forward, not just what we need in our trade agreements, but what we need for the American people. And with that, I will yield back the balance.
Gentleman yields back the balance of his time. The gentleman from Michigan, Mr. Levin, is recognized for 5 minutes for the purpose of closing on his amendment.
Thank you, Mr. Chairman. Thank you and everyone else for your kind words. We've worked hard on trade issues for decades. The purpose has been to expand trade and to shape the terms and conditions as we expand trade. And when that hasn't happened, if the president was Democratic, I voted no. And if we did that successfully and the president was Republican, I voted yes. I worked on the China PNTR with your predecessor, Bill Thomas. It was immensely controversial, and we proposed something that I thought made sense. So let me just say a word. I'm glad you raised these other negotiating subjects. The more we talk about TTIP, and the more we talk about TISA, and we're going to give to the administration the power to negotiate and only say yes or no, we have no real idea what's being negotiated on TTIP. Some idea, but no real idea. How it will handle financial services. So this isn't just for TPP. This is for other agreements where essentially we're saying to USTR, if it isn't a blank check, it's a free hand. And as you said, Mr. Rangel, we're giving up this leverage, and essentially we're left with yes or no at the end, with consultation in between. On all of these other issues, for 3 to 6 years, beyond this presidency, maybe beyond the next president, his or her first term. Let me just say, in terms of objectives, cross-data, services, we didn't include areas where we agree. Let me say a word about giving up our leverage. In the automotive sector, we're giving up a lot of leverage. On state-owned enterprises, we don't really know what the other nations are going to say. They want exceptions, which would make the SOE stuff essentially meaningless. So I think by passing this TPA, we're really weakening the hand in many respects of USTR. Because essentially what we're saying is in many of these areas, the leverage of Congress is gone, and it's been the leverage of Congress that has been the strong hand. So it works the opposite of what's been said here in many respects. And in terms of empowering the administration and USTR, we need to have confidence what's in hand before we hand over our leverage. And I want to close just by talking about the TPA procedure. We've tried to set it up so that there is a process before TPA is granted, that we have instructions, and Mr. Becerra, you have said it so correctly. Aspirations are one thing, but instructions are something else. And essentially, this TPA is loaded with aspirations, and if we vote for this TPA, we're essentially, as I said earlier, putting this Congress in the back seat. I want a TPP. I want one that can get broad bipartisan support. The only way that's going to be that will happen is if we in this Congress will be in the front seat, not in the driver's seat, in the front seat, working in partnership and having leverage on these critical issues. This is giving it away on so many key components of this TPP. It's a mistake to do that, and I hope very much that people will vote for the substitute. I did not talk about process. We'll talk about this later. This is so important. We deserve a vote. We deserve a vote on this substitute. Thank you, Mr. Chair.
Gentleman yields back.
Mr. Chairman.
Gentleman from Ohio is recognized.
Mr. Chairman, I must insist on my point of order.
Gentleman makes a point of order. I am prepared to rule. Let me explain. The amendment does fall outside of the jurisdiction of this committee pursuant to House Rule 10. Let me explain what that means. In the 4 months since I've been chairing this committee, I bet everybody on here is not surprised to hear that I defend our jurisdiction constantly. And if we are to enter into writing legislation in the jurisdiction of another committee, what's to stop us from preventing that from happening in other committees in our jurisdiction? Something that I've been successful in preventing from happening so far. So in accordance with my desire to protect the jurisdiction of this committee and prevent other committees which concurrently are trying to write bills in our jurisdiction in their markups, the point of order is sustained, and the amendment is not in order.
Could I speak on this? And I hope others will.
Can he, yeah, gentleman, you can strike last word? Yeah, okay, this gentleman move to strike last word?
Yes.
Gentleman's recognized for 5 minutes.
I don't think the American public will accept this. I hope Congress won't. I hope the administration won't. We have put together a substitute drawing upon our experience, the work of staff, based on a lot of past efforts and major negotiations and discussions with USTR. Now what's being said is that because in this bill, there is a provision, or there are provisions regarding the role of Congress, therefore we can't have a vote. Well, the basic bill has provisions regarding the role of Congress. So essentially, you're saying what's good for your bill essentially allows you to rule out of order a vote on ours. So what's good for the goose isn't good for the gander. More importantly than that phrase, essentially you're saying on this very major issue, when you have provisions that relate to the role of Congress, and we do, you get a vote on yours, and we don't get a vote on ours. Now, you have the ability to waive it. You should do that. There was never this issue brought up until very recently. This is an unnecessary kind of surprise attack on what is not only the right, but the need for every member of this committee to be able to work on a substitute and have a vote on it. And I just want to say, the implication is you work with the Rules Committee. If the Rules Committee doesn't take this up, we could not even have a vote on the floor on our substitute. I think you'll be sorry if you do this.
Will the gentleman yield?
Yes.
So the Rules Committee has already ceded its jurisdiction. There's no ability for you to go and present the congressional oversight portions of this to the Rules Committee under its substantive jurisdiction, apart from writing a rule on the bill.
Would the gentleman yield? You're controlling the time right now. The underlying bill was written with the Rules Committee, in concurrence with the Rules Committee. The gentleman's substitute amendment was not, does therefore violate Rule 10. And if Rule 10 is not a new rule, Rule 10's been around a long, long
Okay,
time.
but let me take
It's designed to protect the jurisdiction of committees who are writing legislation in their committee's jurisdiction.
And I respect your determination on that, but there's no place for him to go have a hearing.
To discuss this, okay?
Well,
Back and
you're
forth.
striking the last word.
I know,
It's within your right.
But I don't want to cut off anybody, especially the chairman.
It just appears that if you have meaningless congressional oversight, that's in order, but if you have meaningful oversight, it's not in order. And you don't have a Rules Committee to go back to. The tradition is that amendments are not normally allowed on the floor to Ways and Means bills, so you're being denied the one opportunity to present effective, meaningful oversight today in this hearing. It's being cut off entirely.
But what's happening here is trying to use a point of process against a vote on major policy. That is a serious mistake.
Would the gentleman yield?
How you, Mr. Rangel?
Perhaps the chairman has good reason to doing this. We started this hearing off in a spirit of partnership, and I know when you got the votes, you got the votes. So why don't you let the chairman explain why he thinks it's so important that we just don't have a vote, which obviously we're not going to win it. Why don't you let the chairman explain why he's doing this to us?
No, he did, and I'd like more.
He didn't like the explanation.
He explained, and I didn't like it. I'll tell you why. I didn't like it. We're good pals. But it's a mistake to use process. Mr. Rangel, you've been chairman for a long time, I for a short time. We need, in this committee, to discuss policy and not shut off each other with a ruling on a rule.
Time. time for the gentleman has expired. I will move to strike the last word, yield myself, because I want us to have a good civil discourse here, but Rule 10 is an important rule, especially for a committee like this, where there are lots of other committees who would love nothing more than to infiltrate or take over the jurisdiction of this committee, who would love to write bills in their markups within the jurisdiction of the Ways and Means Committee. It should come as no surprise to anybody in this committee that the chair, whoever the chair is, spends a lot of their time defending the jurisdiction of this committee. I'm doing it right now with Foreign Affairs. And so if we decide to waive Rule 10 and then go into the jurisdiction of another committee and write legislation in their jurisdiction, what's to stop another committee from doing it to this committee? This is why we have Rule 10. Look, of course we have the votes. We don't like the substitute. And the gentleman did have the opportunity to rewrite his substitute so that it didn't invoke Rule 10. That was a choice he made not to do that. I understand the choice because it would have substantively changed your bill and you didn't want to change it that way. Nevertheless, this goes into the other committee's jurisdiction. The base text was written with that other committee and with the consent of that other committee. And so because I need to stay consistent in the defense of the jurisdiction of this committee, I am going to rule that the amendment is not in order.
Will the gentleman yield?
I will, yes.
I just want to point out, I think this is a fair and consistent ruling, especially in light of the full discussion we've had on this amendment, and that we are looking at another 16 to 19 amendments that are the provisions of the Levin substitute. Those that are in order and jurisdiction will have a full debate and be voted upon. Those, of course, in other jurisdictions won't be. And so today really is about an open debate on issues that are in our jurisdiction, and the amendments that will follow will have a full and open opportunity to go on the record in support
Would the gentleman yield?
I
opposition.
claim the time, I will, but I would like the minority to know I could have made this ruling at the beginning. I could have made this ruling an hour ago. I chose not to, and let anybody who chose to do so on this side of the aisle strike the last word so that they could be heard on the substance of their amendment.
Heard but not vote.
Well,
Would you
you understand my reasons. You don't like it, you understand it.
Mr. Chairman, would
I
you
will yield to the gentleman.
In reference to Mr. Brady's point, if we were to accept the Levin amendment, we'd be able to leave now.
That's true.
The other amendments would be unnecessary.
Yes. Well, we will get to the other amendments. We can discuss the substitute.
Mr. Chairman, strike the last word.
I'm about to rule, and we have 19 more amendments.
I have one question for
Okay.
you. To you.
I will yield.
My understanding was that we were told that this was going to be in order. And then last night, I don't know, after most of us went home to bed,
That's my understanding as well, but we don't control what the parliamentarian tells you.
Well, but if then we tried to, if we pulled that section out.
That was your choice this morning, and you chose not to do so.
It's more than that. The gentleman yield?
Sure. I mean,
Look, it's more than one section. We put this together carefully. We were told it was in order. I've also been told that one could rule either way. You have the power to waive this rule. And the important thing is the substance that is in our bill that's subject to objection is the precise subject that's in your bill. And now you're saying it's in your bill, it's okay, but if it's in our bill, that's subject matter, no. So you kind of, on this, I'm afraid, you're locking the door and throwing away the key. And that isn't the way that this body should operate.
Gentleman yields back. I can say the same thing over again. I won't for the sake of efficiency here. Understand the point of order is sustained. The amendment is not in order. Are there any other amendments? Mr. Rangel?
Yes, I have an amendment.
I believe the gentleman from New York has an amendment. The gentleman will suspend and let the clerk distribute the amendments.
Mr. Chairman, I reserve a point of order.
Gentleman reserves. I know, I'm trying to find it. I don't have a copy of it. Which one's this, the ITC one? Okay. I think they're headed out. Gentleman from New York is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, when we ask the American people to give their views on trade, I'm certain that they won't be asking us about manipulation of currency in Vietnam and investor protection, but they want to know about jobs. And that's the one area that we cannot find. What kind of jobs are they going to be? Who's going to get them? What skills are necessary? What will the middle class do? Will the corporate executives take all the money? Just give us an idea of what most American wants to know. How does this affect me, my job, my pocketbook, and my community? Now, somebody knows right now which industries, which communities, which corporations support this piece of legislation. And they don't do it because they're just good Americans. They do it because they expect to make money. There are other corporations that know they got to take a hit. But that's what trade and progress is all about. You win some, you lose others. Now, since we will not know ahead of time, because of reasons that allow me to believe that it may impact people's votes, I have here a proposal that directs the Commission, the International Trade Commission, to tell us just what impact this is going to have as relates on jobs and opportunity, on medium wage, income disparity, specific market opportunities for exports and imports. And we want to know really whether or not this is going to take in consideration the disparity of income and what impact economically is going to have on our workforce. Now, in the administration's bill, there are general directions that deals with reports, but none of them deal with jobs. Every time you ask the administration, they said, of course there's jobs, there's economic growth. They don't say, of course, there's going to be opportunities for corporations to make profits. They don't say that there are provisions here for American people to get the training and the skills that's necessary. And so this is after the fact. And I wish we would know ahead of time exactly who's going to be getting these economic opportunities. Will it be in America? What industries? What training? What salaries? What wages? What incomes? And so I don't see how anyone could object to this. And before we have a vote, is there anyone that doesn't believe that the main question in the community will be, you say trade, people say jobs? Is that true, Ms. Ellett? Is that generally what trade means to constituencies, jobs?
Then it means jobs.
Yes. Mr. Reif, when you talk about trade to the people in the street, they don't want to know all of the different countries that will be the beneficiary. Just generally speaking, trade means job and prosperity.
So I think trade does mean economic.
Microphone.
Sorry. Trade does mean economic opportunity.
Jobs.
Jobs, certainly,
Okay,
business
so,
growth.
Mr. Chairman, because of that, I think that we should, as a committee, get specifics in our reports as to jobs. I hope you would agree with me and accept this amendment.
Mr.
Chairman.
Chairman, seeks time to...
Mr. Chairman, before I tell you why...
Move to strike last word. The gentleman's
I'm going to
recognized for
move
5
to strike
minutes.
the last word. Why I'd ask my colleagues to oppose the amendment, since I did make the point of order on the last measure. I just want to remind my friends and colleagues that when we were in the minority, Rule 10 was around as well. In fact, Mr. Rangel was chairman back in 2009 as we sat through a very lengthy health care markup. And we were painfully told that though the bill had jurisdiction within the Ways and Means Committee, it also had jurisdiction, as you might remember, in the Energy and Commerce Committee, as well as the Education and Workforce Committee. And many of us wanted to offer amendments that were outside this committee's jurisdiction, and Rule 10 was used to say, we can't do that. So I just wanted to remind my colleagues, sometimes what comes around goes around. The rule is there for a reason. It's been used by Democrats and Republicans for a reason, as the chairman, I think, eloquently put. I support efforts to be better informed, and I think the issue Mr. Rangel talked about is a legitimate one that informs us of the effects of trade agreements. That's why this TPA agreement, and I think, Mr. Chairman, Mr. Rangel, you know this, and the administration obviously has talked about this, that this TPA requires detailed reporting from the ITC, more detailed reporting than ever before. It includes a report within 1 year of TPA going into force and a follow-up report 5 years later, both of which need to detail the effects of our trade agreements. This TPA also requires ITC to report on the probable economic effects of individual trade agreements and provides them with more time than any time in the past. This committee on a bipartisan basis has worked very closely with the U.S. Trade Rep and ITC, has developed more sophisticated methodologies for the analysis of trade agreements, including analysis of non-tariff bearers, which are so important to what Congressman Buchanan talked about earlier. And we expect to continue to work with the ITC on these future reports. So at the same time, I note that the great difficulty in estimating some of the economic effects, Mr. Rangel, that are being called on in this amendment, and the additional burden that could be created for the administration. I would ask that we reject this amendment. I yield back.
Could I speak briefly?
Anyone else move to strike the last word?
Yes.
Gentleman's recognized for 5 minutes.
First of all, let me just say on the ruling, the problem with your position is that our bill, our substitute, is on the very same subjects as the subjects in the base bill. So essentially, you're saying you can provide provisions like that, and if we include provisions of a different nature, it's out of order.
The gentleman yield?
Yes.
I'm not saying that. Rule 10 is saying that.
Well, but-
Just as when we had the ACA coming through here, a bill was brought to the committee which had provisions in the base text which had jurisdiction from other committees. We were not allowed, as Mr. Tiberi said, to amend that because of Rule 10. Again, these rules are designed to protect committees' jurisdictions. This committee, more than any other committee, has to put up multiple defenses of its jurisdictions on a weekly basis.
What about my bill, Mr. Chairman?
And, well, yeah, that's a good question, Mr. Rangel.
Yeah,
We're ready
let
to
me
go
just-
on your bill.
Okay,
So
let
it
me
is what it
comment
is.
let me just comment on this. I haven't heard a substantive reason against Mr. Rangel's amendment. I yield back.
Yeah.
Mr. Kind, I believe you want to be recognized? Move the
I
strike
do,
last
Mr.
word.
Chairman.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I want to speak in favor of Mr. Rangel's amendment. I think this is a very benign amendment. It's very consistent with the reporting requirements that are already on page 76 of this text. It's just filling out some of the gaps as far as the pre-implementation assessment that ITC is required to do under the base bill to begin with. And furthermore, it complements what is also included in the base bill on page 81, and that's a new reporting requirement that ITC has to do on the effect of the implementation of trade agreements going forward under TPA authority all the way back to 1984, to give this Congress and the American people an update as far as how well these trade agreements are working or not. And that's in the base bill as it exists right now. But what I see Charlie trying to do is complement what's on page 76 on the ITC assessment report, fill it out a little bit more with some more metrics that he's asking for. And I quite frankly, don't see the problem in doing that. So I would hope the chair and members of the committee would consider adopting Mr. Rangel's amendment so we can move on to the next one. I yield back.
Anybody else see? If there's no further discussion, I note that a point of order has been reserved. The gentleman from Ohio is recognized.
Mr. Chairman, Mr. Rangel will be happy to note that I'm going to withdraw my point of order.
The reservation of the point of order is withdrawn as no other members seek recognition. The question is on agreeing to the amendment offered by Mr. Rangel. All those in favor signify by saying aye.
Aye.
Those opposed, no. No. In the opinion of the chair, the noes have it.
Recorded vote, please.
A roll call vote has been requested. The clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Brady, no. Mr. Nunez? Mr. Nunez, no. Mr. Teaberry? Mr. Teaberry, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? Mr. Roscom, no. Mr. Price? Mr. Price, no. Mr. Buchanan? Mr. Buchanan, no. Mr. Smith, Nebraska? Mr. Smith, no. Ms. Jenkins? Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Ms. Black? Ms. Black, no. Mr. Reed? Mr. Reed, no. Mr. Young? Mr. Young, no. Mr. Kelly? Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? Mr. Meehan, no. Ms. Nome? Ms. Nome, no. Mr. Holding? Mr. Holding, no. Mr. Smith of Missouri? Mr. Levin?
Aye.
Mr. Levin, aye. Mr. Rangel?
Aye.
Mr. Rangel, aye. Mr. McDermott?
Aye.
Mr. McDermott, aye. Mr. Lewis?
Aye.
Mr. Lewis, aye. Mr. Neal?
Aye.
Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson?
After this lunch, I know
Mr. Thompson, aye.
to something.
Mr. Larson?
I don't know what it is. But
Mr. Larson, aye.
Jake.
Mr. Blumenauer? Mr. Blumenauer, aye. Mr. Kind? Mr. Kind, aye. Mr. Pascrell? Mr. Pascrell, aye. Mr. Crowley? Mr. Crowley, aye. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Mr. Marchant? Mr. Smith of Missouri? Mr. Smith, no. Chairman Ryan? Chairman Ryan, no.
I do. Mr. Marchant?
The gentleman is not recorded. Mr. Marchant, no.
The clerk will report.
15 yeas, 23 nays.
There being 15 yeas and 23 nays, the amendment is not agreed to. Are there any further amendments? Which one? Becerra? Mr. Becerra is recognized. Gentleman, to suspend while clerk passes out the amendment. Mr.
Chairman,
Teaberry.
I'd like to reserve a point of order.
A point of order has been reserved. The gentleman will still suspend for a moment until we get copies of the amendment. Oh, okay. Yeah. Yeah. Here, let me give you that back. I need some more paper here. I'm running out of paper. Thank you.
I want to see that.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. And this goes back to the whole issue of currency, so I can pose it quickly with the question as follows. If we want foreign companies that want access to our American market, if we want those companies to abide by the rules as they engage in trade with us so that that competition is fair, shouldn't we expect that the foreign countries that are home to these foreign businesses to abide by the very rules they have agreed to in the first place through trade agreements? Otherwise, let's be honest, we can't go after those companies in those foreign lands because we don't have jurisdiction directly over those companies if they're foreign-based. Our laws don't apply to those companies except through some trade agreement. But if we can't figure out a way to enforce those violations of fair competition, then how can we expect that if the country isn't abiding by the rules, that the companies that exist in those foreign countries will abide by the rules as well? That's a very basic threshold question. And when it comes to currency manipulation, it's not companies that manipulate a country's currency valuation. It's the country itself. It's the country which officially plays games with its currency. And if we're not willing to put those companies on the mat to agree to not violate the rules, then I think it really boggles the imagination to believe that those same countries that are violating the rules will expect and insist that the companies that exist within their countries will be expected to abide by the rules that we're agreeing to in these trade agreements. And so we need a trade deal that has teeth, and we need a trade promotion authority that will make it clear that we insist on our trade deals having teeth to make sure that not just the companies, but the countries will follow the rules. The evidence is replete with cases of manipulation of currency, whether you're talking about China, and everyone talks about China because they're so big, and our trade deficit is in the hundreds of billions of dollars a year with China, and we've lost millions of jobs to currency manipulators. Japan has done it. We're concerned that countries like close neighbors, close friends, like South Korea may do it. If we're serious, this is the time to strike a deal to make it clear that we're serious about making sure not just companies, but the countries themselves don't violate the rules. We have every right to do this, but it's more than just a right. It's a necessity. It is indispensable that we tell the American people, American businesses, that competition will be fair, and that we'll make sure that we'll at least ensure that the countries follow the rules, and that gives us a better chance of making sure that the companies in those countries will feel compelled in the pressure to follow the rules as well. And so, Mr. Chairman, once again, if we want to do fast track the right way, we should do, as Mr. Levin said, the right track, not a rush track in getting this done. And we should go after those cheats, whether they're companies or whether they're countries, and we should let them know that we want credible rules and we expect enforcement so that we can't be cheated upon and find American jobs and American businesses going overseas because that's the only way they can compete. With that, I yield back the balance of my time.
Gentleman yields back the balance of his time. Mr. Bastani, do you move to strike the last word?
I move to strike the last word, Mr. Chairman.
Gentleman's recognized for 5 minutes.
I think we all understand that the currency manipulation issue is a big problem and it needs to be addressed. The question is how to do it and how to most effectively do it. We also know that the base bill, the base TPA bill, was carefully negotiated compromise between House and Senate, bipartisan work done. And I think this amendment may go a step too far, as we've had some of the conversations earlier. It would certainly unravel that balanced agreement, that compromise that was struck. But secondly, I think it does put us at risk with regard to TPP in particular and getting to a strong agreement. I think it's important to keep in mind that we, the United States, has the world's reserve currency, and it gives us a unique ability to pressure countries to stop manipulation. And clearly, I think we can do more. I think Treasury can do more. We've had those discussions with Secretary Lew. I think clearly Congress can do more by providing more oversight on the currency reports that are sent back. I don't think we've done enough work there. But I am very concerned that by mandating this type of enforcement mechanism, we actually put ourselves in harm's way. We capture the wrong culprit. We put the U.S. at risk of being accused of manipulation charges. This would make us very vulnerable to lawsuits, as well as jeopardizing our ability to set our own monetary policy, and it could potentially threaten the U.S. dollar's standing as the world's leading currency. I think we need to further focus on strengthening multinational rules to get real results through G7, the G20, and IMF efforts. Clearly referencing Article 4 is important, and our current law does that based on 1988 legislation that went through the jurisdiction of a different committee, not our committee. I want to also point out that the administration agrees with this viewpoint. We had a letter from Secretary Lew just this week quoting any amendment to TPA legislation requiring that the administration only seek enforceable currency provisions as a principal negotiating objective would undermine our ability to successfully conclude a TPP negotiation, end quote. And so in his testimony before the committee yesterday, he clearly reiterated these concerns in responding to Chairman Ryan. Finally, I think it's important, another important step we can take is to keep moving forward aggressively and not timidly on getting trade agreements. Because if we have a more interconnected marketplace where we write the rules, we're going to have less currency manipulation because our partners and other trading countries will have less tolerance for it. So I clearly believe we should reject this amendment and stick with the language in the base bill. I would also be interested in hearing Mr. Reif's opinion on this if he wants to opine on it in the remaining time.
Thank you, Dr. Bustani. Mr. Becerra, thank you for your amendment. I guess I'd offer four brief comments. First, the administration does share the concern that Mr. Becerra, you've noted, and Dr. Bustani, you've also reflected on. Second, for the first time, as pointed out, there is a principal negotiating objective in the bill, in the underlying bill on currency manipulation. It includes enforceable rules as a mechanism. Third, there are efforts the administration has made. We recognize that they're not met with full approval here, but for example, the exchange rate, China's exchange rate, has risen 30% over the past number of years, and that is improvement. We understand that there is continued concern here and in our own administration about that. Finally, there are defensive issues, real defensive issues here for us. When another trading partner began an effort in the WTO to inaugurate a dialogue about these issues, it was the United States that they had in mind and the concerns about our quantitative easing. And I understand the points that were made by Mr. Levin with respect to IMF guidelines and such, but those were not ones that this trading partner found persuasive. So we do have significant defensive concerns with respect to other trading partners. Thank you.
Thank you, Mr. Chairman. I yield back.
Gentleman yields back. Gentleman, Mr. Levin, do you want to
take the
last word? The gentleman's recognized for 5 minutes.
Just briefly, the last thing we should do is run scared because somebody complains in the WTO. I mean, if we're going to do that, every time we try to take action, then China comes after us and files some phony suit in the WTO. And the problem we have is we just need to change the dynamic when it comes to this issue. Currency manipulation has deeply hurt our industries. We lost a quarter of our tool and die industry in 6 months in the 90s, much of it on the East Coast, in part because of currency manipulation by Japan. And we didn't do anything much except talk. And then we were told it was too late to take action. The record is very clear as to China and currency manipulation. It went on and on and on, and we talked and talked and talked. And eventually they began to move, I think not mainly because of our talk, but because of internal considerations within China. This proposal is not earth-shaking. What it says is there has to be a remedy, and it leaves it to the IMF if it's out of bounds. The IMF has clear guidelines. And so, look, if the IMF would take action, we wouldn't be doing this. We wouldn't be doing this. And I've closed by just thinking of the millions of people in this country who have lost their jobs. And I think people who talk about income stagnation had better start talking about what has caused it and how we're going to remedy it. So it isn't just a political slogan. And both parties are now talking about middle-class wage stagnation. What this amendment does is to take a step to do something about it. You bet.
Mr. Brady's recognized.
Mr. Chairman, I'll be brief. We certainly share concern of currency manipulation. That's why both parties agreed to make it a priority, negotiating objective of the TPA and giving the administration, any administration, the tools to address it. The concern is that if we do it wrong, we invite, frankly, lawsuits in retaliation against the United States. We may wish in this amendment that our negotiating partners will stick to the IMF guidelines that don't necessarily address monetary policy. But there's no guarantee they will. Our wish that they ignore the 800-pound monetary policy that's affecting the world's economy will not be bought by Brazil. They've made it very clear they believe that our quantitative easing, which lowered the value of the dollar by over 7%, which over the years, frankly, our trade-weighted nominal value of the dollar is actually lower today than it was when President Clinton left office. We strongly believe that monetary policy is separate, but they're going to make a strong case in court that that is not the case. And while we're distracted with these lawsuits, we'll not be making the progress at G7 and G20 and IMF that actually has backed Japan away from currency manipulation. And we ought to understand, too, that while we are distracted, we will not be addressing the Chinas of the world and their currency manipulation in a way that actually moves us toward a market-oriented value of their currencies. And so while I agree with the intent, clearly I think this takes us in the wrong direction toward where we all want to be, in one in which House and Senate Democrats and Republicans have come together on what we believe is the common ground to address this issue. So I respectfully urge we oppose this amendment.
Mr. Chairman, I'll move to strike last word, and please do put me on the clock. I'll be very brief, and I don't want to keep talking. This is, again, surreal. I'm defending the Treasury Secretary. I think he's right, and he needs to have the kind of latitude that he's had, and he's made some progress. And the renminbi's up 30%. He's made some progress. China's not in this. China's not in TPP. So we're all this complaint about China. They're not even involved in this negotiation. I think we got to watch ourselves from shooting ourselves in the foot. And if we overcompensate, which I believe this amendment does, we will do just that. We are the world's reserve currency, an enormous privilege. And so our monetary plumbing is different than everybody else. We don't pump money into the We don't buy and sell and put money in the system like other countries do because we print dollars. We're the reserve currency, and we have to watch how we manage that situation. Giving the IMF even more clout to toggle this, to turn it on or off, I think is a mistake, because there are all these ideas of other countries that would love nothing more than to replace us as the world's reserve currency. Now, that's not going to happen anytime soon. Nobody's even close to being able to do so. But one of the ideas that does gain traction is this synthetic currency at the IMF. And the last thing we want to do is give credence to the idea that they're going to be the arbiter of an international monetary system more than they are now, in excess of where we are as the world's reserve currency. So I think we got to be careful about how we conduct ourselves and protect our status as the world's reserve currency. And the last point I'd make is, it is a deal killer. I mean, I think the Treasury Secretary is pretty clear. So for that and many, many other reasons, I also urge a no vote.
Mr. Chairman,
Yeah, who said that? Mr. Teaberry.
I withdraw my point of order.
Gentleman withdraws his point of order. Oh, yeah, the gentleman's recognized for the purposes of closing.
Hey, Mr. Chairman, the amendment's very simple. That's all it does. It provides that fast-track procedures under this bill will not apply to a trade agreement that does not contain strong and enforceable currency manipulation provisions. It doesn't say that you have to have this specific type of currency manipulation rules or that this will be the punishment. It doesn't. It just says USTR, American government, if you want to reach a trade deal, you got to come back and show us that you insist that there will be enforceable measures on currency manipulation. That's all it says. So think of it this way. Mr. Chairman, you said the 30% increase in China's currency recently, in the last few years, is progress. And Mr. Reif, you said it's an improvement. Think about what you're saying. The Chinese currency has appreciated 30%. But that's only an improvement because we know they still have to go further, which means that for years, the Chinese have been able to get their producers to have like a 30% plus markdown on the value of their products that all of us are buying. So of course, it shouldn't surprise anyone that we have a major deficit trade imbalance with China because their products look so cheap to produce and for us to buy. It's not that they're so cheap to produce and for us to buy. It's that China is intentionally using its official capacity to game the currency markets to make its products look cheap. So it's a sale not on the backs of Chinese companies, it's a sale on the backs of American companies and American workers. Because when you cannot compete with that 30% sale of that Chinese product, in America, guess what happens? You either lose your wages, reduce your wages, or you see that job and that business cut out of town and get outsourced. That's what we're talking about. And so what we're simply saying is this: let's not be aspirational at this time. This is the time to set down the rules because they want access to our American markets. They want access to our American consumers because they know we've got dollars that we can pay. And so let's not leave our country at risk of being gamed, of having people cheat against our workers and our companies. And by the way, the U.S. is not at risk if we do currency manipulation rules. By all measures, the U.S. does not engage in currency manipulation, by all measures. And by the way, and if we were found to have manipulated our currency for that same reason, to try to game the system and cheat, then the same rules should apply to us, because we have no right to expect others to follow the rules if we're not going to follow them ourselves. It should not surprise anyone that in this panel that the American people are very anxious about trade. And they should be as gung-ho as so many people are about trade. We should all be ready to say, absolutely, because we make the best products in the world. And we should have no problem competing with anyone. But that's not the way it is. In America, too many people say, I don't know about trade. I don't know if it's going to do me any good. And that's unfortunate. But there's something behind that that rings true. The American people aren't dumb. They see it, they get it, they feel it. And we need to stand up for them, because when given the chance, Americans will compete. When given a level playing field, they'll produce the best products and grow the best food in the world. But we just got to give them that level playing field, not let somebody game the markets, game their currency, and give them 30% off every time you're going to try to buy someone else's product. Let's do it now. We can stand up for folks. Let's not be timid. Let's just make sure if we want a trade deal with us, follow the rules. That's all this says. And I hope that my colleagues will join in making sure that we have meaningful measures to stop the gaming of currency that hurts American jobs and hurts American businesses. I yield back.
Gentleman yields back the balance of his time. The question is on agreeing to the amendment offered by Mr. Becerra. All those in favor signify by saying aye. Aye. Those opposed, no. No. The opinion of the chair, the noes have it. Gentleman requests a roll. Roll call vote is requested, and the clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Brady, no. Mr. Nunez? Mr. Nunez, no. Mr. Teaberry? Mr. Teaberry, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? Mr. Roscom, no. Mr. Price? Mr. Price, no. Mr. Buchanan? Mr. Buchanan, no. Mr. Smith, Nebraska? Mr. Smith, no. Ms. Jenkins? Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Mr. Marchant, no. Ms. Black? Ms. Black, no. Mr. Reed? Mr. Reed, no. Mr. Young? Mr. Young, no. Mr. Kelly? Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? Mr. Meehan, no. Ms. Nome? Ms. Nome, no. Mr. Holding? Mr. Holding, no. Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. Rangel, aye. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, aye. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer? Mr. Blumenauer, aye. Mr. Kind? Mr. Kind, no. Mr. Pascrell? Mr. Pascrell, aye. Mr. Crowley? Mr. Crowley, aye. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Chairman Ryan? No. Chairman Ryan, no.
The clerk will report the vote.
14 yeas, 24 nays.
There being 14 yeas and 24 nays, the amendment is not agreed to. Are there any further amendments? Mr. Neal, I believe you have an amendment.
Thank you, Mr. Chairman.
Clerk will distribute. I asked just the gentleman if he could suspend while we circulate the amendment.
Mr. Chairman, can I reserve a point of order?
Gentleman reserves a point of order. Clerk's distributing. Just give us a minute here, Mr. Neal, if you don't mind. Sure.
Thank you.
This is the same amendment. This just doesn't have the IMF switch. Is that what's different here? That's it, just the same, but no IMF. All right, I think think we've got it. Gentleman's recognized for 5
Thank
minutes.
you, Mr. Chairman. Mr. Chairman, it has been acknowledged that over the past decade, currency manipulation by foreign governments has resulted in an increase in unfairly traded imports, and it's made it more difficult for U.S. exporters to compete in foreign markets. The practice arguably has cost America millions of jobs and is responsible in some instances for half of the excess unemployment rate. Commentators and economists point to currency manipulation as a rationale for depressed and stagnant wages. And some have said that it should not be part of a trade discussion. Let me suggest today it should be a major part of our trade discussions. TPP countries account for nearly 40% of global GDP and 1/3 of trade. As all TPP countries would agree, this is an occasion to set the rules for trade and investment in the 21st century. Given the link between trade and finance, and to achieve an ambitious result, currency manipulation must be included to ensure that no TPP member does not have the opportunity to disrupt global trade flows with unfair currency packages. Now, we've just considered one currency amendment here, and it was voted down. And some of the other side have argued that the previous amendment was designed to kill fast-track or free trade agreements because the amendment required trade agreements to include a strong and enforceable currency manipulation provision in order for a trade agreement to be considered under fast-track procedures. I support this amendment because it makes sense, and I know that many Republicans will disagree on that one and this one. But let's try to find a common ground opportunity. Therefore, in that spirit, I'm bringing up this amendment, which was offered in the Senate last night by Senators Portman, Stabenow, Burr, Brown, Casey, and Schumer. It is a targeted amendment, and it's very simple. It makes currency manipulation a principal negotiating objective within TPA. This amendment is targeted because it only deals with the trading partners that we have a free trade agreement with. Furthermore, it gives us and our negotiators the flexibility they need when negotiating to find appropriate remedies and fixes. I'd be happy to have this discussion with the Secretary of Treasury, as we have with many former secretaries of the Treasury, as to the role that QE2 played in economic recovery and the role that the Federal Reserve plays and manages America's monetary policy. But I want to specifically quote two pieces today from the Wall Street Journal. One, the front page, which indicates once again that China has informed us that North Korea is developing larger nuclear capacity than we had previously understood. Anybody who doesn't believe in the past that North Korea's nuclear capacity has allowed China to be an arbiter of American foreign policy in dealing with them is very naive. The question is, at that moment, does Treasury take a backseat to state? And I believe that they have through successive administrations as it relates to that issue. But secondly, I want to quote a letter to the editor today from a former member of this committee and a doctrinaire free trader when he was on this committee, would accept no amendments to the final package. And that's our friend Rob Portman, who also went on to be the USTR under President Bush. Let me quote specifically from his letter to the Wall Street Journal today. I agree there is a critical distinction between currency manipulation and legitimate monetary policy, and that countries should not be constrained in their macroeconomic policy. That is why my amendment specifically distinguishes between the two, using established IMF principles that nearly every country has agreed to abide by to determine when intervention occurs. My amendment also provides discretion on the specific response and simply calls on the administration to establish enforceable rules to combat the offensive and trade-distorting deliberative manipulation of currency exchange rates for the purpose of subsidizing exports. He goes on to finish by saying, my amendment addresses a problem everyone acknowledges exists and provides more support for trade, something I thought the Journal was interested in to see. So I call attention to this proposal largely because an alum of this committee, who was largely the spokesman on the Republican side for any and all free trade principles, has offered an amendment in the Senate that is bipartisan in nature, but his letter to the editor clearly spells out his position as it relates to currency manipulation. And I would yield to Mr. Larson on this amendment, and I hope that he'll have time after this as well.
Well, thank you, Mr. Neal, and I strongly support your amendment, and strongly supported Mr. Becerra's amendment before that. And frankly, I think Mr. Portman stated it extraordinarily well in the Wall Street Journal. Perhaps not as well as my grandfather Nolan used to, who would quite frequently quote Peter Finley Dunne, who would say, trust everyone, but cut the cards. We have a lot of trust emanating from the committee today, and especially as the chairman has noted, maybe awkwardly so, between the administration and the Treasury. But truly, what Mr. Neal and Mr. Portman's...
Time for the gentleman's expired. Does the gentleman seek to strike the last word?
Strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman, and thank you for your indulgences throughout this debate and discussion and last night as well. Well, my grandfather was right, and so was Mr. Neal and Mr. Portman with respect to this. And I think as both Mr. Becerra and Mr. Levin have noted, when it comes to the loss of jobs, when it comes to the true impact and what this means on people, it's hard to explain all the intricacies. And frankly, it's even going to be harder to explain to people back home why we didn't get a vote on Mr. Levin's proposal. That's going to be hard to explain. And I know how cordial, and I know how nice, and I know how pleasant everybody was on the other side. But it's hard to explain that it was Rule 10. It's hard to explain these things when you're not putting them in simple terms. What Mr. Neal's proposal, what Mr. Portman rightly points out, is that if we don't give teeth in the broadest way, in a way that is circumspect and not going to hurt or malign the United States position, but in fact do what we want to see done in terms of cutting the cards to make sure that every American gets a fair deal. And as we talk about trade in general and about TPA, and we talk about the importance of America remaining center on the stage and how this impacts everyone, let's not forget the little guy. The little guy, the one who's left out of this equation, the one who's not in the back rooms, the one who doesn't understand what Rule 10 is, the one who is not a part of the Board of Trade or the Chamber of Commerce. He's not included in this. They just want to see, as Mr. Rangel pointed out, where are the jobs in this for us, and where is the fairness in this? Is my voice being heard? Is my voice being heard at all? That's why I strongly support the previous amendments. That's why I strongly back Mr. Neal's proposal and Mr. Portman's proposal in the Senate to make sure that we strengthen the opportunities that we have on currency. It's the most direct impact on jobs that we can point to. And with that, I yield back to my colleague.
Gentleman yields back. Gentleman from Texas, move to strike last word.
Yes, sir.
Mr. Brady's recognized, 5 minutes.
We all share the concern from Mr. Neal and Mr. Larson about finding effective ways to deal with currency manipulation. We just have to be careful that we are not shooting at China and inadvertently hitting the United States of America. There are real risks in the approach envisioned in this amendment. First risk is that a provision is misapplied to challenge us, the United States. We will be a target for litigation. We can say we won't, we can deny that we won't, but clearly Brazil and others believe that monetary policy is currency manipulation. And while we may believe it's frivolous and we will ultimately prevail, litigation will distract us from broader efforts and more successful efforts to address currency manipulation and shield real currency manipulators like China, who isn't in the Trans-Pacific Partnership nor European Trade Agreement. They're not even in here. The second real risk is that by focusing on currency manipulation trade agreements, we derail efforts to strengthen multinational rules, where we pull together countries at the IMF, at G20 and G7 that have stronger results. Revisions to these rules in these areas, have resulted in significant appreciation of the RMB. Japan has not unilaterally intervened in the currency market since 2011. That's progress. The third risk is capturing the wrong thing. Misalignment and manipulation are not the same, and current rules take this into account by requiring analysis of intent. Rules that don't look the intent of a country run the risk of capturing countries that are doing legitimate things, including the United States of America. The fourth real risk is that you get the calculation wrong. This is complex stuff. It is incredibly difficult to quantify the amount of currency misalignment and the injury that's caused by it. The IMF, for example, in looking at Japan in 2012, their last report, their range of models that have been referenced many times today, in some cases they believe the RMB is undervalued by 20%, and another model that it is overvalued by 10%. This is one entity with 3 different models, a huge variance in there. This is important because some suggest we should retaliate by raising all tariffs on imports countries found to be in misalignment. This is more difficult to do than we believe. And the fifth risk is that we undermine what we're all trying to do within agreements like the Trans-Pacific Partnership. We would have to pay a high price for enforceable currency provisions. It will derail those negotiations and derail our ability to access millions of new middle-class customers for America. That's how we grow jobs and grow paychecks. So I guess my point is that, again, in our eagerness to hit China, we may well hit the United States of America. We should be aggressive. We should be strong, but more importantly, we should be smart. And the reason a majority of Senate Democrats on Senate Finance Committee approved this bill is that the underlying approach, making this a high priority for negotiating objectives, giving the White House, any White House, the tools to address currency manipulation, is aggressive but smart and will move us in the right direction. So again, I very much respect the work that Mr. Neal and Mr. Larson have done. They are sincerely trying to constructively improve this bill, but I would respectfully urge that we oppose the amendment.
Thank you. Mr. Kind, are you over there? I can't see. Did you want to?
Yes.
You want to move the strike the last word?
Move the strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. Mr. Chairman, I am obviously very sympathetic with what Mr. Becerra and Mr. Neal and Larson are trying to accomplish with it. There's no question currency manipulation has been an ongoing problem for us for quite some time. I'm glad to see, however, in the underlying bill that there is, as a core negotiating objective, currency language in the TPP base bill that's offered. But I think we need to remind ourselves that this is not just unique to the United States and our own economy and ability to compete. Currency manipulation affects many, many countries throughout the world. That's why I appreciate what the administration's been trying to pursue, which is a multilateral approach to addressing this through the G7, through the G20. It's through developing that international consensus on what the norms of currency manipulation look like and how it should be defined, and then what stepped-up enforcement mechanism that's going to be needed in collaboration with other nations that are adversely affected by currency manipulation, because we are not alone in this. It's probably the best approach. And also leaves out of the equation in a more significant way, bringing our own Federal Reserve and their own monetary policies that they've been pursuing recently from challenge and from dispute resolution. I think that's one of the traps and dangers that we have here with this approach. But I'm also sympathetic to the administration's caution that if we inject this now into the process in the 11th, it could undermine the entire TPP negotiation, which is on the verge of being concluded, assuming TPA ultimately passes. But there are stronger reporting requirements in the base bill for the administration to adhere to. There's also stepped-up enforcement mechanisms in the base bill for the first time. We've never had that in any previous TPA, so it is an acknowledgement of the need to take action. But I also think this committee would be well-served to take a moment and take a look what the Senate Finance Committee just adopted yesterday in accepting Senator Bennett's amendment on currency manipulation, and the CVD, the countervailing duty amendment that Senator Schumer had offered. That was also accepted in committee yesterday. The Senate's been trying to address this at the same time, and in their mark yesterday, they made progress, I think, in not an insignificant way of trying to address this very serious issue. So with that, I unfortunately am going to oppose the amendment for those reasons, but it's obviously something that this committee, hopefully in the future, will continue to do more oversight and develop the consensus on what the best response will be to those countries that are blatantly manipulating their currency in order to get an unfair trade advantage with us. So I yield back, Mr. Chairman.
Gentleman yields back balance of his time.
The strike last word, Mr.
Mr.
Chairman.
Bastani is recognized.
I thank the chairman, and while I have the highest regard for Mr. Larson, Mr. Neal, and appreciate what they're trying to do, as I do for Senator Portman, we all recognize, I think everybody on this dais recognizes the problem with currency, but the question again comes down to how to deal with this. I think the committee in a bipartisan way has made it abundantly clear to Treasury that we need a much more vigorous economic diplomacy with regard to currency issues. We have seen some success with China. If we go back and look at what happened with Japan in the 80s and the Plaza Accord, we were very successful in getting Japan to double the value of its currency, but yet at the same time, the trade deficit with Japan, between Japan and the U.S., remained the same. It was unaffected. So by that metric, it didn't have the kind of impact we needed. Now, you might talk about jobs and jobs we lost to Japan. That is precisely why we need TPP. We did not have a trade agreement with Japan at the time, nor do we now. TPP provides that level playing field that will help us, get these jobs and see the job creation that's necessary. So that's why this is so important, and I think the key now is to not overstep and go along with what's in the base bill that the Senate agreed to. The Portman Amendment failed, with all due respect. I think we've struck the right balance in the base bill with regard to currency as a priority. Let's stick with that. Let's stick with our pressure on Treasury, as we've done in a bipartisan way, to invigorate our economic diplomacy with regard to currency issues and continue, hopefully, to see success. But most importantly, let's get this trade agreement done. And we can't do it without TPA. So I think let's get a bipartisan TPA bill passed, as we're trying to do here, to really empower our negotiators to get the best possible deal, and I think we'll see all the things we want. The job creation that Mr. Levin and Mr. Rangel have talked about, addressing some of these currency inequities that have existed that we've talked about on both sides of the dais. So with all due respect to my colleagues, I think we need to oppose this amendment and stick with the base bill. I yield back.
Gentleman yields back. The gentleman from Michigan move to strike last word?
I do.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I've spoken on the currency, so I just want to raise again your ruling. I've been handed a copy of H.R. 3019. It was a fast-track amendment from 2001. I was just handed this. And I'd like to give you a copy. This is Mr. Kern's copy, so I won't give this to you.
Okay.
He has his notes, but I'll have it printed. I was just given this. It was, as I said, an amendment on fast track in 2001, introduced by Mr. Rangel, Mr. Levin, our beloved Mr. Mitsui, and Mr. McDermott. It had many subjects. There was no effort to invoke Rule 10 on this. And there was a vote on it. And the vote was, I was just given this, 26 nays and 12 yeas. The yeas were Mr. Rangel, Mr. Levin, Mr. McDermott, Mr. Lewis, Mr. Neal, Mr. Becerra, and Mr. Doggett. Mr. Thompson, Mr. Larson weren't on the committee yet, and the others. I'd like you to take a look at this bill and take a look at the roll call and reconsider you're essentially using a procedural attempt to avoid a vote in this committee. Yes.
I would like to also appeal to the chairman's great sense of fairness, and I think Paul Ryan has been a model on several fronts, and there are, as we know, strict constructionalists, and there's no better person in Congress probably who can construct an argument than Paul Ryan. And I think in times like this, in issues where it's so close in terms of the emotion and feeling and hard work that, as everyone has pointed out, have gone into this, that sometimes loose construction as occurred in 2001 is in order for all of the good reasons that have been laid out before this.
Thank you. Mr. Thomas was the chairman at the time.
Gentlemen, I can't help it that he's a sloppy chairman.
No, I think, Mr. Chairman, this isn't a matter of sloppiness. This is a matter of fairness. And I think the American people expect on a major subject like this that there be a vote. That's our responsibility. And not hide behind a rule. Mr. Thomas did not do that. We had a chance to vote. It was a fast-track bill, which had many subjects on it, I'm sure some not within the jurisdiction of our committee. So I'm going to give you, not this one, but I'm going to give you this. It's many pages. It's 130 some pages, 134 pages, and ask you before we leave here to reconsider your vote.
Gentlemen, I'll use the remaining of your time, so not to take any more. We are debating an amendment by Mr. Neal, not this. I am not going to change the ruling for all of the reasons I stated before, because rules are rules, and I think it's important to follow the rules. I'm sure we could come up with other instances where Rule 10 was invoked by the other side when they were in the majority, and we talked a few here. And I take a look at all these amendments in front of us. It's as if you took the substitute and broke it into separate amendments, most of which here are germane, and we'll vote on these pieces. So it's not as if anybody's hiding from anything. We're voting for the second currency amendment here in a moment when Mr. Neal closes. So,
but our comprehensive amendment.
I respect the person's opinion, the gentleman's opinion, but
let me take back my time. We need a vote on the substitute, a comprehensive vote, because you can't just do this piecemeal. You didn't do your bill piecemeal. You didn't bring it up subject by subject for us to vote. You have a comprehensive package. We deserve a vote on our substitute. And I yield back my 9 seconds, giving you a copy of this soon,
not now,
so there'd be time for you to reconsider. Thank you.
Mr. Neal is recognized for the purposes of closing on his amendments.
Thank you very much, Mr. Chairman. My friend, Mr. Kind, used the term hopefully, and that's the problem with currency manipulation. We're all hopeful that the administration or administrations and various secretaries of the Treasury will tackle the issue. Mr. Brady used the word misalignment. The difficulty is that when we are in a critical national security moment, oftentimes fiscal policy is misaligned with national security interests and takes a back seat to those interests. The principle at work here is not the interference with the Federal Reserve Board and monetary policy, understanding that Congress has fiscal responsibility, but the principle at work here for all of us is this is going to be the last time we're going to have a chance to really address this issue in offering trade promotion authority. And we cannot do it based on being hopeful. I am convinced 6 years ago, Senator Obama would have supported this amendment in the United States Senate. And Mr. Portman, having taken the lead on this issue, during his time on this committee, never once moving away from his belief in the economic accomplishment that was offered by the whole notion of free trade. For him to take this position, and the people from Ohio know exactly what I'm referencing, this is pretty extraordinary. The U.S. trade rep, formally, to take a position on currency manipulation as outlined in a bipartisan amendment in the United States Senate. If we can't heed his advice in this instance, we're going to be back here being hopeful down the road that Treasury secretaries and administrations will address this issue. With that, I yield back the balance of my time and ask for a vote, Mr. Chairman.
Mr. Chairman, I withdraw my point of order.
Gentleman from Ohio withdraws his point of order. There being no more seeking recognition, the question is on agreeing to the amendment offered by Mr. Neal. All those in favor signify by saying aye. Aye. Those opposed signify by saying no. No. Opinion of the chair, the noes have it. So, gentlemen, roll call vote. Roll call vote has been requested. The clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Brady, no. Mr. Nunez? No. Mr. Nunez, no. Mr. Teaberry? Mr. Teaberry, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? No. Mr. Bustani, no. Mr. Roscom? Mr. Roscom, no. Mr. Price? Mr. Price, no. Mr. Buchanan? Mr. Buchanan, no. Mr. Smith in Nebraska? No. Mr. Smith, no. Ms. Jenkins? No. Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Mr. Marchant, no. Ms. Black? Ms. Black, no. Mr. Reed? No. Mr. Reed, no. Mr. Young? Mr. Young, no. Mr. Kelly? No. Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? Mr. Meehan, no. Ms. Nome? Ms. Nome, no. Mr. Holding? Mr. Holding, no. Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. Rangel, aye. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, aye. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer? Mr. Blumenauer, aye. Mr. Kind? Mr. Kind, no. Mr. Pascrell? Mr. Pascrell, aye. Mr. Crowley? Mr. Crowley, aye. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Chairman Ryan? Chairman Ryan, no.
The clerk will report the vote.
14 ayes, 24 nays.
There being 14 ayes and 24 nays, the amendment is not agreed to. Does anyone else seek an amendment? Mr. Lewis, I believe Mr. Lewis has an amendment. The clerk will distribute the amendment. I ask the gentleman to suspend while the clerk distributes.
Mr. Chairman,
Mr. Teaberry.
I'd like to request a point of order.
A point of order has been reserved.
A point of order?
A point of order has been reserved. This is different than card. Thank you. This is not card, right? Okay. Okay. This is a lot more card. Okay. All right. Gotcha. Copies have been distributed. The gentleman is recognized for 5 minutes for purposes of his amendment.
Thank you, Mr. Chairman. First of all, I would like to thank Ranking Member Levin for all of his hard work and his unbelievable leadership. He and his staff fight tirelessly for human rights and labor rights in United States trade policy. My amendment is simple, and it is clear. This amendment will add the labor and human rights process that labor activists and struggling workers in the United States and around the world have requested over and over again. As you know, we lost more than 50,000 young men in a tragic war with Vietnam. Many Vietnamese Americans came to this country as refugees, fleeing communism and oppression. They were hoping to achieve the American dream. 2 years ago, dozens of Vietnamese American citizens from my district came to Washington. they ask, they beg, they really beg to do something about what would happen to their friends, family, and loved one back in Vietnam. I've been to Vietnam. One of our distinguished members on this dais, a member of this committee, the gentleman from Texas, Mr. Johnson, served in Vietnam. One of my younger brothers was wounded in Vietnam. There's no such thing as freedom to organize. Freedom of speech is limited. The freedom of assembly is limited. We have to do what is right. We have to do something strong, something meaningful to protect labor rights and human rights. If we don't act now at this very moment, then who will act? We have been down this path before. We've heard the same fears and the same warning in China and Colombia and in DR and CAFTA. And in each and every case, American workers said, please do not support race to the bottom. We cannot compete with forced labor, low wages. And what do? It is time to act. Every single time workers in these countries say, please do not support trade without making changes in advance. Time and time again, they warn us that empty promises and plans will do nothing. And their words reign true to this day, and every single week I receive reports of continued labor and human rights violations occurring in Colombia in the same places that we supported organ that job would bring safety, security, and labor protection. In a few weeks, in a very few short weeks, the world will recognize the anniversary of the abolition of the transatlantic slave trade. A few years ago, I wrote all of my colleagues on this committee to remind them that the question of human rights and trade is not one which began in the 1970s or in the 1990s. In 1807, this very Congress passed the act prohibiting the importation of slaves. Trade and labor, trade and human rights have always been linked. It is not something that is new. It is as old as our country. This is not an issue for another day, another committee. It is time for us to act. I've said it before, and I will say it again. Our trade policies are a reflection of our values. We must respect the dignity and the worth of every human being. What does it profit a great nation to gain a trade bill and lose its soul? As members of this committee, we must be a headlight and not a tail light, or history will not be kind to us. This amendment responds to a desperate call for action. Congress must do something new and learn from the hard, painful lesson of the past FTAs. I urge all of my colleagues to support this amendment. Do what is right, what is fair, and what is just.
Gentleman yields back, balance of his time.
I yield back.
Gentleman yields back. Mr. Record is recognized for 5 minutes.
Move to strike the last word. Thank you. Well, I don't think anyone on this side of the aisle enjoys following Mr. Lewis's impassioned speeches. So I'm not even going to try to compete with that, Mr. Lewis. There is no stronger voice in Congress, no stronger voice in this country for freedom and for human rights than Mr. John Lewis. We all recognize that, and sir, it's an honor to serve with you in the United States Congress. We both share the same passion for people. I worked in a community for 33 years as a law enforcement officer working with people, and one of the things that I learned that if you're in the community and working with the community and partners with the community, you can help change the community. You can bring people out of poverty, you can bring people off of drugs, off of alcohol, out of domestic violence. You can get them into the services that they need. You can help lead the way. And that only happens if you bring a
passion and compassion for people, which the United States of America does. That only happens if you care about other countries. It only happens if you have a relationship and a partnership with other countries around the world. And what is one of the ways that we can create that partnership and that relationship? Through trade. It gives us that opportunity to interact with those communities and build that relationship. And that's exactly what TPP does. And of course, back to the topic at hand is TPA, and that's how we get to TPP. But I think there are certain things that we need to remember as we move forward, because to get to TPP and build that relationship, TPA needs to be strong, and the language has already reflects a carefully negotiated compromise between Republicans and Democrats in the House and the Senate. This provision goes further than that compromise, and it would unravel the agreement. I think that's a key argument to make in opposition, sadly, to Mr. Lewis's amendment. TPA carefully reflects the May 10th compromise, which forms the basis for our negotiations in TPP. It ensures our trade agreement partners adopt and maintain core internationally recognized labor standards, effectively enforce their labor laws, and do not waive from the enforcement of their labor laws to attract trade or investment. The provision also provides the labor obligations are subject to the same dispute settlements and remedies as other enforceable obligations under the trade agreement. TPA also includes this is a new provision that requires the administration to notify and closely consult with Congress, so some transparency language added, before this agreement can enter into force. So the labor chapter provides substantive obligations. Any action plan is a plan for implementing those obligations and should not go into the text of the agreement itself. Our trade agreements make clear that an agreement may not enter into force until the United States determines that our trading partners are in compliance with the agreement. Conditioning the submission of an implementing bill on this is inappropriate. We cannot expect our trading partners to change their laws before we agree to do the same. So for these reasons, Mr. Chairman, I would suggest we oppose this amendment. I yield back.
Gentleman yields back. Mr. Doggett, do you move to strike the last word?
I do, Mr.
Gentleman's
Chairman.
recognized.
Thank you. I feel that anyone who's not moved by the words of Mr. Lewis on human rights and by the example that he has set with his life is not likely to be moved by my words, but at his request, I want to add a few specifics as they relate to this agreement and to the TPP. About 3 years ago, like most of the committee, I voted for permanent normal trade relations with Russia, in part because we included strong human rights protections in the form of the Magnitsky Act. One of the things that Mr. Lewis's bill will do is to preserve the right to deal with Magnitsky-type sanctions there where Russians brutalized and murdered Sergei Magnitsky, an attorney for foreign investors. He was trying to protect investment rights, and he lost his life in doing so. Thanks to Mr. Cardin and the involvement of a number of other people, we were able to pass the Magnitsky Act, but it was limited to Russia. I think it's very important to consider what countries TPP will open up the American market for. Well, it's probably not worse than Uzbekistan, to whom we accorded benefits through an earlier piece of legislation today with its long habit of child labor and forced labor in a country run by a dictator who has been known to boil his opponents alive. The record of TPP partner Brunei is extremely troubling. The State Department's Human Rights Report found restrictions on religious freedom, trafficking in persons, discrimination against women and the LGBT community, and that was before the Sultan recently introduced Sharia law. Brunei now has harsh penalties for distributing material against Sharia. In one state government after another, There have been those who sought to prevent Sharia law where it didn't exist and wouldn't exist, but we are opening our markets and making a partner of a country that relies on Sharia law. And while certainly its performance is not as bad as Guatemala, where 70 unionists were murdered in the 8 years that USTR didn't do anything about the labor complaint under CAFTA, our TPP partner, Mexico, my neighbor there in Texas, has been involved or has witnessed the arbitrary killing of civilians by its security forces. There is in the Human Rights Report from the State Department the conclusion that there is widespread impunity for human rights abuses. Its Human Rights Commission received 32 complaints in the first 9 months of 2013 and acted upon one of them. In TPP partner Vietnam, to which Mr. Lewis referred, there are so many sad stories about one activist after another. The woman who was attacked by 5 assailants while on a motorcycle with her 2 young children and beat up. People that continue to face very violent responses from groups associated with the security forces for simply expressing their opinion. The report notes severe restrictions on freedom of expression, association, and peaceful assembly. More recently, another of those trading partners, Malaysia, this very month, a cartoonist was charged with 9 counts of sedition for criticizing a court decision. The court decision concerned the fact that the leader of Malaysia decided to bring charges against a former ally of sodomy, and the cartoonist referred to the judges as lackeys in black robes. He now faces a 5-year prison term. I believe that trade, though it hasn't worked that well in China, and I voted for PNTR for China on the theme that trade would open up and elevate human rights, that we need to give consideration to the fact that trade is more than just widgets moving across our border. Our trade agreements need to reflect our values. We certainly must not give an agreement for fast track if it fails to meaningfully address human rights and labor rights as Mr. Lewis has outlined them in his amendment. I would urge the adoption of the Lewis Amendment as a reflection of our values so that our trade is about boosting our economy and more jobs, but it's also about more respect for basic human values that we want for ourselves and our own families and ought to be promoting around the world, and I yield back.
Gentleman yields back. I think gentleman from Wisconsin, move to strike the last word.
Yes, Mr. Chairman. Move to
Gentleman's
strike the last
recognized.
word. Mr. Chairman, I just want to take a moment to voice my support in favor of the Lewis Amendment. I view this amendment as entirely consistent and complementary with some of the core negotiating objectives that are already in the base bill. We have, for the first time in our nation's history, in this TPA legislation as a core negotiating objective, that our negotiating partners have to, if they have not already, adopt core international labor standards. And another negotiating objective is capacity building to help those nations get to that point. Also, as part of the core negotiating objectives is the advancement of human rights. And I couldn't agree more with what Mr. Doggett just said, that these trade agreements are more than just goods and products crossing border. They are a reflection of our values, of the morality of humanity throughout the globe. And I think what's being negotiated right now in the context of TPP is perhaps the most progressive trade agreement along these lines that our nation or the world has ever seen. And what Mr. Lewis is advocating here is something that's entirely consistent with what's in the base bill. It complements what's in the base bill. It doesn't go further than what is already required to be done within the base legislation. And for those who don't realize what those core international labor standards are about, they're specifically defined in the TPA bill as being freedom of association, the effective recognition of the right of collective bargaining, something that perhaps my own governor from Wisconsin should better heed in the future, the elimination of all forms of forced and compulsory labor, the effective abolition of child labor and the prohibition on the worst forms of child labor, and finally, the elimination of discrimination in respect of employment and occupation. So those are goals and objectives that are already in the base bill that the administration is already negotiating in the context of TPP. So I see nothing contradictory with what Mr. Lewis is offering today, and I would encourage my colleagues to support it. I yield back.
Gentleman is recognized for the purposes of closing. Oh, all right. Gentleman from Michigan.
Briefly, I just want to spell out the meaning of this. I'll just give you one example. On page 2, it says, ensure the implementation of the labor obligations in the TPP by, number 1, providing that a union shall not be required to affiliate with any confederation and shall be free to form and affiliate with any vertical or horizontal workers' organization, including any confederation, sector-wise or industry-wide union of its own choice. And BB, workers in a TPP party shall have the right to freely form and join an autonomous and independent union of their choosing. What this language does is essentially spell out what the general language means in TPA as it's presently constructed. And what this sends is a clear, more than signal, but an instruction that in negotiating TPP, in this case with Vietnam, that they have to allow their workers the right to organize and the right to form unions and the right to form organizations. That's what it does. So it spells it out so that nobody can come back and say that, okay, we're going to proceed with Vietnam without these requirements having been met. And if they're not met, it undermines, and to some extent, it refutes the meaning of May 10th that we worked so hard to produce. That's the meaning of this. It has meaning, Mr. Lewis. And I congratulate for your insistence that when it comes to labor rights and human rights, we have to have strong rhetoric, but we also have to have meaningful reality. That's been your life, and I hope all of us will support this amendment.
Gentleman from Georgia is recognized to close.
Well, thank you very much, Mr. Chairman. Mr. Chairman, I want to take an opportunity and thank Mr. Doggett, Mr. Kine, and Mr. Levin, and all the other members for supporting this effort. It is my belief, long before I came to Congress, that we all live in the same house, and it's not just the American house, but it's the world house, and that we must look after each other and care for each other, and respect the dignity and the worth of every human being. And with those words, I yield back.
Mr. Chairman.
Gentleman yields back. Gentleman from Ohio.
I withdraw my point of order.
The reservation of the point of order is withdrawn, as no more members seek recognition. The question is on agreeing to the amendment offered by the gentleman from Georgia, Mr. Lewis. All those in favor signify by saying aye. Aye. Those opposed, no. No. The opinion of the chair, the noes have it. Roll call vote is requested. The clerk will call the roll.
Mr. Johnson. Mr. Johnson, no. Mr. Brady. Mr. Brady, no. Mr. Nunes. Mr. Nunes, no. Mr. Teaberry. Mr. Teaberry, no. Mr. Reichert. Mr. Reichert, no. Mr. Bustani. Mr. Bustani, no. Mr. Roscom. Mr. Roscom, no. Mr. Price. Mr. Price, no. Mr. Buchanan. Mr. Buchanan, no. Mr. Smith of Nebraska. No. Mr. Smith, no. Ms. Jenkins. Ms. Jenkins, no. Mr. Paulson. Mr. Paulson, no. Mr. Marchant. Mr. Marchant, no. Ms. Black. Ms. Black, no. Mr. Reed. No. Mr. Reed, no. Mr. Young. Mr. Young, no. Mr. Kelly. Mr. Kelly, no. Mr. Renacci. No. Mr. Renacci, no. Mr. Meehan. No. Mr. Meehan, no. Ms. Nome. No. Ms. Nome, no. Mr. Holding. No. Mr. Holding, no. Mr. Smith of Missouri. No. Mr. Smith, no. Mr. Levin. Mr. Levin, aye. Mr. Rangel. Mr. Rangel, aye. Mr. McDermott. Mr. McDermott, aye. Mr. Lewis. Mr. Lewis, aye. Mr. Neal. Mr. Neal, aye. Mr. Becerra. Mr. Becerra, aye. Mr. Doggett. Mr. Doggett, aye. Mr. Thompson. Mr. Thompson, aye. Mr. Larson. Mr. Larson, aye. Mr. Blumenauer. Mr. Blumenauer, aye. Mr. Kind. Mr. Kind, aye. Mr. Pascrell. Mr. Pascrell, aye. Mr. Crowley. Mr. Crowley, aye. Mr. Davis. Mr. Davis, aye. Ms. Sanchez. Ms. Sanchez, aye. Chairman Ryan. Chairman Ryan, no.
The clerk will report the vote.
15 yeas, 23 nays.
15 yeas, 23 nays. The amendment is not agreed to. Are there any further amendments? I think you're up, right?
Yes, Mr. Chairman, I am.
Gentleman has an amendment. Gentleman will suspend while the clerk distributes the copy of the amendment. Where's T-Berry? Is he going to reserve? Is he reserving it? Gentleman from Ohio reserves a point of order.
Seems to have a lot of reservations today.
Which one is this, ISDS?
Mr. Chairman, is it parliamentary inquiry, what is the point of order which he is always asserting?
We got to scrub to make sure it's what we think it is to see if it's He's just reserving it. Some of these we know are not germane, so we want to make sure the amendment is what we think it is. We've reviewed some of your amendments, some of them aren't germane. We just got to make sure it is what we think it is. Just being safe. You're jumping around in orders. Copies are distributed, so the gentleman is recognized for 5 minutes for the purpose of describing his amendment.
Thank you very much, Mr. Chairman. Clearly, when an American investor goes abroad, we don't want their property stolen. And sometimes that stealing can be done through direct expropriation, and sometimes it can be done indirectly. So there's good reason to protect investors abroad, and that involves protecting those who invest here. This broad problem of how to do that, consistent with local regulation and regulations to protect our health and safety, is what this amendment is all about. This is part of a broader issue. The amendment that I offer addresses one narrow but important part of it. I have raised with the committee previously in informal session my concern about eroding rights we already have, such as with Australia. I don't deal with that here. I deal only with the standard. And I think the broad concern that I have that this particular amendment deals with is that foreign investors should not be accorded greater rights than American investors here in America, and that it is important to support local and state ability to keep health and safety regulations, to keep our air and water clean, and we ought to be able to do that without having to pay foreigners for the privilege of a city council or a state legislature or the federal government legislating. I believe that there is real danger with private panels and understanding what these private panels are. They may well be the attorneys of multinational corporations that 1 month are advocating for their client in front of an arbitration panel, and the next month are the judges of someone else's panel. I understand the desire of multinational corporations for private justice and avoiding some of the protections of the public justice system, but I think it's important wherever possible to rely on that public justice system. In March of this year, only a month ago, an investment tribunal established under the investor-state dispute settlement system in Canada, in the Bill Kahn versus Canada decision, rendered a very troubling decision. I note that Ambassador Froman has been unable to offer any real explanation of what to do about that decision. I believe it's important that we write into this law some protection against that type of decision. There was a matter of an American investor wanting to expand a rock quarry in a very environmentally sensitive area in Nova Scotia, I believe at the Bay of Fundy. And a decision was made to not permit the expansion of the rock quarry. The dissenting judge, and there was a dissent in the case, said, quote, "The decision of the majority will be seen as a remarkable step backwards in environmental protection." It is true that the rock quarry, they can continue to prohibit it, but Bill Kahn is seeking about $200 million for the fact that they're not able to build the rock quarry. And what is particularly striking about that, and talking about foreign investors having more rights than domestic investors, is that Canadian law does not provide a remedy of that type, but this arbitration panel provided it for Bill Kahn. In other words, only foreign investors were able, because of this decision, to claim monetary damages. The same thing could happen in Texas or Wyoming or New York or anywhere else. If a Vietnamese investor, a Japanese investor, one of these Sharia law investors decides that they don't like a new decision by a city council, by a state legislature, or by the Congress in how we're handling health and safety regulations, and they claim that this is a taking of their properties. The National Conference of State Legislators, which I think is probably has more Republicans than Democrats, has long warned of the problems associated with investor-state dispute resolution. It passed a resolution that it would not support trade agreements that provide for investor-state dispute resolution that would be discriminatory with reference to laws and regulations at the state level, even if the change in the legal environment thwarts the foreign investors' previous expectations. While America has not lost a case itself, the environment has lost. Local control has been lost. The TPA bill contains the same language that was involved in the Canadian dispute, though Ambassador Froman was not exactly forthcoming on that issue. And the Bill Kahn case should serve as a wake-up call, and that's why the amendment tightens the definition of what is the minimum standard of treatment when there is a local regulation. I thank you, Mr. Chairman.
Gentleman yields. Mr. Paulson, do you seek time?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Well, I appreciate the gentleman's laying out good reasons to protect investors, which is clearly what some of these ISDS provisions are laid out to do, and it's one of the more mundane chapters, actually, or provisions, actually, in the TPA legislation. But it's very important, and the legislation I think we have before us right now, I'll ask Mr. Rafe to comment in just a little bit, but this is a very carefully negotiated compromise, actually, between Republicans and Democrats in the House and in the Senate, and I am concerned that the provisions you're offering goes a little bit farther than what that compromise is about and would unravel some of the careful balance that's been struck right now within TPA. Now, the negotiating objectives in TPA maintains very balanced objectives on investment. It directs USTR, of course, to address trade-distorting barriers to investment and then secure for U.S. investor rights comparable to those that would be available in the United States, so including through meaningful procedures for resolving these investor disputes. So at the same time, it also makes sure that foreign investors, they're not going to be accorded any greater substantive rights in America, in the United States, than our investors would receive outside the United States. So this reflects some of the most recent practices we have in the FTAs, and it essentially is going to prevent and ensure that countries don't discriminate in favor of their own companies when applying their laws. It's a proven tool for protecting U.S. investment.
It encourages countries to raise their legal standards and practices up to our level here in the United States. That's the main goal here, because it's no surprise that I think a lot of the countries where we've had these disputes with, they're likely to become embroiled in disputes if they have weak legal systems. So this is about raising the bar. And I think that some of the carefully negotiated provisions we have right here in this TPA legislation provide the appropriate checks and balances to prevent abuse. And so I would oppose the amendment, and I'd like to ask Mr. Reif if the administration has concerns with including this amendment.
Thank you, Mr. Paulson. And Mr. Doggett, thank you for the amendment. ISDS is an important subject. It's important because investor rights, the ability of small businesses, and more than 50% of the ISDS claims are by small businesses, often producing cutting-edge environmental technologies that help us to improve the environment in the United States and around the world. So small individuals or small businesses need to have the access to fair opportunities for adjudication in foreign markets through ISDS, and those small businesses that are involved support millions of jobs here in the United States. At the same time, we need, as a government, to be able to have a zone of regulation in the public interest where there's an ability of the government to operate. And the provisions in the TPP include a safe harbor that, in fact, goes directly to that issue. And if I can, I'll read from that specific text. It provides that non-discriminatory regulatory actions by a country that are designed and applied to protect legitimate public welfare objectives, such as public health, safety, and the environment, do not constitute indirect expropriations, except in rare circumstances. So this language is what is coming into the TPP, is being negotiated with our trading partners, and which we consider does provide, Mr. Doggett, a good balance between ensuring that small investors have the right to utilize effective dispute settlement in foreign markets, and as well making sure that foreign governments and our own government is able to regulate in the public interest. May I make one last comment, Mr. Paulson? There are some cases that have been noted, not the Bilcon case, which is not, Mr. Doggett, it's not finished yet, which may be the reason that we have not given definitive comments on. It's still ongoing. But some of these other cases that have been mentioned involving Australia and others, these are cases that are not subject to the language that I just read to you. They're subject to other governments, other countries that have negotiated weaker ISDS provisions. And so our provisions are much stronger in protecting the ability of a state to regulate.
Well, maybe, Mr. Chairman, just to add, this is again about using, and Mr. Doggett mentioned these panels, but using these ISDS panels, it brings other countries up to our standards. It doesn't bring the United States down to other countries' standards. I yield back.
Gentleman yields back. Dr. McDermott, I think you want to strike.
I either want to ask
recognized.
Mr. Reif or Congressman Doggett. There's been recently a report released that says that the fracking that's been going on in the United States, at least in the state of Oklahoma, has led to a marked increase in earthquakes. And there's a question about whether or not the re-injection of the fluid down into the earth is creating these earthquakes. Now, if a foreign investor were involved in that fracking operation, could they bring a suit against the state of Oklahoma or whomever if they were prohibited from continuing that activity? And in the case of this Canadian situation, since there's no appeal, at least I understand that it is final decision by those panels, how does that get resolved? The city and wherever it is in Canada can be inundated with a $200 million debt. No city can pay for that. So how do these issues get resolved? And is it possible for a foreign investor to bring that kind of suit here in the United States for something like the fracking issue?
So thank you, Mr. McDermott. With respect to the Canadian case, the Government of Canada does have the right to request review in Canadian courts. So there will be a further opportunity, which is one of the reasons that that case is ongoing. With respect to your hypothetical, what I can say is that the standard I just read to you, which is part of the TPP, protects specifically the right to regulate public safety. And I would think that the occurrence of earthquakes or some other natural occurrences like that is a government's right to regulate with respect to public safety.
Could the case be brought, and the panel then would what? Say, under the rules, we can't hear this case? Is that it? Or there would no be panel created? Or what's the mechanism by which it's dismissed?
So there are the TPA, the underlying TPA also contains provisions for frivolous complaints to be dismissed. So there is that added protection. As to a basic case that could be filed,
Define frivolous for me, please, so I can understand.
a complaint that does
I'm
not
an oil
have,
company, and I've invested millions of dollars in this process, and now you're saying to me this is a frivolous?
so it's comparable to a provision under our federal rules of civil procedure. And it basically would suggest that the complainant does not have a basis in law or fact to bring a complaint. More than that, there are requirements. Obviously, there would need to be an investment. There would need to be other jurisdictional requirements before the complaint would be brought. But even on top of that, if there was not a basis in fact or law to raise the complaint, it could be dismissed under this added layer of protection.
Senator, or
Well,
do you want to comment?
I guess I must say that I'm a little more troubled than when I first offered the amendment to hear this response from USTR. I thought that everything in this amendment, specifically the standard established in the Glamis Gold case, was something that USTR supported. To hide behind the fact that there is still a right to appeal the details of arbitration in a Canadian court that can never reach the merits of this case is to be a little bit deceptive. ISDS would not have any value if you went to the panel and then you could consider it all again in the court in Vietnam or Brunei or Canada. This decision is final. It's a 220-page decision. I've read it. It adopts a standard relying on the same law that is in effect in TPP. And we will, if we don't adopt the kind of approach that's taken in this amendment, which I thought was the USTR position, there won't be a decision concerning a landfill in your community by a foreign investor, a decision that relates to a project expansion that a foreign investor might have, and those foreign investors will have more rights than people that live in America. That's what happened in this Canadian decision, where there was no right to damages under Canadian law, but this panel will have the opportunity to consider whether it grants the full $200 million that BillCon is asking for. That is a far-reaching decision. We are seeking, through this provision, not to deal with all the problems, which are many, with dispute resolution.
Time for the gentleman has expired. Does the gentleman seek to close?
I believe Mr. Levin.
Oh, you want to? Okay, all right.
Look, we've been working on this for a long time. What is in this TPA is essentially what is there since 2002. And we've said to USTR, there needs to be added attention. Times have changed. We're not suggesting abolition of ISDS. Not at all. The present rules are inadequate. And MilCon is a good example. It's a good example. We have proposed to USTR 4 changes, including strengthening the minimum standard, also providing for the 2 countries involved to be able to stop the arbitration. But the train just goes on. And we've tried to stop it just long enough to have a serious consideration of this. When I was in Australia, essentially the negotiator said, ISDS is finished. And then there's a briefing, and our negotiator says to staff, it's done. That's what they say. Well, we're appealing to USTR to take a look at very, very positive, constructive suggestions. And we just have gotten nowhere. And so that's why we spelled out in our substitute bill 4 changes that need to be made. And when we had that briefing, Mr. Chairman,
I recall.
Mr. Froman said he'd like to think about a change. So what Mr. Doggett is raising is something so real, and there are more and more of these cases that are being brought challenging local regulations, and that's what's happening. And we need to have a TPP that addresses these and a TPA that is relevant to this issue. And this TPA provision is not relevant enough to what's happening. I yield back.
Mr. Blumenauer, you move to strike the last word?
I do, Mr.
Gentleman's recognized.
I appreciate Mr. Doggett bringing this forward and an opportunity for us to spend a little time on the committee talking about investor state. I must confess that I have a slightly different read on it than my friend from Texas. As I read the decision, first of all, it appears, I'm not certain that it's an environmentally sensitive area because there's already a Canadian quarry on the site. It was approved by the government of Nova Scotia. These American investors spent millions of dollars, years. The record, my understanding, is something like 3,000 pages. And those of you who've served in local government as I have, I confess 17 years in city and county government, listening to zoning and development appeals. And when I actually first started reading this, because I was given by one of my environmental friends their talking points of why Bilcon was a terrible decision. And I looked at it in their own material. They talked about how the turning point was not an objective standard, but it was a community value. We don't, in my community, which is in Oregon laws known for being pretty progressive in terms of the first comprehensive statewide land use legislation, it's worked with developers and environmentalists because we had objective standards. It wasn't who gave the last campaign contribution or who packed the room. It appears from the record that this was a 90-hour hearing, and the proponents, the American company, had about 90 minutes, and it turned on community value. I'm not saying that that shouldn't be something that factors in, but we want to have these provisions protect American investors abroad, not by having a local heated kangaroo court that I've seen in my state, in my community. I've faced down both developers who've mobilized their forces and neighborhood association who've mobilized their forces to have something decided on other than something that's objective. Now, my reading of this case is not that it was egregious in terms of something that this company just dropped in, took pristine wilderness, and is trying to make out like bandits making a profit. It looks to me like a Canadian company was treated differently than an American company in an area that has rock quarries, and there was an effort to try and resolve it. And the ultimate decision was made around this community value. I believe in community values. I've worked as an elected official to translate them into law that can in fact be enforced in a uniform basis. So I think that the more I look at the investor state provisions, we've never lost one. 4 of the countries that we have in TPP already have investor-state provisions. Mr. Froman is committed to working in terms of if there are things that can be done, and let's by all means get real and get specific as we work this thing through the process. But the BillCon, as I look at it, is not necessarily an example of abuse, but if you were representing that company in your community, you'd probably think maybe they had a right to try and move things forward. And I've had enough experience in the countries that we're trying to bring in with TPP to know that I'm not interested in people that I represent rolling the dice with an Indonesian court. I think investor state is something that works to the advantage of people who play by the rules. We can work to make sure there aren't egregious examples, but so far I haven't seen the ones, and this isn't even resolved finally, and it's NAFTA as we're trying to move forward with things that go beyond NAFTA. So I appreciate my friends spotlighting on it, but my read of the case is that it's not quite as bad as it seems. And on that basis, I'm not willing to abandon investor states with 3,000 such agreements around the world, and we're party to 51 of them. And I think we probably would want to have this if TPP moves forward. Thank you.
Mr. Dockett, you seek time to close.
I do.
Gentleman's recognized for the purpose of closing on his amendment.
Well, I do have a very different reading of this opinion than Mr. Blumenauer just advanced. And I believe that the provisions in the amendment, which refer to a case that happened in California that was another open pit mine where we prevailed, is the standard that ought to be applied in the future. Certainly there are unjust decisions that are made at the local level, one way or the other. And the way American investors would resolve those matters is to go to court and consider the record. That's exactly what could have been done in Canada with a Canadian justice system as old as ours. Instead, this particular investor preferred to go to a 3-member panel under NAFTA with the same standard that applies in TPP. And that standard was, I believe, very misconstrued, whatever the facts of the case, and I think the facts do suggest that there was an endangered species issue with reference to several species, and that there was a serious environmental problem here that the dissent recognized. And let me just quote from his opinion: in this day and age, the idea of an environmental review panel putting more weight on the human environment and on community values than on the technical feasibility, and concluding that these community values were not outweighed by what the panel regarded as modest economic benefits, does not appear at all unusual. A chill will be imposed on environmental review panels by this decision. I want to prevent that chill on these type of panels and not to endanger local decision-making. If foreign investors choose not to turn to American courts, which is where every American would turn on their investment to get fair play, then we need to ensure that these investment panels are playing by a rule of law that recognizes and shows appropriate deference in the minimum standard for regulation, not just by a city council or a zoning board on the expansion of a project of this type, but on a decision by a state legislature concerning health and safety or pollution in California, a decision by the United States Congress. There is a section in this act as currently proposed that says we're not going to be changing any federal law without the action of this Congress in the future. And that's true. But we can certainly be forced by these arbitration panels, these ISDS panels, to pay a pretty penny for keeping that federal law or that ordinance or that state regulation. And the problem is not just the millions and millions of dollars of taxpayer money that are at stake, because taxpayers can be forced to pay dearly here, but it is the threat of these actions. Indonesia, as the gentleman should well know, is not a party to TPP. It's one of those countries that got left out in the very spotty coverage of Asia by the administration. But take another small country involved in the pack. Just the threat, as has been the case in the past, of these type of actions has been enough to discourage appropriate, not just environmental, but health and safety regulation. And so I believe the standard that is set forth in the amendment is a narrow one. It does not end, as I think we probably should, it does not end dispute resolution. It does not change the panels. It simply assures that the standard that they use when they evaluate these decisions is consistent with a case that the United States won. One of those proud cases referred to by supporters of this that we continue to win victories. Well, then let's use the standard in that victorious decision to decide whether what happens in your community when attacked by a foreign investor is right or is not right. And I urge adoption of the amendment.
Mr. Chairman?
Gentleman from Ohio is recognized.
Mr. Chairman, before I withdraw my reservation of the point of order, I just want to let the record show that the BillCon 11 case went against Canada, but according to the Canadian Embassy, they still fully support ISDS, fully. So, Mr. Chairman, I withdraw the reservation of the point of order.
Okay, the reservation of the point of order is withdrawn. Question is on agreeing to the amendment offered by the gentleman from Texas, Mr. Doggett. All those in favor signify by saying aye. Aye. Those opposed, no? No. In the opinion of the chair, the noes have it. Gentleman requests a roll call vote. The clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady?
No.
Mr. Brady, no. Mr. Nunez? Mr. Nunez, no. Mr. Teaberry? Mr. Teaberry, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? Mr. Roscom, no. Mr. Price? Mr. Price, no. Mr. Buchanan? Mr. Buchanan, no. Mr. Smith of Nebraska? No. Mr. Smith, no. Ms. Jenkins? No. Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Mr. Marchant, no. Ms. Black? Ms. Black, no. Mr. Reed? Mr. Young? Mr. Young, no. Mr. Kelly? Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? Mr. Meehan, no. Ms. Nome? Ms. Nome, no. Mr. Holding? Mr. Holding, no. Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. Rangel, aye. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, aye. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer? Mr. Blumenauer, no. Mr. Kind? Mr. Kind, no. Mr. Pascrell? Mr. Pascrell, aye. Mr. Crowley? Mr. Crowley, aye. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Mr. Reed? Mr. Reed, no. Chairman Ryan? Chairman Ryan, no.
The clerk will report the vote.
13 yeas, 25 nays.
13 ayes and 25 nays. The amendment is not agreed to. Any other amendments? Mr. Becerra.
Mr. Chairman, thank you, and
Gentleman has amendment. Gentleman will suspend while the clerk distributes copies of the amendment.
we'll do so.
Mr. Chairman, I'd like to,
Gentleman from Ohio.
Mr. Chairman, I'd like to reserve a point of order.
Gentleman from Ohio reserves a point of order. Ms. Becerra. Is this your ISDS amendment? Yes.
Hey, Zach, I've got his business card here. This guy was at the table last night. What I want to do is I want to get a copy of that New England Council report on jobs and precision manufacturing. And I want to be able to send it to this guy fast, okay? He's going to bring it up at the real estate roundtable. We'll do. Okay. Thank you.
Thank you.
Thank you.
Ms. Becerra. Gentleman's recognized.
Thank you, Mr. Chairman. So this picks up on what Mr. Doggett's amendment attempted to do. So let me go right to the point with regard to the investor-state dispute settlement system. Again, we're talking about the rights of investors who seek to do business in another country and the system for settling disputes between those investors and the governments where those investments are proposed. Mr. Chairman, I don't think anyone would deny that that whole issue, that whole area is a moving target. We're floating in an evolving area of law, and for that reason, I think all of us want to figure out a way to deal with investors, those states, and the dispute settlement system that will be used by those investors in those countries so that we can have some certainty, some predictability, and fairness. Whether the investor is an American investor going abroad or whether it's a foreign investor trying to come to the U.S., we want to make sure that there's not discrimination and that people understand the rules and understand what it would take to make an investment, a fair investment, in that particular country. Now, that's not just good for the investors, it's good for consumers, whether here or abroad, and it's good for policymakers, whether here in this Congress or in any other legislative chamber or body that's trying to make sure that there are laws that make it clear how you operate in that particular country. Fair play, fair treatment. I think that's what everyone's looking for. At the same time, we want to know that our domestic laws here in this country, and I suspect every other country will say the same thing, and our rules, whether at the federal, state, or local level, so long as they're fair and even-handed, will be respected and not be blindsided by a ruling not made by a court of relevant jurisdiction in that local entity, whether it's a city or county, or by that state, or certainly by the federal government here in this country, is all of a sudden overturned by a small panel of arbitrators who have maybe no connection to the U.S. And I think it's fair to say that in America we feel we have a pretty established and evolved system of laws and rules. Now, a lot of folks around the world may not agree with us. In fact, sometimes we don't agree with each other in terms of what those rules and those laws say and how they should be implemented. But at least we have a very rigorous set of rules and laws that have been around for a long time. My amendment is very simple. It simply says this: Medicare which today covers around 55 million Americans who paid into the system by having a deduction made from their paycheck to make sure they had Medicare. The Children's Health Program, which taxpayers we pay for. The Medicaid system, where about 61 million Americans also receive decent health care. That those pillars of health care for America that make it possible for so many Americans, especially our seniors who are now in retirement, can live out their lives in dignity. That we don't find that all of a sudden the Medicare system and all those seniors and all those Americans who rely on the Medicare system are blindsided by some ruling, by some arbitrator outside of the U.S. that says that we got to change Medicare because some investor from abroad says that our rules were unfair. And so this amendment is tailored very narrowly to say, when it comes to the whole issue of investor-state dispute resolution, hands off of Medicare, hands off of Medicaid, hands off of our public health system that has been there for a long time. And if you want to play within our healthcare system, the rules have been around for a long time. 50 years we've had Medicare and Medicaid. No one should believe that they can be blindsided by the rules for Medicare and Medicaid, and therefore no one should believe that they should try to use an outside body through some trade dispute system to try to undo the rules that we have for tens of millions of Americans who paid for those benefits. So, Mr. Chairman, I would urge my colleagues to support this amendment to make sure that no one is blindsided with their Medicare when it comes to trade deals that have nothing to do with the Medicare system. With that, I yield back.
Gentleman yields back. Gentleman from Minnesota, Mr. Paulson, is recognized.
Move to strike the last word.
Gentleman's recognized.
Mr. Chairman, I'm looking at the amendment, and it looks like just exempting Medicare and Medicaid programs from this investor-state dispute process, it doesn't make sense in this context. The concern seems to be that some ISDS settlement is going to undermine somehow the ability of Medicare or Medicaid to provide services to beneficiaries, right? You talked about the 50 years of history we have here. But the rates that are set by these programs for services that are provided to these beneficiaries, it's determined by U.S., state, federal government policy. I mean, we set this. Congress sets this. This is our job. This is what we do. And an ISDS panel, it can't change a country's laws. That can't happen. But there is a danger that if we exempt certain programs from this investor-state dispute process, that ISDS disputes would then prompt similar actions from other trading partners, and then that would absolutely prevent the United States from protecting businesses or jobs that are being unfairly targeted. So I'm not aware in the 50 years of Medicare or Medicaid history that we have with all the 3,000 agreements and the U.S. being a party to 50-some, that we've ever even had a case brought forward this, and it's hard to even imagine how we would see a case brought forward in this. I would yield back.
Gentleman is recognized to close on his amendment.
Thank you, Mr. Chairman. I respect what Mr. Paulson has said, and I think he's right. Medicare and its workability for over 50 years is a challenge at this stage. But neither did we expect to see some of these challenges we're now seeing played out in these investor-state dispute resolutions and in these tribunals. No one expected that this provision about investor-state regulation would impact the ability of Australia to decide truth in marketing for all products, but it has. I suspect Canada didn't expect that it would be challenged by an investor on how it applies its patents, but it has. And while I would hope no one around the world would try to challenge Medicare, because we've had it for 50 years, they might. And all I'm simply saying is, let's not get there. Let's not take a chance that some healthcare investor with a lot of money says, hey, I don't like the way you operate Medicare, that you guarantee that they will have access to a doctor. What if I don't want to treat that particular senior? And I think it's unfair to have a rule that says a senior has a right to be able to choose his doctor. I think that's unfair. And you challenge that not under our courts, not under the Medicare law, but through some tribunal that has to do with trade. And that's what we're trying to avoid. And certainly I will yield.
So if there were a future decision to reduce or change payments for Medicare Advantage, and instead of it being an American healthcare company, it were a foreign healthcare company they might well have a basis for going to, instead of coming to federal court, instead of coming to Congress, going to a three-member corporate panel of the type that decided the Bilcon case in Canada. And we keep the law. They can't force us to change the law, but they can force us to pay an unlimited amount of damages, whatever they say they can show by virtue of the decision, couldn't they?
Well, that's the problem. That's the concern, is that taxpayers who've already paid for Medicare would now have to pay a foreign investor if that investor should win in this tribunal, who knows how much money, simply because they didn't think that they were getting a fair shake out of the way the Medicare system operates for more than 50 million Americans. And that's the only thing this amendment tries to do, is it walls off Medicare and says, hey, the system works well. You want to participate in it. The rules are clear. Don't try to use some outside body, some tribunal, to try to get your way as an investor, trying to take away our Medicare from our seniors. And so I would urge my colleagues to support this amendment and move forward as we see the laws and rules evolving on the investor-state dispute settlement system. But in this case, keep your hands off of our Medicare system.
Gentleman yields back the balance of his time. Gentleman recognizes the gentleman from Ohio.
Mr. Chairman, before I withdraw my reservation, I just want to remind everybody here that Ambassador Froman told us that 17 out of thousands of cases that were filed in the U.S. court system, the best in the world, only 17 went to something outside of our U.S. court system, none of which were ruled in their favor. With that, Mr. Chairman, the reservation of the point of order, I would like to withdraw.
Gentleman withdraws point of order. The question is on the amendment offered by the gentleman from California, Mr. Becerra. Those in favor signify by saying aye. Those opposed, no. No. Opinion of the chair, the noes have it. Gentleman asks for a roll call vote. The clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Brady, no. Mr. Nunes? No. Mr. Nunes, no. Mr. Teaberry? Mr. Teaberry, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? Mr. Roscom, no. Mr. Price? Mr. Price, no. Mr. Buchanan? Mr. Buchanan, no. Mr. Smith of Nebraska? No. Mr. Smith, no. Ms. Jenkins? Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? No. Mr. Marchant, no. Ms. Black? Ms. Black, no. Mr. Reed? No. Mr. Reed, no. Mr. Young? No. Mr. Young, no. Mr. Kelly? No. Mr. Kelly, no. Mr. Renacci? No. Mr. Renacci, no. Mr. Meehan? No. Mr. Meehan, no. Ms. Nome? No. Ms. Nome, no. Mr. Holding? Mr. Holding, no. Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. Rangel, aye. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, aye. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, yes. Mr. Blumenauer? Mr. Blumenauer, no. Mr. Kind? Mr. Kind, no. Mr. Pascrell? Yes. Mr. Pascrell, yes. Mr. Crowley? Mr. Crowley, aye. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Chairman Ryan? No. Chairman Ryan, no.
Clerk will report.
13 yeas, 25 nays.
There being 13 ayes and 25 nays, the amendment is not agreed to. Are there any further amendments? Mr. Thompson?
You have an amendment.
Gentleman has an amendment. The clerk will distribute. Barry? Gentleman from Ohio. Point of order is reserved. Oh, sorry. Let him go, yeah, okay, yeah, sure. Yeah, gentlemen, the amendment is mostly distributed, and those who haven't gotten it yet are willing to see the conversation start, so the gentleman's recognized.
I don't want to deprive anyone from having an opportunity to read it from cover to cover before we get started. Thank you, Mr. Chairman. Both during yesterday's hearing and today's markup, I've raised concerns that I've heard from my constituents and stakeholders on this issue of trade regarding the investor-state dispute settlements. And as I said, I share those concerns, concerns about safeguarding our federal, our state, and our local practices. As I mentioned, my state of California has some very progressive and innovative laws that protect our environment as well as workers' health and safety. The amendment that I'm offering today would require that all trade deals negotiated by the administration safeguard labor, environment, and public health laws and practices. Under this amendment, all negotiated trade deals would have to include provisions prohibiting foreign governments and companies from suing the United States on the grounds that our labor, our environment, or public health laws constitute unfair trade barriers. So, for example, under this amendment, a foreign government or a foreign company could not sue the United States by claiming California's clean air and water standards or our workers' safety protections constitute an unfair trade barrier. As was pointed out in one of the earlier amendments, it's just wrong to grant greater rights to foreign countries and foreign companies than we grant to our U.S. Citizens. In California and many other states, we've gone to great lengths to protect our environment and to safeguard the hardworking men and women in regard to their health and safety. Congress should not pass legislation that would allow these laws to be undermined or international trade tribunals. So I urge support of this amendment, and thank you for your support.
Gentleman from Minnesota, does he seek time?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, just real quick, I mean, this is similar to some of the other ISDS amendments, and I understand the objectives that Mr. Thompson is laying out. Now, some of these objectives are already covered in other aspects of the negotiating objectives that are laid out in TPA. But again, knowing that the ISDS provisions have already been a carefully crafted, negotiated compromise, House and Senate Democrats, I think just putting this provision in there, it goes further than the compromise, and it's going to unravel that balance that's already been struck, and I would oppose the amendment.
Gentleman's recognized for the purpose of closing. I'm sorry.
Clarifying
It's getting ahead of myself there. Mr. Blumenauer.
Mr. F., could I ask just a question of you, because we've gone over this repeatedly with USTR. My understanding is that within the framework of TPA, it is explicit that investor state cannot be used to undermine established government policies. Am I misinterpreting? I thought I heard Mr. Paulson say that. I'd like you to just clarify, because I thought I'd heard representations repeatedly about the protections that are in there already that have been negotiated.
Mr. Blumenauer, that's correct. There are protections in the TPP and in the ISDS that specifically create a zone of safety, a safe harbor for regulation in the public interest. And it goes beyond just labor and environment. It covers anything, again, it's any legitimate public welfare objective. That's the scope of the provision.
And obviously, I mean, you have it there, that's how things will be determined. Nothing stops anybody from bringing a case. They can bring a case the same way people can sue at a drop of a hat. And we have hundreds of thousands of suits, and foreign corporations file them all the time and can do so at will. Just because they can file suits or try and wear people down, we don't prohibit them from filing lawsuits. And so, I mean, I wanted to have that clarified, that this is something that actually has been addressed in the efforts of trying to refine and clarify what investor-state dispute mechanisms are focused on in this agreement.
The gentleman yield on that point?
I would be happy to yield to my friend.
Just to be more explicit, and Ms. Ellard, Mr. Wright, you can jump in here if you want, but on page 100 of the underlying text, unless I'm reading something wrong, and I think my friend from California should feel reassured by this provision, but it explicitly protects U.S., state, and local sovereignty under that clause. And I quote, "No provision of any trade agreement entered into, nor the application of any such provision to any person or circumstance that is inconsistent with any law of the United States, any state of the United States, or any locality of the United States shall have any effect." And then it goes even further by explicitly saying no provision of any trade agreement can prevent us, any state of the United States, any locality, from amending or modifying our own laws. So that is explicit in the base of the underlying text. Unless I'm misinterpreting something here, that's how I read that provision.
That's correct, Mr. Kine. And in addition, I would point to page 4, lines 9 through 13, with respect to the overall negotiating objectives, noting to take into account other legitimate U.S. domestic objectives, including but not limited to the protection of legitimate health or safety, essential security, and consumer interests, and the law and regulations related thereto.
Yeah, so I think not only does it address Mr. Thompson's concern, but all the ISDS amendments that apparently are being offered here, that this is explicitly protected in the base of the legislation. I thank my friend for yielding.
Well, reclaiming my time, I appreciate your going to the text. I think it's important here to note that it is already covered, but putting in something that is redundant and unnecessary, not only, as my friend from Minnesota pointed out, starts messing with the work that's been done to be able to have something that's balanced and understood, but it starts raising questions. As it stands now, all of this stuff is unnecessary. It's covered. But if you start carving out an exemption somehow for Medicare or somehow for something else, I mean, we could be here all night dealing with the parade of horribles, and maybe we approve one or two. If you approve one or two of those, it raises questions about whether the underlying language, which affords the protection, really means what it means. And I think more ambiguity does not help us settle the question. So I respect my friends. I don't want to see goofy things happen. I don't like goofy lawsuits filed, but sometimes they are. But not only is there a risk of unsettling the balance, but it will raise more questions if you start rifle-shotting things. It raises questions about whether the text means what it means. I think the text means what it means, and we're better off and on firmer ground allowing it to stand. I thank you, and I yield back.
Gentleman's time has expired.
Mr. Chairman, I move to strike the last word.
Who said that?
I did.
Oh, Mr. Doggett?
Yes.
Doggett's recognized.
The text does say exactly what it says. It protects sovereignty. It protects the rights of these cities, the counties, the Congress to act. There's no doubt about that. But it does not protect us from paying for exercising that sovereignty. That's the point that doesn't seem to be getting through to some of our colleagues. It is the penalty that exists in Canada for this expansion of the facility there. They can exercise their sovereignty. It just may cost them $200 million to exercise it. And who will be paying those penalties? The taxpayers. It may be the taxpayers of the city, of a state, are of the United States. It is an unfair burden on taxpayers. And as to whether or not this has a balance and is all resolved, the history is very different. Mr. Levin had a number of reasonable reforms to the investor dispute system. He has a lot more confidence in it, frankly, than I do. But he proposed a number of reforms, and the response from the U.S. Trade Ambassador was, it's closed. They didn't want to hear about any of those reforms. There was no balance whatsoever. As to the further claim that, don't worry, there have been practically none of these suits, what that ignores, I would tell my colleague from Ohio, is that with the success that you hope to have with this agreement, the 40% of international commerce, you are adding literally tens of thousands of different plaintiffs and their plaintiff attorneys to challenge anything they don't happen to like and to enjoy rights that American investors do not have, to challenge whether it is Medicare Advantage or a health care system that doesn't like the Medicare system, whether it is a company that wants to put in a foreign landfill in property that they own in Central Texas, or whether it is a decision of the state of California with reference to tobacco or with reference to, I guess that would be probably a federal decision under the current administration, but with reference to its environment and having heightened environmental standards to protect the coast and the environmentally sensitive areas there.
Will the gentleman yield?
I yield.
I would, again, emphasize not only with what Ms. Ellard said, or what Ambassador Froman has said, what Mr. Reif has said, but if you look at the text on pages 12 and 13 and 14, it continues to go at great lengths recognizing United States law and recognizing that.
I'll reclaim my time. I've looked at those pages, and I thank the gentleman. It does not provide any protection to the taxpayers from having to pay for the exercise of that right to pass that law or that ordinance. And you are opening the way for tens of thousands of additional foreign investors under this agreement to come in and challenge those decisions, and to do it not in a United States court, not in the system of justice that all the rest of us rely on, but in front of three arbitrators that may one day be bringing their own case and are concerned about the effect of their decision on their future case. One day they're judges, the next year, the next month, they are the person bringing the plaintiff's case. The taxpayers of the United States, not just the environment, not just of those of us who are concerned about health and safety, the taxpayers of the United States and of various jurisdictions within our country are the ones who will suffer from the decision that's being made here. And I would just close with this. Frankly, I think Mr. Thompson's amendment is incredibly modest. He does not change the investor dispute system, which I question. Let me just read you the amendment in its entirety. He adds mechanisms to safeguard the role of governments in developing and maintaining labor, environment, and public health laws and practices. That's the entire amendment. He just adds that as a negotiation objective, and the unwillingness to accept even such a modest amendment that USTR probably wouldn't follow anyway strikes me as an indication of what a significant split we have over not the personalities but the substance of this issue, whether we can have trade and expand and create more good jobs and expand economic opportunity, at the same time protect local decision-making and states' rights and health and safety. I believe there's a way to do that, but this fast-track agreement is not the way to accomplish it. I yield back.
Gentleman yields back. Mr. Levin, do you seek to strike the last word? I see your mic is on.
Yeah, just briefly. You read language. The reason Mr. Thompson's amendment is in order, you can't say that under the present language, no investor from another country can sue in an arbitration panel in the United States rather than the courts with our rule of law. You can't say that because they can. The question is whether there are adequate safeguards. That's the issue. And what we're saying is there aren't. And that has been shown in cases brought in Australia, brought in Canada. You can argue about the decision, but it is undeniable that under ISDS, investors can bring cases in countries like ours with the adequate rule of law, instead not going through the courts, but going to an arbitration panel. And what we're trying to do is to establish a structure. We have suggested 4 of them, including preamble that we have had before, that no foreign investor should have greater rights than someone in this country. And USTR has refused to try to negotiate that kind of language. So I think those who object to any further clarification and improvement are in a state of denial, and if I might say so, are adding ammunition to those who oppose TPP and TPA, perhaps any TPA, which isn't true of many of the critics. This is an issue, and denial is not an adequate answer. What Mr. Thompson is doing, he comes from a state which has been in the vanguard pioneering some additional rules and regulations regarding safety, regarding health, etc. And he wants to be sure that there cannot be challenges to those through an arbitrator when there's an adequate rule of law. That's what he's asking. And he wants a further safeguard. And so essentially what we've had so far, I must say, is stonewalling. Stonewalling. And that we need to break through that stonewall. That's what we're trying to do. As part of our effort to shape a TPP that we can support. I yield back.
I'll withhold. Gentleman is recognized for the purpose of closing.
Thank you, Mr. Chairman. I want to thank everyone who spoke in favor of the amendment. And Mr. Levin said that I'm from a state on that's in the vanguard of change and progressive policy. I'm also from a state that benefits greatly from trade. And I want very much to see a trade bill that will continue to provide opportunities for not only my district, but every state in the nation to build upon our trade successes, because that is important. We do need to pass trade legislation. We do need to provide opportunities to grow our economy, to grow the exports that come out of this country, and send them to the markets that are out there. We've all been to the different countries where that will benefit from a trade bill that will allow us to export more, and our constituents will all benefit from that. But we need a trade bill that also recognizes the importance of protecting our workers and our environment and our health and safety that we make a priority here in this country. And that's all that this amendment does. As pointed out, it's very succinct. It's a very narrow shot at trying to make sure that we can take the generalities that are in the underlying bill that deal with sovereignty and pinpoint the specifics that will make sure that we can protect the great work that's been done, not only in my state, but in all the states across the country. When our local elected officials and our local legislators work to improve conditions for workers and the environment at home, the last thing that we need to do is provide an opening whereby they can be challenged as having created an unfair trade barrier. And that's all we're trying to do. We know we're not going to change the law. The law will stand. And it will apply to anybody in our districts that's trying to do business. It'll apply to anybody in the country that's trying to do business. But just by allowing foreign companies or foreign governments to use that unfair, what they would call an unfair trade barrier, I think is inappropriate. It disadvantages our own citizens, and this is a very modest attempt to narrow in on the provision and provide protection for not only our folks here who are doing the exporting, but also for the people that we represent. And I would appreciate your support in passing this amendment. I yield back.
Gentleman yields back balance of his time. The gentleman from Ohio is
Chairman,
recognized.
Before I make a motion, I'd just like to point out on page 12, line 15, I'll quote, recognizing that the United States law on the whole provides a high level of protection for investment consistent with or greater than the level required by international law, the principal negotiating objectives of the United States regarding foreign investment are to reduce or eliminate artificial or trade distorting barriers to foreign investment, while ensuring that foreign investors in the United States are not accorded greater substantive rights with respect to investment protection than United States investors in the U.S. With that, Mr. Chairman, I withdraw the reservation of point of order.
Reservation of the point of order is withdrawn. The question is on adoption of the amendment offered by the gentleman from California, Mr. Thompson. All those in favor signify by saying aye. Aye. Those opposed, no. No. Opinion of the chair, the noes have it. Hands? Okay. Recorded vote is requested. The clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Nunez? No. Mr. Nunez, no. Mr. Teaberry? Mr. Teaberry, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? Mr. Roscom, no. Mr. Price? Mr. Price, no. Mr. Buchanan? Mr. Buchanan, no. Mr. Smith of Nebraska? Ms. Jenkins? No. Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Mr. Marchant, no. Ms. Black? Ms. Black, no. Mr. Reed? Mr. Reed, no. Mr. Young? Mr. Young, no. Mr. Kelly? Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? Mr. Meehan, no. Ms. Nome? Ms. Nome, no. Mr. Holding? Mr. Holding, no. Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. Rangel, aye. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, aye. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer? Mr. Blumenauer, no. Mr. Kind? Mr. Kind, no. Mr. Pascrell? Mr. Pascrell, aye. Mr. Crowley? Mr. Crowley, aye. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Mr. Brady? Mr. Brady, no. Mr. Smith of Nebraska? No. Mr. Smith, no. Chairman Ryan?
No.
Chairman Ryan, no.
Clerk will call the roll, or report the roll, excuse me.
13 yeas, 25 nays.
There being 13 ayes and 25 nays, the amendment is not agreed to. Are there any further amendments? Mr. Doggett.
This would be the transparency.
Okay, gentleman will suspend while the
Mr.
clerk
Chairman?
distributes. Gentleman from Ohio.
Mr. Chairman, I reserve a point of order.
Gentleman reserves a point of order. Everybody okay if we start talking about the amendment while it's distributed? All right, but gentleman's recognized.
Thank you so much, Mr. Chairman. I drafted this amendment because I believe that open trade begins with more open access to trade documents, and that USTR really thrives on secrecy. They've opposed proposals from our trading partners for greater openness and have denied Congress full access to information already available to foreign governments. The amendment does not deal with all of the issues concerning access, but it does deal with some specific problems that we've encountered in recent months of trying to get access to these documents. Simply putting a stamp on the documents that they're confidential, keep them in your file cabinet, transmit them over your fax or with electronic, has been enough to keep these documents secreted from our staff, even staff with top security clearance. And this measure simply seeks to make the information available consistent with whatever the security classification is on the document. If it is top secret, then only those with top secret. But if it's merely confidential and it's being shared with anyone the trade ambassador thinks will be helpful to him in achieving his objectives and not shared to others, then I'd like to put a stop to that. I remember a time not very long ago in this committee, I think it was about 50 votes on repealing Obamacare ago, maybe a few more, give or take half a dozen, that I used to hear from people about the need to read the bill. Well, I'm interested in the ability in this very complex trade agreement of the ability to read, study, question for me and for my staff and for other members of Congress, the documents that are there. And it is not only the final document, like some of those that have had significant changes in negotiation, but it is information submitted to foreign governments. The Vietnamese Politburo knows more about some aspects of these trade negotiations than the people sitting at this dais. And I think we ought to have the same amount of access that they do to these documents. This piece of legislation refers to accountability and transparency, but I don't think it accords much because it leaves the same kind of terms such as appropriate that the U.S. Trade Representative apparently relies on now. He's been unable, and the Council today has been unable, to cite any legal basis for the restriction of access of members of Congress to these documents. Simply creating a chief transparency officer, as the legislation does, will not assure broader transparency. The problem isn't lack of bureaucrats. The problem is a lack of a willingness to share this information at a time that a member of Congress can look at it, study it, and understand how the United States position has changed. So I would urge adoption of the amendment and yield back the balance of my time.
Mr. Chairman.
Mr. Tiberry
last
is
word.
recognized.
Thank
Mr.
you.
Tiberry is recognized for 5 minutes.
Mr. Chairman, this TPA has the greatest transparency ever of any TPA agreement. And let me be, again, not the first Republican to defend not only the Obama administration, but the U.S. Trade Representative for his openness. This bill establishes for the first time in law, that the text of a completed trade agreement must be public for at least 60 days before the President signs the agreement. It's unbelievable. I wish the health care bill that applies to me was made public for 48 hours before it was voted on. Ladies and gentlemen, this is a huge step forward. I'd like to ask Mr. Reif if he'd like to add anything or has any concerns with respect to the amendment.
Thank you, Mr. Tiberry. And thank you, Mr. Dogger, for the amendment. The TPA bill that is the underlying bill today is the most transparent, will call for the greatest degree of transparency of any TPA bill since 1974, when the Congress and the executive began to work under these types of procedures. And we continue, Mr. Dogger, we continue to try to improve on these. I'm sure there are areas where we're probably not doing as well as we could, but every single week, every single month, we are doing more. So just in the last several weeks, new procedures were announced to provide members greater degree access, staff with members, for the full negotiating text that's out with attribution of individuals. So I would say that's my first point. My second point, you've asked a number of times what the basis for classification is. There is a 2009 executive order the President signed that covers classification in the executive branch, and the classification procedures that USTR operates under derive from and are based in that executive order. So there's a legal basis. The documents that we negotiate off of are classified. They are classified under a term noted as modified handling, and the procedures are established for handling those documents. The procedures, sir, that are established up here are typically set by the Sergeant at Arms, by the security office here, and the security office that applies for procedures in the Senate. Whenever we can, let me perhaps come to first principles. Our core goal as an entity representing the President, as an entity representing the United States overseas, is to negotiate the best agreement we possibly can. The working people, for the businesses, the farmers, and the ranchers in the United States. We are dealing with foreign governments, and so security procedures have to be established with respect to that. And so we have. We do that with the greatest degree of possible transparency, obviously with members of Congress who have the greatest access of any of the entities that we are called upon by statute, created by the Congress. But members of Congress, such as yourself, have the greatest degree of access to all the information that we operate under. So yes, Mr. Tiberi, this is the most transparent TPA that has been presented to this committee or to the Congress. And on top of that, we are working every week. We're trying to respond to the concerns that members like Mr. Doggett and others have raised with us to try to ensure that we have the greatest degree of access so that we understand what the positions are, the concerns, the interests represented by the Congress, so we can negotiate the best deal for the American public.
Thanks for your work. I yield back.
Great. Mr. Blumenauer.
As I listened to my colleague from Texas with his amendment, I recall the crusade that he and Sam Johnson were on to try and make sure that the Medicare card didn't have Social Security numbers. And the committee, Mr. Doggett, Mr. Johnson, were focused on that for years and years. And I'm feeling, as I'm hearing this exchange, I feel the same sense. Because I remember in our informal meetings with the U.S. Trade Rep, Mr. Doggett being there, a number of us echoed that sentiment, that we were overclassifying, that there was too much information that wasn't available to us, with the ability to have somebody working with us who spends more time doing the deep dive than we're able to do, to work with us. And slowly but surely, we're incrementally getting, I think, some modest adjustment. But I have been, I must say, I share Mr. Doggett's frustration. Yes, this is the most open TPA, but you're talking past each other. I mean, we have had security briefings where we check our iPhones and our electronics at the door, where, as near as I can tell, about 98% of the information that is available, presented, is stuff that's readily available. And I think it is a disservice to the process to be overly restrictive. It raises questions where there shouldn't be questions. It makes it harder for the committee to do its job. And I would hope that we are favorably oriented towards what our colleague from Texas has advanced. I think it benefits all of us. I don't think there's any downside. The notion of having the classification commensurate with what the classification is of the information that is being disseminated, I think that's just common sense. And I would hope that we can take this into a different era of where we're not overclassifying, we're not making it hard for Congress to operate. We don't have to keep having this conversation with subsequent administrations. So it's like the Doggett-Johnson crusade to get the Social Security number off the Medicare card. This seems to me to be something that every member of this committee can identify with. Nobody is harmed, everybody is helped, and I think it raises confidence in a process that needs to have confidence raised. So I'm hopeful this might be one of the things that we could embrace and march forward. Thank you, and I yield back. Yeah.
Mr. Chairman?
Mr. Tiberi.
I'd like to withdraw the reservation point of order.
Gentleman withdraws point of order. Would the gentleman like to close?
Well, I think I take Mr. Blumenauer's remarks as an endorsement of the amendment, and I just want to point out that it does only three things. One, it says don't put a classification on here that is higher for members of Congress than everyone else. I agree with him fully that 98% of these classified briefings haven't had any classified materials. A stamp has been put on this document to obstruct congressional access. Getting any access has been like pulling teeth and more from USTR. The second thing that it does is to say if you're giving out this information to the Vietnamese Politburo or another government, members of Congress ought to be able to access, not just members of this committee, but members of Congress ought to know what that position is. And finally, because USTR, to the extent that this is the most open ever, suggests how closed this process has been. This is not about private Social Security or private health records. It's about public policy and the implications of what happens here, hopefully for good in stimulating economic activity, but the potential perils of what happens here concern every American. And our elected representatives ought to be able to have access to those documents. Trying to change the culture of secrecy at USTR is a challenge, and the general language that is included as the third provision says, consistent with effective negotiations, the United States trade representatives shall encourage maximum accessibility to trade texts, the proposals made by the United States and other trading partners, something USTR has refused to provide. The policy is to make negotiations as open as possible and to identify major issues that are the subject of negotiations. A number of our trading partners in Europe have actually put their text up on the web so that citizens can see them. The Bush administration, when it was considering a trade agreement in earlier years, did the same thing. This is not a radical approach. It may be radical for USTR that has become so comfortable with secrecy, but it does these three reasonable things to ensure that our decisions are informed. The bill itself is only designed to give USTR a statutory basis that it lacks now for taking this action. We don't need to expand the bureaucracy by adding a new transparency officer, which this bill does. We instead should simply try to inspire USTR to open the process up a bit, engage people with more than just pep rally meetings, and give us the facts to be able to see whether the book matches the cover. And I believe that this amendment would accomplish that. I appreciate Mr. Blumenauer's endorsement of it, and I move its adoption.
Gentleman yields back the balance of his time. The question is on the amendment offered by the gentleman from Texas, Mr. Doggett. All those in favor signify by saying aye. Aye. Those opposed, no. Nope. Been the chair of the noes have it. Gentleman asks for a roll call vote. The clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Brady, no. Mr. Nunes? No. Mr. Nunes, no. Mr. Tiberi? Mr. Tiberi, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? No. Mr. Roscom, no. Mr. Price? Mr. Buchanan? Mr. Buchanan, no. Mr. Smith of Nebraska? No. Mr. Smith, no. Ms. Jenkins? Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Mr. Marchant, no. Ms. Black? Ms. Black, no. Mr. Reed? No. Mr. Reed, no. Mr. Young? Mr. Young, no. Mr. Kelly? Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? Mr. Meehan, no. Mrs. Nome? No. Ms. Nome, no. Mr. Holding? Mr. Holding, no. Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. Rangel, aye. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, aye. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer? Mr. Blumenauer, aye. Mr. Kind? Mr. Kind, aye. Mr. Pascrell? Mr. Pascrell, yes. Mr. Crowley? Mr. Crowley, aye. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Mr. Price? Chairman Ryan? No. Chairman Ryan, no.
The clerk will report the vote.
15 yeas, 22 nays.
There being 15 ayes and 22 nays, the amendment is not agreed to. Are there any further amendments?
I've got one more. Surely this is a winner.
Thank
Thank you, Mr. Chairman.
Gentleman from Texas is recognized.
Mr. Chairman.
Clerk will distribute, and let's have you discuss it while they distribute. Is everybody okay with that? All
That's
right, great.
fine,
Go for it.
Mr. Chairman.
Gentleman's recognized.
Mr. Chairman.
Oh,
Mr. Reich.
my bad. Oh,
I reserve a point of order.
thank you. I was used to the Ohio voice.
This is.
Mr. Chairman. Just point of order is reserved. Mr. Doggett is recognized.
Thank you, Mr. Chairman. Thank you, Mr. Reichert. This is a very narrow amendment. In 2007, an agreement that we've talked about often today, the May 10th agreement, was reached largely between Mr. Levin, his efforts with Peru concerning environmental and labor provisions. This concerns only one portion of those environmental provisions. That agreement dealt with the question of what do you do if you have a trade agreement, but these countries have already agreed to a multilateral environmental agreement, specifically trade in endangered species, the ozone treaty, called Montreal Protocol, marine pollution, the Tuna Convention, the Wetlands Convention, the regulation of whaling, and Antarctic marine living resources. Fairly weak agreements, but multilateral agreements that we're committed to and those other countries are committed to. The language of that agreement said that we will see that those matters that they've agreed to are implemented by the country and or enforced. And this uses the same language verbatim that was in that agreement and provides for it here. I have studied the environmental chapter of this proposed TPP. I don't think it matches its cover, and this amendment is simply designed to ensure not to change anything that the Bush administration agreed to on multilateral agreements, not to add to it or to subtract from it, but to simply use the same language and ensure that we achieve what the administration has said that's going to have the strongest environmental protections ever. I just want to ensure that we don't have less than what the Bush administration agreed to in 2007 on this matter, and I yield back.
Mr. Chairman, I move to strike the last word.
Gentleman from Louisiana is recognized.
I just want to address the gentleman's amendment, and I oppose it. TPA was negotiated to carefully track the bipartisan May 10th consensus that's reflected in Peru, Colombia, Korea, and the Panama agreements, as the gentleman stated. These provisions require very effective enforcement of environmental laws and prohibit trading partners from waiving or derogating from our environmental laws in a manner affecting trade or investment. TPA ensures that environmental obligations are subject to the same dispute settlement remedies as every other obligation. And because the amendment does not track the bipartisan compromise, I oppose the amendment. But furthermore, this amendment would force countries to join multilateral environmental agreements that they may not be wanting to join. That goes far beyond the May 10th agreement. Our negotiating partners might, in fact, seek to force the United States to join certain multilateral environmental agreements that we're not party to as of now. And so for those reasons, I oppose the gentleman's amendment. And I yield back.
Gentleman yields back balance of his time. Gentleman.
Oh, no,
I think.
Go ahead.
The gentleman from Michigan would like to strike the last word. Gentleman's recognized.
yield as you
I
begin.
agree.
On the last point that Mr. Bustamante, I know, made in good faith, if you read the amendment, it does not open us up to any future multilateral agreements. It deals solely with the same 7 that the Bush administration agreed to. It does not increase our obligations at all. It uses verbatim that language that Republicans agreed to. Because my concern from reading this agreement is that the Obama administration is weakening the commitment to what the Bush administration agreed to. I thought we set a floor, but they've gone below the floor despite their claims, and I want to provide the protection that we got from the Bush administration.
All right, so I need to state this carefully because some of the text is not able to be discussed in public, which is part of the problem. All the environmental text that's being negotiated, in my judgment, should be able to be seen by the public now. So I'm waiting. There was one leaked document that I can refer to, I guess, and I'm waiting to see it. But in several instances relating to the 7 agreements in May 10th, the language is not shall, but is much weaker than that. And that's why in our substitute, we make it clear that that shall not happen. It reads, instructs the President to ensure a level of environmental protection at least as high as the level provided under the May 10th agreement. It also recognizes the need to replace weak commitments with strong ones, such as prohibiting imports of illegally harvested wildlife products. The problem is the language now doesn't use that term. Under the restrictions, I guess I can't say what language it uses. And I mean, it's classified. And by the way, our staff wasn't able, when we were gone, to see the text without us, even if they had security clearance. So I just want to be sure that I can read this? This is the leaked text. Okay, this is the leaked text. Accordingly, each party shall seek to operate a fisheries management system that regulates marine wild capture fishing and that is designed to prevent overfishing and overcapacity. So the language used there, shall seek to operate, is unenforceable. It's, in a sense, meaningless. It's not meaningful, it's meaningless. So I can only quote this because it was leaked. And I think it's important to adopt Mr. Doggett's amendment as a clear instruction, the kind of instruction that we have in our substitute. So I need to stop there, Mr. Chairman, because the rest of the discussion I would like to have is classified it's needlessly, in my judgment. We should really have an open discussion with the public about key issues like this, and I'll close with this. To say the public is going to see it after it's done, that's what your bill says. It says lots of days, but after the deal is finished, and essentially we're left, and the public is left, with simply saying yes or no. And we need to do better than that. I yield back.
Gentleman yields back. I'll take just a second. I try to withhold because I want to get things moving. As the gentleman knows, there is a very carefully crafted, bipartisan, bicameral agreement that we are presenting here, that we're defending here, and that we're trying to keep this agreement intact. That's point number one. Point number two, and that's really a statement for all of these amendments. Point number two is I guess there's just a difference of opinion on what's the best process. We can't unilaterally here write trade agreements. You know, there are other people we're trading with. So other countries also have a say-so. And so there's just a point to where, and it is an eye of the beholder judgment call, but there's a point to where we can go too far to dictate what a trade agreement is to the point where we can't get a trade agreement. And that is why this carefully crafted, bipartisan, bicameral, unprecedented access and transparency and accountability and guidance-seeking TPA bill is drafted the way it is, and this administration, a Democratic administration, is endeavoring to get us an agreement, and if you don't like the agreement, vote against the agreement when the agreement comes through. So we in Congress have the final say. So I'll just leave it at that, go on, and I'd like to recognize Mr. Doggett for the purpose of closing on his amendment.
Thank you, Mr. Chairman, and I certainly respect the point of view that you just voiced. I think it's really appropriate that we were able to consider both of these amendments together. The notion that this committee, charged with this important responsibility that affects so many American families, would be restricted in being able to discuss a chapter of this trade agreement because Mr. Froman exercises the whim of stamping confidential. There's nothing in the statute that he referred to that refers to trade agreements at all. Yeah, there's some authority that people can do classification. He has no basis for that stamp. He puts confidential on it to prevent a free and open discussion of that provision, to prevent your staff from being able to look at and read that over the Easter recess, which we just tried to do and were denied the opportunity for them to do it. No basis for that confidentiality at all. So it restricts this discussion. So I'll honor what I think is a truly phony classification system applied here with no justification whatsoever. And I won't talk about what's in the agreement. I'll talk about what I believe is not in it. I believe that this language that President Bush agreed to, that this committee approved, that you adopt, maintain, and implement these 7 provisions that these are agreements that we've agreed to and that other countries have agreed to, and only these 7 provisions, that we do that we maintain that standard. And this administration, I think, would be willing to accept, try hard, do your best, give it your, every shot to try to do this, but, things happen. It's a tough world out there, and, maybe whaling is a little more popular in Japan than it is in the United States. This whole agreement leaves open the question, well, what happens if Peru agreed to the Bush standard, and now we're going to have another agreement to the lower, less protective environmental standard that this administration says is the strongest possible, but when you read the document, it clearly is not. We don't have a way in this agreement to date, as I see it, as to how those conflicts will be resolved. I believe sticking with the strong language that we have there already, limited to these agreements. I'd like to do more, but all this amendment does is to say adopt, maintain, and implement the agreements that Peru and the other countries that were involved in May 10th said they would do. They haven't done it. USTR has not perhaps done a good job of enforcing it, but let's at least have the language there and have some consistency there, and then let's over time, and I know the chairman has had some interest in opening this process too, let's open this process up more. There's no reason that we have to wait to see what the administration has done and whether it has led up, whether it has fulfilled its commitment and its promises and its pep rally talk, or whether in fact the environmental chapter deviates from that and is weaker and is a step backward from May 10th. So I would urge adoption of the narrow amendment dealing with these 7 multilateral agreements to use the precise wording that we are currently committed to under the agreement signed by President Bush, and I yield back.
Gentleman yields back the balance of his time. The gentleman from Washington is recognized.
Mr. Chairman, I withdraw the reservation of a point of order.
Point of order is withdrawn. The question is on agreeing to the amendment offered by the gentleman from Texas, Mr. Doggett. All those in favor signify by saying aye. Those opposed, no. No. In opinion of the chair, the noes have it. Gentleman's asking for a roll call vote. The clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Brady, no. Mr. Nunez? No. Mr. Nunez, no. Mr. Teaberry? Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? Mr. Roscom, no. Mr. Price? Mr. Buchanan? Mr. Buchanan, no. Mr. Smith of Nebraska? No. Mr. Smith, no. Ms. Jenkins? Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Mr. Marchant, no. Ms. Black? Ms. Black, no. Mr. Reed? Mr. Reed, no. Mr. Young? Mr. Young, no. Mr. Kelly? Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? Mr. Meehan, no. Ms. Nome? Ms. Nome, no. Mr. Holding? Mr. Holding, no. Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. Rangel, aye. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, aye. Mr. Neal? Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer? Mr. Blumenauer, aye. Mr. Kind? Mr. Kind, aye. Mr. Pascrell? Mr. Pascrell, aye. Mr. Crowley? Mr. Crowley, aye. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Mr. Teaberry? Mr. Teaberry, no. Mr. Price? Mr. Neal? Mr. Neal, aye. Chairman Ryan?
No.
Chairman Ryan, no.
That's your phone? It's a big phone. The clerk will report the vote.
15 yeas, 22 nays.
There being 15 ayes, 22 nays, the amendment is not agreed to. Are there any other amendments? Mr. Thompson is recognized.
Thank you, Mr. Chairman. I have an amendment at the desk.
Gentleman's amendment at the desk. Gentleman from Ohio.
Thank you, Mr. Chairman. I'd like to reserve a point of order.
Point of order is reserved. While copies are being distributed, the gentleman will be recognized for
Fine with
purposes
that.
of describing
Thank
his
you,
amendment.
Mr. Chairman. As we all know, climate change is one of the biggest challenges faced in our country and the world today. It affects every one of our districts and every one of our communities. Sea level rise, global temperature rise, warming oceans, growing number of extreme weather events, increase invasive species, and boil it down and look at just, the state-by-state issue. If it's a multi-year drought in California, if it's huge hurricanes and tornadoes along the eastern shoreboard, these are tragic events that disrupt all of our communities and harm us both personally, physically, and economically. And a good trade deal has the potential to address this in a serious way. It could put strong, scientifically sound environmental protections in place by which countries who are part of a good trade deal would have to abide. This would greatly enhance our global effort to combat climate change, and my amendment would require that any trade deal negotiated by the administration recognize the serious and growing issue of global climate change and promote international collaboration and cooperation to mitigate and address its impacts. We can't continue to stick our heads in the sand and go on with policies that are destroying our planet and our economy at the same time. This is an important amendment on an issue with broad support throughout our country and around the world. I just got back from a trade national security CODEL over the break. There's another member of this committee was on it. And we met with foreign leaders, either the prime minister or the president in each of the 5 countries we were in: Cambodia, Vietnam, Burma, Korea, and Japan. We raised the issue of climate change and the need to make sure that our trade agreements recognize the importance of dealing with this. We got no pushback from anyone. There's nobody in the trading partner category that is concerned about this. Everybody recognizes it's an issue, and it's an issue we should be dealing with, and I don't think there should be any pushback here as well. If we want to approve a truly breakthrough trade deal for a modern era, we shouldn't exclude climate change from the discussion. So I ask for your support of this important issue, and I retain the balance of my time.
Mr. Brady's recognized.
Thank you. I respect Mr. Thompson's strongly held views about climate change, global warming, and environmental issues. TPA is about finding common ground. We have on environmental issues, as Dr. Bastani pointed out, the May 10th consensus that really pulls together Republicans and Democrats on a wide variety of environmental issues, and that have served us well in agreements such as Peru, Colombia, Korea, and Panama. This provision requires the inclusion of climate change, global warming obligations, something that goes well beyond the May 10th consensus. It is domestically very controversial. There isn't common ground either among lawmakers in Congress, regions in the country, even states and cities within them have disagreement. And finally, there are serious questions as to whether the United States would be in compliance with this negotiating objective itself. So it is tough to ask other trading partners to agree in an area where we have no agreement ourselves. And because this amendment doesn't track the bipartisan compromise, I respect and respectfully oppose the amendment. I yield back, Mr. Chairman.
Thank you. Gentleman's recognized for purpose of closing on his amendment.
Thank you, Mr. Chairman. I just want to point out that there may be some who haven't come to grips with the scientific facts, but it's pretty hard to argue that climate change isn't real. We see it every day in our district, in our lives. We spend about $22 billion a year, the federal government, dealing with this issue. I mentioned the congressional delegation trip we took to these 5 countries. We started in PAC Command, and we heard from the military leaders of our country that deal with the Southeast Asia area. Every branch of the military and our intelligence community is working on the issue of climate change. They know that when you see oceans rising, you displace populations, that creates wars. When drinking water sources go away, it displaces population. That creates wars. This is something that's bigger than the 2 or 3 or a handful of people who don't agree with the science. This is something that has overreaching fiscal and very serious international impact. And I think we're going to be really short-sighted if we don't ensure that we use this trade agreement to raise this issue and try and figure out how it is that we can put forward policies that mitigate, not exacerbate, the issue of climate change. And I yield to Mr. Doggett.
Well, I appreciate your offering the amendment. You're dealing with the most significant environmental and health issue of our time, and really economic issue, because it's going to have severe impact on the economy of so many parts of our country and of the world, and it's a national security issue. And I think if we were able to see all of the information that I've been attempting to get but have been unsuccessful in getting from USTR, we would find out that USTR has abandoned climate change and global warming and achieving it in this agreement, and that indeed some of our trading partners have urged that we do the very type of thing that you're talking about in this amendment, because the rest of the world doesn't have its head buried in the sand. Much of the rest of the world recognizes the severity of this problem and the opportunity we have here to address it in this bill. And so I commend and support your amendment, and I regret that USTR does not have similar enthusiasm for addressing the most critical environmental issue of our time.
Thank you. Yield back.
Gentleman yields back balance of his time. Gentleman from
I
Ohio.
withdraw the reservation point of order.
Reservation point of order is withdrawn. The question is on agreeing to the amendment offered by the gentleman from California, Mr. Thompson. Those in favor signify by saying aye. Those opposed signify by saying no. No. In the opinion of the chair, the noes have it. Gentleman asks for a recorded vote. The clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Brady, no. Mr. Nunez? Mr. Nunez, no. Mr. Teaberry? Mr. Teaberry, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? Mr. Roscom, no. Mr. Price? Mr. Buchanan? Mr. Buchanan, no. Mr. Smith of Nebraska? No. Mr. Smith, no. Ms. Jenkins? Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Mr. Marchant, no. Ms. Black? Ms. Black, no. Mr. Reed? Mr. Reed, no. Mr. Young? Mr. Young, no. Mr. Kelly? Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? No. Mr. Meehan, no. Ms. Nome? No. Ms. Nome, no. Mr. Holding? No. Mr. Holding, no. Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. Rangel, aye. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, aye. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer? Mr. Blumenauer, aye. Mr. Kind? Mr. Kind, aye. Mr. Pascrell? Mr. Pascrell, aye. Mr. Crowley? Mr. Crowley, aye. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Mr. Price? Chairman Ryan?
No.
Chairman Ryan, no.
The clerk will report the vote.
15 yeas, 22 nays.
15 yeas and 23 nays.
No, 22, sir.
22, I'm sorry. 15 ayes and 22 nays. The amendment is not agreed to. Any other amendments? Mr. McDermott.
Mr. Chairman, I got an amendment at the desk.
Gentleman's got an amendment at the desk. Mr. Teaberry. Gentleman reserves point of order. While the amendment's being distributed, the gentleman's recognized to describe his amendment.
Mr. Chairman, this is a rare day, and I think everyone should take note of it. We passed the SGR on a bipartisan basis, and now we've got a bill before us that we're going to give the president exactly what he wants. The Republican Party have never given the president what he wanted. And you are giving him not only this power, but you're giving it to the next president. Perhaps it'll be Mrs. Clinton. She'll have 2 terms of free trade fast track. You're giving away 6 years of fast track without thinking what you're doing beyond TPP. Everybody, all the talk here has been about the 11 countries and the Chinese and all the rest. But the fact is that the real agreement that's going to be interesting is going to be TTIP. Because TTIP is where we come to an agreement with Europe and they begin to write the economic rules under which the international economy, the global economy is going to operate. The real issue here is not TPP. That's really irrelevant compared to what we're going to sign or what's going to be presented to us to sign with respect to the European financial arrangements. These are not about tariffs. Everybody knows that. Tariffs are largely not what's going on here. This is all about the rules of economics, about insurance, about banking, about how investor-state resolutions, all those kinds of issues are the ones that we've been arguing about here today. Nobody's arguing about rules for rice or dairy products or anything else. We're arguing really about what's going to happen to us economically. Now, the American people have watched since 1992 when NAFTA came in. They've watched their wages stagnate. They've watched their pensions go away. They've watched their kids get buried in college debt. And they're saying to themselves, where does a working stiff make it? Whether it's a woman or a man, they're working harder and harder to keep up in this economy. And this agreement says, we're going to pass a trade agreement and everything's going to be all right for you. Believe me, that's going to be a tough sell out on the street. The American people are not so foolish as to believe this trade agreement is going to fix the problems of this economy. And here we are. We're giving this ability to the president. And all I'm doing here is saying, let's give it just to President Obama. And then we can have this argument. I mean, this is so much fun that we can come back and do this in 2 years with Mrs. Clinton or with Mr. Rubio or Mr. Cruz or Mr. Bush or whoever. We can come back and argue whether we want to give this kind of authority to the president. But you're willy-nilly giving away 6 years of this power to whoever sits down at 1700 or 1600 Pennsylvania Avenue. You have no idea what you're doing. We didn't have any idea when we passed the authorization for use of military force in the Middle East. When we voted that in 2001, we didn't know what we were doing. And we're looking now at 15 years of war. And as it unfolds, you sort of wonder, well, why did we do that back then? Well, we thought it was a good idea at the time. We had a nice president there, George Bush. He seemed to be a pretty good guy. Let's give him power to go into any country in the world and create war. So we got Yemen, we got Tunisia, we got Libya, we got Syria, we got Iraq, and you're doing the same thing economically. You're giving an authorization to the president to go and negotiate whatever he wants and come back and say to you, yes or no. Now, you can have all the qualifications you want in there, but in the end, he has it.
Time for the gentleman has expired. Mr. Young is recognized.
Well, thank you, Mr. Chairman. This is a very important issue. In a way, I'm glad that my colleague has brought up this amendment. It provides an opportunity to talk about the importance of trade in sort of a broader context. This is, of course, about U.S. showing its economic leadership. This is, of course, about providing jobs and better opportunities for Americans. This is, of course, about selling to the roughly 95% of the world's consumers and facilitating means to do so. This is far broader than the Trans-Pacific Partnership, which we hope will be consummated by the end of the year. There are, in fact, other important agreements. TTIP was mentioned, which comprises, between the United States and the European Union, over 50% of the world's gross domestic product. To the extent we can cement economic relations between our different countries and regions, that will redound to the benefit of all Americans. There are, in fact, other agreements which will take longer to consummate, longer than 18 months. WTO agreements, the environmental goods agreements, TISA, the Trade and Services Agreement. So we need more time, we need more certainty, but we need to send a message. We need to send a message to the world during this time, frankly, when there's apprehension about U.S. global leadership, that the United States remains a global power. The United States intends to stay engaged, not just militarily in the world, but economically, diplomatically, in a humanitarian capacity, and all the other various capacities in which the U.S. has long shown global leadership. Trade is an essential component to these various instruments of power that we have. TPA is about asserting our global role. We send the wrong message here if we try and narrow this current legislation to an 18-month period. Don't take it from me, take it from President Obama's former national security advisor. Happened to be my commandant when I was in the Marine Corps. General Jones earlier this week wrote the following: "Trade runs right to the heart of international security in the 21st century. Maintaining global stability essential to America's peace and prosperity is no longer a function solely of our ability to deploy and defeat, but rather of our capacity to engage and endow, and ultimately to turn promise and opportunity into jobs and a higher quality of life. By leading on trade," he says, "the United States tightens our bonds with allies around the globe, strengthens our influence in would-be hotspots, and fosters greater global stability through expanding economic cooperation." In the Pacific context, this is a genuine pivot. There are geopolitical implications to consummating a Trans-Pacific Partnership, but I'll say there are also geopolitical, geostrategic implications to further strengthening our relationship with the NATO powers. There are geopolitical, geostrategic implications to finishing these other environmental agreements, World Trade Organization agreements. You know, Secretary of State Cordell Hull long ago said that, and I'll quote him, said that he came to the belief that if we could increase commercial exchanges among nations over lowered trade and tariff barriers and remove international obstacles to trade, we would go a long way toward eliminating war itself. Now, he may have overstated that, but I think we go, I think we do a fair amount to advance that notion. People that have incentives to trade among one another, people who do commerce with one another, are less likely to fight. It applies in neighborhoods, it applies in states, it applies within countries and between countries. This is why we need more certainty. This is why the United States of America needs to lead. This is why it's important that we not curtail this to an 18-month extension. I have great respect. I want to reiterate for my colleague, Mr. McDermott. He's an earnest man. I believe he has deep conviction in offering this amendment. I believe it's deeply wrong, and that's why I rise to speak against it.
Gentleman yields back balance of his time.
I'm just going to ask Mr. McDermott a question as he closes.
Gentleman's recognized.
It's difficult to find much about the importance of trade that Mr. Young has just spoken so eloquently about that I find any basis for disagreeing. It is important. It's the question of the terms of trade, and the tariffs that Cordell Hull talked about were the significant barriers at that time in a European trade agreement where one bank after another from Europe is being fined and sanctioned for its wrongdoing. Financial services industry in Europe is eager to team up with those in the financial services in America that never have agreed with the Wall Street reforms that were incorporated in the Dodd-Frank legislation and to undermine that legislation. They see, much as the Financial Times described the Trans-Pacific Partnership Agreement, they see an opportunity in having a charter for corporations rather than a high-level trade agreement. And with reference to food safety, with reference to one issue after another that has nothing to do with tariffs, but has to do with agreements that might be reached. Some of them might be very good for our economy. I think there is potential in opening up more trade with Europe, but it's important that Congress have a role in that. If Mr. McDermott's amendment is adopted, we will have the opportunity to see how well this TPP worked, to see if some of the concerns that some of us have advanced about fast track and about what's in this agreement, what's been hidden and secreted in this agreement, we'll have the benefit of that. There's nothing to prevent an administration, whether it be Senator Cruz or Secretary Clinton, from coming back. There'll be some uncertainty about how that election comes out with our trading partners, but to keep them from coming back on day one and asking the Congress to provide fast-track authority. And we would be informed in providing that authority by what happens here with TPP. Hopefully it will go much better than the many concerns that I think are legitimate that have been voiced here today. But all that Mr. McDermott's amendment does is say, you got now until 2017, I believe, and after that, come back and ask the Congress again. Don't cut the Congress out of this entirely. Let us consider these issues at that time. And I yield back.
Gentleman yields back. Gentleman is recognized for purpose of closing on his amendment.
Well, thank you, Mr. Chairman. It's clearly, I put this amendment up. I know it's not going to be adopted. I mean, no change is going to be made to this holy writ that's been brought down off Mount Olympus or wherever it is. I don't know which place it came from. Somewhere in the Capitol. I don't remember the room number. The fact is that you are making a decision, and Mr. Doggett alluded to it. Clearly, the banking system in the world has been in trouble. And certainly, the problem in the Congress often is nobody has any memory. I mean, some of you, of course, weren't here in 2007 when it all fell apart, and the Secretary of the Treasury was running around with his hair on fire, telling us if we don't give $700 trillion or $1 billion immediately, the whole thing is going to collapse. Now, you think that the banks in Europe are in any better shape today? Just read the newspapers, and you can see the problems. And they want to have a system that works for all the banks. And writing a corporate structure at that level does not help the working people of the United States. Just remember that in this election in 2016. Are the working people of the United States going to have a better deal out of this? Mr. Rangel, others have tried to talk about jobs, and we're going to get out of all this trade. We know there aren't going to be big surges in employment. But what we do know is that the folks who are manipulating the money at the top are waiting for that opportunity to get Europe and the United States together in the TTIP. And we're giving that freedom for the president to do it all before the election of 2016. You may have a second event out here on that issue before you run for re-election. But giving it for 6 years is really giving it out into the future and having no idea what's going to go on economically in the world. Who would have predicted 2007? I mean, we were rolling along, spending money like we had all the money in the world. We were fighting wars in 2 different places, and suddenly the banking system collapsed. And we haven't done anything about derivatives. We haven't done a whole lot of things in the economic sector that need to be worked on, and yet we're going to have a negotiation that's going to be out there about these issues. And that's why I want to make people aware that the working people of the country have not benefited from free trade. Their wages are stagnant since '72. That's why they don't trust this stuff. That's why they're angry and upset about it. Free trade doesn't mean anything to them. That they can get something for a little less down at Walmart or at Costco or someplace, that helps a little bit, but it's not what's driving. Their kids can't get out of debt and buy a house because they got so much college debt that their credit rating is so bad they can't go out and buy a house. So the housing industry, there are a whole lot of areas in this economy right now that are not working well. And to lay it all on this trade agreement and say, let's give them 6 years to go out there and find out whatever they can do, is giving the people who have brought this economy to where it is, it's giving them a free ticket for 6 years. And I think you ought to think very carefully about whether you would do that in any other area. We did it in war. That hasn't worked out very well. We're not out of there yet. In fact, we're deeper in ISIS and Syria and Iraq than we were 5 years ago, or 6 years ago, or 7 years ago. So trying to guess where we're going to be in 6 years is really kind of a risky business, and I really think this is a reach. We ought to adopt this amendment, but I yield back the balance of my time.
Gentleman yields back the 15
Chairman, I
seconds
withdraw
he has remaining.
reservation of the point of order.
Gentleman from Ohio withdraws his point of order. Question is on the amendment offered by the gentleman from Washington, Mr. McDermott. All those in favor signify by saying aye. Aye. Those opposed signify by saying no. No. In the opinion of the chair, the noes have it. Yeah, you get it. Do you want a roll call vote? Okay, roll call vote has been requested. You got to ask for it if you want it. Roll call vote is requested. The clerk will call the roll.
I thought it was like the point of order was kind of a...
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Brady, no. Mr. Nunes? No. Mr. Nunes, no. Mr. Teaberry? Mr. Teaberry, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? Mr. Roscom, no. Mr. Price? Mr. Price, no. Mr. Buchanan? Mr. Smith of Nebraska? No. Mr. Smith, no. Ms. Jenkins? Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Mr. Marchant, no. Ms. Black? Ms. Black, no. Mr. Reed? No. Mr. Reed, no. Mr. Young? Mr. Young, no. Mr. Kelly? No. Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? No. Mr. Meehan, no. Ms. Nome? Ms. Nome, no. Mr. Holding? Mr. Holding, no. Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. Rangel, aye. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, aye. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer? Mr. Blumenauer, no. Mr. Kind? Mr. Kind, no. Mr. Pascrell? Mr. Pascrell, yes. Mr. Crowley? Mr. Crowley, aye. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Mr. Buchanan? Mr. Buchanan, no. Chairman Ryan? Chairman Ryan, no.
I'm going to go after Blumenauer.
Yeah, but Blumenauer's next, right? Yeah. Yeah, it's germane. It's not germane here. The clerk will report the vote.
13 yeas, 25 nays.
13 ayes, 25 nays. The amendment is not agreed to. Who's up next? Mr. Blumenauer, I believe you have an amendment.
Thank you, Mr. Chairman. This amendment is part of a package of a half dozen items that I'm sorry.
Gentleman will suspend. Point of order is reserved. Clerk will disseminate. While the clerk's disseminating, I'd ask the gentleman to explain his amendment.
and I'll let my friend hold on to his point of order. I'll make a 4-minute explanation. I'm not going to force us to go through the ritual of voting down an amendment. I offered the package of a half-dozen proposals to you, to the administration, to my colleagues on this side of the aisle, for items that would speak to things that we've heard about that aren't going to interfere with the process and might be part of developing a package that would either, God forbid, merit support or would make people feel more comfortable with it even if they didn't support it. This is one of the provisions. I'm serving notice, even though I'm not going to take the full 5 minutes. I'm not going to call for a vote. I don't want to debate it. But it's something that I will be working on over the course of the next couple weeks with the committee staff on both sides of the aisle, with the Senate Finance Committee, to be able to have, and with the administration, to have a package that strengthens this and makes it better. There is a huge problem with the illegal trafficking of wildlife and plants. I have worked for years and with some of the members of the committee dealing with illegal logging, not just in the Peru Free Trade Agreement, but we've got things in the Ag Bill to deal with this serious problem. Things like illegal logging and taking of wildlife damages the environment. It hurts indigenous people. In some cases, it hurts American business because we're cheating. We're trying to compete with cheaters in the international arena. This amendment, which I hope somehow finds its way into the final agreement, is consistent with 100 years of American law, domestic law. It's part of the administration's national strategy for combating wildlife trafficking, and I'd hope that they will be more aggressive in helping us move forward. We've lost 100,000 elephants since 2010, just picking one out of the air. And so I would hope that as we work our way through, that we deal with adding a principal negotiating objective to prohibit trade in illegally harvested wildlife, timber, or living marine resources. I would not think anybody in the committee would object to it. It is entirely consistent with what the administration says they're trying to do. I hope it finds its way into the final process, but I'll give you back 2 more minutes.
Yeah.
Won't force a vote, and work with you, Mr. Chairman, and other members of the committee to see if we can embed this in the final.
Before you give up your time, will you yield it?
I'm happy to yield.
First of all, I want to thank the gentleman for all of his diligence, all of his work. He's paid great attention to detail on these issues. May I assume this discussion involves the other pieces of the package that he's been discussing, or is that something he's going to bring up later?
I will touch lightly on other items, but I'm not going to force any votes.
Okay. Okay. So we're currently reviewing this package of these number of items. I think some of these items do have support, and we're just trying to find out if we're going to work with the gentleman to further these issues, particularly the enforcement measure that he's talking about in customs, the outerwear issue that he's talking about, and we will continue to work with the member on all of these issues.
Mr. Chairman, I appreciate your courtesy and clarification. Yeah. As I say, I won't spend a lot of time tonight debating it, asking for votes. I'm committed to them. I take you at your word. I do think they are things that people on the committee hopefully will feel comfortable with. We've made some progress in the other body. A couple of them have been picked up in the Senate version, and I appreciate people's attention, patience, and courtesy. Thank you very much.
Absolutely.
And I yield back.
He yields back.
Oh,
you got 30 seconds left. Do you want to?
If I have 36 seconds, I give it to the ranking member.
I just wanted to say to you, we all need to join in. You helped so much put together the provisions for Peru and timber, because it's a national, international issue. And I say this with more than friendship to Mr. Reif and to Angela. We haven't really done a very adequate job enforcing those provisions in May 10th relating to Peru that we worked so hard. And we simply have to do better. It gives a bad name to trade expansion. So, Mr. Blumenauer, I congratulate, we're all going to work together. Whatever happens, we're going to have a continued battle over TPA to try to get a better TPP. We're going to work together on these environmental issues. Thank you.
He does. The gentleman asked unanimous consent to withdraw his amendment? The gentleman does. The amendment is withdrawn. Are there further amendments? I think, Mr. Levin, you're jumping in the queue here, correct? The
Yeah.
gentleman's recognized.
I was waiting until the amendments came up that were clearly germane.
Mr. Chairman, I reserve a point of order.
Yeah, and this one I think will be ruled not germane.
Yeah, the gentleman from Ohio reserves point of order. The gentleman from Michigan is
Okay,
recognized.
so just, this is a necessary amendment relating to competitiveness and infrastructure. And I just want to highlight what's in there so that all of us realize the work that needs to be done and should be done. One is the Currency Reform Act, the countervailing duty anti-dumping provision that was put into the customs bill in the Senate. I understand it's going to be eliminated at some point, unfortunately. It's one of the ways we could be addressing currency reform, and the administration indicated its opposition to that as well. We've passed that bill several times here. Then the Enforce Act that relates to the collection of duties, and there'll be some further discussion of that. Then there are some other trade remedies provisions in the Leveling the Playing Field Act that need to be addressed, as well as the Stand Up for America Act relating to the role of Congress in the enforcement of trade agreements. Further is the Stronger Act that creates an enforcement fund to improve the enforcement of trade agreements by using money collected from anti-dumping and countervailing duties, as Mr. Blumenauer knows. The Trade Enforcement Act is another one. It sets up a statutory basis for the establishment of the Interagency Trade Enforcement Center that's now within USTR. The Green 301, which is an effort to combat foreign country trade practices that harm the environment. Super 301, which was in existence for a number of years, has been allowed to expire. That's unfortunate. It should have been legislated long ago, because right now what USTR does is to identify the violators, but there isn't an effective delineation as to what our priorities are. And Mr. Neal, you'll be interested. I know also we're including in this legislation the bonds, the Build America Bonds provision. The Build America Bonds provision is in this infrastructure and competitiveness that you and I and others have worked so hard. And Mr. Rango, you have taken the leadership. And the last is the energy credit, the 48C program, which we think all of these should be in a package that is tied into any trade legislation, because it picks up the theme that we need to focus in on the creation of jobs. So I'll yield my time if you like, Mr. Neal. You'll
Yes.
want to take more time.
Thank you, Mr. Levin. And I want to highlight what Mr. Levin has said, because he's right on target. A month ago at the White House, a month ago tonight, I was with the President, a couple of us sitting in the Oval Office, and I suggested to him, Mr. Levin, at that moment, that he entertain precisely what you've offered here. The suggestion being that we tie a big infrastructure program to TPA, TPP, and TTIP that would give us the avenue, as you've noted, in response to what has really been slow growth. And the best way to do this, and there was ample evidence that the Build America Bonds program was highly successful, but all you have to do is drive around the streets of your hometown to find out what's happened to the highways and the roadways and the bridges. Our allowing these projects to languish and going back and time and again with these small investments has gotten us to this point of stalemate where nothing's happening anywhere across the country. And I'll speak in this time for Mr. Rangel and myself in the Northeast. It's a short construction season. So if those contracts aren't at the door, by the beginning of the year, there's no construction because it's over by November. So I think you're right on target, Mr. Levin. I think this whole notion of competitiveness, economic growth, is where we all ought to be able to agree. And at one time, this committee had the capacity to do precisely that. So thank you, Mr. Levin.
Mr. Levin, would you yield?
I have only 30 seconds, so grab some more time. Take the 30 and then ask for more.
Well, no, I won't take long, but it's the whole theme that everyone is saying in a bipartisan way. The president, the Republicans, and the Democrat, we are not very popular with the people there. These intellectual exchanges we're having to improve the quality of international trade for 10 or 20, 30 years, no one can challenge it's not the right thing to do. But, Mr. Chairman, if the House congressional leadership could get together with the president and say, in order to have a decent trade package, we need infrastructure and we need skills and education, and all that leads to jobs. What it will do for the Republican Party, what it would do for the president, and what it would do for the Congress and the country. And it's not a question of putting all of this into legislation. Just coming together and telling the American people that we're talking about doing it together. And I can give assurances that this Congress would come together and support the package. And I just appreciate the opportunities that you really have given us to express ourselves so that nobody can say that we all aren't on the same page for improving the quality of life, increasing jobs, and providing American leadership in this most important area. You've been kind and generous with the time, and I only wish that the administration was a part of the discussions that we're having today, but we still got a little time left.
Okay, that time is a minute and a half past. So
Mr. Chairman.
I take the gentleman, and the time for the gentleman has expired.
Mr. Chairman, Mr. Chairman, I insist on my point of order. The amendment's not germane.
Gentleman from Ohio will state his point of order, please.
I insist on it because the amendment is not germane.
Does anyone wish to be heard on the point of order? I don't want to just jam it. I mean, somebody would.
I think it's correct. This is not germane, unlike the decision not to let us have a vote on this. And I hope you'll consider, you'll continue to consider. So I won't withdraw it, but you'll rule it out of order.
I am prepared to rule.
You're batting 500.
Okay.
You struck out on our substitute.
Gotcha. Well, I just don't want to be duplicitous. I'm prepared to rule the amendment is not germane to the bill because it violates House Rule 16, Clause 7, as it is outside the subject matter of the bill. Therefore, the point of order is sustained and the amendment is not in order. Are there further amendments? I think, Mr. Pasquarello, you're up to the bat. The clerk will distribute the copies of the amendment. Mr. Teaberry is recognized.
Thank you, Mr. Chairman. I reserve a point of order.
Gentleman from Ohio reserves a point of order. Mr. Pasquarello, why don't you describe your amendment while the copies are being disseminated?
Thanks,
Gentleman's
Mr.
recognized.
Chairman. I have a few amendments here. The first one is food safety amendment. The TPP would require the United States to allow food imports if the exporting country claims that their safety regime is equivalent to our own, even if it violates the key principles of our food safety laws. These rules would effectively outsource domestic food inspection to other countries. And I've listened to all this day, denials, you're going to blow up the agreement, you better read the text, and the redundancy. I want to see who is redundant when we finish this one. The United States Food and Drug Administration already inspects less than 1% of all seafood imports for health hazards. Entering the TPP with Malaysia and Vietnam would increase seafood imports and further overwhelm inspectors' abilities to ensure our food safety. Some of the countries party to TPP have serious shrimp and fish safety issues. Vietnam seafood has had high levels of contaminants even with minimal inspections. I have serious concerns that the TPA, as written, will leave us with a take them at their word policy on food safety, and I find that unacceptable. Now, let's go to the videotape. Let's go to the text. Let's go to the text. Let's go to pages 6 to 12 in Section 3 of the bill. Page 6 says, and I'll sum up so I don't have to read every word. Trade in agriculture says the objective is, listen to this, the objective is to open markets for experts. Section 2, improve regulatory coherence and, quote, equivalence of health and safety protection systems of exporting countries. And Section 3 says measures should be not more restrictive on trade than necessary to meet the intended purpose. We are putting our citizens at risk with this bill. And don't you tell me we're not. I'm reading the text right here. Section 4, improve import check processes. Oh, there's a lot of processes in this legislation. While recognizing countries may put in place measures to protect human, animal, or plant life or health consistent with international obligations. This amendment, Mr. Chairman, would prohibit trade agreements that permit the import of food, feed, or food ingredients or products that do not meet or exceed U.S. standards with respect to food safety. I urge my colleagues, regardless of where you live, to support this amendment. I yield back right now, Mr. Chairman.
Gentleman yields back, balance of his time. Who do we have? Mr. Smith. Mr. Smith is recognized.
I move to strike the last word. Certainly, this amendment does offer duplicative language, and already the very measures or very items that you're seeking to prohibit, it's already illegal to bring in such items. I think
that is not true.
Pardon me, that I would suggest that it's important to listen to the very processors, producers themselves who engage in this on a regular basis. And so I don't want to myself be duplicative in my opposition, but certainly it's unnecessary for this language to be added to the text, and I yield back. Thank you.
Gentleman's recognized to close on his amendment.
Mr. Chairman.
Mr. Chairman, if I could.
Go ahead.
If I can strike the last word, Mr. Chairman.
Gentleman's entitled to, so the gentleman's recognized to strike the last word.
Thank you. Mr. Chairman, I want to speak in favor of Mr. Pascrell's amendment. I do think there are growing concerns not only about international import of foods that Americans are questioning, but right here at home. So is it really too far-fetched to be concerned about competing with a country like Vietnam that doesn't have the same standards or laws in place to protect its own citizens as we have right here? I think that Mr. Pascrell is onto something on this issue, and I don't think it should be dismissed out of hand. I do think that it's worthy of support, and with that, Mr. Chairman, I want to express my support for Mr. Pascrell's amendment. Okay. Yield back.
Thank you. The gentleman yields back balance of time. Gentleman from New Jersey is recognized to close.
Thank you very much, Mr. Chairman. Mr. Chairman, you and I would not like to have food that's contaminated. There is not. I've read through this, and I ask you to do the same. I've read through the sections. I read page by page. I picked this out as an example because it affects all of us, Mr. Chairman. We want food safety. There is nothing in this legislation that protects the American people. One iota. You could quote me. I have the sheets right here. You show me where it's at. This is a big deal to the American people. This is another fake trade deal. Another fake trade deal. This is another imposition on the American people that you better have somebody else check your food before you eat it. That's what we're saying. We don't even inspect the food that's coming across the Rio Grande, 40% of it. Most of it's not inspected. We are not inspecting the food that's coming into this country from other countries, which we know have contaminants in many cases. What are we doing about it? You tell me what we're doing about it, Mr. Chairman, and I will listen. Thank you, Mr. Chairman.
Gentleman yields back the balance of his time.
Thank you, Mr. Chairman. I withdraw the reservation of a point of order, but I'd like to address my really good friend, and I sincerely mean my really good friend, as he knows, Mr. Pascrell. Secretary Vilsack, who you know better than I do, I thought did a very good job yesterday in addressing this very issue. I yield back.
The point of order is withdrawn. The question is on agreeing to the amendment offered by the gentleman from New Jersey, Mr. Pascrell. All those in favor signify by saying aye. Those opposed signify by saying no. No. Opinion of the chair, the noes have it. Roll call vote is requested. The clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Brady, no. Mr. Nunes? No. Mr. Nunes, no. Mr. Teaberry, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? No. Mr. Roscom, no. Mr. Price? Mr. Price, no. Mr. Buchanan? No. Mr. Buchanan, no. Mr. Smith of Nebraska? Mr. Smith, no. Ms. Jenkins? Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Mr. Marchant, no. Ms. Black? Ms. Black, no. Mr. Reed? Mr. Reed, no. Mr. Young? Mr. Young, no. Mr. Kelly? Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? Mr. Meehan, no. Ms. Nome? Mr. Holding? Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. Rangel, aye. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, yes. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer? Mr. Kind? Mr. Kind, aye. Mr. Pascrell? Mr. Pascrell, yes. Mr. Crowley? Mr. Crowley, yes. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Ms. Nome? Mr. Blumenauer? Mr. Blumenauer, aye. Chairman Ryan?
No.
Chairman Ryan, no.
Clerk will report the vote.
15 yeas, 22 nays.
15 ayes and 22 nays. The amendment is not agreed to. Are there any further amendments? Ms. Pascrell, I think this is number 2 out of 4, correct?
Mr. Chairman, I reserve a point of order.
Gentlemen, suspend. A point of order is reserved. Ms. Pascrell, while the clerk will distribute the copies of the amendment, and while the copies are being distributed, the gentleman is recognized for 5 minutes for the purpose of describing his amendment.
Thank you, Mr. Chairman. Today, I'm introducing an amendment right now that would prohibit trade agreements that weaken, undermine, or necessitate the waiver of the Buy American Act. While many of our past trade agreements have pushed more and more American jobs overseas, the data is clear on this. The United States Buy American laws support producing goods and services here in this country, which helps keep and create jobs within our borders. When some hear Buy American, they cry protectionism. When I hear Buy American, I say we're stimulating the economy. When the federal government is investing in a new Amtrak line, purchasing the steel to build those new tracks from a U.S. company, it puts Americans to work. As a result, more Americans have wages to put back into the economy, supporting grocery stores, movie theaters, restaurants, and the federal and state local governments have reliable sources of income.
The gentleman will suspend for a moment. I think the order was believed that you were doing rules of origin next, but you're doing your Buy American amendment. Is that
okay?
Well, sure. We just have to turn. Let's have the clerk pass out the Buy American amendment.
I'll continue. You can,
and then
you can pass them all out.
well, I think that's what we'll probably end up doing here. So the rule of origin one is the one that got passed out. So I just want members to note that this is not the amendment that's being considered now. We will consider, because that's what you're talking about, the Buy American amendment. Clerk, please distribute the Buy American amendment, and I ask members to hang on to the rule of origin amendment because let's make that one the next one.
You want me to go to the rule
Stick
of
with Buy
origin?
American. Stick with Buy American.
Okay, fine.
And then we'll do rule of origin next.
So as I was saying, Mr. Chairman, when the federal government is investing, and I gave an example, if that steel is being purchased from the United States of America by our steel workers, by our vendors, we all have success from that, every one of us, all good consequences. So keep in mind that some of the loudest opponents of Buy American are companies that want to ship American jobs overseas to take advantage of cheap, exploitive labor. I yield, Mr. Chairman. Mr. Chairman, can I just add one more thing? I'll have time?
Sure.
I'll be quick. Approving a trade agreement, which from my perspective is lacking in protections for American workers, that would allow these important and impactful laws to be weakened or undermined, sets the average American back even further. Our Buy America laws have overwhelming popular support amongst Democrats, Republicans, independents, you name it. I urge my colleagues to support this amendment to strengthen American production and to support American manufacturing jobs. I yield back, Mr.
Gentleman yields back balance his time. The gentleman from Texas, Mr. Brady, is recognized.
Thank you, Mr. Chairman. I know that Mr. Pascrell is sincere and has been a long-time champion of Buy American provisions. Here's an area that there is common ground. The U.S. maintains robust Buy American provisions in law through the Buy American Act of 1933 and the Trade Agreements Act of 1979 and other statutes. These are long-standing rules which are manageable for our job creators and aligned with international standards. So when the U.S. concludes trade agreements, access to U.S. procurement markets is part of the reciprocal market access, as is access for U.S. companies and service providers in other foreign markets. In other words, we obtain new access to these growing markets as part of the trade agreement. Overall, stricter Buy America provisions that go beyond this carefully negotiated compromise undermine the U.S. government's ability to buy the highest quality goods and services at the lowest cost to taxpayers, and makes it harder for us to convince our trading partners that they need to open their procurement markets to our American goods and services. The world has changed. It's not enough to merely buy American. We need to be selling American through every corner of this world. When we do that, when we create one-way trade, make a two-way trade, return trade deficits into trade surpluses, and in countries that we have agreements with, per capita, they buy nearly 13 times more of American goods and services than other trading partners. That is why I respect the gentleman's opinion. In this case, this goes beyond the compromise, and I respectfully urge that we defeat the amendment.
Gentleman is recognized for purpose of closing on his amendment.
Thank you, Mr. Chairman. Mr. Chairman, we do want to sell all over the world. I find that to be a very noteworthy, very important to the economy of this country. But what we don't want to do is sell out the American worker. We want to sell all over the world, but we don't want to sell out the American worker. And I personally believe that we do that when we could purchase right here in the United States, particularly governmental entities, which we have found buying products that are in other countries rather than deal with our own manufacturers. And on the other side of our mouth, we're saying that we want to help American manufacturers. So I want you to know that I think that this is not a frivolous amendment. I think it's very important to the very center of what we've talked about. And when we say, what do we mean by Buy America? We have not lived up to that. We have not lived up to that at all. And I could cite chapter and verse on that. I yield back, Mr. Chairman. Thank you.
Mr. Chairman, I withdraw the reservation of my point of order.
Gentleman,
I withdrew.
gentleman withdraws point of order. Gentleman yields back his time. The question is on the amendment offered by the gentleman from New Jersey, Mr. Pascarell. All those in favor signify by saying aye. Those opposed signify by saying no. No. Opinion of the chair, the noes have it. Noes have it. Gentleman asks for a recorded vote. The clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Brady, no. Mr. Nunez? Mr. Nunez, no. Mr. Teaberry? Mr. Teaberry, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? Mr. Roscom, no. Mr. Price? Mr. Price, no. Mr. Buchanan? Mr. Buchanan, no. Mr. Smith of Nebraska? Mr. Smith, no. Ms. Jenkins? Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Mr. Marchant, no. Ms. Black? Ms. Black, no. Mr. Reed? Mr. Reed, no. Mr. Young? Mr. Young, no. Mr. Kelly? Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? Mr. Meehan, no. Ms. Nome? Mr. Holding? Mr. Holding, no. Mr. Smith? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, aye. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer? Mr. Blumenauer, aye. Mr. Kind? Mr. Pascarell? Mr. Pascarell, aye. Mr. Crowley? Mr. Crowley, aye. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Ms. Nome? Mr. Rangel? Aye. Mr. Rangel, aye. Mr. Kind? Chairman Ryan?
No.
Chairman Ryan, no. The gentleman is recorded as yes. Fourteen ayes, 22 noes.
There being 14 ayes and 22 noes, the amendment is not agreed to. There are any further amendments? You got one more, right? Or
two more.
Two more.
Mr. Chairman.
Let me just, is this the rules? We're on rules of origin now, right?
Yes, sir.
Okay. Everybody's already got a copy of this one.
I reserve.
Mr. Reichert reserves point of order. The gentleman's recognized for 5 minutes.
The TPP doesn't include sufficient rules of origin, Mr. Chairman, which set the rules on how much content produced in country a product must have before it can benefit from the trade deal. Very important. It's a big issue when we debated the Korean deal. Big issue. In other words, Chinese textiles, if I give you an example, assembled in Vietnam, or a Japanese car made from Chinese steel could, in theory, enjoy the protections and benefits of the TPP, even though China is not a part of the agreement. Paving the way for more inexpensive Chinese steel to enter U.S. markets can only hurt domestic producers. This is what we tried to stop, and we didn't, in the Korean deal. In fact, many of us were prepared to vote for that trade deal, except for how this was handled, this particular part. You have a part of an automobile, you send it over to Korea, you finish the Korean deal, and then China gets the benefit. If you think that doesn't stink, then you should go back to the first page of this agreement. The rules of origin in TPP for autos have been described as being weaker in this deal than in NAFTA. Now, you have to go really deep into NAFTA to find out where the rules are for that. Of course, they didn't want very many people to know about that being an issue in the first place. We don't want to see any more erosion of our manufacturing base and loss of these jobs. Even though some in the textile industry have sold out for a weak deal, our textile industry, our domestic steel, our autos, our domestic manufacturing, our food safety, all need much stronger rules of origin. Rules of origin protections in our future trade agreements. My amendment would require that, and I urge its passage to protect what we've already worked so hard over the centuries to do. I yield back, Mr. Chairman.
Gentleman yields back the balance of his time. Gentleman from Louisiana is recognized.
I really appreciate what the gentleman's saying and what he's trying to accomplish. I mean, this issue is absolutely critical for our domestic autos industry and for textiles. And the TPA language we have includes some very robust negotiating objectives, expanding these opportunities for promoting U.S. goods, fostering growth, and promoting full employment in the U.S. And I think the objectives really, in effect, get to the same point that you're requesting with the amendment. So in a sense, it's duplicative. The TPA language that we have has been negotiated bilaterally, bicamerally. You know, we're trying to get this done, and I think this would actually it's duplicative. But if we start adding additional language, it starts to unravel the agreement. So,
Will the gentleman yield?
Yeah, I'll be happy to yield.
Thank you. Through the chair, if you read the language of NAFTA and you compare it to, we hope we're going in a stronger direction in terms of what we all want to accomplish. I think we're all on the same page there. Maybe we're not. Maybe I'm assuming too much here. But they are weaker. They are not stronger. And you know, just as well as I do, and maybe better, that rules of origin are critical in trade negotiations and trade deals. And
yeah, we're claiming my time. There's no question about it. And I've been very focused on the textile issue because it affects business in my district as well. And we're really pushing to make sure with these current negotiating objectives in TPA to ensure that we get the right priority placed on this in these negotiations. So I'm going to oppose the amendment because I think it's duplicative, and in the interest of moving TPA forward, I think that would be the best way to go.
The gentleman yield. You got more time.
I'll yield.
You've read this just as well as I've read this. You concluded that there's sufficient language within that section of the agreement, which we're debating right now, that upholds manufacturing in this nation of ours. Not only textile we're talking about, I think you'd agree with that, we're talking about automobiles. I can't find that. Can you show me where this is a,
Well, reclaiming my time, let me have Mr. Reif comment on this.
Thank you, Dr. Bustani. Mr. Pascal, thanks for your amendment. We have are negotiating very robust rules of origin in the TPP, including in the autos area. It's very important that the benefits of the rules of origin go to TPP partners, including our automotive industry. It's a very difficult undertaking, so we've been in very close consultation with the companies and other stakeholders, and including, obviously, with members of the committee. So we feel strongly that we're on the right track with respect to the rules of origin in the autos and with respect to other products also.
may I ask him a question, Mr. Chairman, through?
Mr. Bustani controls the time.
I still have the time. I thank Mr. Reif for his comments, and I'm prepared to yield back in the interest of time.
Gentleman yields back the balance of his time. Mr. Levin, you move to strike the last word?
Yes.
Gentleman's recognized.
I mean, the problem is in this TPA, there is no even guidance on rule of origin. So when it's said that it's duplicative, it's not there. And it's a vital issue, as we discussed yesterday with Vietnam, for example, because more and more of the material in their apparel industry, and I think their shoe industry, comes from China. And so if you don't have a strong rule of origin, essentially you're opening up our trade to China, reducing the tariffs on their material, which is an increasing part of the good. So I hope there'll be one, but one of the defects in this TPA is there is no guidance in this bill on rule of origin. And in our substitute, we have a clear instruction. Thank you.
Gentleman yields back. The gentleman from New Jersey is recognized to close.
Mr. Chairman, there is no there there. There is no there there. I think the ranking member, Mr. Levin, pointed this out.
You want to talk about it? The gentleman will suspend, I think, the General Counsel from the USTR. Did you want to comment?
Thank you, Mr. Chairman. Sorry to interrupt, Mr. Pasquale. I just wanted to point your attention to the principal trade negotiating objectives. We are instructed in the trade and goods section to obtain fair and more open conditions of trade. And so that, I think, Congressman Levin describes what our objective is. As evidence of the strength of our negotiating position in TPP, probably the two most difficult sectors are automotive and textiles. And the National Council of Textile Organizations, the NICTO, has formally endorsed the TPA bill. So we're trying to do everything we can, which is an unusual occurrence, as you know, for NICTO to be supportive of TPA. So we have spent an enormous amount of time, Ambassador Froman and all of the team, to ensure that these rules are negotiated in a way that benefits American workers and businesses.
Let me just take my time back if I have it.
Well, you don't, but Mr. Pasquale will be happy to yield to you, I think.
I'm not questioning that, Mr. Reif, Jim. I think there's been progress in textiles. The issue is very open when it comes to the automotive sector. And the problem is, in this TPA, there's no direct reference to rule of origin. So there is a reference to general language about fair, whatever it is. There's no specific language, even a negotiating objective, as to rule of origin itself. And that's why we placed an instruction. And that's why, go ahead.
Mr. Chairman,
So if
get my
there's going to
time
be,
back?
It is your time, but you're yielding to your ranking member right now.
I think Mr. Levin is done?
yes.
Okay.
Okay.
Can I?
Gentleman may resume.
Thank you. You know, here's what you do in trade deals, Mr. Chairman. You pluck off one industry at a time. So we know what's happened to textiles in the past 5 agreements. So what you did this time is you slipped that sentence in which you mentioned, and you say that this is protection for rules of origin, you got to be kidding me. You got to be kidding me. It's not there. And I think this will do more to destroy industry in this country than anything else. I know you don't want to do that. Then why did you? Well, you didn't write it. The people who write this move one industry against the other. There are winners and there's losers. And that's what we want, a balance of things that happen, so that we can, all boats rise. Isn't that the best way to do it? Do we need these arguments when we're going to trade with other countries every time we have a trade deal? No. We don't trust the system. Let me change my words here. I don't trust the system. I don't trust the process, not only because of the lack of transparency, because when you look into the document itself, when you look into that document and you read it, you have a million of the word may. May. You have very little about this is what you must do in order to trade with the United States of America. We have shaped, we've molded, we beveled our policy to everybody else but our own workers. And what is the result of it? The worst thing that's happened is that not only did we lose manufacturing jobs, but now those manufacturing jobs that we gotten back during this rebound over the past 2 years are lower paying manufacturing jobs. And as Alexander Hamilton said, you are not going to grow the nation, the first treasurer. You're not going to grow the nation unless manufacturing is part of the base of the economy. These trade deals have sucked the air out of the room we call our beloved nation. And I am not going to stop saying what I'm saying. I don't care who the president is, who the vice president is, who the janitor is. This is what I believe. I'm for the little guy. As John mentioned before, John Larson, I want you to be for the little guy, and there's nothing wrong with that. We can't start off just protecting certain industries. We must look at the whole ball of wax, or else we find ourselves arguing with each other. I know your background, you're a good person. But what's happening to the
Time for the gentleman has
results of
expired.
what you've decided is not good.
Time for the gentleman has expired. Does the gentleman from Washington
withdraw
his point of order? The gentleman from Washington withdraws his point of order. The question is on agreeing to the amendment offered by the gentleman from New Jersey, Mr. Pasquarello. All those in favor signify by saying aye. Aye. Those opposed by saying no. No. In the opinion of the chair, the noes have it. The gentleman requests a roll call vote. The clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Brady, no. Mr. Nunes? Mr. Nunes, no. Mr. Teaberry? Mr. Teaberry, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? Mr. Roscom, no. Mr. Price? Mr. Price, no. Mr. Buchanan? Mr. Buchanan, no. Mr. Smith of Nebraska? Mr. Smith, no. Ms. Jenkins? Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Mr. Marchant, no. Ms. Black? Mr. Reed? Mr. Reed, no. Mr. Young? Mr. Young, no. Mr. Kelly? Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? Mr. Meehan, no. Ms. Nome? Mr. Holding? Mr. Holding, no. Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. Rangel, aye. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, aye. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer. Mr. Blumenauer, aye. Mr. Kind. Mr. Kind, aye. Mr. Pascrell. Mr. Pascrell, yes. Mr. Crowley. Mr. Crowley, yes. Mr. Davis. Mr. Davis, aye. Ms. Sanchez. Ms. Sanchez, aye. Ms. Black? Ms. Black, no. Ms. Nome? Chairman Ryan? Chairman Ryan, no.
Clerk will report the vote.
15 yeas, 22 nays.
There being 15 ayes and 22 nays, the amendment is not agreed to. Do you have one more, Mr. Pasquarello? I believe you do. The gentleman is recognized. The clerk will disseminate the amendment, and Mr.
Chairman, I
Reichert?
reserve a point of order.
Mr. Reichert reserves a point of order. While the clerk is disseminating the amendment, this is the China currency one, am I correct?
Yes.
Yes, okay, the gentleman's recognized.
Mr. Chairman, this amendment is a sense of the Congress. You know, in other words, what direction are we going in? That's important. We've had a lot of currency amendments come before us today. This amendment expresses the sense of Congress that China should not join the Trans-Pacific Partnership until both chambers of Congress certify that the country has not intervened in its exchange rate for a year and has fully transitioned to a market economy. American workers deserve access to a fair playing field. But currency manipulation harms American manufacturing, can negate, can reduce the benefits of trade agreements. Some estimates put job loss due to currency manipulation at close to 5 million American jobs. A free trade agreement that doesn't address currency can further harm the American economy. China is the elephant in the room. If China wants to join TPP, it should be required to stop manipulating its currency. Remember, this is a sense of the Congress. I want China to play by the rules, and I want it to earn congressional approval. I don't see the harm in any of that. I yield back, Mr. Chair.
Gentleman yields back. Mr. Bustani, would you like to be recognized?
Yeah, I move the strike
Gentleman's
last word.
recognized.
I'm reading this amendment. It says, sense of Congress that China should not join negotiations for TPP until the certification occurs. This is a new process being proposed, and we've done a lot of painstaking work to lay out the process for how countries join in the negotiations and how the executive branch presents this to Congress. I think this new process for pre-certification turns TPA on its head, given the current notification requirements we already have in place. Secondly, it's premature. We're not negotiating with China. They haven't expressed the desire to come into TPP negotiations, but we are doing BIT negotiations, a bilateral investment treaty with China. And I get a little concerned that this may affect the tenor of those negotiations, which is what we really need to do with China. So for those reasons, I would oppose the amendment, and I yield back.
Gentleman yields back balance of his time. Gentleman like to close?
Please.
Gentleman's recognized.
Mr. Chairman, bringing China on board at that given time, the contrary to that is bring them on board, and then we'll try to let them follow through on what we do. That's what we've been doing. Forget about China for a second. A lot of nations. A lot of nations. That's why I pointed out earlier today that the real protocol, I think, for agreements on trade, we struck the balance in the Peruvian deal. The folks who worked on that May 10th agreement, I think, set the stage for what we should have followed up on. That went leaps and bounds past all the other deals we had made prior to that. That May 10th deal, which was 7, 8 years ago, was important and significant for both Democrats and Republicans. It was a path to less cantankerousness and joining together in reconciliation. Why we didn't follow that path, I don't know. But I think China has to heal before they become part of any trade deal we could see in the future. And I know where this is going, and you know where this is going. China may not be part of this deal now, but tomorrow morning it might be. And I'm saying to you, I just want these to be qualifications for China to be accepted, like any other nation, into the fold of trade partners. And yes, I will yield.
Unfortunately, is a 6-year agreement, and the administration can't seem to decide whether this is against China or is laying the groundwork for China. All that you do in your amendment is to make a statement by the Congress that if you're bringing China in, don't let them take advantage of us again with their manipulated currency. You don't affect the negotiations. You don't change this
Not one iota.
inherent balance that's been developed that won't permit any other amendment to go on.
That is
You're
correct.
just adding a statement that we don't want China in this agreement if they are if they continue to manipulate their currency and gain advantage over American manufacturers, those that want to make it in America, not let them have that advantage. And the least we can do, if we won't put any guarantees in here, is just make a statement that Congress opposes that. That's all you're trying to do.
Sense of the Congress. That's all I'm trying to do.
Well,
and I don't believe that there's anybody here who's harmed by that.
To reject the amendment would seem to be an open invitation to China to come on in and continue manipulating and taking advantage of our manufacturers and our workers and our jobs.
Well, since you mentioned that, if you don't agree with this sense of the Congress, then what you would agree with is the sense of the Congress that would say, come on board and then we'll figure it out later on. Now that's pretty simple, although I guess we want very, very convolutive arguments in this day and age. I'm asking you to vote for this, both sides of the aisle. It's just a sense of what we believe should, whether it's China or anybody else. I don't think there's anything wrong. I don't think anybody gets hurt. I yield back.
Gentleman yields back. Gentleman from Washington.
Mr. Chairman, just a quick comment first. This discussion that the two on the other side of the aisle are having does have an effect on the agreed upon language in the bill between the Senate, the Democrats, and this bicameral, bipartisan agreement. So I think that's the impact that this has, and I withdraw my reservation.
Gentleman withdraws his point of order. The point of order is withdrawn. Question is on agreeing to the amendment offered by the gentleman from New Jersey, Mr. Pasquarello. All those in favor signify by saying aye. Those opposed signify by saying no. Nope. In opinion of the chair, the noes have it. Noes have it. The gentleman, roll call vote has been requested. The clerk will call the roll.
Mr. Johnson. Mr. Johnson, no. Mr. Brady. Mr. Brady, no. Mr. Nunes. Mr. Nunes, no. Mr. Teaberry. Mr. Teaberry, no. Mr. Reichert. Mr. Reichert, no. Mr. Bustani. Mr. Bustani, no. Mr. Roscom. Mr. Roscom, no. Mr. Price. Mr. Price, no. Mr. Buchanan. Mr. Buchanan, no. Mr. Smith of Nebraska. No. Mr. Smith, no. Ms. Jenkins. Ms. Jenkins, no. Mr. Paulson. Mr. Paulson, no. Mr. Marchant. Mr. Marchant, no. Ms. Black. Mr. Reed. Mr. Young? Mr. Young, no. Mr. Kelly? Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? Mr. Meehan, no. Ms. Nome? Mr. Holding? Mr. Holding, no. Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, aye. Mr. Rangel? Mr. Rangel, aye. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, aye. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Becerra, aye. Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer? Mr. Blumenauer, no. Mr. Kind? Mr. Kind, no. Mr. Pascrell? Mr. Pascrell, yes. Mr. Crowley? Mr. Crowley, aye. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Ms. Black? Ms. Black? Ms. Black, no. Ms. Nome? Chairman Ryan? Chairman Ryan, no.
Clerk will report the vote.
13 yeas, 24 nays.
There being 13 ayes and 24 nays, the amendment is not agreed to. Ms. Sanchez, I believe you are up to bat. Gentlelady recognized.
Thank you, Mr. Chairman.
Chairman.
I have an amendment at the desk.
Gentlelady's amendment at the desk. Clerk will distribute.
Reserve a point of order.
Mr. Reichert.
Reserve a point of order.
Point of order is reserved. She has one amendment, just only. Yeah, number 19. Is this is the LGBT, right? Right. Yeah. Yeah. Gentlelady's recognized.
Thank you, Mr. Chairman. I'm going to try to be brief. I know we've been here for quite some time. The amendment that I have would simply address the issue of countries whose laws call for imprisonment, torture, or even the death penalty for the supposed crime of one's sexual orientation. Recently, 119 Democratic and Republican members of Congress wrote to Ambassador Froman calling for the suspension of Brunei from TPP negotiations until they revoke a new criminal code that violates these basic human rights. I wish the TPA bill before us today gave Congress a truly meaningful say in the trade negotiation process before trade negotiations were almost finished. But as we sit here at the 11th hour discussing negotiating objectives, I hope we can at least agree that one bright line rule should be the most basic of fundamental human rights, to not be put to death based on one's sexual orientation. As a democratic country and as an example for other countries around the world, this should be obvious. This simple amendment lets our trading partners know that U.S. market access isn't just a free pass. If you want to do business with the United States, we will not tolerate this type of barbaric behavior. As Congress is contemplating this bill to delegate negotiating authority to the administration, it's our duty to send clear marching orders when it comes to the rights of the LGBT community. And with that, I urge my colleagues to support this amendment, and I yield back my time.
Gentlelady yields back balance for time. The gentleman from Texas, Mr. Brady, is recognized.
Mr. Chairman, I appreciate the gentlelady from California's strong belief in this issue, and perhaps that is why in this bill there is a new negotiating objective specifically on human rights that directs the President and really recognizes the importance of advancing internationally recognized human rights standards, of promoting respect for internationally recognized human rights, and creating more open democratic societies to this end. And the TPA as written, also requires the President to take all this into consideration before launching trade agreements with new partners. Mr. Reich, may I ask, under the TPA as written, is the White House fully committed to advancing the goals and reforms that the gentlelady has referenced? And is it your belief that engagement rather than isolationism helps advance those efforts to obtain internationally recognized human rights standards?
Gentlemen.
Great. Mr. Brady, thank you. And Congresswoman Sanchez, thank you for the amendment, obviously, on this very important issue. The State Department which takes the lead for us on human rights issues such as this, is engaged with the government of Brunei, with other governments that have this issue around the world. So there already is, Congressman Brady, engagement. It is a landmark development that there is a specific negotiating objective including human rights, the first time in any bill of this nature that's happened. So yes, we're fully committed to enforcing it.
Thank you. Based on the White House strong commitment, I urge opposition to the amendment. Yield back.
Gentleman yields back balance of the time. Mr. Davis, would you like to be recognized?
Yes, thank
Gentleman's
you,
recognized.
Chairman. I move to strike the last
Gentleman's
word.
recognized.
Mr. Chairman, I agree wholeheartedly with Ms. Sanchez's amendment. This type of behavior by any nation, any country, is inhumane, and we have to keep bringing attention, drawing attention, and make sure that they know that we are not interested in helping them to promote this type of behavior. And so I strongly support the Sanchez amendment and yield back the balance of my time.
Gentleman yields back. Mr. Crawley, would you like to be recognized?
Yes, Mr. Chairman, I'd like to strike the last word.
Gentleman's recognized.
Let me also thank our colleague Linda Sanchez for bringing this worthy amendment forward to bring attention, not only bring attention, I think, but we should not be trading with countries that, in my opinion, and I think in many people's opinion, I think more and more every day the American people believe that discrimination against someone because of their sexual orientation is immoral and is outrageous. We ought not to be even trading with countries that don't recognize this level of human rights. And so I applaud her for bringing this amendment forward. I wish she didn't have to bring it. I wish that the rest of the world was enlightened. But for too many of the countries that we're engaged with on this particular agreement, they're not there yet. So I applaud her for bringing this amendment forward, and I hope that my colleagues would see fit to support it. With that, Mr. Chairman, I yield back the balance of my time.
Gentleman yields back the balance of his time. Mr. Leavenwood. Gentleman's recognized.
You know, it's late, but I hope everybody will pay attention to this amendment because it really illustrates what the problem is with TPA as it's been drawn. There is now a new provision about human rights, and it can be said that there's commitment to implement it, but it is totally unclear how it will be implemented in terms of Brunei and these issues. There's no one today on this committee who can say what the likely result will be. And so we need some instructions, if you want to call it bright lines. And this objective is not a bright line. It's well-intentioned and it's meaningful, but very, very inaccurate and really kind of fuzzy as to what it will mean for the trade negotiations that we're having. Because I think otherwise it's likely no one will say that if Brunei doesn't meet this standard, we will not include them. No one's willing to say that. So what we're saying is we'll negotiate. The same issue relates to so many other areas, for example, labor in Vietnam, even as to Mexico. The same is true of other provisions in this TPA where there is something that's well-meaning, but it isn't clear what the likely outcome is going to be in the negotiations. And I think, Ms. Sanchez, that's why you're raising this, because no one here has any idea what the likely outcome is going to be as to negotiation with Brunei. What kind of requirements will be made of them? Over what period of time? So an objective, and it goes back to what Mr. Becerra said, an objective is something different than an instruction or requirement. And essentially what Ms. Sanchez has done in a very clear-cut way is to set forth a requirement. That's what it is. And we need to do much better on this issue than the general language that is better than no language, but not nearly good enough in terms of its real meaning. So I hope we'll support this amendment. And this amendment shows the weakness in the negotiating objectives overall. I yield back the balance of my time.
Mr. Speaker.
Gentleman goes back. Excuse me. Mr. Lewis is recognized. Sorry.
Thank you, Mr. Chairman. I move to strike the last word.
Gentleman's recognized.
I want to thank the young woman, my friend, Linda Sanchez, for offering this amendment. It is a good amendment. It is necessary. In our own country, we've come so far. We made so much progress, and we need to send a stronger message as possible around the world that discriminating against someone, putting someone down because of sexual orientation will not be tolerated. It's not a part of the American message for the rest of the world, and it's the right thing to do. And I want to thank the young lady for bringing this amendment to our attention.
Mr. Doggett, do you seek time?
I want to, yes, Mr. Chairman.
Gentleman's recognized.
Strike the last word.
Gentleman's recognized.
And thank the gentlewoman from California for raising this important issue. We raised it in a broad sense in the Human Rights Amendment that Mr. Lewis and I spoke about earlier, but I'm pleased that you are focusing in on this particular issue. We've made great progress in our country. We have not always carried the same message firmly to the rest of the world. I was just noting in one of the countries that I talked about, Brunei, that they are implementing Sharia law. The penalty for any same-sex consensual activity will be capital punishment, stoning of individuals that engage in same-sex activity. That's one of the countries that we've decided to open our markets to in the TPP. In Malaysia, same-sex activity was alleged, I think never proven, against a political rival of the leader of Malaysia. And that is the country in which a cartoonist was recently sentenced to 5 years for criticizing the court that upheld the faulty sentence of that competitor of the leader of Malaysia. When we engage in these trade agreements with these countries, and all that we do is put human rights on a wish list, and that wish list of human rights does not even mention the important rights of the LGBT community, I think that we sell our country short. I believe that we can enjoy the benefits, the economic benefits of greater international commerce and remain true to our values. And I believe that your amendment really centers on a problem that affects much of the world, but we have an opportunity to deal with it here. And this is one of the reasons why giving away all of our authority in fast track without addressing these issues is so very important. So I appreciate you raising the issue. It's yet another as to why we need active congressional participation to see that these issues are raised. I thank you, and I yield back.
Anybody else seek time? I think gentlelady is recognized for the purpose of closing on her amendment.
Thank you, Mr. Chairman. I want to thank my colleagues who have spoken in favor of this amendment. But most especially, I'd like to thank Mr. Lewis for calling me young. I'd also like to thank Mr. Brady for agreeing that LGBT is part of internationally recognized human rights. But I do want to go back to the fact that it is merely an objective in fast track. It's not a condition precedent to entering into these negotiations. And what this amendment would simply do is just deny fast track procedures for countries that penalize or criminalize folks on the basis of their sexual orientation. It doesn't say you can't negotiate trade agreements with them. They would just be subject to Congress being able to amend them and perfect them. I think it's important that as the democracy that holds itself out as the shining example to other countries, we need to lead and be very clear with where our values lie. And although economically tempting to engage in trade with countries that have a lot of catching up to do, quite frankly, when it comes to basic human rights, I think it's appropriate that it should be a condition precedent to fast-track procedure. The president wants something. He wants expedited negotiating authority. We should send him a very clear message about what we want to see him negotiate and with whom. And again, we are discussing the parameters for the authority as TPP is wrapping up or finishing up. I wish we would have had this conversation at the start of TPP negotiations because it might have influenced exactly the direction in which those talks went. So again, I think it's a simple amendment. I think it's not asking a lot to say that if we as a democracy hold ourselves out as the model for other countries around the world, we should hold those countries to the condition precedent that you cannot torture or kill people based on the fact of their sexual orientation. And with that, I will yield back the balance of my time.
Gentlelady yields back the balance for time.
Mr. Chairman, I withdraw my reservation.
Mr. Reichert withdraws the point of order. The point of order is withdrawn. The question is on agreeing to the amendment offered by the gentlelady from California, Ms. Sanchez. All those in favor signify by saying aye. Those opposed signify by saying no. No. Nope. Pending the chair, the noes have it. A recorded vote is requested. The clerk will call the roll.
Mr. Johnson. Mr. Johnson, no. Mr. Brady. Mr. Brady, no. Mr. Nunez. Mr. Nunez, no. Mr. Teaberry. Mr. Teaberry, no. Mr. Reichert. Mr. Reichert, no. Mr. Bustani. Mr. Bustani, no. Mr. Roscom. Mr. Roscom, no. Mr. Price. Mr. Price, no. Mr. Buchanan. Mr. Buchanan, no. Mr. Smith of Nebraska. Mr. Smith, no. Ms. Jenkins. Ms. Jenkins, no. Mr. Paulson. Mr. Paulson, no. Mr. Marchant. Mr. Marchant, no. Ms. Black. Ms. Black, no. Mr. Reed. No. Mr. Reed, no. Mr. Young. Mr. Kelly. Mr. Kelly, no. Mr. Renacci. Mr. Renacci, no. Mr. Meehan. Mr. Meehan, no. Ms. Nome. Mr. Holding. Mr. Holding, no. Mr. Smith of Missouri. Mr. Smith, no. Mr. Levin. Mr. Levin, aye. Mr. Rangel. Mr. Rangel, aye. Mr. McDermott. Mr. McDermott, aye. Mr. Lewis. Mr. Lewis, aye. Mr. Neal. Mr. Neal, aye. Mr. Becerra. Mr. Becerra, aye. Mr. Doggett. Mr. Doggett, aye. Mr. Thompson. Mr. Thompson, aye. Mr. Larson. Mr. Larson, aye. Mr. Blumenauer. Mr. Blumenauer, aye. Mr. Kind. Mr. Kind, aye. Mr. Pascrell. Mr. Pascrell, yes. Mr. Crowley. Mr. Crowley, aye. Mr. Davis. Mr. Davis, aye. Ms. Sanchez. Ms. Sanchez, aye. Mr. Young? Nay. Mr. Young, no. Ms. Nome? Chairman Ryan? Chairman Ryan, no.
I mean, not too long, but I don't think it's going to be that quick. The clerk will report the vote.
15 yeas, 22 nays.
15 ayes, 22 nays. The amendment is not agreed to. One more amendment. And I have an amendment at the desk. I will ask staff to distribute. The amendment, let me just explain what this amendment is. The amendment makes changes in line with the version reported by the Senate Finance Committee last night. It first includes a principal negotiating objective that reinforces our opposition to official actions that boycott, penalize, or otherwise limit commercial relations with the State of Israel. Second, it moves the good governance, transparency, and rule of law overall negotiating objective, which includes reference to internationally recognized human rights, to become a primary negotiating objective. At this time, I'd like to yield to Mr. Roscom, who has done the yeoman's work on the Israel boycott language. I want to thank him for his excellent work on the Israel issue, and I'd like to invite him to make any comments he chooses to make.
Thank you, Chairman Ryan. You know, it's fitting that we're considering this this week. This is the 67th birthday for the State of Israel. And if you take a step back and look at the challenges that Israel has had, the first challenge was largely a military challenge through the War of Independence and then subsequent wars. The second challenge was largely the challenge of terrorism, and those things have not been able to wipe Israel off the map. But the third is a more insidious challenge, and this was brought to my attention by the former Israeli ambassador, Michael Oren. And the third challenge is this: to isolate Israel and to make Israel not legitimate and to make it a fringe country. It's known as the BDS movement, boycott, divestment, and sanctions, and it is bad, bad news. Now, lest we think that this is only a foreign policy question, let's not kid ourselves. We are the tax writing committee, we are the trade committee, and the U.S.-Israeli free trade agreement was the first free trade agreement that ever existed, and so now we have an opportunity to defend this. And what this does is very simply, it says that it should be a principle or a goal to make sure that these types of attacks, these types of efforts to marginalize Israel, our trade partner, we push back very, very hard against them. I want to congratulate Senators Portman and Cardin, who were successful in putting this amendment together in the Senate version. I want to thank my colleague, Congressman Vargas, with whom I've worked extensively over the past several months on this issue, and I urge its passage and yield back.
Gentleman yields back. Yeah. Gentleman moved to strike last word. Yeah. You might want to turn your mic on there.
I think this is...
Yeah, go ahead. Can you get it?
Yes. I think this is one exciting political idea. I don't know how it's germane to a trade bill, but I assume that all of this has been cleared with the parliamentarian as it relates to...
It has. The gentleman will yield. It has been cleared to the parliamentarian. As you've heard us repeatedly mention throughout this markup, we've been trying to protect the agreement that is bipartisan, bicameral, and keep this agreement intact. This amendment conforms to that agreement.
Good, because if I'd known you were going to do this, I would provide sanctions against any country doing business with Iran so that we could just wrap up this whole Middle Eastern thing here. And
if only it would be so easy.
You know?
Yeah.
So how do we improve this? Since I didn't know this was coming, that I didn't know we were going to have we're going to do this to the other countries. Let me ask Mr. Reif here now.
Reif.
Can we provide sanctions against partner countries in this if they are supportive of something against the state of Iran? or any other country for that matter, can we unilaterally tell the rest of them that we got to provide sanctions for them? How does this work? Is it like if you violate this, everybody's going to pay for it or what? Well, why don't you explain it since it's been cleared through you?
Thank you, sir. So what this provision would do would add a negotiating objective, particularly targeted towards the TTIP negotiations with Europe, to say that countries should not be engaging in this movement, the divestiture and the boycott movement involving Israel. And it includes
That's good,
that.
but
Yes.
how does this relate to the negotiations with the other countries? I mean, if we put this in a bill, has this been already negotiated by USTR?
So the subject of the boycott and the participation of some European countries is something that the State Department is discussing with them through their
Let me
own.
try it again, Mr. Reif. We don't want to bring down this tremendous bill, right? It's a very important historic piece of legislation. My only question, since we cleared it with the parliamentarian, is did our trade representative believe that this was a proper subject to bring into, was it discussed with him, and you representing him, not the parliamentarian? I just wanted you to weave this into the success of our trade agreement.
Yes, it has been discussed, and we are supportive of including this amendment in the base bill.
Will the gentleman yield?
Yes.
I'd like to point to the fact that the gentleman, myself, and Mr. Reif in 2006 negotiated this very language for the Bahrain trade agreement. This is not new language. This is language that we put in Bahrain, and if I'm not mistaken, in the Omani agreement as well.
I'm not objecting to the
So
language.
this is not new to the committee, and this is
I am not
clearly
objecting.
germane.
I was just startled since this had never come up before, and wondered whether I would have an opportunity to provide sanctions against any other country that does business with Iran. I mean, I know an election's coming up, but I just would figure we could strengthen this thing and knock off Iran at the same time we support Israel. You think that would be germane?
So I can speak about this amendment, sir. I don't know about others.
I'm
On
talking
this-
about germaneness. I know that you
This
support.
is germane because this is an element, this is a negotiating objective that we would be engaging with European countries on, and indicating that the United
I
States.
know what this is. I'm asking you,
Mr.
do you
Reif.
think there would be any objection if we negotiate and told them that it'd be violative of this agreement if they do business with Iran? That's my point. What do you think?
Sir, I'm not, I think, in a position to entertain that suggestion. It's
Okay, what
something
do you
that
think,
comes as a
Mr.
little bit of.
Chairman?
So
that idea.
let me say in the next 15 seconds, Mr. Reif's not the parliamentarian, so he can't speak to germaneness. You're asking a new
I'm talking
policy.
about the
You're
right
asking
thing
for.
to do.
You're asking the question of a new policy that the gentleman has not been able to
No,
consult
I'm
with.
asking you now.
What we have before us is something that has been vetted and agreed to and scrubbed on a bicameral, bipartisan basis, along with the administration. What you're asking is something that has gone through none of that analysis.
No, because I never knew you were thinking this way.
Well, here you have it.
Well, I yield back the balance.
Okay, the gentleman yields back the
Chairman?
balance of his time. Anybody else? Mr. Doggett?
Yes. Mr. Chairman, when you refer to a.
Mr. Doggett, move to strike last word.
Move to strike last word.
Gentleman's recognized.
When you indicate there is a bicameral, bipartisan agreement, you're referring to an agreement between yourself and the ranking member and chair of the
Yes.
Senate Finance
Yes.
Committee and the administration?
Correct.
On each of these?
Correct.
Okay. And does, this amendment will, to some extent, allow us to conform the House bill
That's right.
to what the Senate has passed?
That's right.
Did you also include in that the human trafficking amendment that was adopted in Senate Finance yesterday?
No.
Is there a reason for excluding? I know this was a delicate balance, so delicate we couldn't
It
even
was.
have
The
a
reason
sense
is
of
it was
Congress.
not agreed to by all parties involved because it adds more complications than I think the drafters of the amendment at the time thought.
I mean, it was approved by a good majority in the
Right.
Senate Finance Committee, but a provision here on human trafficking is being rejected?
No, nothing's being rejected. We're just adding what has been agreed to by the administration, the majority of this committee, and the majority and the minority of the Senate Finance Committee.
Who objects to the including
I think there are,
limitation on
I think
human
there are
trafficking?
concerns, if the gentleman will yield, I think there
Surely.
are concerns that that amendment went beyond what people thought it did, because what it does is it excludes a particular country from TPP negotiations, which makes it extremely difficult to put TPP together.
Malaysia, which has
Yes, that's right.
not only a bad record on other human rights, but is very involved in human trafficking.
No argument there, only that it makes it much more difficult for this administration to negotiate TPP with all the TPP countries.
And lastly, as to the amendment that we will be adopting, and I expect by unanimous consent,
I believe that's the case.
it adds these provisions concerning Israel to the wish list. You chose not to make it mandatory, make it a condition. You like doing something here that would be supportive of Israel, but not so much that you made it a mandatory provision in the agreement.
The gentleman will yield. I think we've had, what, about 10 hours of debate on principal negotiating objectives, not wish lists, versus mandatory. That speaks to the entire nature of the debate we've been having, which is whether or not we're exceeding the direction that TPA ought to go to give the negotiators ability to negotiate with other countries, or are we having 535 negotiated trade agreements? We disagree on that.
And we have disagreed respectfully, and I appreciate
absolutely.
the way you've run the hearing, but though you may not agree with my term wish list,
I
it
don't.
will be entirely possible, though, with the amendment, if we adopt it, because we believe in support of Israel, it'll be entirely possible to adopt this amendment and never have a word about this in any future trade agreement, because there's no requirement. It's just hoping and aspiration that this will be done.
I guess I have more faith in the president than you do.
Or the next president, or whatever, but
the next
on this issue, perhaps you do. Thank you, and I yield back.
Gentleman from Wisconsin, would you like to be
Chairman,
recognized?
I'd like to strike the last word.
Gentleman's recognized.
Just for my clarification, Mr. Chairman, the amendment you're offering here, this is identical language that was adopted in the Senate Finance markup yesterday?
Yes.
Okay, and it only applies to the ongoing TTIP negotiations?
No, it applies to the principal negotiating objective for the TPA.
For
TPA, which
for
is
TPA.
TPA.
Okay. But TTIP is specific.
My bad.
TTIP is specific.
I apologize. It's just TTIP. You're right.
Okay.
You're right.
Just the TTIP, not TPP
Correct.
negotiations either.
Correct.
Right. And I guess, Mr. Reif, a question for you and the administration. With this language, and I understand the chairman's not prescribing what type of action could be taken, but just looking over these paragraphs quickly, I is to discourage, subparagraph II to discourage, subparagraph III to seek elimination. Do you envision any enforcement mechanism with this at all that could lead to trade sanctions or what?
Mr. Kine, I think it's a little early in the discussion of the TTIP and the role of this particular amendment. I think the purpose of it is to underscore to our negotiators, as well as others who are engaged with a number of countries participating in the TTIP negotiations, the importance of this issue, the importance of pushing back on this BDS movement. And that's, I think, the key purpose of including this, incorporating this as a principal negotiating objective at this time.
So right now, you can't tell whether this might lead to some type of enforceability or sanctions effort in the context of TTIP negotiations. Is that right?
I think it's early yet to describe exactly where.
Well, would our negotiating partners in the EU be surprised with the addition of this amendment to TPA?
So I haven't been engaged with them in a discussion of what would be in the TPA. They are aware of our concern as a country, I believe both from our agency and principally from the State Department, which leads on this issue.
Has there been any discussion about this with the EU?
I'm not, Mr. Khan, I'm not in a position to answer that.
Okay. Thank you, Mr. Chairman. I yield back.
Gentleman yields. Mr. McDermott, do you seek time? Gentleman's recognized.
Back to the last word. Mr. Reif, we hadn't had a
bit of discussion about TTIP until just this moment. So I'm unfamiliar with what's going on there. Which countries is this directed at? I mean, why did the Senate think that they had to put a provision in to say that a country could not engage in a boycott? Are they talking about Germany? Are they talking about Italy? Are they talking about France or Spain or Belgium? Or who are they talking about? Or is this?
So thank you, Mr. McDermott. I don't know specifically what countries may have motivated this. There is a concern. My understanding of the derivation of this provision that arose yesterday in the Finance Committee and now is here is that there is concern about the susceptibility towards this BDS movement in some European countries. So we are seeking to make clear through a number of different channels, through our State Department and here in the trade sphere, because of the importance of the TTIP conversations, because that is a conversation that encompasses the European Union Commission as well as the individual member states of the EU, to make clear that the United States is concerned about this issue and wants to work with the EU and with the member countries to push back against this BDS movement.
Well, what I understand that you're saying is that, let's say, the French got their back up and decided they were going to join the BDS operation and put on a boycott against Israel. They would not be included in TTIP, or they'd be somehow excluded because they had instituted a boycott. Is that correct?
So in the first instance, Mr. McDermott, these will be conversations, as with other parts of the trade negotiation, these will be conversations between U.S. government officials and government officials in individual member countries, as well as with the European Union Commission.
Now
This will be a
that would not be the same. We had an amendment down here from Ms. Sanchez about the LGBT community. And we're not saying we're going to exclude anybody because they have some kind of policy, legal or otherwise, against gay people or LGBT generally. They would not be excluded. We're not going to kick out Brunei on that basis, or Malaysia or some Muslim country because they have this policy. We voted that down here. And now we're saying if somebody else has that kind of law or social movement going on in the country, we're going to exclude them. Is there, I'm trying to see what the equivalency here is.
So perhaps I can, Mr. McDermott, perhaps I can suggest that Congressman Roscom described his purpose in offering this, but may also offer a historical comment. Europe and the rest of the world has been aware of the United States' concern about this problem, the boycott issue, for more than 35 years. It arose in the late 1970s. Legislation was passed by the Congress on a bipartisan basis, been reinforced since then on a bipartisan basis. This is a many decades-long concern. This is simply the most recent iteration of this boycott movement, and so I think there is broad awareness of the concern by the United States.
But it would never be used to exclude. It never has been in those 40 years you've been talking about. And we've never excluded any country who's had any kind of boycott going on.
Sir, I don't think the amendment talks about exclusion of countries. And in my attempt to offer clarifying answers, I have not used that language. What I've indicated is, like other negotiating objectives, these will be directions to our negotiators and to other government, U.S. government officials to engage with countries to make clear what our concerns are.
So, but what I'm trying to understand from the USTR's point of view, you would go to the table and you would say, if you have a boycott, you got to get rid of that boycott, or we're not going to sign you up into the TTIP.
Mr. Richter, I've tried my best to offer as much clarification as I can. I don't think I'm in a position to go and offer more detail on that.
Is what does this allow you to do? It would allow you to do what I just suggested, right?
What this would allow our negotiators to do is to raise this issue specifically punctuating the role of the Congress in providing these negotiating objectives to us, which has been a very important part of the United States' engagement on the boycott issues over many decades. It will enable our negotiators to raise these issues.
Time for the gentleman's expired. Why don't let's recognize Mr. Roscom. Maybe he can shed some light for you. Mr. Roscom is recognized.
Thank you, Mr. Chairman. You know, I think what we're trying to do here is to send a very clear message, particularly to the Europeans. How this manifests itself in the future, how this plays itself out, is not clear at this time. But here's one thing we need to do. We need to send an unambiguous message that the United States chooses not to be complicit with efforts to isolate Israel. In fact, we choose to do everything we can to make sure that Israel is an economic success. Why? Because that is in the best interest of the United States of America. That's why. So to say that this is now a principal negotiating objective of the United States is to say, all right, this is on this list. And as you're going in and negotiating, raise these issues. But this is not hypothetical. This is not something that's just, you know, in some white paper somewhere. Let me give you a couple of examples about how real this is. There's a number of European countries, such as the UK, Norway, Denmark, and the Netherlands, that are actively wielding economic instruments to pressure Israel into unilateral political concessions. Sweden's Nordea Bank, Denmark's Danske Bank, and the Netherlands' largest private pension fund have divested from Israeli financial institutions. Contracts with Israeli entities have been canceled at the urging of home governments, not just private participants, but home governments for alleged violations of international law. And it goes on and on. So here's the point. Let's communicate clearly that the United States chooses not to be complicit in this. Let's empower the USTR to say this is one of many principal negotiating objectives. And then at that point, there could be subsequent activity that this committee has to be involved in. But I think we ought not underestimate our ability to be a restraining influence on absolute nonsense that's happening on the other side of the Atlantic. Absolute nonsense. And to isolate one country and to have one country set to a standard that no other country is held to. And this doesn't have anything to do with the adventures in Iran, which we've got a very rigorous sanctions regime on. This is about one country that is being singled out unfairly by enemies. And this is an opportunity for this group right here tonight to have a disproportionately positive effect. And so for us to mirror what has happened in the United States Senate, to pick that language up on a bipartisan basis and to move forward on this, I think is going to be a very, very, very good thing. I yield back.
Mr. Pasquarello, do you seek time?
Very short.
Good. Gentleman's recognized.
Mr. Chairman, I think that there isn't a member, I know many of the folks here on this panel, that doesn't support Israel 100%. But this amendment, this proposal here, is really ambiguous at best. You know, we mentioned how many times the term the delicate balance throughout the day. Got to keep that delicate balance. You proclaim this, and you insert this as a requirement. What about public health? What about labor? What about food safety? Aren't they as critical as what we're talking about here? No one disagrees. No one's questioning your motivation, not yet. But it would seem to me that this is a bit Pyrrhic in the midst of our debate at the end of the evening for us to insert this. A little suspect, just a little bit. And I don't know, Mr. Chairman. I don't know. We couldn't get some other things done, but we can get this done? It doesn't make sense. Where's the delicate balance that we're talking about? Thank you, Mr. Chairman.
Gentleman,
You've
yields
been very
back.
patient today.
Gentlemen test it sometimes. The delicate balance is established and achieved when we pass this amendment. Mr. Crawley, did you want to seek time?
I do, Mr. Chairman.
Yep. Gentleman's recognized.
Mr. Chairman, just a quick question. I understand that this is directed towards the TTIP negotiations. Is that correct?
Correct.
And I'm asking you, Mr. Chairman, is that correct, Mr. Chairman?
Yes.
Is there any reason why this was not done? And by the way, let me preface this by saying I would have called to attention the rise of anti-Semitism throughout Europe. Very familiar with the ongoing movement within the academic world within Europe to boycott Israel. I've been strongly speaking in opposition to that, and I understand where this comes from. I understand this was done in the Senate. I understand Mr. Roskam's and your, Mr. Chairman's, objective here. But it's not the only part of the world where there is anti-Semitism, anti-Israel sentiment. And my question is, I'm also very aware of the Arab boycott.
Yes.
I don't know what Brunei's position on that is. I don't know what Malaysia's position on that is, and as to why it is that we're focusing on the European, which I understand why we're doing that, and not on all the agreements that are being covered by this fast track. Why is it that Europe is being isolated here and not what's happening in the Pacific? I don't know what that answer is. I don't know what those countries' positions are, but I suspect that many within those countries may also be engaging in anti-Semitic, anti-Israeli movements. Just a guess on my part.
Will gentleman yield?
I will.
I think because of what Mr. Roskam said and the alarming trend that is underway in Europe in particular.
Reclaim my time, Mr. Chairman.
Okay.
I understand the alarming trend that's happening in Europe. I understand fully the history.
That answers your question.
No, Mr. Chairman, it's my time. That I understand in Ireland, for instance, where our forebears came from. I understand the movement that's taking place in parts of Ireland, in parts of Great Britain, in France, and Germany, where we had a horrific war that led to the slaughter of 12 million people, including 6 million Jews. I understand that. And I'm not arguing the merits of doing this for the TTIP. My question is, why is it not a part of the negotiation with the TPP countries? I don't know if necessarily New Zealand or Australia. I mentioned Brunei and I mentioned Malaysia just too, but whether those other countries also have a similar movement. I know the connection between Great Britain, Australia, Ireland, and New Zealand, et cetera, is just an example. That maybe some of the thought process that goes on in Europe is actually happening in Pacific. I don't know. I'm not casting dispersions. I'm just asking, why is it that it's simply focused on Europe and that negotiation, and not on all trade agreements that we go forward with? I think it's a good idea. I'm not opposed to it. I want to know why it is we're not doing this for all trade agreements moving forward.
Will the gentleman yield?
Yes, Mr. Ross.
So I think the reason is that there's, you answered the question basically, and I want to echo back an argument that you made, and that was the pace at which this is happening in Europe. The pace that it is nowhere near in terms of scale. Europe is far ahead of the rest of the world, literally, than anybody else.
Let me reclaim my time. I don't pretend to know, and maybe if Mr. Reif has an answer, or someone has an answer as to how far gone the Arab boycott is, or how far gone the Muslim boycott is to Israel. Now, I would suggest, I know that, for instance, Bangladesh does not deal directly with Israel. They're not a part of the TPP. Maybe someday they will be, I don't know. I know there are other countries in that region that don't have not only diplomatic relationships with Israel, they don't have trading relationships with Israel. So in terms of going too far, I think some countries are already way over anti-Semitic and anti-Israel, some that have called for its destruction, or at least support its destruction, or support the terrorists that want to undermine it. So I would disagree with the sense that I don't think that the government of France itself is at that point yet, nor do I think the government of Ireland or the government of Great Britain. There are other governments in the world that actually have those objectives. And I would just suggest that we're talking only about the TTIP. I'm not objecting to this particular motion. I'm asking a question, why is it not applied to TPP? Why is it not applied to other trade agreements?
Mr. Crowley, I can only echo Mr. Roscom. I think that the sense of
That's not the echoing.
cause of, yeah, I mean, that's the thing, the
Mr. Raff, I
derivation
understand
of the
it.
amendment was
You may not be in a position
problem
to
in
answer the
Europe.
question. I think that's probably more.
Time for the gentleman
more
expired. I
lines.
would just say to the gentleman, he may not like the answer, but he got an answer to his question.
He did. He agreed with Mr. Roscoe.
Yes, and Mr. Roscom answered your question.
No, Mr. Roscoe answered the question the way which he wanted to. He didn't answer my question.
Well, he didn't answer it the way you wanted him to answer it,
That's
but
correct.
he answered the question.
Yeah, maybe that's correct. Yeah.
I think I'm a graduate.
Why is it not applied to
I don't-
TPP?
think
Why
I'm a-
is it not applied to TPP?
All right, time for the gentleman is
Mr.
expired.
Roscoe, why is it not applied to TPP?
Time.
That's the question.
I don't think he has the answer for that. Time for the gentleman is expired.
And he doesn't have an answer.
Move to
for me. I
strike the
appreciate
last
it, Mr.
word.
Chairman. Thank you.
On
Did
this
you already get?
Not on this amendment.
You didn't?
Nope.
You, all right. Gentleman's recognized.
Mr. Chairman, with reference to this amendment, would you and it's your amendment, I believe, would you be open to a unanimous consent request to apply it to any agreement negotiated with this fast-track authority?
No, I would not, because the primary goal of this amendment is to get us in conformity with the Senate finance mark that came out of Senate finance mark.
Well, it's good for us to get in conformity with the Senate. It's also good for them to get in conformity with us.
Well,
I know
they're already out of committee.
I know that, well, they have a little more free amendment process over there in the Senate. Reclaiming my time, it would seem to me that if we have a good idea in this committee, if there's really a strong commitment to Israel, and this is not just something done here on the eve of an election, and if we're willing to unsettle the delicate balance that we have heard about all day long that prevents even a sense of Congress resolution regarding future participation by China, that we would want to apply this to all agreements negotiated in the 6 years of this fast-track authority, and we would not limit it to one possible agreement. Let me ask Mr. Reif if you know whether either Malaysia or Brunei are participating in any boycott of Israel. Surely that must be something you've explored, given the sensitivity of the administration to this issue.
Mr. Doggett, I've done my best to answer the questions about this amendment.
I'm not asking you about the amendment. I'm asking you whether Brunei participates in any boycott of Israel.
Yes, I don't have further information.
Along with their Sharia law. And how about Malaysia? Does it participate? Do you know whether it participates in any boycott?
I don't have further information, sir.
Well, I think that if there is really a deep commitment to addressing this issue, it wouldn't be narrowly targeted to just one agreement. We don't even know how many future agreements over the course of the next 6 years may come up, and with which countries, and which countries may use the TPP to be added. And I would think we would want to ensure, if our commitment is deep and comprehensive to Israel and to this issue, we wouldn't limit it to one. We would certainly, because this amendment specifically addresses not just this discussion in Europe, but it refers to the Arab League boycott of Israel. I don't know whether Brunei or Indonesia, that might join this agreement in the future, the largest Muslim country, or Malaysia, are participating in the boycott or not. I'm surprised that USTR would agree to an amendment like this without knowing. But I would, Mr. Crowley, I'd be glad to yield the balance of my time to you, because I think you have raised a very important issue with this surprise amendment after hearing nothing else could be accepted that appears to be helping on part of this, but it would seem to me we ought to apply it to everything under this fast-track negotiating authority.
I appreciate Mr. Doggett for yielding me the balance of your time. I do think it's intriguing. At the 10th hour, literally it was a 10th hour so this amendment was brought up. I was not aware this amendment was going to be brought up this evening, but I do think it's applicable to all trade agreements. If this standard, which I believe in, again, Mr. Roskin, Mr. Chairman, should be applied to Europe, it ought to be applied to all the trade agreements that we're entering into. I think Israel is that important to our country. to our national security and to theirs as well. Mr. Chairman, you probably have already indicated you will not amend your amendment. Is that correct? Correct. To include, so the majority side is not willing to amend the amendment before us to include the TPP in this attempt to.
Will the gentleman yield?
Yes, I will.
I'm advised that APAC originally asked that this apply to all free trade agreements, which is exactly what you and I are advancing here, that if we're going to add this amendment at the last minute, that the House have an opportunity to expand it to all free trade agreements. And it's hard to understand why, at this late point, USTR wouldn't even know what the effect would be in these other agreements.
Well, as I've indicated, I would support that for all the trade agreements, including the ones that I've supported in the past, and some that I may support in the future. Mr. Chairman, I think it's that important. You've raised the issue here at the 10th or 11th hour. It is that important. We ought to show the support to Israel that it deserves, and that is not just for trade agreements that deal with Europe, but for all those countries that we suspect have anti-Semitic, anti-Israel motives.
Time for the gentleman has expired. The committee will note his enthusiasm for the issue. The question is on agreeing to the amendment offered by myself. All those in favor signify by saying aye. Aye. Those opposed signify by saying no. In the opinion of the chair, the ayes have it. The amendment is agreed to. There are no further amendments. I will now recognize Mr. Johnson for the purpose of offering a motion.
Mr. Chairman, I move the committee favorably report H.R. 1890 as amended to the House of Representatives.
The question is on favorably reporting H.R. 1890. All those in favor signify by saying aye.
Aye.
Those opposed signify by saying no.
No recorded vote.
In the opinion of the chair, the ayes have it. The motion is agreed to. A roll call vote has been requested. You sure you want a roll call vote?
Sure.
A roll call vote has been requested. The clerk will call the roll.
Jesus.
This is final on TPA.
Mr. Johnson? Mr. Johnson, aye. Mr. Brady? Mr. Brady, aye. Mr. Nunes? Mr. Nunes, aye. Mr. Teaberry? Mr. Teaberry, yes. Mr. Reichert? Mr. Reichert, aye. Mr. Bustani? Mr. Bustani, aye. Mr. Roscom? Mr. Roscom, aye. Mr. Price? Mr. Price, aye. Mr. Buchanan? Mr. Buchanan, aye. Mr. Smith of Nebraska? Mr. Smith, aye. Ms. Jenkins? Ms. Jenkins, aye. Mr. Paulson? Mr. Paulson, aye. Mr. Marchant? Mr. Marchant, aye. Ms. Black? Ms. Black, aye. Mr. Reed? Mr. Reed, aye. Mr. Young? Mr. Young, aye. Mr. Kelly? Mr. Kelly, aye. Mr. Renacci? Mr. Renacci? Mr. Renacci, aye. Mr. Meehan? Mr. Meehan, aye. Ms. Nome? Ms. Nome, aye. Mr. Holding? Mr. Holding, aye. Mr. Smith of Missouri? Mr. Smith, aye. Mr. Levin? Mr. Levin, no. Mr. Rangel? Mr. Rangel, no. Mr. McDermott? Mr. McDermott, no. Mr. Lewis? Mr. Lewis, no. Mr. Neal? Mr. Neal, no. Mr. Becerra? Mr. Becerra, no. Mr. Doggett? Mr. Doggett? Mr. Doggett? Mr. Doggett, no. Mr. Thompson? Mr. Thompson, no. Mr. Larson? Mr. Larson, no. Mr. Blumenauer? Mr. Blumenauer, aye. Mr. Kind? Mr. Kind, aye. Mr. Pascrell? Mr. Pascrell, no. Mr. Crowley? Mr. Crowley, no. Mr. Davis? Mr. Davis, no. Ms. Sanchez? Ms. Sanchez, no. Chairman Ryan? Chairman Ryan, aye.
The clerk will report the vote.
25 yeas, 13 nays.
There being 25 ayes and 13 nays, the bill is agreed to. H.R. 1890 is ordered favorably reported. Without objection, I ask that staff be authorized to make technical and conforming changes to the bill, and the members may have 2 additional days to file with the committee clerk supplemental, additional, and dissenting or minority views. Let me also say, for the record, it's been 13 years since this committee passed this kind of legislation. 13 long years. And so I understand this has been a long day. We've been here since 9 a.m. this morning. We've got 2 more bills to get to, which won't take as long. But I want to thank all of the members of this committee for a very civil but a very vibrant debate. It's a big issue, and it is receiving the proper amount of attention. And I want to thank all of our members of this committee for the conduct of this high-quality debate.
Could I second that?
Absolutely. Thank you. Our third order of business is a bill introduced by Mr. Reichert, the Trade Adjustment Assistance Reauthorization Act of 2015. Mr. Reichert, you are now recognized for an opening statement on your bill.
Thank you, Mr. Chairman. I speak today in support of H.R. 892, the Trade Adjustment Assistance Reauthorization Act of 2015. This bill is the cornerstone of a carefully crafted bipartisan bicameral agreement that has allowed us to move forward with this robust 4-bill trade package. During our conversations on TPA, it became clear that the future of TPA was uncertain if there was no bipartisan deal on TAA. We took this to heart and made a decision that we had to do everything in our power to reach an agreement so that the trade package could move forward with support from both sides of the aisle. Now, many Republicans, too, understand the necessity for a TAA program. There's no question that trade is a big net positive for America. In the state of Washington, this is most certainly true. That doesn't mean, however, that there won't be some communities that see the downside along the way. TAA program makes sense to help these workers get back on their feet and once again support their families. But that doesn't mean just any program will do. No, we need a streamlined and cost-effective TAA program, and that's what we have here today. The core principles of our conference, ensuring smaller government and cutting spending, were the foundation of our negotiating stance. As a result, contrary to initial demands that we reauthorize the 2009 TAA law, we agreed to return to the 2011 TAA compromise and build on that. We streamlined TAA as a whole. For example, the TAA for Community Colleges program created in 2009, the 2009 law, and funded at $500 million per year is not reauthorized. Funding for training, administration, and services other than benefit checks is consolidated and reduced by 22% from $575 million per year under the 2011 legislation. We also made some important improvements to TAA by further enhancing the performance measures and accountability in all of the TAA programs, including aligning TAA with other job training programs. On top of all that, we fully offset the program so that the taxpayer will not pay an additional dime. I encourage my colleagues to consider the 4 votes today as a comprehensive package and a model of bipartisanship for creating jobs and enhancing economic growth in this country. And therefore, I urge all my colleagues to support this legislation, and I'd like to yield some time to Mr. Reed.
Well, I thank the gentleman from Washington for yielding, and I join him in the efforts, as well as my colleagues on the other side of the aisle, in recognizing that trade presents an opportunity to create jobs and supports millions of jobs across America. 38 million jobs across America, with 2.6 million jobs in New York State alone. The new trade deals being negotiated have the potential to create tens of thousands of new jobs, but as articulated by my friend from Washington, there may be some individuals and businesses that are adversely impacted as a result of these negotiations and these trade agreements. And so I stand with my colleagues on the other side of the aisle, and as well as my colleague from Washington, and urge support in this trade adjustment assistance program to recognize and care for those individuals and workers that are potentially going to be have adverse impacts as a result of the decisions being made here today. I would also applaud the reforms that have been recognized in the TAA as negotiated and agreed upon, where we're aligning the job training and programs with other work training programs across America, improving the program's accountability, and giving states the latitude and flexibility to determine the most appropriate training and work supports for the TAA recipients in their local communities. And with that, I urge colleagues to join in support, and I yield back to the gentleman from Washington and thank him for doing the hard work on this issue.
Mr. Chairman, I'd like to yield the remaining time to Mr. Meehan.
I thank the gentleman, and we have well articulated throughout this hearing the 96% of the world's consumers outside of our shores, and 1 in 5 jobs tied to trade, which underscores the importance of the work we're doing here today with this bill. But it's a recognition as well that where some people may be put into position, particularly middle-class families who may be displaced as a result of trade-adjusted demands of the global economy, I think it's very, very important. We've all experienced in our own neighborhoods and backyards the impact that can happen. This legislation that has been put together, particularly the job training benefits and the maintenance of health insurance during this period of time, and from my own experience, it's that mid-level worker, sometimes halfway through his career, the ability to be able to get job training to get back into some of the new jobs that may be created by this are so vital. We've done this before. It's been alongside other trade authority legislation in the past. You've made great progress in streamlining and eliminating programs that haven't worked, and I hope that my colleagues on both sides of the aisle will be supportive of this important effort. Thank you.
Mr. Chairman? Mr. Chairman?
Who is seeking?
Mr. Chairman, I yield back.
The gentleman yields back. We're not in walkthrough yet. We're doing opening statements right now. So Mr. Levin is recognized.
Oh, okay, I'm sorry.
For the opening statement. Mr. Levin, you're recognized, and whoever you want to designate.
Well, there are several who want to speak. So why don't I just say something briefly? I'm an original sponsor of the TAA extension, and all of us on this side very, very much support its continuation, and to do so at appropriate levels of funding. We're going to have some amendments, or at least one, I think two, that relate to the pay-fors. And so I'll just say this briefly, and as you and I have discussed, though you're going to object to these amendments under so-called Rule 10, though you're going to do that, you're going to allow discussion. So let me just be very brief. I think the sequester, to start with, is a bad policy. I think it's a bad precedent to extend it beyond its current expiration. I think it's also very concerning to use Medicare money to pay for trade. And I think, finally, we just passed SGR, and now what we're going to do is to essentially ask for some additional monies from providers. So I think while I would like very much to vote for this, very much as someone who's fought for it for decades and who has, with my colleagues, placed legislation in order, I think you're going to find, as we discussed, that because of the pay-for, we're going to oppose it. Maybe I'll yield to you now.
You want to do it now?
Yeah, why don't I
Okay,
do
sure. The gentleman will yield. The gentleman and I have had conversations throughout the day on this issue. I understand people have concerns about one of the pay-fors, which is the Medicare sequester. I share those concerns. It is something that's in 2025. If we don't have the Medicare sequester fixed by then, 2024, no, and then it goes into 2025. Heaven help us. I mean, we've got to replace this Medicare sequester a whole lot sooner than that. I think that's what all of us want to do. The gentleman would like to explore options for replacing that. I'm willing to explore options for replacing it between now and when this gets into law, and when it gets to the floor, perhaps. So I'm willing to work with the minority on that. The amendments that we have here don't cut that muster. You can say anything about me today, but you can't say I'm inconsistent on Rule 10. I have to be consistent on Rule 10, and I do not feel I can be duplicitous on this. When I insist in other committees that they not go into our jurisdiction, I can't do the same here in this committee. Therefore, for the people who are going to be offering amendments that are not in our committee's jurisdiction, I'm going to have to invoke Rule 10 for consistency's sake. But let me just say, I am happy to work with members to find a better offset that can also comport with the agreement and get, look, we just changed on the Israel boycott. I'm happy to work with members of the minority and members of the Senate to try and come up with a better mix for the pay for.
All right, so,
Chairman Neal.
well, that's my time. So, now you, I just want to say, therefore, to drive home our point, how inappropriate this pay for is, we're going to, I think, vote no, just to make that point clear. At the same time, it is we on this side, if I might say so, more than any others, who have been pushing, who drafted, who originated TAA, and who have vigilantly supported it and will continue to do so. Mr. Rangel?
Yes, I was hoping that through talking this out, that there would be some way that we can support this watered-down TAA if somehow the chairman could just extend his willingness to change the spending, the support for this bill. I mean, I know he says he's willing to work with us, but I think he is trustworthy enough that you, Mr. Levin, and we should be willing to consider if he can say that he will find another support for this rather than child care, dialysis, and anything related to the already cutback in Medicare. I'm not suggesting that he publicly state his position, especially after you already said that we may have to vote against this. But I do hope that rather than have us to vote against it, that perhaps you two could have a sidebar, and if the chair was willing to say just one step further than just is willing to work, that we have to and we will find a better way to fund this already watered down TAA. I just ask you, as and respect all the work that you've already done, to see whether or not we can save the time and at the same time, without having checked with my colleagues, to see whether we can get a positive vote for the substance of the bill.
So let's go through the amendment.
Yeah, we're past time. I let the indulgent. Let's get, we still have the walkthrough to get through too. So let's go through the walkthrough, start the amendments, and then we'll get going here. So the committee will now proceed to consideration of H.R. 1892. Without objection, the measure will be considered as read and open for amendment at any point. I offer an amendment in the nature of a substitute, which was distributed in advance, along with a description explaining it. Without objection, the amendment in the nature of a substitute shall be considered as read, open for amendment at any point, and consider base text for purpose of amendment. Without objection, all minority amendments drafted to H.R. 1892 shall be considered as drafted to the amendment of a nature of a substitute. I will now turn to Angela Ellard, Staff Director of the Trade Subcommittee, to provide a description of the trade provisions, and Tom Barthold, Chief of Staff to the Joint Committee on Taxation, to discuss the revenue provisions, as well as Tim Reif, General Counsel at the USTR. I ask members hold their questions until the presentations. Ms. Ellard, you're recognized.
Thank you, Mr. Chairman. Section 2 of this bill repeals the sunset provisions that were included in the Trade Adjustment Assistance Extension Act of 2011 and reinstates prior law as of December 31st, 2013, subject to the changes made in the bill as of the date of enactment. In Section 3, the section modifies the authorization termination date for the TAA for workers, TAA for firms, TAA for farmers, and the reemployment TAA programs to June 30th, 2021. The section also caps total annual funding for training, administrative expenses, and employment and case management service expenses as well as job search and relocation allowances under the TAA for Workers program at $450 million for fiscal years 2015 through 2025, reduced from the $575 million under prior law. Section 4 contains extensive performance measurement and reporting requirements, amending the data collection and reporting requirements of TAA to align with the performance accountability measures and reporting requirements under similar federally funded job training programs, such as those implemented under the Workforce Innovation and Opportunity Act. Section 5 contains the applicability of trade adjustment assistance provisions. Section 6 has the sunset provisions. Section 7, my colleague, Mr. Bartold, will discuss the extension and modification of the health care coverage tax credit. In addition, the bill is fully offset. Section 8 contains customs user fees. Section 11, the coverage and payment for renal dialysis services for individuals with acute kidney injury. Section 12, the modification of the Medicare sequester for fiscal year 2024. And my colleague will discuss the remaining offsets.
Thank you, Ms. Ellard. Mr. Chairman, Mr. Levin, the members have before them Joint Committee documents JCX 77, 78, and 80, which describe the Internal Revenue Code provisions affected by the proposal before you today. There are three primary provisions amending the Internal Revenue Code. The first provides an extension of eligibility to all months before January 1st, 2020 for the health coverage tax credit. This is a 72.5% credit for premiums paid by eligible individuals for qualified insurance, and it also provides for the advance payment of this credit to insurance providers. The chairman's modification addresses an interaction between the refundable portion of the $1,000 child tax credit and the foreign earned income exclusion under the Internal Revenue Code. In general, the child tax credit is refundable, but subject to limitations on modified adjusted gross income and the amount of earned income that an individual has. By exempting certain earned income under the foreign earned income exemption, it's possible for some taxpayers who might otherwise be ineligible for the refundable portion of the child tax credit to be in a position on their tax returns such that they could receive a refund. The chairman's modification would exclude eligibility for the refundable portion of the child tax credit for any for taxpayers who claim any exclusion under the foreign earned income exclusion. And then lastly, the chairman's modification provides that corporate tax payments by large corporate taxpayers would be increased by 2.75% for payments due in July, August, and September of 2020 for their corporate estimated tax payments during that period, and that there would be an offsetting adjustment in the subsequent 3 months of 2020. That concludes my description. Happy to answer any questions that the members might have.
Any questions for the witnesses?
Yes, I do.
Mr. Rangel.
Under the present TAA, public workers who are adversely affected by trade, are they included now? I'm asking him.
Yeah, that's yeah, okay.
I might tell you, my problem is some people say they are covered and that this new bill, that they're excluded, and only employees from the private sector that's adversely affected would be eligible. So all I'm asking, is that true?
Yes, Mr. Rangel, it is.
It is true.
Is your question, I'm sorry, I didn't quite catch it. Is it regarding service workers? I didn't catch your question. I'm
Okay,
sorry.
the question is, we're talking about employees, public and private,
Yes, okay.
that are eligible under TAA now, today. Is that true?
No, only private sector workers are eligible today, and this bill continues the eligibility only for private sector workers.
So
not
public sector
public
workers were cut out, they never were in.
No, it's not in this
Okay.
legislation. Public
Now,
sector workers have not been eligible since 2011.
Okay. The other question I have is the amount of money that's available to help these people. Has that amount of money been reduced or increased to take in consideration TPP?
For TPP? I'm sorry, Mr. Engel, I thought
This
you said TPP.
trade agreement assistant basically is to support, I would think, the workers that are adversely affected as a result of the trade agreement. And in view of the fact that we have the greatest trade agreement since the history of the United States of America, and certainly in the last 13 years, I'm talking about the funding of the program, it would seem to me that there would be more people in need. I'm only asking in terms of the amount of money that's been set aside, whether or not there's more money for them, considering the onslaught of effect that it would have on the working people. Is it more or less money?
Well, Mr. Rangel, the way the legislation would work, any worker would be eligible if that worker's factory or facility moves to an FTA country or to any other country.
I'm not
And that would
framing
be-
my question correctly. We have a pay-for here that's coming out of healthcare and whatnot. How much money is that, Mr. Ballhart? Are we going to pay? How much money is involved in paying for this bill?
Mr. Engel, I'm not familiar with the total amount of
Let's start
customs
all over again.
user
We
fees.
have a bill here, and the major problem that we have is how it's being paid for. And I know that we just got finished cutting out 35 billion people for the healthcare industry, and I think it's generally accepted by both sides that at least for now, and the chair's going to work with us to make whatever changes later, but at least for now, we're asking that a certain amount of money be taken out of the healthcare industry to pay for TAA. I just want to know what that money is and whether or not the money for TAA has been increased or decreased. Any one of the three of you, or the chair.
I don't have the score on me, but what's the score of the Medicare sequester component?
It is
That's what he's asking.
$700 million.
$700 million.
And how much are we spending now? Are we increasing the amount of money that's going to be available for these workers or decreasing it? Okay, if you don't know, it's okay.
It's the baseline.
Okay.
We got the spreadsheet. I can show it to you in a spreadsheet.
Okay, listen,
Will a gentleman
I
yield?
don't have any more questions. I want to thank you for what you've told me.
Here's the table.
Okay, thank you. Thank you, Mr. Chairman.
Hang on, I got a long list here. Mr. Kind, you have questions.
Yeah, thank you, Mr. Chairman. I have some questions. Thank you, Mr.
Chairman's
Chairman.
recognized.
First of all, I appreciate the chairman's remarks at the beginning of this discussion about the offset problem that we have, and we'll look forward to working with you and others to see if we can find a more acceptable offset. This is a major issue, obviously, on our side. I'll have more to talk about it when I offer my amendment with the intent to withdraw it right away, so I don't care about Rule 10 with it. But questions in regards to the substance of this. It's my understanding that with this TA reauthorization that all employees in the private sector are eligible now for TAA assistance if they've been adversely impacted by trade, regardless of whether it involves a country that we have a trade agreement with. Is that right, Ms. Eller?
Yes, that's correct, Mr. Kind, yes.
And that is an expansion of past TAA practice where it was confined to just countries we have trade agreements, or is it consistent with it?
Yes, back in 2002, it was more limited. In 2011, the legislation was expanded to cover services workers and countries, the shift in production, as it's called. So regardless of whether it was an FTA partner, if your company shifted to another country, you would be eligible.
Does this reauthorization include service workers?
Yes, it
in
does.
coverage? But it doesn't include public sector workers, is that correct?
That's correct, it does not.
Is there a policy reason why we're excluding public sector workers? Or should I ask my friend from Washington State, Mr. Reichert, if he knows the answer to that
Yes, for a
question?
policy reason, I
Yeah. Dave, is there a reason why we decided to exclude public sector workers?
Well, the expansion of the program in FY 2009 included workers in public agencies was a temporary expansion during a time of above-average unemployment. In fact, for the 2 years under the 2009 TAA program, in which the public sector eligibility was allowed, 0 petitions, we're getting to the reason here, 0 petitions of public agency workers were certified. So based on this experience and based upon this information, there's no evidence that this policy, even if it were revived, would provide any assistance to the people actually affected by trade.
Okay, well, reclaiming my time, a couple of concerns jump out at me. One is there are instances of some states moving call centers overseas right now, and therefore displacing some public sector workers. But I also recall in the past that some military personnel had qualified for some TAA assistance. Is that correct, Ms. Eller? Are you aware of any instances of military personnel having qualified for TAA assistance?
I am not aware of military personnel who qualified. In fact, my understanding is that no one has ever qualified under the public service worker provision.
Okay. Well, we may want to check into that just a little bit further as we move down the line here. It's also my understanding that the healthcare tax credit has been restored, but only at 72.5%, not the original 80%. Is that right?
72.5%.
72.5, yeah. Again, Mr. Reichert, I'd defer to you if there's a reason why, other than just cost savings, why we're dropping from 80 to 72.5 for purposes of this reauthorization.
Well, the reason is that we've never really reached that cap. So the cut was as a result of looking at past expenditures and realizing that it never reached that 80%, but it was 72.5%. I think that's one of the
Not for tax purpose, not for tax
Will the
credit.
gentleman yield?
Yeah, I'd be happy.
Ms. Ellard or Mr. Barthold, that's current law. It was just an extension of the current policy, correct? It was 60 to begin with, then it went up to 80, and then it went back down to 72.5. We're carrying 72.5 out, correct?
That's correct,
That's
Mr.
why.
Chairman.
Okay, again, I don't have an adequate answer why we decided to go back down to 72.5, having been at 80 before, but that might too be a subject to conversation, unless you know.
No, it already went down to 72.5 previously, and we simply extended that going forward.
It went down in 2011 to 72.5.
It's extension of the 2011 law, which, so previously, the gentleman is right. It went from 60 when we first did this in, I don't know, 2000, whatever, up to 80, and then went back down to 72.5, and we treated this as if it were like an extender, and that means sticking with 72.5, which is where it was last year, and just carrying that forward. And this is retroactive, and then goes forward for 6 years.
Okay, great. That's all I have, Mr. Chairman. I yield back. Thank you.
Mr. Neal, did you have Mr. Neal, you have questions? Gentleman's recognized.
Thank you, Mr. Chairman. To the panelists, as one derives the benefit, they begin to draw down the benefit because of a dislocation caused by trade, what is the role of the community college in this initiative?
Community colleges provide training, and people who are eligible under Trade Adjustment Assistance for Workers program can avail themselves of community college training. The services, it is possible to be able to get training by going to a community college, yes, and to get a 2-year degree, for example. That would be an eligible expense.
So there's the terminal benefit in the sense that somebody completes 2 years, or they can complete the 2 years and then transfer to the 4-year degree program? And it would continue through 4 years of college as opposed to just 2?
The additional 2 years of college, though, would not be covered under TAA.
So it's 2 years with the community college?
Yes, that's right.
Mr. Chairman, I would submit that there's a chance here, as I noted before, really for this committee to do some big thinking, not just about the dislocations that come from trade, but for future trade benefits, linking those to the use of Build America bonds, linking those to an expanded community college initiative, to really speak to those people as we address the whole notion of the worker participation rate in America and what's happened to it, and trying to figure out what happened to those 8 to 9 million people who have just left the market, those who have drawn a Social Security disability benefit, those who took the Social Security benefit at 62, because they got laid off at 61, and not anticipating going back to work. So there's an opportunity here to do some thinking outside the box for this committee, rather than sometimes the strident rhetoric that we employ to make a point.
Gentleman yield.
Please.
This, off the top of my head, it sounds like a great hearing for Human Resources Subcommittee to get into labor force participation rates and what's going on underneath those statistics. I think that's something we ought to do a hearing on.
And link it to infrastructure, Mr. Chairman. Community colleges, infrastructure, all of these initiatives to embrace a pro-growth economic initiative that the country sorely needs. Economic growth now for better than 12 years has really bumped along. And we're not going to get there at 2.2% growth in a quarter. We've got to be north of 4% for a couple of years just to go back to where we were. And I think those are the kinds of discussions that we ought to have. And they ought to start right here in this committee, Mr. Chairman.
Yes. It's the right thing to do, it's the moral thing to do, and it is the political thing to do. America and the world will look at us to see Republicans and Democrats working with the president for all of the people here, trade, infrastructure, education. It just makes a lot of sense.
Add a flat tax to that and you got us.
That will fall flat.
Yeah, that would fall flat. Mr. Crowley, you want to ask, you have a question?
Thank you, Mr.
Crowley's
Chairman. And I
recognized.
hope, Mr. Chairman, I hope I will be as enthusiastic now as I was in my prior line of questioning for you. Okay. But I do have a couple of questions pertaining to the pay for. Given that the focus of the pay for is on the Medicare and the extension of sequester an additional 6 months, albeit, as the chairman has pointed out, in year 2024, I don't think anyone's holding their breath yet. As the architect of, one of the architects of sequester, that will change it anytime soon. My hope is we will. But if we were not to change it, can anyone answer this question as to how many jobs will be lost in the healthcare industry as a result of this nearly $1 billion cut to them? Can anyone answer that question?
It occurs in the 9th year, so to make a projection is very difficult and would not really be indicative of what could happen.
I would suspect, though, that there would be some ramification. In other words, no one individual swallows the $700 million, no one hospital spread throughout, and there would be some ramification. That's maybe beyond your pay grade, but I would suggest, I think we'd all agree that there would be some ramification to a $700+ million cut to an industry. Getting to the point of my question, though, is would those individuals, although they did not lose their job because of the trade bill, would they be eligible for TAA because they lost their job because of the passage of the TAA bill? That's my question.
The eligibility...
Kind of interesting, kind of funny, isn't it, that we think about it?
The eligibility conditions for trade adjustment assistance would not include that. It's workers who lose their jobs because of trade.
And isn't that ironic that we're helping workers who lost their jobs through trade, through TAA, yet those who lose their jobs because they're the pay for the TAA bill will not be eligible for TAA assistance. It's kind of interesting. Something to keep in mind. We keep going back to the same well, to go after the healthcare industry, to doctors, to physicians, to nurses, to technicians, that, that profession is the one we can keep going back to for pay fors. I would just remind my colleagues, enough is enough. We have to be a little more imaginative in terms of finding ways to pay for the things we need to pay for. I support TAA. I think it does great things for people in crisis during a very, very difficult time in their lives.
Sir,
but we need to find a different way to pay for this.
Gentlemen will spend, we're in the walkthrough question and answer phase of the witnesses, so.
I was just, Mr. Chairman.
When we have amendments, we can give the speeches,
Mr.
but
Chairman,
right now
I was
we're
just
asking
making-
questions.
I was making an observation and comment to the laughter that took place during, which I understood.
It was Mr. McDermott that I heard laugh.
Regardless of where it came from. The important thing is, it does show the irony. I was responding to the
Copy.
irony of the comment by Ms. Allard. That's
All right, gentlemen,
I would also note, if I may, that trade adjustment assistance is authorized only for 6 years. So there would be a lag in time before the sequester takes effect.
Mr. Chairman, regaining my time, again, showing once again, paying for things, for people who will be affected after this is even expired. People who potentially lose their job after this is expired. I'm just pointing that out, Mr. Chairman.
are there any other questions? There being no further questions, are there any amendments to the amendment in the nature of a substitute? Let's see.
Chairman,
Ms. Crowley, I think
I do.
you're up.
Thank you,
Chairman.
sir.
I reserve point of order.
Gentleman from Ohio reserves a point of order. Clerk will disseminate the amendment, and Mr. Crowley is recognized. And I'll, let me just say, the gentleman understands that there's a rule violation here, but please go ahead and explain your
sir.
amendment.
As said before, like many of my colleagues in the committee, I do believe in the importance of trade adjustment assistance. It provides important training programs to those who are affected by trade, the loss of their job through trade. However, I am concerned that this bill before us today would pay for it once again, cutting funds from health care providers that serve our seniors on Medicare. This bill would increase the amount cut by the sequester by $700 million. That's money being taken away from our nation's hospitals, doctors, nursing homes, and health care providers. In my home state of New York, this cut would cost $70 million from hospitals alone, many of which are serving the sickest and poorest patients. And in fact, in the Bronx portion of my district, healthcare is the #1 job provider in my district. We can't keep talking and keep talking about taking from these critical health providers and expect it not to have the negative effects on our seniors and access to care. If doctors stop practicing, or hospitals and nursing homes are forced to close, or home care agencies have a longer wait list, that hurts our seniors. In fact, when Congress passed the misguided, damaging sequester in the first place, they made sure to put a cap that health providers serving seniors on Medicare could not be cut by more than 2%. There was a reason for that, because Congress recognized that the need to protect providers and beneficiaries that they serve. But this bill today would increase the sequester cuts above the 2% protection, hurting both providers and their patients. We also can't expect our health care providers to be used as a piggy bank for every bill that comes before us, particularly not as we just came together in a bipartisan way to improve the Medicare payment system for the long term. It brought stability to Medicare payments after years of uncertainty and short-term patches. But if we're going to tell our doctors and other health care providers that they should constantly be worried about facing cuts to pay for pay not just health bills, but for trade bills or anything else that needs funding, that undermines those very same goals. I know it might not be easy to say, well, this cut doesn't happen until, it may be easy to say this cut doesn't happen until 2024, so let's not worry about it. We have to worry about it, because now's our chance to make it right. That's why I'm offering an amendment. I understand you'll rule it out of order, Mr. Chairman, to strike this offset and replace it with one that actually helps by improving tax compliance. My amendment would extend the statute of limitations for when the IRS can recover unpaid taxes from people who intentionally misrepresent their profits to avoid paying their fair share of capital gains tax, going after tax cheats. That's tax revenue that the American public is owed, but is being underpaid by the wealthiest in this country. Just yesterday, we had a hearing on the IRS, where the IRS told us that they have had to cut back on assistance to taxpayers because of lack of funding, in part from wealthy tax cheats. This offset would help us collect this revenue instead of continuing to give the wealthy a get-out-of-tax-free card. It will raise $1.2 billion in new tax revenue we need and that the American people deserve and are owed. To me, this amendment is an easy decision, no matter how you plan to vote on the TAA bill. Ensure fair enforcement of tax policy or cut health services for seniors. Go after tax cheats or cut services to our seniors. To help make that decision easier, I'd like to enter into the record a letter from the National Committee to Preserve Social Security and Medicare opposing these sequester cuts.
Without objection.
That's in addition to this, to another letter that I have from the American Hospital Association, American Medical Association, American Healthcare Association, and the National Association for Healthcare and Hospice.
Without objection.
Thank you, Mr. Chairman. The providers who are worried about their ability to care for seniors as well, I'd like to enter them, and you've indicated your support. I'm voting to support America's seniors, and I hope all my colleagues will join me in that effort, and I yield back.
Gentleman yields
Chairman.
back. Mr.
Chairman, I make a
Mr.
point of
Tiberi,
order.
the gentleman will state his point of order.
I make a point of order to the amendment because the subject matter is outside the jurisdiction of this committee pursuant to House Rule 10.
I am prepared to rule. Does anybody want to be heard? I do. Jeez, really? Turn your microphone on.
It's going to be difficult as a member of Congress to say that we're trying to give assistance to those people who lost their jobs and their hope, but we got to take the money away from those people that are on dialysis and
That's
those
not even the Medicare sequester.
Well, $35 billion have already been cut from Medicare. It's my understanding that even though it won't happen, it's a concept here that we want to help people. And the only way that you can't help them now is because of rules that we have in the budget and the committee. And I don't think that flies because it's hard to explain this to somebody that already is being underfunded as a result to cuts we've made and promises we made to them. So I understand that somebody has agreed that this is the way to go, and I guess I should be thanking you for letting us to have the opportunity to say this is totally wrong, for you've done this at the expense of those people that have already been cut, and I would like to unanimous consent that we put into the record that every religious and every spiritual organization opposes this. Of course, they don't. But by the time that they hear me calling on them to speak out, I hope their voices will be included in the record, Mr. Chairman.
The people can be heard on the ruling of the point of order. We're not debating substance now. We're discussing the point of order. Rule 10. Who would like to be heard on the matter of the point of the order?
Well, Mr. Chairman, Mr. Crowley's amendment, you allowed him
Yes.
to discuss the
I indulged him to
Okay,
make his
sir.
points, included in the record his letters.
Okay, that means nobody else can comment on Mr.
Well,
Crowley's.
you've got Mr. Kine's amendment coming up, and you've got two of McDermott amendments coming up.
But if somebody else
What's,
wants...
Mr. Chairman, what is appropriate to comment on at this particular point?
The point of order.
Well, but when will people like Mike be able to comment on the substance of this? I mean, I think you should allow a discussion.
All right, I'll do that. Mr. Chairman. Okay.
Because we're in favor of TAA and
no.
opposed to this pay for it.
Go ahead and strike the word. I'll just look.
Strike the last word.
Oh, go ahead. Go ahead.
Thank you very much. I strike the last word to speak on behalf of TAA. I'm a supporter of it. I think there's plenty of record as to the good that it's done. But what is troubling today is that I'm going to vote against it because of this pay for it. You know, we just went through a very long, arduous effort to fix the sustainable growth rate. We came together in a bipartisan way. We did it. We told the senior citizens in every one of our districts and the doctors in every one of our districts that no longer are you going to have to face this threat of cuts in health care. And we're not going to bother you. We're putting together a plan whereby you can be reimbursed. You'll know what you're going to get. You don't have to worry every year if we're going to pass another one-year extension. We did that 17 times. And every time there was a huge buildup with both the senior citizens and the medical professionals that we represent, anticipating that they were going to get a cut, not being able to deliver health care to the people that they swore an oath to serve. And now we turn around on the heels of that. It hasn't been weeks since we passed that thing, and now we're saying we're coming again. Now, I appreciate the fact that you're willing to find another pay for, and I'm more than willing to work with you. But I just want to say for the record today, I will not vote for this measure, notwithstanding all the good it will do, and pay for it on the backs of senior citizens and our medical professionals. Yield back.
Gentleman yields back. Mr. Davis, recognized.
Thank you very much, Mr. Chairman, and I appreciate your indulgence. And I know you got to try and find money wherever it is. And so wherever you can find it, then you try and use it. But it seems real odd to me that we were all bragging a couple weeks ago about coming up with the doctor's fix, that we were going to be able to make sure that seniors didn't have to worry about getting their services. We've made a lot of progress in health care. We've made a lot of progress. As a matter of fact, I was at a church the other day, and the pastor had 2 heart transplants and a kidney transplant, and still living and working and doing all that he does. And that's what it would seem that we would want our healthcare delivery system to do. And the progress continues, the research, new approaches, new ways. But then we're going to take money from it in order to pay for trade. I agree with Mr. Thompson. I can't see how I could vote to take money from health care and health services to pay for trade. So I agree with all of those in the healthcare industry who have suggested that we need to find another way to do this, another approach. And I appreciate the fact that you're willing to look, but I hope that we'll also find. And I yield back.
Gentleman yields back. Mr. Lewis, would you like to strike the last word? Gentleman's recognized.
I want to strike the
Would
last
like to be heard on the motion.
I'd like to be heard. I want to identify with the words of Mr. Thompson and Mr. Davis. It's not fair and it's not right to rob the most vulnerable segment of our society. And I yield back.
All right. I see no other comments. I am prepared to rule. The amendment does fall outside of the jurisdiction of this committee pursuant to House Rule 10. Point of order is sustained, and the amendment is not in order. Are there any other amendments?
Mr. Chairman, I object to the ruling of the chair.
Okay.
Mr. Chairman, I move to table the appeal.
Question is on the motion to appeal the chair's ruling. The question is on the motion to table the appeal of the chair's ruling. All those in favor signify by saying aye. Aye.
Aye.
Those opposed say no.
No.
Opinion of the chair, the ayes have it. The motion to table is agreed to.
Voice vote, please, Mr. Chairman.
Yeah, it was just voiced.
Well, I'm sorry, I meant roll call vote.
Oh.
Thanks for correcting me, Mr. Chairman.
Yeah, well, yeah.
It's getting late.
You asked for a voice vote, you got one. Okay, you actually.
I'd like a recorded
Roll
vote.
call vote is requested. The clerk call the roll.
Mr. Johnson? Mr. Johnson? Mr. Johnson, aye. Mr. Brady? Mr. Brady, aye. Mr. Nunez? Mr. Teaberry? Mr. Teaberry, yes. Mr. Reichert? Mr. Reichert, aye. Mr. Bustani? Mr. Bustani, aye. Mr. Roscom? Mr. Roscom, aye. Mr. Price? Mr. Price, aye. Mr. Buchanan? Mr. Buchanan, aye. Mr. Smith of Nebraska. Mr. Smith, aye. Ms. Jenkins. Ms. Jenkins, aye. Mr. Paulson. Mr. Paulson, aye. Mr. Marchant. Mr. Marchant, aye. Ms. Black. Ms. Black, aye. Mr. Reed. Mr. Reed, aye. Mr. Young. Mr. Young, aye. Mr. Kelly. Mr. Kelly, aye. Mr. Renacci. Mr. Renacci, aye. Mr. Meehan. Mr. Meehan, aye. Ms. Nome. Mr. Holding. Mr. Holding, aye. Mr. Smith of Missouri. Mr. Levin. Mr. Levin, no. Mr. Rangel. Mr. Rangel, no. Mr. McDermott. Mr. Lewis. Mr. Lewis, no. Mr. Neal. Mr. Neal, no. Mr. Becerra. Mr. Doggett. Mr. Thompson. Mr. Larson. Mr. Larson, no. Mr. Blumenauer. Mr. Blumenauer, no. Mr. Kind. Mr. Kind, no. Mr. Pascrell. Mr. Pascrell, no. Mr. Crowley. Mr. Crowley, no. Mr. Davis. Mr. Davis, no. Ms. Sanchez. Ms. Sanchez, no. Mr. Nunez. Mr. Nunez, yes. Ms. Nome. Mr. Smith of Missouri. Mr. Smith, yes. Mr. McDermott. Oh, Mr. McDermott, no. I didn't hear you the first time, sorry. Mr. Becerra. Mr. Doggett. Oh, Mr. Doggett, no. Mr. Thompson. Where? The gentlelady's not recorded. Ms. Nome, yes. Mr. Thompson? All right. Chairman Ryan? Chairman Ryan, aye.
Is Mr. Thompson en route? No. Okay. Okay. We'll just let's let her report. The clerk will report the vote.
23 yeas, 13 nays.
There being 23 ayes and 13 nays, the motion to table is agreed to. I believe, Mr. Kind, you have an amendment?
I do, Mr. Chairman. I have an amendment at the desk.
Mr. Chairman, I reserve a point of order.
Gentleman from Ohio reserves a point of order. The clerk will disseminate the amendment, and the gentleman is recognized for purposes of describing his amendment.
Thank you, Mr. Chairman. I'm going to try to be brief. I know the hour is late, but I'm offering this amendment for purposes of discussion only. I'll ask unanimous consent to withdraw after the discussion. And it's because I appreciate the chairman's assurance that we're going to continue working on an appropriate offset, something that hopefully we can reach a bipartisan agreement between now and rules and before floor action. This is an important issue. And why this is important for overall TPA discussion is because there's always been the understanding, whether implicit or explicit, that to do TPA meant doing TAA reauthorization in a bipartisan fashion. And now going to this offset, calling for further Medicare sequester cuts in order to pay for a trade measure just doesn't fly. And I think it's unfair, and the policy is wrong. Starting with the argument that these cuts don't take effect until 10 years ago, that's never going to happen, something's going to intervene. Those are the type of arguments that give this institution a bad reputation, these type of budgetary gimmicks. And there has to be a better offset that we can point to in order to avoid the bad optics around this. But furthermore, the sequester cuts itself make no sense because they're across the board, they're indiscriminate. They affect every healthcare provider in the country, regardless of whether they're hitting quality benchmarks, regardless of whether they're producing good quality value care. And this, Mr. Chairman, is particularly onerous to our Wisconsin providers, who are typically at the top range when it comes to quality outcomes, because they are practicing value-based medicine. And yet, we're proposing to just, again, another round of indiscriminate across-the-board cuts, regardless of what type of services, what type of quality care are being provided. That doesn't make sense as well. But I don't understand why the other side, your side, has this knee-jerk reaction against the amendment that Mr. Crowley has just offered and the amendment language that I'm offering here tonight, which is consistent with what Senator Warren raised yesterday during their markup. And I know that conversation is still taking place on the Senate side. Our amendments are not calling for a new tax. We're just calling for tax compliance, getting additional information to the IRS so they can do a better job of policing noncompliance in the tax code. Mine specifically deals with some valuable pieces of information that the IRS needs, some common sense minor pieces when it comes to information affecting the mortgage interest deduction. And we know that there's been a lot of noncompliance in this area. The offset would more than be enough to pay for what's needed here with the sequester cuts. And we're not talking about a new tax. And I think this relates to what we're dealing with TAA, since we are talking about a health care tax credit. So to me, it makes sense that we also look to a code in order to help pay for a tax credit in TAA. So I'm just asking the other side to keep an open mind on this as we go forward, because I can imagine, and privy to some of the conversation that took place leading up to this offset being used, that there could be a whole nother list of bad spending cut offsets offered to replace the Medicare sequester. And that's going to put us right back into the same hole again. I would just submit this evening that it's going to be awfully hard to round up the bipartisan votes we need to get TPA passed on the House floor unless we can reach a bipartisan agreement with appropriate offsets for TAA. And that's why I'm offering the amendment. I believe that's why Mr. Crowley was offering the amendment, why there's discussions going on the Senate side that's identical to the language I have here tonight. But I know we've got time to discuss this, and with the chairman's assurance that we will try to reach a good compromise agreement on offsets, hopefully we can get this resolved before the Rules Committee. So with that, I yield back.
Gentleman yields back. Anybody
And
else?
I ask consent to withdraw.
I'll just speak briefly. You're going to
John's
withdraw, Mr. Kine.
He would.
You haven't withdrawn it yet.
Yeah.
Look, I mean, the irony is you're proposing something that's within our jurisdiction, and it's being ruled out of order because it would replace something that's not in our jurisdiction. That's the irony. And we're going to have to find a way.
The XM Bank was with.
Yes, we're going to have to find a way to resolve this without trying to use procedures. We're going to tie ourselves.
The gentleman would yield on that point,
Yes.
just briefly. And I'm not so much concerned about the rules and whether it's in order and whether we get a vote, because even if we had a vote, chances are it was going to go down. But what I am concerned about is the honest, good faith assurance that we're getting from the other side that we've got time to work this out, and that's, I think, what we're all shooting for.
Remember, to work it out, we're going to have to not use alleged issues of jurisdiction or rules. Otherwise, we're never going to rule this, we're never going to work this out. I'll just leave it at that. We favor TAA, we oppose this pay for.
Gentleman yields back balance of his time. The gentleman, I appreciate the gentleman's point. We discussed it now quite a bit. Gentleman asking as consent to withdraw his amendment, and without objection, The amendment is withdrawn. Appreciate the gentleman's sentiment. Mr. McDermott, do you have an amendment?
Mr. Chairman, I have amendment at the desk.
Mr. Chairman, I reserve a point of order.
Point of order is reserved. The clerk will disseminate the amendment. Mr. McDermott, is this the TAA for Firms amendment?
Yes.
Okay. Gentleman's recognized.
No point of order? Oh, he did?
Yeah, but I think you're okay.
Oh, yeah, I know I am on this one. I'm ready to argue it. TIA Firms is a program that helps businesses, small businesses. Everybody thinks of TAA as only helping individuals, but it also helps small businesses who are impacted by the challenges of competition. It's the only federal program specifically designed to help small manufacturers that have been negatively impacted by import competition. The cost-shared technical assistance it provides enables these companies to improve their global competitiveness, to adjust to their new economic environments, recover, and remain employers in their community. Last year, 842 firms in 48 states with over 70,000 workers received assistance through the program. It's a program that helps our economy adjust. It helps businesses remain competitive and evolve to meet the challenges we face in our globalized recovery, or economic world. The effectiveness of TAA for Firms program has repeatedly highlighted by internal studies and outside evaluations. For example, the most recent GAO report on the program found it had a significantly positive impact on both firm sales and productivity. Also, GAO's survey of recent clients found that 84% reported the program helped them stay in business, while 71% said it helped them retain employees, and 57% said TAA for Firms helped them hire new employees. Unfortunately, this program is significantly underfunded, and this bill maintains that. There is currently a large backlog of approved but unfunded technical assistance projects for companies already certified as trade impacted, plus new companies petitioning for assistance each month. Our economy has changed in the decades since TAA was established. That same GAO report noted that part of the program's success came from its ability to adjust to accommodate the various sectors of the U.S. economy that are impacted by trade-related competition. It does this through having the needed number of dedicated staff to identify as well as the resources with which to serve impacted businesses. We all want the United States to remain a leader in the world economy, but we need to make sure that we are positioned to successfully navigate the consequences of our trade agreements. We're working toward this TPP thing. We know we're going to have more of this business. That means ensuring that TAA for Firms is properly funded. Today's discussion reminds us of that obligation, and I urge my colleagues to support this amendment, which will provide $50 million in funding for this program.
Gentleman, yields back balance of his time. Mr. Reichert?
Mr. Chairman.
Mr. Reichert's recognized.
Thank you. I agree with my colleague and friend from Washington State that we all want to help small businesses, and this is a program that is designed for that. But here are some of the facts. The expansion of the TAA for Firms program in FY 2009 to $50 million per year was designed to be a temporary expansion during a time of above-average unemployment. In fact, recent experience shows that this proposed expansion is unnecessary. And here's why. At no time since fiscal year 2002 has the TAA for Firms program been appropriated more than $16 million annually, even during the FY 2009 and 2010 period of time, when the program's authorization was raised to $15 million per year. The program was still appropriated at $15.8 million. But since 2012, the actual cost of the program has hovered between $10 million and $12.5 million per year. In terms of the number of firms that might need this help, except for a temporary spike in the 2010-2011 era, there's been a steady decline in the number of firms being served by this program. So in 2004, there were 177 firms. In 2014, 10 years later, 107. This shows that an increase in spending here is unwarranted. This bill reflects a carefully designed and negotiated balance. Again, we talk about the balance between the House and the Senate. And while we might find things to disagree with in this legislation, this amendment threatens to upset the balance and derail the progress we're trying to make on trade and jobs. I yield back.
Gentleman yields back. Anyone else seek to be recognized? Mr. Pasquarello, do you move to strike the last word? Gentleman's recognized.
I want to thank my friend from Washington for his amendment. What we do know is that unfair trade can devastate some of our firms and send certain jobs overseas. I've seen that in my own hometown. Because of that, a program close to my heart is the Trade Adjustment Assistance for Firms program. This is different from personal program. This program has been incredibly successful in the 9th District of New Jersey and throughout North Jersey. No business wants to have to use this program, but firms are adversely affected by trade agreements, and the Mid-Atlantic Trade Adjustment Assistance Center is there for us. I believe these centers across the country have done wonders on their less than adequate budgets, and there is much more to be done, especially if TPP goes through and becomes a reality. The current TAA for firms funding level is wholly unacceptable. It is our duty to assist those whom our trade agreements severely hurt. TAA can avert the need for millions of dollars in unemployment compensation, dislocated workers' compensation, welfare cash assistance, food stamps, and other programs designed to address unemployment. TAA helps to assure that the worker is never unemployed in the first place, thus never requiring these temporary responses to job losses. I support the gentleman's amendment, and I yield back. Thank you, Mr. Chairman.
Anybody else seek to be recognized?
I'll close.
Gentleman is recognized to close.
Mr. Chairman, my colleague from Washington State suggests that, there's been money, too much money or something. This is an authorization. This is not an appropriation. We're not the Appropriations Committee. We're the Authorization Committee in this case. And there are significant there's a big backlog of approved but unfunded technical assistance projects. The fact that they've only spent $16 million, well, if that's all you got appropriated, that's one thing. But we got to show the Appropriation Committee that they should spend more here. This is a place where it makes good sense to spend it. It helps both individuals and small businesses. And I think that's the reason why I think putting the extra money out there is to say to the Appropriations Committee, this is what we want you to do. And for that reason, I urge the adoption of the amendment.
Mr. Chairman.
Mr. Tiberi.
I withdraw the reservation and point of order.
Gentlemen, the point of order is withdrawn. The question is on agreeing to the amendment offered by the gentleman from Washington, Mr. McDermott. Long night. Those in favor signify by saying aye. Those opposed signify by saying no. No. In the opinion of the chair, the noes have it. You want a roll call vote? Roll call vote is requested. The clerk will call the roll.
Mr. Johnson? Mr. Johnson, no. Mr. Brady? Mr. Brady, no. Mr. Nunes? Mr. Nunes, no. Mr. Tiberi? Mr. Tiberi, no. Mr. Reichert? Mr. Reichert, no. Mr. Bustani? Mr. Bustani, no. Mr. Roscom? Mr. Roscom, no. Mr. Price? Mr. Price, no. Mr. Buchanan? Mr. Buchanan, no. Mr. Smith of Nebraska? No. Mr. Smith, no. Ms. Jenkins? Ms. Jenkins, no. Mr. Paulson? Mr. Paulson, no. Mr. Marchant? Mr. Marchant, no. Ms. Black? Ms. Black, no. Mr. Reed? Mr. Reed, no. Mr. Young? Mr. Young, no. Mr. Kelly? Mr. Kelly, no. Mr. Renacci? Mr. Renacci, no. Mr. Meehan? Mr. Meehan, no. Ms. Nome? Ms. Nome, no. Mr. Holding? Mr. Holding, no. Mr. Smith of Missouri? Mr. Smith, no. Mr. Levin? Mr. Levin, yes. Mr. Rangel? Mr. Rangel, yes. Mr. McDermott? Mr. McDermott, aye. Mr. Lewis? Mr. Lewis, yes. Mr. Neal? Mr. Neal, aye. Mr. Becerra? Mr. Doggett? Mr. Doggett, aye. Mr. Thompson? Mr. Thompson, aye. Mr. Larson? Mr. Larson, aye. Mr. Blumenauer? Mr. Kind? Mr. Kind, yes. Mr. Pascrell? Mr. Pascrell, yes. Mr. Crowley? Mr. Crowley, yes. Mr. Davis? Mr. Davis, aye. Ms. Sanchez? Ms. Sanchez, aye. Mr. Becerra? Mr. Blumenauer? Chairman Ryan?
No.
Chairman Ryan, no.
Nope.
Well, when you finish, you want a yes.
Yeah. But we're not there yet.
Okay, I'm just checking.
The clerk will report the vote.
13 yeas, 23 nays.
There being 13 ayes and 23 nays, the amendment is not agreed to. I believe, Mr. McDermott, you have one more, correct?
Yes, yes, Mr. Chairman, I have an amendment at the desk, although I will ask unanimous consent after I talk about it to withdraw it. So
Okay.
you can save your
I
point
reserve a point of order
Point
anyway.
of order is reserved anyway. Clerk will disseminate, and the gentleman's recognized.
Earlier in the evening, Mr. Crowley made some conversation down here, and I laughed, and you pointed out that I laughed.
You have a good laugh.
The Irish are inflicted with the sense of irony. And the irony in this place tonight is really striking, and that's why I'm offering this amendment. It's to extend the Export-Import Bank. Now, we've spent all this time talking about giving the president the TPP or TPA so he can do TPP, and we've talked about TAA, where we're going to give all this assistance, but we don't have an Export-Import Bank in about a month. And I don't know what in the world is the matter with the people on your side of the aisle. I don't think there are very many of them on this committee, so I might be preaching to the choir. But I raise this issue because without the Export-Import Bank, you have serious problems. A lot of people think of it as the Boeing Bank. Well, it isn't the Boeing Bank. It is the bank that backs up exports from the United States by offering insurance on the money that people are going to collect. We have made money off this bank every year, and we've used it for a variety of things in this country. But most importantly, it backs up our exporters. And if every industrialized country in the world has an export bank, and the failure of this Congress to extend the Export-Import Bank, and we're now within about 6 weeks of the end of it, is really kind of funny when you think about it. With all this, we're going to save the country with more trade, and we're going to prop up the economy with more trade, everything else, but we don't have an Export-Import Bank. It's like tying your arms behind your back and then deciding you're going to go out and play football. It just doesn't make any sense at all. And I, with due respect, or with all due respect, I ask unanimous consent to withdraw my amendment.
Mr. Chairman?
Before you withdraw, I think somebody wanted to. Mr. Neal, you moved to strike
I
last
do,
word?
yeah.
Gentleman's recognized.
Knowing the element of which Mr. McDermott spoke,
Another urgent.
this is an example of what's gone awry in this institution. I don't know how we can begin the conversation about TTIP and disarm major American corporations who are going to try to compete internationally. And that's essentially what letting the Export-Import Bank do. This is not, in the history of this Congress that I've served in for 27 years, ever been a partisan dispute. This is about international competition. When you watch what's going to come to the table in TTIP negotiations, If we don't understand that we cannot have our companies having one hand tied behind their back internationally, and that's what's going to happen. I have good employers who never say, I'm a Democrat or a Republican when they come in. They simply say, this is how I've used the Export-Import Bank. And it's not an argument about Boeing. There are a lot of small companies that take advantage of this. And I think once the trade negotiations are done with TTIP, my hunch is the French farmers are going to hold on to just about everything they've got. And much the rest of Europe, they're going to hold on to the benefits they have. This is not about a subsidy. This is about a loan guarantee. This simply puts our corporations into the ballpark to compete on a level playing field. So I hope, even though Mr. McDermott is going to withdraw this amendment tonight, I hope we can have a full throttle discussion here before once again ideology trumps all in this institution, as opposed to a good faith, good sense, common path forward.
Gentleman yields back. Is Mr. Pasquarello and Mr. Kine, I see. Mr. Pasquarello, you move to strike last word.
Mr. Chairman, the Chambers
recognized.
the Chambers of Commerce, the state of New Jersey, have wholeheartedly supported the Export-Import Bank. We've had several conferences on it. It doesn't cost money. It is a guaranteed loan. Many of the smaller companies are taking advantage and using this. I recommend it very, very highly. If not in this venue, then a venue I think that we'll have to debate it, obviously, and come up with it. I wholeheartedly support this, and I yield back.
Gentleman yields back. Mr. Kine, do you move to strike last word?
I do, Mr. Chairman.
Gentleman's recognized.
Mr. Chairman, briefly on my support for this amendment. My prediction is somehow, some way, at some point this year, the Speaker's going to figure out a way to bring XM reauthorization to the floor. And there's going to be the votes to pass it. Because I cannot fathom that we would be dumb enough to unilaterally disarm when it comes to an important institution that's supported not only just big employers in this country, but small employers and supply chains. Earlier this year, I had the chairman of the XM Bank, Fred Hochberg, in our congressional district in Wisconsin. And we visited with many small businesses who relied directly on the program, the services offered there to increase their exports. One was Darley Manufacturing up in Chippewa Falls, with over 160 employees manufacturing fire engines. The day we were there, they were literally out the door exporting 15 fire trucks to Africa. And the next week, they were sending another 22 to China. And Mr. Darley at the company said there's no way they'd be willing to do that and take that risk without the guarantee of the Export-Import Bank behind them. And those are good paying jobs in the district. So this isn't just about Boeing. It's about a lot of small business manufacturers, probably in each of our districts, that's utilizing the services of XM. And how this relates to TPA is I've been talking to our colleagues on this side about their support for TPA. This is one of the major issues that they keep raising is the XM reauthorization. And I would predict that if you find a way to include this in TPA legislation, you're going to have a lot more votes on the floor when it comes time for this to come up. So with that, I yield back.
Gentleman yields back the balance of his time.
Mr. Chairman, may I,
Yes.
claim 30 seconds of my time? Denny Heck from the state of Washington has a letter with 195 signatures of people who will vote for the Export-Import Bank. So if you could find about 25 or 30 on your side, I think we got a deal.
All right. Well, as you know, it's not our jurisdiction. But, gentleman, does the gentleman ask unanimous consent to withdraw his amendment? Gentleman asks with unanimous consent to withdraw his amendment. The amendment is withdrawn. Okay, so now we're going to go to final. Just to make it clear for all the members here, we're going to go to final passage and report the bill without a recommendation to get this bill to the floor to move the process forward. So since there are no further amendments, the question is on the adoption of the amendment in the nature of substitute as amended. Not all those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of substitute is agreed to. I will now recognize Mr. Johnson for the purposes of offering a motion.
Mr. Chairman, I move that the committee report H.R. 1892 without recommendation as amended to the House of Representatives.
The question is on reporting H.R. 1892 as amended without recommendation. All those in favor signify by saying aye. Aye. Those opposed signify by saying no. No. In the opinion of the chair, the ayes have it. The motion is agreed to. This is the roll call you want, right? Nobody needs one? Nope. All right. It's the ayes have it. The motion is agreed to. H.R. 1892 is ordered reported without recommendation. Without objection, I ask that the staff be authorized to make technical and conforming changes to the bill, and that members have 2 additional days to file with the committee clerk supplemental, additional, dissenting, or minority views. Home stretch. Fourth order of business is a bill introduced by Mr. Teaberry, the Trade Facilitation and Trade Enforcement Act of 2015. Mr. Teaberry, you are now recognized for an opening statement on your bill.
I'll be brief. U.S. Customs and Border Protection plays a pivotal role in helping ensure that our trade agreements, preference programs, U.S. trade laws are enforced and the legitimate trade is facilitated. We're facing increased competition around the world, and it's critical to keep the flow of trade moving efficiently. The last time this committee passed a custom bill was in 2003. This bill strengthens enforcement of U.S. trade laws and is another major pillar of this bill. Enforcing U.S. intellectual property rights and anti-dumping and countervailing duty laws prevents our competitors from gaining an edge by cheating, and the bill would establish tools at Customs and Border Patrol and hold it accountable to effectively act against evasion, anti-dumping, and countervailing duties. CBP has made great strides in streamlining and modernizing its programs. I'm confident that this long overdue bill is one step in the process to put us on the right track. Mr. Chairman, I yield back my time. Mr. Chairman, I yield back my time.
Gentleman yields back the balance of his time. Mr. Levin, you are recognized for an opening statement.
So this bill has a lot of strengths. It also has a substantial weakness. The strengths include closing a loophole that permits imports of some goods made with forced labor, including forced child labor. But it doesn't adequately address this circumvention issue that we have been discussing for so long. And I believe that Ms. Sanchez has an amendment that would cure this flaw, and I hope...
On the amendment.
What?
No, I'm sorry.
She has an amendment.
No, never mind.
So I'm going to end now and leave it to Ms. Sanchez to highlight the flaw in this bill.
You're going to yield her the bulk of your time?
Mr.
No.
Joe, Mr. Crowley?
Are you?
Quick point of order. Are we not going through questions or?
Yeah, we're going to go through the walkthrough. We're not at the walkthrough yet. He's just doing his opening statement.
Yeah. Okay, sorry. Thank you.
Yeah, that's why I was trying to.
I was being brief. Okay, that's it.
Okay. The committee will now proceed to consideration of H.R. 1907. Without objection, the measure will be considered as read and open for amendment at any point. I offer an amendment in the nature of a substitute, which was distributed in advance, along with a description explaining it. Without objection, the amendment in the nature of a substitute shall be considered as read, open for amendment at any point, and considered base text for the purpose of amendment. I will now turn to Angela Ellard, Staff Director of the Trade Subcommittee, to provide a description of the underlying bill, as well as Tim Reif, General Counsel of the Office of USTR, and I ask that members hold their questions until after their presentation. Ms. Ellard.
Thank you, Mr. Chairman. Title I of the bill sets out provisions relating to trade facilitation and trade enforcement, including partnership programs, establishing key performance measures, a GAO study measuring the effectiveness of CBP in trade enforcement activities, educational seminars, a biennial joint strategic plan. The bill also authorizes the Automated Commercial Environment, the ACE computer system. In addition, it amends current law by adding an information technology infrastructure called the International Trade Data System, the ITDS. It also codifies and expands the role of the Commercial Customs Advisory Committee, the COAC. It also requires the Commissioner, in consultation with the private sector, to develop and implement Centers of Excellence and Expertise, the Cs. It establishes a commercial targeting division in CBP. It requires the Inspector General of the Department of Treasury to conduct periodic reviews of CBP's revenue protection and enforcement measures. Title II establishes an interagency import safety working group. Title III relates to protection of intellectual property rights. It authorizes and directs CBP to share information with rights holders to help quickly ascertain whether a suspect good crossing the U.S. border at a port of entry violates a copyright or trademark, except in such cases as would compromise an ongoing law enforcement investigation or national security. Section 308 requires the Commissioner to effectively train CBP port personnel to detect and identify IPR infringing imported goods. Section 309 requires the Secretary of Homeland Security to coordinate with competent foreign law enforcement agencies to enhance IPR enforcement. Title IV contains the prevention of evasion of anti-dumping and countervailing duty orders provision, also known as PROTECT. This provision establishes the Trade Remedy Law Enforcement Division within CBP to coordinate information exchange, to serve as the primary contact point for evasion allegations, and to provide parties updates on the status and outcome of investigations or other activities resulting from allegations. It also directs CBP to exercise all existing information collection authorities to identify evasion, to issue questionnaires, and to apply an adverse inference against a party that does not provide the requested information. It authorizes increased data sharing between CBP, the Department of Commerce, and the International Trade Commission. It directs CBP to enter into agreements with foreign countries to increase cooperation in combating evasion, and to allow CBP to conduct overseas investigations. It establishes as a negotiation objective for future trade agreements the creation of arrangements with foreign countries to address evasion of trade remedy laws. Subtitle B is a new provision. It establishes procedures for investigation of evasion of trade remedy laws by granting the Department of Commerce the authority to investigate evasion of anti-dumping and countervailing duty orders and to establish procedures. It requires CBP to provide the Customs and Border Protection Agency to provide the Department of Commerce with information that's required to conduct these investigations. It also requires Commerce to submit an annual report. This Commerce process has deadlines associated with it, and it is subject to judicial review. The legislation also directs GAO to submit to Congress a report on the effectiveness of the provisions. It directs CBP to assign sufficient personnel responsible for preventing and investigating evasion. It requires CBP to submit an annual report to Congress, and it terminates the ability of new shippers to post bonds during new shipper reviews, and establishes criteria with regard to bona fide sales by a new shipper. There are additional trade enforcement provisions in Title V. It requires the administration to identify enforcement priorities in consultation with Congress and to more regularly consult with Congress on the administration's enforcement strategy. It also allows the administration, under certain conditions, to reinstate a retaliatory action if such action has terminated previously and if it receives a request from the affected domestic industry. It also requires the International Trade Commission to create a web-based import monitoring tool to provide data on the volume and value of imports, and to provide quarterly web-based periodic reports. Title VI raises the de minimis amounts from $200 to $800. Section 606 implements drawback modernization by allowing the use of 8-digit harmonized tariff system classifications. It establishes reporting requirements for interagency programs, including the Interagency Trade Enforcement Center. Section 608 sets out U.S. policy identifying the importance of the bilateral U.S. trade relationship, the bilateral U.S.-Israel trade relationship. It establishes principal U.S. trade negotiating objectives for foreign countries, for trade agreements with foreign countries. It has reporting requirements. It amends the Security Exchange Act to require reporting by a foreign issuer of such acts. And it also has provisions relating to whether courts, it bans courts, U.S. courts from recognizing or enforcing particular judgments by a foreign court against a U.S. person doing business with Israel, and on which was based a determination by the foreign court that the location in Israel is sufficient to constitute a violation of law. Section 609 eliminates the consumptive demand exception to the prohibition on importing merchandise made by convict, forced, or indentured labor, and to provide a report to Congress. Section 610 contains the offset for the bill, which is customs user fees. And then finally, Section 611 requires the Commissioner to submit to Congress a detailed annual report on each reimbursable agreement and public-private partnership agreement that CBP enters into. That concludes my presentation.
Any questions for Ms. Ellard, Mrs. Ellard or Mr. Reif?
Chairman.
Mr. Kind and then Mr. Crowley. Mr. Kind.
Thank you, Mr. Chairman. Not a question, but just a quick comment and also a thank you, because earlier this year, I'd introduced legislation along with Mr. Levin, Rangel, and Lewis that would repeal the consumptive demand exception to rules prohibiting the importation of child, prison, or forced labor. The chair has included that language in the chair's mark, and we thank you for that. Also previously, Mr. Marchant and I had introduced legislation to streamline the reimportation of residue and trucks over the border. These are trucking companies transporting grain or other substance. Because of the language in this bill, they will be able to save money that they can now reinvest in their company and create more jobs. The chair has included that in the mark, and we thank you for that as well. And with that, I yield back.
Gentleman yields back. Mr. Crowley, do you seek recognition to ask a question?
I do, Mr. Chairman. Thank you.
Gentleman's recognized.
In Section 608, you alluded to it near the end. It's the section dealing with the United States-Israel trade and commercial enhancement portion. On page 177, I'm just going to read it. Under principal trade negotiating objectives of the United States, commercial partnerships, among the principal trade negotiating objectives of the United States were proposed trade agreements with foreign countries regarding commercial partnerships are the following. A, to discourage actions by potential trading partners that directly or indirectly prejudice or otherwise discourage commercial activity solely between the United States and Israel. Is this new language?
New language. This is language that was included in Mr. Roskam's legislation.
Is it in law today, I'm asking?
Is it in law today? I don't believe so.
So this is new law we're making today.
Yes.
So we're making new law as it pertains to a holistic approach in this law as it pertains to Israel, but not in the previously passed TPA bill that we discussed earlier.
Well, gentlemen, yield real quick, I can answer that question. This, Mr. Roskam's bill was in the customs bill. Mr. Cardin and Mr. Portman amended Mr. Roskam's language, similar language, into the TPA bill. The chairman then to try to...
Beginning my time, though, absent the TPP, only gearing it towards TTIP and not TPP. This is more, it seems to be a bit more encompassing, that it is more thought out, well thought out. It's actually covering all trade agreements and enforcement by customs, as I read that. Is that not correct?
Yes, that's correct.
It is.
Mr. Crowley, will you yield?
Yes, I will.
So if I understand the answer you just got, they started by applying it to all trade. And then in the fast track bill, which is the one we'll be asked to deal with, they apply it only to TTIP, not to the Trans-Pacific Agreement. And
that's how I understand it.
I've been searching during this time we were considering the other bill, trying to determine why you couldn't get an answer to your question from those people who said they were so concerned about Israel here.
Will the gentleman yield?
Not yet.
I have the time.
As to why
you want to know the
they've
answer?
been excluded.
I'll give you the
I'm going to provide the
Beginning
answer.
my time. I'll come back to you.
Okay, I understand.
And the answer is because with a little research, Brunei, with its stoning for violation of Sharia law, does not recognize Israel. And Malaysia does not recognize Israel. And I believe with your help, maybe USTR couldn't determine what the Malaysia position was immediately, but if they'd simply looked in any Malaysia passport, they would have found out that it says this passport is valid for all countries except Israel. A citizen of Israel cannot even enter Brunei, and a citizen of Malaysia apparently cannot even enter Israel. And so if we really wanted to provide immediate assistance, an expression of concern about Israel, the place to do it is in the delicate balance, which was just altered after we considered all other amendments with reference to this issue. And I appreciate your raising it.
Reclaiming time, I appreciate that. I just point that out. Again, the irony, we're dealing with it in a holistic way in this more well thought out piece of legislation as it pertains to our relationship with Israel and countries that we trade with. But we failed to do that, or the majority failed to do that in its attempt, or actually its success in passing the TPA language that we just passed on. And I will yield to Mr. Teaberry.
I'll yield back.
Let the record reflect. I offered to yield with a minute to go. With that, Mr. Chairman, I'll yield back.
Anybody else have questions? There being no further questions, Mr. Young, do you move to strike the last word?
I do,
Gentleman's
Chairman.
recognized.
Mr. Chairman, I just thought this was the most opportune time. I know everyone's been here late today, but I wanted to briefly highlight the issue of the MTB, miscellaneous tariff bill. Every person here, every representative has manufacturing interests that are important to their economy. I happen to represent the most manufacturing intensive state in the country on a per capita basis. And I just feel with deep conviction that we have to work expeditiously to move to the MTB. And absent finding a solution, we're going to be imposing what is effectively a tax, continuing an unfair tax on our manufacturers, makes them less competitive vis-a-vis their international competitors. And so we have to move swiftly, work with leadership, and I'd seek some reassurance, Mr. Chairman. Reassurance, Mr. Chairman, from you as staff. You're talking with staff about other important issues, that we're going to rededicate ourselves to working with leadership to moving on MTB later this year. I know it's...
Yeah, the gentleman will yield. Yes. As you know, it's in violation of our House rules pertaining to earmarks. We have not reconciled this yet. Many of us, I think this is just, we're needlessly raising prices on consumers because these are taxes on goods that aren't being produced domestically. So I agree with that. But we are not in agreement with leadership at this time about a modification of these rules.
Mr. Chairman.
Yeah. Mr. Young controls the time.
Mr. Chairman, what you've said is entirely consistent, I think, with the views of so many on this committee, certainly myself, and so I look forward to finding a path forward. If there's any way I can be of assistance in a bipartisan way, I look forward to being so.
Would you yield, Mr. Young?
And I will yield. To the gentleman from Massachusetts.
He's expressed the right sentiment here, and I think that there is that opportunity for us to move forward. Manufacturers, as you know, are getting hit pretty good as we await some action on the MTBs. I think there's broad support on both sides for it, and so I share Mr. Young's view, and I hope, Mr. Chairman, that you'll be able to reconcile your differences.
I agree as well. No, I agree as well. We're not there with our House rules right now, and I'd like to find a way to get there.
Thank you.
Yeah.
Could I strike the last word? Wherever we are.
Mr. Young, do you yield back your time?
I yield back my time.
Okay. Gentleman recognized, strike last
So,
word.
Mr. Young, I could not agree with you more. So just so the record's clear, we've been trying for several years now to get action on MTBs. We put forth, Mr. Reif was with us then, the clearest rules regarding openness. The clearest. People had to list everything about any MTB, everything. So nobody could hide that they were for an MTB who would benefit. The problem was that when you passed the rule, I think without much thought, you included the word tariff. which is really not the same. You included it. And we have been trying to get action on this, how many years now? 2 years?
More than that.
More. And I just want you to put pressure within your ranks and get it done. You're also going to have to talk to a few people on the Republican side in the Senate because they've been holding this up or threatening to hold it up. We've been determined to act. There's so much misconception. People don't realize we're talking about an import that can't threaten any American production, and in most cases it becomes a component in an export. So we talk about the importance of export jobs. So I think, if I might say so, we'll do everything we can to help you, but you're going to have to help yourself. I mean, you're going to have to help yourself. I mean, it was...
Will the gentleman yield?
Yeah, sure.
I look forward to working together. I think you've articulated the issue fairly well. I think I would
think
probably
very well.
I think I would characterize it somewhat differently, and there are other issues. Perhaps we can work together to get over the line of
Okay, look, I
majority
didn't
support.
mean to say this in a negative way, but tariff was included as an earmark when it isn't. And you put that in there, and we've urged you to take it out. So we've been trying to do everything we can to move this along. And so, Mr. Chairman, anything we can do to get this moving. Because... Okay.
Duly noted. All right. Gentleman yields back the balance of his time.
Just do it.
Let's do some amendments now, all right? Are there amendments? I think, yeah, Ms. Sanchez.
Mr. Chairman, I reserve a point of order.
Gentleman reserves a point of order. Ms. Sanchez, you have an amendment. Let's have the clerk disseminate the amendment. And Ms. Sanchez, you are recognized for the purpose of describing your amendment.
Thank you, Mr. Chairman. I have to say I was extremely frustrated with the path that led us to the House Republican Customs bill before us today. Over the last 2 days in this room, I've been hearing that this should be a bipartisan and balanced process, and I'm hoping, beyond hope, that we can still get to that. Senators Hatch and Wyden, along with a substantial number of senators on a bipartisan basis, reached an agreement after some 10 years or so of negotiations on how we should properly enforce our trade remedy laws, and I'm hoping that House Republicans will also be part of that solution. For the last several years, one of my biggest priorities has been finding a way to combat the blatant abuse and the duty evasion by foreign producers that undercut American industries. Foreign companies use a variety of schemes to avoid paying duties that they owe on their goods that are brought to the United States. Not taking this opportunity to give real teeth to our enforcement procedures, not only is that disappointing, but it sends a message to domestic manufacturers, their employees, and workers that this Congress, well, doesn't really care much about customs enforcement. And I would argue that there is even more need for these enforcement measures when you look at the recent trade trends that have been going on. In California, for example, we have a significant concentration of steel pipe production in the greater Los Angeles area, and that steel pipe production is done by companies who are mostly small to medium size and who are suffering the consequences of a deluge of cheap imports. First quarter 2015 imports of pipe and tube products were at 2.7 million tons, which was a 49% increase from first quarter 2014 levels. And these imports are on products that are covered by orders, many of which have been part of an ongoing duty evasion investigation with Customs. What I am asking is that House Republicans work with Democrats, like our Senate counterparts managed to do, to give Customs legitimate tools to aggressively enforce anti-dumping and countervailing duty orders, putting those who break our laws on notice that flouting U.S. law is no longer going to be tolerated. And to that end, Mr. Chairman, I'd like to ask unanimous consent to enter a letter into the record dated April 22nd, 2015, for the American Iron and Steel Institute, the American Wire Producers Association, the Coalition to Enforce Anti-Dumping and Countervailing Duty Orders, and the National Association of Manufacturers, supporting the enforced language that is contained both in the Senate Customs Bill and in the amendment that I'm offering tonight.
Without objection, the letter will be included in the record.
Thank you, Mr. Chairman. The idea of doing this doesn't hinder free trade. Instead, it promotes fair trade and sends a strong signal to foreign producers that the U.S. is not going to continue to tolerate the kinds of abuses of internationally agreed upon trade rules. By increasing our customs security measures, we can ensure that American companies which play by the rules are not disadvantaged as a result of evasion by foreign competitors. I urge my colleagues to support this amendment, and I thank the chairman and yield back the balance of my time.
Gentlelady yields back the balance of her time. Anyone want to strike the last word on the amendment?
I move to strike the last word.
A gentleman from Louisiana is recognized.
I think we all agree we have a very serious problem with evasion of our anti-dumping and countervailing duties law. It's a serious problem. It needs to be addressed. It's not a partisan issue. And I know I've worked very, very hard over the last several years with the committee to come up with a series of tools that will greatly enhance customs as well as an interagency process to take care of the problem. And we have been working very closely for a number of weeks now with Senator Wyden, and we haven't gotten to conclusion. And I think we can get to a better bill than what the Senate has in the long run if we can add some of these additional tools in place, which we hope to do by going to conference. So I would respectfully ask the gentlelady to work with us on this and to withdraw her amendment at this time so that we can actually continue this discussion. We were getting very close. TAA plus the Senate markup calendar created the problem with getting to finality on this. And so I would hope that I could prevail on the gentlelady to work with us and to withdraw her amendment at this time, and let's move the process forward.
Let me interject. I want her to honor that request, but I think a few other members want to be heard on the amendment. So let's do that. You see in a little bit. Let's get to some other members who I think want to be heard on this point.
Will the gentleman from Louisiana yield?
I will be happy to yield.
Just briefly, I think the gentlelady is onto something here, Mr. Chairman, and I would join in the effort, especially in the area of steel and wire, having steel industry in my district. The concern here, I think, is legitimate. It warrants further investigation, and I look forward to working with the gentlelady on the other side of the aisle to come up with a solution, and with the gentleman from Louisiana that really does get to this unfair trade practice and create a level playing field for our American workers. We yield back.
I'm happy to yield what time I have left to the gentleman from Missouri.
Thank you. Thank you, gentlemen. Not many times in this committee can I say that I agree. I'll agree with the lady right next to me, but I'm in full agreement with this, and I look forward. We've had discussions into seeing where we can get in a compromise piece of legislation, and I look forward of a better piece of legislation where we can come, because this is extremely important to the manufacturers in the state of Missouri and throughout the Midwest. So I look forward to seeing the final product of where we're going to arrive.
I thank the gentleman. I do think that if we get these additional tools in place, and Ms. Ellard outlined some of them in the discussion of the what's in the bill, these will greatly enhance Customs' ability to lean forward and stop this before we're trying to chase money and chase these problems here in our borders. This gives us a much more forward-leaning approach to it. And so my conversations with Senator Wyden directly were positive. In fact, he even made a statement when they were discussing their version of the Customs bill, saying we're working with our House counterparts to strengthen and improve our approach to AD/CVD enforcement. So I think we're getting close to really getting a very good solution to this problem, which needs to be done. So with that, I will yield back.
Anybody else wish to be heard? Mr. Renacci, would you like to move the strike last word?
Yes, I would.
Gentleman's recognized.
Thank you, Mr. Chairman. I also agree. Steel plays a very important part in my district, and I spoke to the gentlelady earlier before, actually probably a few hours back, but I do think she is moving toward a right answer here and a right opportunity, and I'd like to be able to work with her also to move this legislation forward.
The gentleman yield.
Yes.
Yeah, and I also would like to get on that. Ms. Sanchez, I think you're heading exactly in the right direction. I mean, there's nothing that I think any of us could talk about. And when you go back home, this is crucial. It's not just important, it is crucial to our survival. So thank you so much. Doctor, thank you for working with us, and I think we'll be able to push this through and get the Senate on board. I'm really looking forward to this piece of legislation. Ms. Sanchez, thank you for bringing it up. Now I yield back.
Mr. Chairman?
Mr. Levin?
Just briefly to strike the last word.
Gentleman's recognized.
I think this has been a very constructive discussion. The Senate Finance Committee voted unanimously for this provision. So the problem in this case hasn't been on the Senate side. And so all of you on the majority side who have spoken, if you'll really work on this with us, we've been in favor of this forever, then we'll get it done. It's going to be up to you, to be very blunt.
Gentleman yield?
Yes.
I do anticipate a very frank, open discussion in conference. I do believe we will go and have a productive conference committee on this bill, and I think I'm very confident that we can all come out with a solution that I think everybody's going to like.
Good.
Gentleman yields back. Anybody else seek time? Does the gentlelady like to make her unanimous consent now?
I'd like to just briefly say that I'm heartened by the number of my colleagues on the other side of the aisle who see that this is a critical problem that we need to address, that are willing to reach across the aisle to work on it. I know I had conversations with Mr. T-Berry Bustani, Renee and Smith earlier this evening, and based on the assurances that I received that there is a sincere effort to work towards a solution to this problem, I will respectfully withdraw my amendment.
Gentlelady withdraws her amendment. I think, are there any other amendments? Mr. Pasquarello?
Yes, Mr. Chairman, how are you tonight?
Hey, it's great talking to you too.
Mr. Chairman, I reserve a point of order.
Point of order is
That was
reserved.
Mr.
Pasquarello. We're getting slapped. We're down to the last one here. The clerk will disseminate, and the gentleman is recognized.
Thank you, Mr. Chairman. Mr. Chairman, the last discussion precipitated by my good friend from California really centers around the subject of unfair competition. We talk about expanding trade through a number of new trade agreements. We also need to be talking about the impact expanded imports have on U.S. businesses, especially when those imports are sold in the United States at artificially low prices designed to undercut American companies or with the benefit of subsidies from their home government. We cannot compete on a world market if governments are subsidizing businesses in other countries in terms of the trade agreements that we've made. And we seem to be without any response to this. We talk about it a lot. But we know that we need international rules-based system. We need that. I don't think we have it. Our trade remedies laws have not updated to take into account the practices of foreign companies that have learned how to better evade and abuse our system. I introduced the Leveling the Playing Field Act, and I really don't like the word leveling the playing field, but I used it anyway, the term, because we say that so often, but we really don't apply it to anything concrete that's happening. How do we level that playing field? How do we make free trade fair trade? This act would restore strength to anti-dumping and countervailing duty statutes that allow businesses and workers in the United States to petition the Commerce Department and the International Trade Commission when foreign producers sell goods in the United States below market price or receive illegal subsidies. Importantly, these changes are all consistent with our WTO obligations. I think that what I'm suggesting here is included in the Senate bill. I'll stand corrected if not. This legislation will make a number of changes, such as enhance the Commerce Department ability to select appropriate facts available or adverse facts available when a foreign party fails to cooperate with the agency's request for information, addressing court decisions that have second-guessed Commerce's selection. Second, the legislation would also make a number of important changes to the manner in which the ITC finds that a domestic industry has been injured. The bill clarifies that the ITC shall not make a negative determination merely because the domestic industry is profitable or because its performance has improved. Third, directs the ITC to consider a greater number of injury factors, including gross profits, net profits, the ability to service debt, productivity, the return on investments, return on assets, and capacity utilization. 4, revises the captive production test for whether the Commission should focus primarily on merchant market sales when assessing the performance of a domestic industry. 5, clarifies how the ITC should consider whether subject imports are a cause of material injury. I know. And 6, provides guidance on the ITC's use of a longer period of investigation to include the first year from the preliminary investigation and a final injury investigation. This bill would clarify that Commerce's authority regarding the selection of voluntary respondents in order to reduce the burden on the Commerce during its cases. These types of changes are desperately needed by U.S. industries that are facing unfair competition from abroad. The main complaint I get in my office is this complaint.
Time.
I will.
Gentleman's over his time.
I will yield back.
Mr. Chairman, may I strike the last word?
Gentleman yields back the time he does not have. Gentleman.
May I strike the last word?
Gentleman from Ohio is recognized.
I know the gentleman from New Jersey's intent is heartfelt, and I share a ton of his concern. I really do, and would like to work with him on this. I will tell you that there may be, the way that this is drafted, some unintended consequences. I'll give you an example. I just found out earlier today that a group of retailers and other businesses within our state that import goods and services are concerned of the unintended consequences it may have on them and their employees, and I know that wouldn't be something that you would like to see happen. So, like the commitment I made to Ms. Sanchez, who I thought made a very good presentation as well, as the Subcommittee on Trade, you have my commitment and my word that I would like to work with you to try to figure out how to solve or work towards solving this problem, and I'll yield back.
Well, your word is good for me, Mr. I will withdraw the amendment if that's what he's saying.
Gentleman withdraws his amendment.
Thank you, Mr. T-Berry.
I think there's one more amendment. Mr. Bustani has an amendment at the desk. Clerk will distribute copies of the amendment, and the gentleman is recognized for the purpose of describing his amendment.
Thank you, Mr. Chairman. My amendment would ensure that post-liquidation interest received from payments collected under a customs bond is available where eligible for distribution to domestic producers in accordance with current law, the Continuing Dumping and Subsidy Offset Act. This amendment prohibits customs from transferring to the General Treasury any payment received under a bond so that it's available to be distributed to domestic producers where applicable. I'll give you an example. In Louisiana, just last year, Customs and Border Patrol made a decision that because it took an extremely long time to investigate and resolve an ongoing surety bond case involving Louisiana crawfish processors, that most of the $6.1 million it had collected would be applied to its own general late pay interest. Only then did CBP pay the remaining amount to the local processors that is rightfully owed to them. That's the wrong message to send to our domestic industry. Federal agency misbehavior and overreach should not be tolerated. I also want to inform my colleagues that Senator Thune was able to get this exact same amendment language included in yesterday's Senate Finance Customs bill because the honey producers in that state have also been affected by this. So I hope my colleagues will join me in supporting this amendment.
Ms. Noem, did you want to strike the last word? Ms. Noem is recognized.
Thank you, Mr. Chairman, for holding this hearing, and Mr. Bustani for bringing up this issue. I've heard a lot of issues from producers in South Dakota with China's abuse and dumping of honey. And as a representative of one of the top honey-producing states, this issue is of big concern to me. Now, there is an anti-dumping order in place, but Chinese producers are committing fraud by shipping their honey through other countries or blending it to avoid these anti-dumping duties. Our honey producers need these duties to be enforced. And of course, it's not just honey facing these problems, but a wide variety of other goods as well. Customs and Border Protection is making a rule change about the distribution of payments under custom bonds for anti-dumping and countervailing duties, but this amendment would make sure that collected payments would be distributed to domestic partners impacted by this as well. Our CBP works for our producers, and this amendment will reflect that. In fact, Senator Thune from South Dakota last night in the Senate Finance Committee was effective in getting this amendment added to the bill over there as well, and so I would ask for support for this amendment and urge my colleagues to do the same. With that, I yield back.
Gentleman yields back balance for time. Mr. Levin, did you want to strike the last word?
Strike the last word.
Gentleman's
Ms. Allard,
recognized.
is this, in your judgment, WTO consistent?
I'm sorry, Mr. Levin, I didn't hear that.
In your judgment, is this amendment WTO consistent?
That's a hard question to answer because, as you know, the WTO did rule against the United States with respect to the Byrd Amendment. But this amendment relates to a very narrow issue concerning the payment of interest. So therefore, it's consistent with commerce practice right now, at least at the moment, to be paying interest. It's changed back and forth. And there has not been a case brought against us on this particular issue.
Okay, thank you.
And this issue is something that countries do watch carefully.
Thank you.
Anyone else move to strike the last word on this amendment? The question is on agreeing to the amendment offered by the gentleman from Louisiana, Mr. Bustani. All those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it. The ayes have it, and the amendment is agreed to. There are no further amendments. The question is on the adoption of the amendment in the nature of a substitute as amended. All those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute as amended is agreed to. I will now recognize Mr. Johnson for the purpose of offering a motion.
Mr. Chairman, I move that the committee favorably report H.R. 1907 as amended to the House of Representatives.
The question is on favorably reporting H.R. 1907 as amended. All those in favor signify by saying aye. Aye. Those opposed signify by saying no. In the opinion of the chair, the ayes have it, and the motion is agreed to. Motion is agreed to, and H.R. 1907 is ordered favorably reported. Without objection, I ask staff to be authorized to make technical and conforming changes to the bill, and that members may have 2 additional days to file with the committee clerk supplemental, additional, dissenting, or minority views. There being no further business before the committee stands adjourned.
GAO doesn't think they work either.